here for law marathon, not regular class. So I hope we have studied something. You guys have revised something, you guys know. So it's more like, can I ask just questions instead of just revising? Sir, Avella Helre will just walk out. No questions, sir, strictly. In the entire marathon, no questions. I can ask. So I'll tell you what is going to be the approach, people. I'm thinking of doing it for 3 days. Today, I do not want to. Last time I had done everything in probably 1.5 day. So around 15 hours. That's like overburdening because we have some time. Let us take it a little slow. So what is that I expect from you guys? If you are done with something today, if you are finishing some chapters today, go home. Again, by the time you come for the next marathon, make sure you finish completely. So this entire marathon has to be like a complete revision for you. It's not like again you sit again, ayo macha, what happened? That should not be the case. Correct? So this acts as a revision. So from my end, I'll be trying to go letter by letter. There won't be difference between a normal class and this class. I mean, in terms of content, I'll be covering everything. So I won't leave anything. I'll be covering every content. Wherever possible, I'll be telling you where is a possible question expected, as well as any other thing which we can cover, we'll be covering. And towards the end, we'll also see there is no much amendments, so there is nothing predominant as such. So in the class only I tell you, I think I've covered also, I'm not sure. One we have already covered, but I'll tell you there are only 2 amendments that is applicable for you. And towards the end, let us also take up your RTPs that is relevant for your exam. That will be our 3rd day's agenda. Yes, so that is your study plan. So with that, let us start your marathon. And for the people who are watching the recorded marathon, first thing people, whatever is the material I'll be using in the class, because of IP issues, please don't ask for the soft copy. It won't be available. And even to place a hard copy, for with regards to law I'm speaking about, law might take a little time, probably another 20 days or so. So for your attempt, the chart books might not be available. But after that, probably by the beginning of May, first week of May, the chart books should be available. So, but still, even otherwise, I'll be using the chart books in the class. So this won't be available for you to download. Again, I'm telling you due to IP issues. Who is that, sir? IP? IP is that intellectual property. I think I've told you why I am again telling you this is because I know people will start asking, sir, please upload this material. I'm so sorry. I wish I could, but I'm not able to upload because in the past, there were incidents where I saw, few academies directly taking these and started teaching in their academies and colleges, which I feel it is not right and not okay also. So that's something which I don't like to happen. That's the main reason. So the materials of the soft copies and all won't be available. But otherwise, for people watching the marathon, if you guys have studied it somewhere else also, it's absolutely fine. The theory or whatever is a law won't change. Even for you, it might still be the same. So just sit, relax for whatever is the next few hours. Is clear all of you? Yes, sir. And macha, this is not regular class, marathon. I will try to cover everything, but don't depend on this and go and write the exam. I hope that is clear. Okay, so that is your what is that disclaimer, and whatever we are doing now is law marathon for new syllabus people. Agreed? That's your thing. Okay, done. So before I start, people, I hope we know the format, marks, how many parts. Yes, people. Part 1. What is your law bifurcation? Part 1 no part 2. D. Company law. Interpretation illa. And we have interpretation of statutes. Temperature 30. Idro 35, 40 idri. Oven agogutte. Okay. Yes, sir. So, yes, people, company laws and other laws. Company law, how many marks? 20, 70 marks and 30 marks. Do you guys have MCQ now? You have it, Do you have negative choice, I mean, what is that? Negative marking, You have, So what is one thing which we need to be sure of? You don't have negative marking people. Inky pinky ponky, mark everything the donkey. Correct? Huh? So people, everything is important. Even if it's alag bulak also. Who cares? RCB should win, that's all. So we don't know how and all magic or something. Correct? Same thing, people don't leave everything. So make sure you guys are attending even MCQs also. My approach of how you guys have to do it, whenever you're writing MCQs as well, when you know the answer, there only mark it off. Whenever you don't know the answer, somewhere just have a dot, go back, after writing everything, you have time, come and mark it. So wherever you think you're not sure, just keep it, because don't waste every second you have, don't waste everything in the first half only. Write off your paper, save some time. When you have some time, go and think the provision. You will have some time on, towards the end. So that's how you guys may approach. Agreed, all of you? Okay, done. So that is how your marks are allotted. So with this, let us start your what is that? Chapter 2. So I'm starting from company law. In company law, definitions, let us look at the last. Wherever there is a relevant definition, let us do it with the concept only, and anything left, let us do it towards the last. Okay. So chapter 2, people, it talks about incorporation of company and matters incidental thereto. Okay. Now you guys tell me, people, first of all, if I want to incorporate a company, now first thing you guys tell me, what are the different types of companies that are there in India? Indian company, what are public company? Private company, OPC, Section 8 company, Nidhi company, listed companies, unlisted companies. Okay. Now, what do you mean by a private company? If a person wants to start a private company, okay, how can he start? What and all he needs to know? What is a private company? Taka. Tell me, people.
Memorandum and articles limits the number of members to 200.
It restricts the transferability of shares, limits the number of members to 200. So in a private company, the maximum number of members can be 200. Equity or preference? Can a private company have 500 debenture holders? Debenture holders. Possible, then what is 200? So people, that is for members. Members includes, remember, throughout Companies Act, wherever you guys have seen, if at all the word used is called member, member always includes equity, member always includes preference. Correct? Yes. So debenture holders, there is no limit. So a private company can have 1000 debenture holders also. Agreed? Yes, sir. Okay, sir. In this limit of 200, certain people are not counted, it seems. Who are they? Whenever there are joint shareholders, the joint shareholders are not counted in the limit of 200. So whenever there are 3 people, imagine they have a demat account together, or 3 people are holding a certain part of shares together, then people, they will be treated as 1 and not 3. And the past and the present employees will not be counted in the limit of 200. Agreed? Yes, sir. If at all they're asking you, it may be a MCQ point of view. That's the maximum question you can expect. The third thing, people, can a private company invite public to invest in its company? Not allowed. They are not supposed to advertise about their shares. It is not possible. Only thing they can do is private placement and rights issue. Public offer is prohibited. So in a private company, 3 words you need to remember in the definition of private company. What is that? First of all, what is the definition? Which section?
Section 2 clause 69.
68 or 69? 68, sir. Section 2 clause 68, people, talks about a private company. 3 things you will remember. One is restrict, transferability of shares. So it's not prohibit, it's restrict. Why is the word restriction used there? Because a private company, if an existing shareholder wants to transfer the share, I'm not telling you are not supposed to transfer. You can still transfer. But the only condition is that you need to ask the existing shareholders first. Macha, I want to go out. Can you please buy my shares? If your macha, that is your existing shareholder, does not want to buy, then he can't stop you from selling it to an outsider. So that is a restriction. What is a restriction? Ask your existing shareholders first. If they say no, then you guys can go and you are free to ask the outsider. Is this clear? The next one is limit. The third thing is prohibit. So restrict, limit, prohibit. One definition is done na? Pakka na? Okay. What do you mean by a public company da? Private company. Sorry, public company is a company which is not a private company. But in public company, what question you guys can expect? In a public company, the question will pakka come that is revolving around a subsidiary company. Where and all it can be affected. Remember, the first way, direct way, there will be an impact. That will be in the case of small company. They can build a scenario. What do you mean by a small company? Define quickly.
Small company is a company.
First definition, whatever you guys can remember, according to ICAI guidelines, you are expected to write section number for all the answers. But macha, can we do it? Humko nahi chahiye. Whatever possible, remember. There are so many definitions. Can we remember everything? Not possible. Private company, important, remember. Small company, what is the definition? 85, important. What else is important, people? Subsidiary company, important. 87. Whenever you guys are getting confused, imagine you have remembered everything and you have gone. But in the exam you are feeling, macha, what is small, what is subsidiary? 85 or 87? Remember, all the sections are classified according to their alphabetical order. However, you check your dictionary. Remember that book, old days. How you used to check your dictionary. That's how even the sections are placed. Small, SM, subsidiary, SU. Which comes first? SM. That's why it is 85. SU. This is 87. In marathon, we are seeing all this. Okay. Understood? Okay. Now tell me, what is a small company? I hope there is an amendment and we know about it. Yes.
Small company is a company which has paid up share capital of 4 crore.
First point is important. What is a small company? A company other than public company. They do not directly say whether it is a private company or not. So what is a small company? Directly lawmaker said a public company can never be called a small company. Okay, a company other than public company. So a public company cannot be a small company. Okay, and which satisfies two conditions. What is that? A company whose paid up share capital less than 4 crore or less than a exact 4 crore. Can I call it a small company or not? Is it a small company? Correct. Yes, sir. So whenever you're remembering, remember that. So whichever company which has a paid up share capital not exceeding 4 crore and turnover not exceeding 40 crore. Agreed? Yes, sir. So, sir, 4 crore and 40 crore as the case may be. If at all it is exceeding that people, then this will be considered as not a small company. And the condition is and. Agreed? And certain companies can never be called a small company, it seems. Which are they? Section 8 company can never be called a small company, irrespective of their capital or turnover. And which company? Holding or subsidiary company. They can never be considered as a small company. Question can come here near holding and subsidiary company. Remember. Okay, third one. Which other company? Statutory companies or special companies which are governed by special act of the parliament. Even this also cannot be called as a small company. Remember, definition from MCQ point of view, very, very important. Agreed all of you? Yes. So this is the second definition, again important according to the concept. Okay. And the next one, sir, one more thing. A public company, I told you, we were talking about subsidiary and we went there. What is important with regards to public company, people? In a public company, a subsidiary company of a public company will be a deemed public company. Whatever are the regulations that is applicable to a public company, same regulations will also be applicable to that deemed public company. But the name and all will be written as private limited only. But with regards to the applicability of sections and a small company and all, these exemptions will not be applicable to that subsidiary company, even though it is a private company. Is this clear? Yes, sir. Okay, few people will have doubt there. That is done. Next one, what other type of company I can form? It's called as OPC. Taka. Tell me of all the provisions. What is a OPC?
are resident in India or otherwise.
Three conditions to be satisfied. First one is people, you need to be a natural person. The second thing is people, you need to be a citizen of India. The third thing, people, you need to be a
Resident in India or otherwise.
you need to be a resident, and they brought in one condition, that is resident or otherwise. Agreed? Yes, sir. Sir, what do you mean by this resident or otherwise?
Stayed in India for 120 days in the previous year.
You should have stayed in India for minimum of 120 days in the preceding financial year. Agreed? Sir, today's date, most of the people will have a question here. Now, what is that, sir? Whenever we are looking at this, can a NRI come and open a OPC in India? People, this is what is the realistic and real life scenario, people. Nirmala Sitharaman in her budget, why did she even give this? Earlier, people, it was 182 days. Why was it reduced to 120? Forget even about that. Earlier, you should have been a resident in India. Now that resident has been made resident or otherwise. Whether you constantly stay in India or not is none of our issue. Now imagine if at all there is Priyanka Chopra, technically a citizen of India. Now she married a person outside. Imagine, people, if she is still a citizen of India and she is staying abroad. She is not staying in India. Once in a while she comes. So technically, let us imagine she is staying for 60 days in the preceding financial year. Now my question is, can Priyanka Chopra open an OPC in India? Is it possible? She is staying only for 60 days. It is possible? Possible, people, because of the significant amendment called as otherwise. All of you, if at all they are asking you any question on OPC that is with regards to this, make sure you highlight this point to avoid any confusion. But you have to make sure that 120 days condition is also written in your attempt. Don't vaguely write off. Is this clear, all of you? I hope this is clear, all of you. Okay, this one condition is satisfied. Next one, people, if at all I want to be a nominee, even nominee should satisfy all these conditions. Nominee should satisfy all these conditions. Can a minor be a nominee? Minor. Minor cannot be a nominee, people. Why? On the death of the member, next nominee only will become a member. So people, a minor cannot be a nominee. Next one, people, the condition is whoever is the member and a nominee, they have to satisfy all these three conditions. So that is nothing but, people, even the nominee should also have to satisfy these three conditions. Agreed? Yes, sir. Okay, at one given point of time, one person can be a member in how many OPCs? Not more than one OPC. Can I be a member in any other company? Not a OPC. In a private, public? Allowed? Possible? Possible, people. The restriction only is for OPCA. So if I'm a shareholder in OPCA, I can be a shareholder of private, public and all. Possible. Nominee. How many companies can you be a nominee? I mean, how many OPCs can you be a nominee? One. At one point of time only, can I be a member and nominee of this at same given point of time? One member in one OPC, one nominee in another OPC. Can I do it? So technically, can I be a member and nominee at the same point of time or not? Huh? Possible, people. Then your answer should be yes, possible, and then will come the condition. So what is the condition? A person can be a member and nominee at the same point of time. It is allowed, provided you need to satisfy the condition. If there is a breach, meaning wherever you are a nominee, imagine the member pass away. You become a member of two OPCs. Now you have to quit one OPC within 180 days. That's the condition. Agreed? OPC cannot do certain activities, it seems. What is that? A OPC, very good point. A OPC can never be converted into a Section 8 company. Next one, they cannot do an activity, it seems. Book the top. That's what I said. Revision, no. One activity cannot be done. Which one? NBFC activity cannot be done. A OPC can never do a non-banking financial activities. Example, it cannot be a Muthoot, Manappuram. They cannot do it. Agreed? Okay, sir. Next one, sir. They cannot do one more thing. What is that? They cannot make investments in other body corporates. Not allowed. They cannot make investments. They cannot have subsidiaries and all. That is not allowed. Is clear? So there are three restrictions. What is that? Cannot convert into Section 8, cannot do NBFC related, and third one cannot do investments. Agreed, all of you? Yes. And always remember, whichever is the type of the company's name should mandatorily have the words OPC in the case of OPC, in the case of private limited, private limited, in the case of public limited, limited should be there in its name. Agreed all of you? Yes. Okay. So that's your definition part. I hope we covered OPC. Did we cover everything? Nominee's consent has to be taken, and a nominee can also be changed whenever they want. And always remember, in MOA, there will be some clauses. The last clause is called as nominee clause. The nominee clause says who is the nominee. Agreed all of you? Yes. Okay. Okay, we saw public or private or small company, a company other than public company having paid up share capital not exceeding 40 crore, and the 3 people can never be a small company. Okay, done. The next one, sir, subsidiary company will come back later. Okay, what is section 3A? Again, important, they can ask you a question. Remember, exam point of view, important. What is section 3A? What is the situation?
If the minimum number of members is reduced.
Okay, the question to you only. You guys tell me. A public company is there, people. A public company, how many minimum shareholders has to be there? 7. Private company, 2. OPC, maximum the
OPC 1.
OPC maximum is 1 na. Not audible, ada? Online, not audible. Stuck. Ram Rama. Is it clear now? Audible now? Low voice. Is it? Is it everyone? It's the same, ada? Is there any disturbance in video and all that? Is there a disturbance in the video or something? Has there been a lag or something? No. Okay. Discourage చేస్తావు కదరా నీ దాంట్లో ఇంటర్నెట్ ప్రాబ్లం రా ఓకే డన్ ఓకే సో we were looking at section 3A. Section 3A important from exam point of view. Okay, question to you. Imagine there is a public company. In the public company, technically there should be minimum 7 members ano. Because of some reason 2 members left ano. Now there are 5 members. So when 7 members are there, 2 people left. That means what happened to their shares? In those 5 people, 1 person purchased those 2 people's shares. Now technically you can imagine like this, 4 plus 1. This person purchased all the shares of the rest of the people. Now the company continued working even without those 2. So technically today there are 5 shareholders only. And how long did they continue the business for? They did the business for 1 year. Now my question to you, what is going to happen for all the contracts entered by the company in this 1 year? You as a chartered accountant advise, sir, you tell me what and all can happen.
For 6 months they have to correct it, nothing will happen.
So first 6 months there will be no liability. That is very important because people will be confused when the liability will start from. The liability will start from after 6 months for all the contracts that the company enters or continues after 6 months. Okay, that's the first thing. Second one.
After 6 months, whoever members are there, they will be unlimitedly liable for all the contracts.
So who and all will be liable? There's 5 members. Agreed? Yes, sir. No people. Remember, whoever is aware of the fact will be personally liable. Now lawmakers will come and ask, hey, you 4 people, did you know that those 2 people left? Ayyo sir, humko nahi pata hai. So people, the 4 people will not be touched at all. This 1 person will be called. Did you know that these 2 people left? Yes sir, I only purchased. Did you know that there should be 7 but there are only 5 shareholders? Did you know that? Yes sir, I knew that. A person who is aware of the fact that you are running with a less number of shareholders, this person will be unlimitedly and severally liable for the contracts post 6 months. Section 3A, very, very important. Exam point of view, mark a question there. This is the maximum that can come down. Nothing else can come. Clear? Pakka na? Okay. Next one, sir. That is section 3A. The private company, public company, incorporation of OPC. Towards then we'll see what is a promoter and all. And for people who were watching some questions here, there were some questions. Some questions can be there where there has been an amendment. For example, few people were confused with regards to small company also. Some questions were taken from past syllabus. So if at all the answer is different from what we discussed, it's okay because the answers are taken from the past syllabus. So if you guys are thinking, sir, small company, because it might have still 20, earlier the limits were different, 2 and 20, small company. According to that, the answers might have been given. So that 1 or 2 question, there is something confusion in that. I've deleted in the new material. Okay. Members severally liable, remember that. The important point is, see, people will be asking me, sir, in law, are we expected to write cut, copy, paste what is there in the book? Not required, but keywords are important. This is a keyword. Cognizant of the fact. Cognizant means the person aware of the fact. Is clear all of you? Yes. So remember that. So see, in short, only those members are liable who are aware of the fact, and unlimited liable starts from the contracts entered after 6 months of reduction. Okay. Next one, people, incorporation, MOA will come later. Yes, people, taka tell me with regards to incorporation. First of all, which is the form you will file for incorporation of the company? INC 32. It is also called as people SPICE plus. Okay, I will file SPICE plus. What is the procedure that you will follow when you are incorporating a company? What is the procedure? First, you will reserve the name of the company. Okay, and okay, when you are reserving the name, you need to have certain things in mind. That your name should not be. It should not be undesirable. It should not be similar to any existing company or LLPs or registered trademarks, and it should not government related, or it should not have the words like banking or insurance or telecom without taking the proper approvals. So if I have the word called insurance, I should have taken IRDA's approval. If I have the word called bank in my company's name, I should have taken RBI approval, as the case may be. Yes, sir. Agreed. Okay, sir. So first I will file this SPICE plus. In the SPICE plus, sir, there are various parts. The part 1 people will talk about your name of the company. Part 2 will talk about my incorporation of the company. So whenever I'm incorporating a company, there are certain things I need to keep in mind. What is that? First of all, you need to give all the details about the company, like the director's details, the promoters, that is the shareholders details, who will be the first director, their ID, address proofs, capital, object of the company, everything will get into this particular incorporation document. And finally, this incorporation, that is a document, has to be certified by one person. Basically, a declaration has to be given that everything is properly there, sir. I checked. ROCA, you don't worry, I have checked everything. One person is certifying that everything is right. Who is that? A professional. It can be a practicing advocate, chartered accountant, CS, cost accountant. So, sir, these people can certify that whatever is given in the format, is in the form, is true, and we have checked. You need to give a declaration. The declaration is given in a format or form called as INC 8. Yes, sir. So in INC 8, you guys have to certify that whatever is given is right. So that is called as declaration. Is this clear? Okay, sir. And next one, whoever are the first subscribers and first directors, they also have to give a declaration that, sir, we are not disqualified from any law. For example, you are not found guilty in the past for any of the fraudulent activities. I am not disqualified in the law. You have to give a declaration. Who will give this? The first subscribers and the first directors will give this declaration. They will give it in the format called INC 9. If they are asking you question on this particular incorporation, then try to have these particular names. It might add value. Yes, sir. And everything goes and sits in one form. That form is called as SPICE plus. Why is it called SPICE plus, sir? It's a acronym for Simplified Proforma of Incorporating Companies Electronically. Why is there a plus? Because there has been an amendment to the form. That's why there is a plus. Or you can also write it as INC 32. The form is same only. INC 32 in the industry has been given a name called Spice Plus. The name is same only. Is clear, all of you? Pakka? Okay. So, sir, you will be filing all these details. I will file all these details to whom? I will file it to ROC. If everything is fine, people, ROC will give me a certificate of incorporation. In the certificate of incorporation, he will clearly mention the date of registration, the date of incorporation, corporate identification number, a 21 digit alphanumeric number, and PAN details will also be there, TAN details will also be there, which will be certified by the registrar. Agreed? Yes, Pakkana? Okay, sir. So, SIN, date of incorporation, PAN, all these details will be given in your certificate of incorporation. If at all, sir, whatever the details given, we will be filing certain forms to ROC. If the details are not right or if the details are not adequate, there is few more information that ROC requires. What will ROC do? ROC will send you the form for resubmission. You will have to check, you'll have to correct all the documents and you have to file it again within 15 days. This process is called as resubmission. Is this clear? Pakkana. Sir, once the company is registered, once you get certificate of incorporation, now the company's characters will start. What is that? Artificial separate person, artificial legal entity, separate legal entity, perpetual succession. So all those company can enter into contract and all those things will come into picture. Yes, so quickly just look at the company's incorporation procedure. So incorporation, sir, section 7 talks about it. Stage 1, care to be taken in choosing the name 8A, 8B. Similar and it should not be, restricted or prohibited according to the government. Next one, sir, reservation of name. The name can be reserved for 20 days. If at all you do not, I told you, the spice will have two parts. Part 1, once you file part 1, if the name is available, the name will be freezed for 20 days. Within that 20 days, you have to file all other details. If you don't file all other details within 20 days, the name will be unfreezed. Anyone else can also apply for it now. Yes, sir. Okay. If at all it is for change of name, meaning existing company changing its name. In such case, the name will be reserved for a period of 60 days. Not so important, but okay, just remember. Okay, it is found that name was reserved by giving information. Okay, this is fine. You can leave it. Sir, stage 3, documents and information to be prepared. MOA, AOA, duly signed by all subscribers. Required, yes, sir. Next one, declaration by subscribers and first directors. You will be declaring it in INC 9. Not convicted of any offense in formation of company. You know what do you mean by not convicted? Convicted. Recently, one person is arrested. Yes, so many people are arrested, sir. Arvind Kejriwal. Now, Arvind Kejriwal is a CM. Can a CM be arrested and can still continue the government? No, people, CM is arrested. No, CM is arrested. He is in the jail. Can a CM continue the government when he is in jail? He is a CM. How will someone else continue? That's what. Now, then how come there is no one else appointed now? How come still Arvind Kejriwal only is the CM? The word is called people convict. Convict means people, it is proven that you have only done the offense. Arvind Kejriwal as of now is just arrested. Accused is the word. Accused means it is not yet proven. As long as you are accused, there is no restriction in any law on you. It's 100 people will be filing case on you. Just because case is filed, if I start disqualifying you, no one can run anything in the world. So accused does not have any disqualification. That's the word they are used. Convict. Convict means case has been proven. If at all, even against Kejriwal, if case is proven, he cannot continue. That's why he is still able to continue. Sitting in jail is passing orders. Okay. Not found guilty of any fraud during last 5 years. All documents filed is correct and complete. Declaration from advocate Understood? Yes. Subscriber and director details correspondent address of the officer. You remember, I believe I told you in the incorporation of the company, you can give the temporary address now. Later also, you will have 180 days time. Later, you guys can give a permanent address as well. It is your choice, which is okay. All the information is filed with ROC in form Spice Plus. Next stage, if all information is correct, certificate on the name of the will be entered in register of companies. Next one is order of tribunal. What is this, people? At any given point of time, it is proven that the company was formed by following or by giving fraudulent information. I have given my Aadhaar, but that's not right one. I have faked it. Sir, in such case, sir, if tribunal gets to know about it, the tribunal can pass these orders. What is that? If company is incorporated by furnishing false information, the tribunal in this regard may pass such order. What is that? For regulation of management of the company. You guys come down the directors, I will appoint the directors, or you guys will listen to what I say. Next one, sir, changes in MOA. Take your documents down. I will tell you changes. Make your changes. Whatever you said will not prevail going forward. Third one, liability will become unlimited. Till today it was limited, now it will become unlimited. Removal of name from registrar, meaning strike off. Directly come down. Next one, order for winding up. What is the difference? Here, the company wouldn't have even started the business. If they have started the business, you need to follow the liquidation procedure. It will not be so easy. Directly, you cannot strike off the name because the assets are there. Company would have started the business. If they have not started people, you will go for strike off. That's the difference. Yes, sir. And promoter and first director. Yes, sir. Okay. Commencement. What is certificate of commencement of business? Section 10A. Section 10A talks about certificate of commencement of business. Important from your exam point of view. What is certificate of commencement of business?
The director should file within 180 days. The subscriber to the memorandum have paid all their dues.
It is declaration filed by the directors of the company that two things are followed. What is that? Whatever our subscribers told that they will pay the money, capital, initial capital, they have paid, sir. Next one, the company has filed its registered office to the ROC. These two things you have to declare. Who? Directors will declare to ROC, sir, whatever we should do according to the law we have done. Can we please start the business now, sir? Okay, na, sir? Pakka, na, sir? ROC will say, go forward. Once ROC says go forward, now you guys can commence the business. Within how many days I need to file this, sir? You need to file this within 180 days. Sir, what will happen if I don't file it within 180 days? ROC may strike off the name of the company. It may lead to dissolution. Understood? Important. Remember section 10A. It's clear all of you? Yes. Okay, sir. Next one, sir. Steps for incorporation. No, anything which is very important. Okay, section 8 company, we'll come back to that. And whenever people, of course, if you have given fraudulent information, if it is proven that you have given fraudulent information, you will also be liable under section 447. Okay, effect of registration. Once a company is registered, you get certificate of incorporation from that day. Perpetual succession, whatever is your, you can acquire, hold, you can enter into contract, company can sue, can be sued. Correct? Yes, sir. Yes, correct. Perfect. Next ones are MOA. Okay, let's do it off. MOA, people. Taka, tell me, what are the different clauses? Everything with regards to MOA. Okay, MOA has totally how many clauses? Section 4. How many clauses? First one is 6 clauses. Okay, name clause. Name clause signifies what is the nature of the company. Name is known, nature is public or private. That is what is the significance. Second one, registered office clause signifies the state where the company is registered. Third one, capital clause. Third one is object clause. Object clause signifies what is the object of the company. Fourth one, capital clause signifies Authorized capital. Liability clause, correct. Whether the company is unlimited, limited, guarantee is signifies there. And the fifth clause is your liability capital we saw. Next one is your sixth one, subscription clause. Subscription talks about what is the first initial shareholders. What did they agree to buy? That is the sixth clause, subscription clause. Last clause only happens in the case of OPC, that is called as nominee clause. It's clear, Pakana. Any changes, sir, possible, you need to pass special resolution. Except one clause. Which clause? Object clause is also special resolution only.
Object clause within the same city.
Shifting also, yes, I will take it within the same city, allowed, possible. Next one is capital clause. When you are following section 61, you will follow capital clause, increase, alteration of capital. That also does not require special resolution. Ordinary is sufficient. Remember, we'll give a cross reference when we go there. Is it clear, all of you? Pakka? Okay. That is your MOA. Okay. Next one, people, is your AOA. AOA, what all will be there? Nothing is there. People, I am a company, ABC Private Limited. I want to make the provision applicable on my company stricter. How stricter, sir? According to the law, if I want to alter my object clause, technically if I want to alter my MOA, according to Companies Act, I need to pass special resolution. But in my company, special resolution, janta nahi. We need to pass unanimous 100%. Now I want to implement in this my company. You as a chartered accountant advise. What should I do? Entrenchment. How?
In two cases you can do, sir, at the time of incorporation or when we are conducting.
I'm already registered.
Already for private company, unanimous approval is required.
Agreed. If at all it's a public company or private company, you need to see, sir. In the case of public company, special resolution, sir. In the case of private company, unanimous. All the shareholders have to agree. Then you guys can do something called as entrenchment. What do you mean by entrenchment, sir? Whatever is the law that is applicable on my company, making that law stricter, more restrictive. They told me 75%. I'm making it 100%. So for that, this is important. During at the time of incorporation, you can do whatever you want. Post incorporation, if you have to do, you need to make sure if it's the case of private company or public company. Is it clear? That's very, very important. Okay, that's your AOA. Now let us see about alteration. Okay. Okay, MOA, there are those doctrine also. Let's see it off. Name clause, register office clause, okay, done. Okay, there are some three doctrines. What is the doctrines? Doctrine? Doctrine, ENT doctrine? Which doctrine? Tell the doctrines. Doctrine of ultra wires, constructive notice, indoor management. What do you mean by? Okay, I'll tell you a statement. You guys have to justify whether this is right or wrong. Ultra wires the company, intra wires the directors. Ultra wires the company, intra wires the directors. Can be ratified. The second statement, ultra wires the directors, intra wires the company. Can be ratified by the shareholders. Which of the statement is true? Second one. Justify what you mean by the second statement. What do you mean by ultra wires the directors, intra wires the company?
Directors, but inside the power of company.
Yes, madam.
That is not through the power, within the scope of company.
Okay, whatever is the actions done, it will be within the scope of the company, but it is beyond the scope of his power. In such case, sir, you can call for a meeting. He has already entered into a contract. If the shareholders agree, you can still ratify it. Agreed? Okay. So remember that statement is important. They may ask you a question there. What is the statement? Ultra wires the directors, intra wires the company. Important in that aspect. I'm telling you, there are so many things you would have studied. In that, what is that questionable point? These are the questionable points. Clear? Okay, whenever it's ultra wires contracts, people, it will end up becoming void. It is not enforceable. Company will not be liable for such contracts. Okay. Next one is called as doctrine of constructive notice. constructive notice can be merged with one more concept. Which concept? In charges people, they would have given you one thing. Imagine I'm entering into a contract to buy a property from a company. The company has taken loan on that property, but idiots never told me at all. I agreed to buy. On the date of registration, I'm getting to know that there is a loan on that document. Can I go and file a case on the company or not? Right? You don't support me? Drohis? So, constructive notice can be merged with the actual concept in company law. Why, sir? Once it is there in public domain, you are supposed to know that. That's only called as deemed to be aware of it. Agreed? Doctrine of constructive notice. Again, I'm telling you, see, these are generic points you might miss, but how they can merge with real life examples. Okay, third one is called as indoor management, meaning whatever happens within four walls and doors, outsiders do not have access to it. How do they know what did you discuss in the meeting? So, outsiders are protected from the company in doctrine of indoor management. In doctrine of constructive notice, company is protected from outsiders. Agreed? Yes, sir. Indoor management has three exceptions. What was that? Knowledge of irregularity, negligence, forgery. Knowledge of irregularity means if someone knew it, still he entered into a contract. That means what did we discuss? Anything happens within four walls. You are not actually aware of it, but you are aware of it. You still did it. Law will not protect you. Second one, negligence. I think I told you an example also. Anand Bihari Lal. The property.
Minimum efforts we could have got to know it, but we did not.
Imagine I will sell. This laptop is for sale. You will buy, This laptop this laptop, this TV and all is for sale. Will you buy, 10,000 rupees wholesale deal. Wait, Correct, What if you buy from me? It is your knowledge that you should know that who has right, who has no right. That's what is the case. In real life, one person purchased property from one company, and who sold it? An accountant sold it. Accounts department person sold the property of the company. Technically, it is your duty to check whether he has a right or not. That's what is the case law. Forgery. I told you, I have given you example also. In India, whatever is the story, however, you will feel still the person who is lost only. You cannot win the case. Indoor management won't apply. Great Fingal Ruben. A person will take inside share certificates, he'll sign all I would have told you. Okay, understood? Okay, articles of association, entrenchment, this is important. Private company, all members should agree. Public company, special resolution. Important, questionable point. Effect of registration, okay, commencement of business, done. Incorporation, done. Stage, done. Alteration of name of a company, very, very important. Can I change my company whenever I want? Possible? Once the company is registered, can I change my company's name? Can I change the company's name? Is it possible or not? There are two sections which talks about it. One is section 13(2). Next one is section 16. Section 13 talks, if at all you guys want to voluntarily change to some other, is it possible? Yes, you just have to follow the procedure. How? Special resolution, that's all. You have to call the reserve unique name, you need to follow all that procedure. Run application you need to file. The name will be reserved for a period of 60 days. And you need to call the shareholders, you need to pass a special resolution. All these conditions have to be satisfied. Yes, sir. Next one is section 16. What is section 16 talks about?
If our name is very similar to any registered trademark, then they should file within 3 years.
If at all the name of the company was similar to any existing trademark or any company, that company, now for example, let us imagine original company, duplicate company. So I'm already there. Arivupro is already there. One more person will come and say Pro Arivu. Yes, sir. Now is it allowed, people? Arivupro is there. Can I do Pro Arivu? Why not?
Identical.
So remember, whatever is the name I told you, you cannot rephrase the names and you cannot call it a new name. That is also not allowed. So Pro Arivu cannot be filed. Now imagine they did it off. Now they are telling me, sir, whenever Pro Arivu was incorporated, I need to go within 3 years of duplicate company getting incorporated. If I don't go in 3 years, sir, I lose my right of going and claiming this particular thing. Sir, I need to go and appeal where? I will need to file an application where? Central government, sir. I need to go and tell it to the central government. Central government will tell the duplicate company, after checking, yes, your name is similar, I will pass an order. Whenever central government passes an order, you need to change your name within 3 months. What if they do not change? What will happen? I will only give you one name. Nice, no sir, bumper offer, but the name will not look right. It will not look nice. It will say that central government's order not followed, regulation number, they will give, that will be your name of the company. You need to update it in all the places. Understood? Yes, sir. Sir, further, can I still change my name? Remember, according to me, that can be a question. Further, even after government changing your name can still be voluntarily changed as well. You are not stopped from doing so. Clear, all of you? So that's your entire name change provision. I hope that is clear. Alteration of name of the company. Okay. 3 years, 3 months. Correct? Okay, done. Next one, sir. Anything which we left? Section 8 company we discussed. You don't know Section 8 company? Then should we discuss? Okay. What is Section 8 company, people?
Promotion of commerce, art, culture,
Science? Illa. Research? Okay. So basically, people, there is no, can I earn profits, people? You can earn income, people, just that you need to put it back into the business. Possible question number 1. Can I give dividends? No. You need to put it back into the business only. It is prohibited from giving dividends. And they need not use the words limited, private limited in its name. Example, people, Reliance Foundation. Sir, whenever, if at all you want to function as a Section 8 company, you need to take a special license from central government. Central government is so busy. Central government, MCA is so busy. So MCA has given this power to ROC only. So today for you to function as Section 8 company, license will be given to you by ROC only. Agreed? Yes, sir. However, if you guys fail to follow the rules, certificate or section, or anything, if you do not so good, sir, then people, central government which has a right to give also has a right to take back, meaning they will take back the license given to you. And what they can do, they will pass an order. Which order? They may tell you, don't continue as Section 8 company, continue into some other form of business, private or public. They can order to convert the company's form of business. Next one is wind up. Next one, they can tell you to amalgamate with company having similar objects. Reliance Foundation merge with Infosys Foundation. That can possible. Sir, winding up, sir. Winding up means, sir, I'll sell off all my assets. Whatever is the money left, with that money, I will first repay all my liabilities. Even after that, if I still have my money left, what will I do? It'll, which does not belong to anyone, belongs to me, says central government. That is a fund created called as Insolvency and Bankruptcy Fund. Is clear? Pakkana? 100%? Okay. Alteration. This also can be important, people. If at all a Section 8 company wants to alter its MOA or AOA, anything they want to do. If you're a normal company, special resolution was sufficient. But if at all you are a Section 8 company, you need to take prior approval of central government to alter your MOA, AOA. Exceptions. Generally, every company will give 21 days notice. For these people, 14 days is sufficient. Minimum directors requirement not applicable. Independent director not applicable. They need not form nomination remuneration committee, stakeholder relationship committee. This is not there in our syllabus, so let us not know about it. Agreed? Okay. Next one, sir. Shifting the register office of the company. A company can shift its registered officer. Section 11. What is Section 11? Section 11 was omitted and reintroduced as Section 10A. That is only certificate of commencement of business. Section 12 talks about, sir, your registered officer. Now, we'll see that. Section 12, sir, shifting of registered office. Now, how will I can shift my registered office, people? 4 scenarios will come. The first one is, imagine if I'm in Bangalore, I will shift within Bangalore only. Next one is, one city to another within the same state, Bangalore to Mysore. Next one is, from within the same state, from one jurisdiction of ROC to another jurisdiction. This can happen only in the case of 2 states, that is Maharashtra and Tamil Nadu. So sir, and this can also happen, they will give you directly by Mumbai to Pune and Chennai to Coimbatore. That is the name, sir. So there are two ROCs in Mumbai, Pune, Chennai, Coimbatore. The scenario will also come there only. The last one, sir, is your one state to another. I'm going from Bangalore to, I'm going to Chennai. So sir, you tell me approvals, taka. Ordinary alla kano, board resolution is sufficient. Whenever I'm traveling from Bangalore to Mysore, what is required? Bus ticket. What is required? Special resolution is required. If at all I'm changing from Maharashtra to Mumbai to Pune, what is required?
Regional director.
Board resolution, no? Special resolution, no? Whenever you're writing, don't forget to write that is mandatorily there. And next one is RD's approval. The last one, sir, whenever I'm shifting from one state to another, all two there, sir, excess is central government. Central government is so busy, Nirmala Sitharaman ji, so they have given all this power to RD only. So technically here, though you will be writing as central government, the person who will be giving you approval is RD only. Pakkana. Sir, not only that, people, in the last case, you need to also take approval of creditors. Very, very important. Creditors, either pay them off or take no objection in the last approval. And sir, you need to employee, very good. You need to make sure no employee was removed in this transition. You have to retain them. They will leave, you can't do anything, but you have to give them an opportunity to continue. Clear? Yes, sir. Okay, done. Just that one timeline is given. Just see that. So special RD approval, the approval to be given within 30 days by RD. Within 60 days of him giving, the company has to file it with ROC, the approval given. And within 30 days, ROC has to reply to you that yes, you can continue shifting your address. Clear? That is the meaning of 30, 60, 30. 30 years is once I file an application, within how many days they have to reply? Within how many days you need to go? And within how many days again he needs to reply. Clear? All of you. Sir, and one more thing, there is something called as section 12.9. What is 12.9? What does it talk about, people? 12.9 talks about whenever you have given registered office address, ROC people, Papa wanted to meet you for a cup of coffee. I gave a sudden inspection. I came there, you were not there. Meaning, people, whatever is the address you have given, you should be present there. If you are not present, people, ROC can pass an order of strike off on the company. If at all on physical verification, it is found that the company is not carrying on the business in the prescribed address, ROC may pass an order to strike off the company. Important, again, 12.9. Remember. Yes, sir. Here there is one amendment also in rules. The amendment is not directly applicable for you. ROC off late, earlier and all they used to say, he used to just strike off the company's name. Now, what is the guarantee? ROC did not do it wantedly. What if some grudge is there? So they introduced an amendment. What is that? ROC has to take a signature on the order he passes from the localites. Now imagine my company, he is coming and telling, in this address he is not there. You need to go and take a approval from my neighbors, next building or up floor. They need to take that, yes sir, ROC had come, Arivupro is not there here. You need to take a declaration. They have added it, that's all. Clear? Not there for us, but just remember. Yes sir, in what else is important? Can a subsidiary company invest in holding company? Can a subsidiary company hold shares in holding company? Section 19. Can a subsidiary company hold shares in holding company? Which what are the provision? What are the exceptions? As a legal representative, meaning, let us imagine, I am a shareholder of one company. There is some company called as Infosys. Infosys has a subsidiary company called as Edgeverve. There is a subsidiary called as Edgeverve. Yes, sir. Now, I am a shareholder of Infosys. Who? Mr. X is a shareholder of Infosys. Mr. X has written in his will, after I die, all my shares will belong to Edgeverve. X died. All the shares went to Edgeverve, which is a subsidiary of Infosys. Is it an exception? Yes, allowed. It is an exception. But one exception is there? No, we'll see. Is this clear? First one. Next one, people. As a trustee. So, a subsidiary company can be appointed as a trustee to take care of the shares of the holding company. Possible. Third one, I was a investor even before I became a subsidiary. I already had shares in your company. That's a third exception. So I was already a shareholder. Correct, sir? Now, with regards to voting rights, in these three cases, one case does not have a voting right. Which is that case? That's the important MCQ question.
Trustee.
As a trustee, you cannot vote,
As a trustee,
or as a legal representative, or online. One case you guys cannot vote. Subsidiary company will not have a right to vote in the meetings of holding company. In one what is that criteria?
trustee.
Was already an investor, The online, Hey, this civil work will be going on, usually also, Drilling. No, it's fine, correct. Do you guys listen? Is this audible to you also, This is drilling and whatever is the, No? Okay. Good. Yes, people. What is the question? In one case it is not applicable. Which case? Trustee, legal representative, or already a shareholder? Logically think, people. Logically think. Logically you think. Trustee, logically you think. I had given you one note also there. That also. That's what. Okay, see here. Such subsidiary company shall have a right to vote at a meeting of the holding company only in respect of the shares held by it as a legal representative or a trustee. Meaning, I have a right to vote as a legal representative, I have a right to vote as a trustee. I don't have a right to vote only in one aspect. For what is that, people? Because logically think that is the only thing that is I'm holding in my capacity. Rest of it I got through others. So technically it is not mine. I'm just a caretaker. But this is mine only. So I cannot exercise my right on the shareholdings I hold because I have been controlled by holding only. He will vote in mine, I will vote in you. What logic? That loop? That's a reason. That's a logic. Clear? Yes, okay. Section 18, sir. That is section 19, important from exam point of view. Remember. Next one, section 18 talks about conversion of company. Not so important for us. Private company can be converted to public company can be converted to private company. It's actually rules is very vast. The rules are not there for us. So what is there for us? Yes, it is possible, it is allowed. Alter your MOA, you can convert, it is absolutely allowed. The only thing that you need to know, after conversion also, the liabilities, assets, court cases will continue. That will not come to an end. Yes, sir. Okay, certificate of commencement of business we saw. Covered, register office of company we saw. Alteration of articles. A company by special resolution can alter its articles as well as MOA. Okay, let us go to the next section 19. What is section 20? This is important. One thing is important there. Okay. Service of documents, sir. What do you mean by service of documents? Whenever you want to give any notice or any document to a company or to a person or to the registrar, how can I give it, sir? If you want to give it to the company, you can give the document by registered post or speed post, or you can give it by courier, or personally you will go and give it to them. That is leaving at its registered office. Fourth one, by means of any other electronic mode, meaning you will have no investor grievances or ROC we saw. What is that? Launching complaints. You have your own designated, for example, Arivu, you have tickets. We have created a website for you to communicate to us. You have to communicate through that. That's the electronic mode. Understood? Yes, sir. Okay. If you have to service, if you have to send any document to the registrar or member, then what and all are the modes allowed? One is post, registered, speed, courier, by delivering again. Everything is same, people. One extra post only will come. I hope we have discussed in the class what is the difference between ordinary post, registered post and speed post. Correct? No? That we don't know. Registered post is nothing but at the end, the postman will take a signature from you as an acknowledgement. That is called as registered post. Ordinary post acknowledgement will not be available. Generally, when will we send registered post? Whenever whatever is the content sent is very important, like credit cards, money orders, is what will go under registered. Ordinary, all your something and all you will be getting no magazines, any magazine you will get no subscriptions. Your ICI also you will. So they will not take a signature from you. That is when all comes under your ordinary post. People, important thing here can be, now imagine a company will send to all its shareholders notice of general meeting by email, but I am a shareholder, I am requesting a company to send it to me by post. First of all, is the company under an obligation to take my requirement? Should, can't they reject it? Can't they say I am giving everyone by email, why should I give it to you by, can I? But what is the complete criteria? If a special request is made, so whatever is the fees made, sir, that has to be paid by this particular person. Then in such case, whatever is the mode I am requesting to make, the company has to make it in that mode. Note, however, a member may request for delivery of any document through a particular mode for which he shall pay such fees as may be determined by the company in its AGM. Clear all of you? Yes. In the case of Nidhi company, 1,000 rupees, remember 1,000, imagine I exactly hold 1,000. Can I request for physical mode?
More than 1,000.
Kalla. Yes, sir. Remember, that's why I always tell you in exam the actual thing is not the 1,000, the word previous to 1,000. Always the question in your exam will revolve around the word before the limit. That's the word. Okay. Now, a Nidhi company, the document may be served only on members who hold shares of more than 1,000 in face value or more than 1% of the total paid up share capital, whichever is less. For rest of them, it will be newspaper. But for these people, physical mode will be served. Okay, done. Sir, in case of delivery by post, within how many days will it go and reach?
First we have that 48 hours and then
48 hours. This is how it will connect section 101. That's why there you say, what do you mean by clear days? When you are calling for a general meeting, how many days in prior you will call? 21 clear days. And why are you exactly adding 48 hours there? The reason is this. In the case of notice of a meeting, it is assumed that by the end of 48 hours, the post will reach. Whether reached or not is not our scenario. Technically, that is the maximum time. So 48 hours, this is the logic. That's why we add 48 hours in section 101. Clear? Yes, sir. Okay. In any other case, as the case may be. Okay. Authentication of documents. Wherever a company has to sign, on behalf of the company, someone else will sign. Who is that? It can be KMP or any other officer authorized by the board. Okay. KMP, sir, who and all are KMP? CEO, Managing Director, Manager. CSO, whole-time director, CFO, such other officer, one level below the board and who is in full-time employment and designated as KMP and such other officer as may be prescribed. Clear, all of you? Okay. Next one, sir, execution of bill of exchange. Meaning, sir, if I want to sign a check, promissory note, bill of exchange, sir, all these, how do I sign, sir? You need to appoint a person to sign these things. Now, how do I have to appoint a person, sir? If you have a common seal, you affix the common seal and say, going forward, Mr. A can enter into a contract or he can sign a check on behalf of the company. If not, if common seal is not there, then two directors, or if a CS is there, one company secretary and one director, they will have to sign and nominate a person. Correct? By this we complete your second chapter. Yes, people. You will understand it, I hope. Revise that, Revise that, ఏమో చెప్పావు చెప్పరా, ఏమో చెప్పావు కదరా, ఉట్టి వాణికి మాత్రమే.
1 hour లో మనకు బాగుంటుంది.
1 hour లో మీకు కూడా రివైజ్ చేసేకి వస్తేనా? You will do. That's what I told you. Now see, you guys would have already done for one time. How many times revised it? Huh? Many times you have revised. So if you guys have already revised for one time, now this will act as your second time. Now as soon as you go to your home, that is what you need to do. Immediately go through everything. That's what I told you. See, my marathon name itself is marathon, but how I do, I try to cover the maximum content. If you see, if you play 1.5x your first chapter, every detail whatever you have seen in first chapter will be there in marathon also. Even the questions you would have seen in the class. Agreed, huh? Huh? Questionable points or whatever it is. So you guys have to take it forward. Okay, Taka will finish off the next chapter also. Chapter 3. Revised, huh? Yeah, we revised everything, sir. So tension mat le. Correct, Oda? Law, I'm telling you, 100% you guys can get more than 60. 100%. In professional exam, I'm sitting and I'm telling you, I'm not sitting in 10th BCom and all. In CA exam, I'm telling you, you guys can get 60. Pakka. Just read and go what I've given. 100% sufficient. Even your notebook can be sufficient. Huh? Is that AC working, Ada? Huh? I don't think it's working.
No, sir, it is working.
Okay. Yes, people. Okay, let's start with next chapter. PAS, Prospectus and Allotment of Securities. Okay. So first thing, sir, section 23. Section 23 talks about public offer and private placement. So whenever a public company wants to issue securities, they can issue securities by going for public offer, private placement, rights issue, bonus issue. The word public offer means, according to section 23, Allah, IPO, FPO, OFS. These three words are called as public offer itself. What do you mean by IPO? Da? Initial public offer. When a company for the very first time, if they issue securities to the shareholders, that is called as public offer. FPO. I'm already listed, sir. I want to raise more money. I will issue more securities. That is called as FPO. OFS. Existing people selling shares to the shareholders is called as OFS. OFS will be seeing in detail when we are seeing section 28. Okay, so public offer and private placement. So we saw a private company can raise money. How in all? Private placement, rights issue, bonus issue. I can't do any other thing. Offer for sale, can I do it or not? No, okay, people, here is the amendment. Amendment number 1. What is that, sir? People, now whenever a company wants to issue securities, yes, now here I'm only speaking from Indian context. Now my question is, can a company issue equity shares in America? Let us imagine Infosys company. Can I go and issue direct shares in America? Huh? Depository receipts. So indirectly what used to happen, our government only, when our company is trying to grow, we do not have a proper instrument or a proper section which covers this growth. So what did our government do? They added 2 subsections here. And what is that they added? They added section 23, subsection 3. I think this was seen in your book or I don't remember. Now what did they do, people? Earlier, if you want to raise money from international market, you had to issue something called as GDR. Remember, GDRs were there. So you had to issue GDR earlier. Now what did they do? Why not to issue that instrument, this instrument, convert it to equity share? Why all that? Now I'm giving you an option. Directly, if you want, you can issue securities even outside India. List it on any stock exchange outside India also. NASDAQ. Go and list there. Why only NSE, BSE? They added a provision. Now what is that provision? See here. Or else you would do one thing. Write this particular thing down. 23 subsection 3. This is the amendment. The amendment says such a class of public companies Such a class of public companies may issue such a class of securities for purpose for the purpose of listing on permitted stock exchange in permissible foreign jurisdiction. And there is 23(4) which says a central government may exempt any class of public companies given under 23 subsection 3 from chapter 3, chapter 4, section 89, 90, section 127. They said you guys know everything, it seems, these chapters and all.
Chapter 3, prospectus and allotment of securities.
So this is nothing but the chapter you are doing now, prospectus and allotment of securities. This is share capital and debentures. 89 and 90, beneficial owner and significant beneficial owner provisions. 127, failure to pay dividends. Penalty on failure to pay dividends. That's fine. But one thing I told you, that one section remembered. Penalty skipped, sir. The entire thing. Why 127 is important? Because generally, if at all you declare dividend but you do not pay the dividend, you will be punishable except certain scenarios. That is covered in 127. That is important. When we go there, we'll see. Is clear, all of you? Now, what is the amendment, sir? Section 23, subsection 3, till now, in section 23, they said a public company, if they want to issue, they can do IPO, FPO, OFS, private placement, rights issue, bonus issue. Now, if you want, you can also issue securities outside India also. Listed there also. Section is allowing you to do. Who, sir? Everyone, sir. Such a class of public companies. The rules are yet to be prescribed. But what is at such a class and all? Not in our syllabus. So don't worry. But not every company, only certain authorized companies can go. They will have requirements and all. They will have limits and all. Only they can go and do it. Okay. Next one. Impermissible. Okay. Listing on permitted stock exchange in permissible foreign jurisdiction. Don't say I'll go and list in Pakistan, Afghanistan and all. Obviously, it is prohibited. Our country does not allow you to do. That's the word you use, permissible foreign jurisdiction. Sir, central government may exempt. Now, whenever you are doing all these sections, it may so happen that we will not be able to follow certain chapters. That's the reason they are saying, for the operational convenience, I may exempt you. I'm not saying I'm already exempting you. As the case may be, I may exempt you from this chapter. Why, people? Why? Logically think, if I'm issuing securities in NASDAQ, take New York or some London or anywhere, hey, I'll have to follow his law. Why will I have to follow my law? His prospectus I will follow. His shareholders' interest he will take care. Why will SEBI come and poke its nose? That's why they're telling you PAS is not applicable. Share capital and debenture is not applicable. Because you will follow there. Next one is 8990 BO and SBO provisions. Next one is your 127 failure to distribute dividends. Punishment on failure to distribute dividends. Clear, all of you? So this is the amendment. Remember. And there is only one more amendment, that's all. I think we did this in the class, I'm not sure. We did it, huh? Huh? Material is there, no? Da? Material is there means we have done or not, da? We did, huh? Because I remember somewhere telling it, I'm not sure. Okay, done. So that's what we saw. Okay, next one, section 23 is done. Next one is prospectus. Whenever I want to do a public offer, I need to do it mandatorily through a document called a prospectus. Prospectus means what, sir? Section 2, subclass 70 defines a prospectus as any document issued as prospectus. It includes the shelf as well as red herring. Any notice, circular, advertisement, whatever you issue into the inviting offer from the public is again called as prospectus only. Now, Taka, tell me, what do you mean by red herring prospectus?
Prospectus, which does not have complete information about the price and quantum of the area.
So, sir, what do you mean by red herring prospectus? This is a prospectus which has all the information in it, except two things. One is people, price of the shares won't be there. Next one, people, quantum of the shares won't be there. How many shares or the price of the shares? These details won't be present in the prospectus, except that people, all other details will be present in the prospectus. Why is this, sir? I told you in the class we will be doing to decide the price. That is only called as book building issue and all we had seen. Example of Zomato, price band and all we had seen, 72 to 76. Something and all we had seen. So, sir, so always remember, this is not a complete prospectus because some information is missing. Once the offer is complete, you need to file one last document to the ROC informing, sir, now take the details, sir. This is the price I issued it. This is the shares I issued. You will finally give one document to ROC. Now everything put together will become a prospectus. Understood? Pakkana? Yes, sir. This is called as what, people? Red herring prospectus. The next document is called as what, people? Shelf prospectus. What do you mean by shelf prospectus? Whenever there is a company which wants to raise money, not at once, because opportunity cost is there, your FM is there. If I keep everything, my return of capital, my earning per share or whatever it is, it obviously goes down. Cost of capital is always there. So certain companies decides to raise as and when they need. But every time should I issue prospectus? Not required. So issue a prospectus called as shelf prospectus. Why is it called shelf? Because this other shelf. Allah, idallo. Allah, shelf. Adikadra. So sir, ingandra out dreaming. Sir, shelf prospectus means what, people? It has a shelf life. Shelf life means, people, it is valid only for a period of 1 year. 1 year from where? 1 year from the day the first offer is made. So once the first offer is made, you need not have to make any further prospectus. Only the first prospectus is sufficient. So what if, now imagine first offer is made. I again wants to raise more money. So it is second offer, third offer, fourth offer, all this is happening. So every time you are telling me not to file prospectus, that time what I need to do, sir? I need to file a document called as information memorandum. Information memorandum is filed in the form PAS2. Sir, in information memorandum, what will be there? Any new charges created when compared to my first offer and second offer. Have you taken any more loans? You disclose that information here. And change in financial structure. Financials, if at all there is any change, disclose that in a document called as information memorandum. That is called PAS2. Important, remember from your exam point of view. Clear? Yes, sir. Okay. Okay. We'll do a deemed prospectus, Yes, sir. Okay. What do you mean deemed prospectus, sir? Because people, whenever you're doing anything, whenever a company is issuing prospectus to public, the SEBI is trying to protect the interest of the shareholders as much as possible. So now what did another company do? Another company thought of a way, instead of directly issuing it to the public, they wanted to issue a mediator, a third party in between. So I am not issuing it to public. I will not call it as a public offer at all. So what did they say? Remember, even if you give directly to public or if you give it to a mediator, middleman, agent, and then he gives it to public,
Whatever you do, if at all this way or this way, whatever document you used, it will be called as prospectus. Meaning what? This middleman would have used one document to sell shares to people. Huh? This will also be termed as prospectus. Sir, what if it is termed as prospectus? Whatever are the obligations applicable to prospectus, everything is applicable to this document as well. Clear? Yes, sir. Pakka na? Okay, sir. So, when is that applicable? See here. Any company allots securities or they enter into an agreement to allot. They are entering into an agreement today with a third party, middleman. To a company or a firm or any other person, that's the third party. We are agreeing to give it to the third party, the shares. What is the intention? The intention is to that the third party will further give it to the public. How are they giving it? They are giving it through a document. So, if at all they are using it through a document, then they are telling you the document shall be deemed to be a prospectus. When two conditions are there, either of the condition has to be satisfied. One is satisfied also, it will be called as what people? Prospectus. Agreed? Now, what are the conditions, sir? Now, the question is, sir, imagine there is a company called as Company Y who wants to go for public offer but not directly. So, what did they do? They gave it to a middle person, that is an agent. Now, this person is further selling it to the public. Now, sir, this person is using one document to sell the shares to the public. Now, when will this document be called as a deemed prospectus? One question they will ask you, what? You, middleman, when are you selling the shares? Sir, I took the shares from company Y on 1st January 2024. Okay, when are you selling the shares? I am selling it to the public on 1st February 2024. You took the shares last month and immediately you are giving? No, it will be called as prospectus only. Why, sir? First condition, people, within 6 months, if at all you sell any shares you got from the company, it will be deemed to be a prospectus. Meaning, until 30th June, he is not supposed to sell one share also. Understood? Second condition, sir. Sir, second condition, okay, I should not sell it by 30th June. Okay, take, sir, 1st July 24, I am selling. Okay, now can I sell? Will it be called as prospectus?
But in all consideration was not restricted.
Sir, the second question I will ask you is, hey, you sell whenever you want, but one thing, how many shares did you take? How many shares? I just took 500 crore shares. 500 crore shares. Have you paid money? No, sir. How can I get money for 500 crore shares? I will take from them, I will give it to them. Then no, 6 months, never. Until you pay the complete consideration. If you cannot further issue to public. If you have paid the complete consideration, then you are free to sell. So indirectly, minimum freezing period is 6 months. Meaning, sir, on 1st January I took, 1st January only I paid out the entire consideration. On 2nd January I can transfer it to public. Not possible. First condition is there, 6 months. Why logically think someone, his money for around 500 crore shares gets blocked? How will you function? Impossible. Shares I am telling is 500 crore. Money? What is Reliance Capital? 600 crore shares. 660 crore shares are there. Shares amount Allah. Now multiply 3000. That's the amount. That's why Mukesh Ambani ji, Akash Ambani ji, engagement happened. Salman Khan danced. Pre-marriage, pre-wedding, sorry, pre-wedding, Salman Khan, Amir Khan, Shah Rukh Khan danced. And after 3 days, they said it's not wedding, it seems. Wedding is in July, it seems. Only Ambani sir can do. Amitabh Bachchan is coming to serve, Shah Rukh Khan is coming to serve. They can only do all that. Correct? Because that's what it says. Remember, in that, how many shares they have? Yes, okay. Got it? So, provided following conditions are satisfied. What is the condition? Such offer of share was made to public within 6 months of allotment or agreement, or on date of offer, the whole consideration in respect of securities had not yet been received by it, or it is any one also. If it is satisfied, it will be called as a prospectus. Clear? Sir, what if it is prospectus? All the disqualifications. Basically, liabilities will apply to this document also. Like matters to be stated. Section 26 will apply. Section 34, 35. Criminal liability, civil liability. What is 36?
Yeah, 36.
Huh?
36. Oh, 1 minute. Such a bit.
36, 37 no
Fraudulently inducing people to
invest money. 36, 37 no everything talks about liability only. Yes sir, class action suit also will come. Yes sir, we'll see that. Sir, what if it's a prospectus, sir? If it's a prospectus, if the document is deemed to be a prospectus, then people, someone has to sign. Who is that? A third party. Who are you, da? If you are a company people, at least 2 directors has to sign the document. A third party, if you are a partnership firm, at least half of the partners has to sign. Clear? Pakka na? Feeling cold, da? No. Anyone feeling cold? No. Okay, done. So this is your section 25. Okay, the next one will do of matters to be stated in prospectus. Nothing is there. What are the matters to be stated in prospectus? First thing is, whatever is the information SEBI tells after discussing with central government, that information you need to mention. But what is that? As of now, nothing is mentioned. So you need to give whatever is given in SEBI Act. That information has to be disclosed. Indirectly, they have said, don't follow Companies Act to follow SEBI Act. Clear? Okay. In that also, they have said, until SEBI specifies SEBI Act 1992 in respect of financial information and reports on financial information shall apply. However, the content, that is 26.1 will not apply in 2 cases. According to me, this is important. 26.2 is important. If at all I am issuing shares to public, still I need not disclose whatever is given in 26.1. When is that? Whenever you are doing a rights issue. Meaning for your existing shareholders only you are giving more shares. Why do you have to again give the entire history? For example, you guys came for the second module. Again they gave you prospectus. Again they made you sit in that chamber. Again did they show you everything? No, because you are already known. That's what is rights issue, no? You are already here. Why should I again explain you everything? Agreed, Okay. Next one, sir. Issue of prospect. Yes, sir. Now, recently I had done a IPO, sir. Again I am doing a FPO. The terms are similar. Nothing has changed. Even in that case, the financial information need not be disclosed. Obviously, because nothing has changed. So one is rights issue. Second one, nothing has changed in this time. So it is uniform with the previous issue. In these 2 cases, 26.1 is not applicable. Do online no? 26.1 is not applicable. Understood? Yes, okay. 26.3, date indicated. Basically, in the prospectus shall be deemed to be the date of publication. What is the date you put in prospectus? That is the date it is coming into picture. Prospectus shall not be issued until it is filed with ROC. So before you give it to SEBI, you have to first give it to ROC. Once you give it to ROC, within how many days you have to give it? The validity period is 90 days. Clear? Prospectus shall not be valid if it is issued after 90 days from the date of filing it with ROC. Next one, sir. 26.5. Expert statement. Meaning what? Sir, this IPO, sir, bet my life, sir. You will become crorepati, sir. You will become Lakshadipati, sir. You invest in this IPO, pakka. So if someone is coming and telling you that, sir, this IPO is pakka hit, that person is called as expert. Meaning someone is telling you, hey, believe me, da. So he's an expert only, no? So he will be made liable. If you remember, civil liability, criminal liabilities. Civil liability, his name will come, expert. Yes or no? Prospectus not to include expert statement. Generally don't put. Unless, meaning in these cases you can put. When he is a person not engaged in the formation or promotion or management of the company. Meaning, if at all I am only the person who started the company, if I am the person who helped you to start the company, if I only am an expert, then you are being partial because it is your company, then expert statement cannot be put. That means they are telling you, you should not be involved in the company. Then you can put your expert statement. If you are involved, expert statement not possible. Next one, gives us written consent that okay, you can take it. So before giving my, before they put my paragraph in the prospectus, I should have given my written consent to put it. Next one, not withdrawn such consent before delivery of prospectus with ROC. Before I give it to ROC, I should not take back that consent also. A statement to that effect shall include in the prospectus. I am agreeing, I acknowledge all these points, I have to put it in the prospectus. If all these are allowed, then I can put a expert statement. Clear? Simple? Done. Next one, let us do of misstatements in, okay. Whenever there is misstatement in prospectus, sir, 26 I have given. Section 26 says, what and all the information to be maintained in the prospectus. What if the information maintained in the prospectus is fraudulent, not true? Sir, in such case, what is going to happen? Whenever such things happen, people, you will be held liable specially, mainly under two sections, sir. One section is called 34. One section is called 35. Criminal liability, civil liability. Under criminal liability, people, they say go to 447. Under 447, they will collect some penalty from you. Give it to government. And Macha, you have done such a big sin. Go and sit in jail. And is mentioned. It is fine and penalty. Is cross-checking. Clear? Yes, sir. In civil liability. Civil liability. Now people, imagine a company gave a fraudulent information. I saw the fraudulent information and I invested in the company. I lost money. You are telling you are arresting him. Okay. You are telling you are taking penalty from him. Okay. What am I getting? I lost money. That's why civil liability comes into picture. Civil liability acts as a compensation. Whoever has lost money, you will be unlimitedly liable to repay that money. Understood? Pakkana? Okay. But can you get yourself excused from these liabilities? Grounds are important. You believed it to be true or you withdrew your consent? Yeah. So sir, first one is criminal liability, section 34. Every person who authorizes that issue shall be liable under section 447. If the person proves that such statement or omission was immaterial. So I am telling you did not give this information. If you can prove that it has no significance, then you can leave it. Next one, he had reasonable ground to believe up to the time of issue that the statements was true. That's why I gave. Or such inclusion or omission was necessary. So you need to prove that what you have given is right. Then yes, you will not be liable. Next one is section 35. Where a person has subscribed to securities relying on any statement. So I have purchased the securities by looking at the prospectus. Here people had, in the class, we had seen bunch of questions. Remember,
Yes, sir.
Yes, sir. We will not look at you, sir, but we will say yes, sir. We had seen some questions. People remember, civil liability will come into picture only in the case of primary issue. Meaning, imagine Y saw the prospectus and purchased the shares. Y purchased it. And from Y, Z purchased it. Meaning, Y transferred it to Z. But there were misstatements in prospectus. Z cannot get civil liability. If at all you need to get civil liability, you should have purchased directly in the stock exchange. Secondary purchase will not be covered under this. Important question, exam point of view. You saw that series of questions were there in the class. Okay. In the prospectus which is misleading and suffered loss, then the company and every person who is a director will be liable, has authorized himself or becoming a director will be liable, is promoter of the company liable. So director, proposed director, promoter, has authorized issue of prospectus, is an expert as given in 26 by. We told you don't give. He said no, humko chahi hai. Then take. We are giving you the liability. Clear? Yes, sir. Okay. If it is proved that it has been defraud the applicant, then personally and unlimitedly liable. Exception, people. What is that? That he withdrew his consent to become director before issue of prospectus. How is this point related? If you remember section 26, who has to sign the prospectus? A proposed director, a person who is proposed to be appointed can also sign. But that person resigned. He took back his consent. I don't want to continue as a director. That person will not be liable, provided he takes back his consent. Next one, that prospectus was issued without his knowledge or consent. On becoming aware, he forthwith gave public notice that it was issued without his consent. I did not know that they went. I saw that there is irregularity. You have to directly give a public notice. Next one, that the statement made by expert was correct and fair to his knowledge. So all of us will sit here, professionals. Clear? Sir, fraud for 447. What is a fraud, sir? If at all the amount involved is a 10 lakh or 1% of the turnover of the company, whichever is less, then you will be punishable with
Fixed or less than that.
minimum 6 months, maximum up to 10 years is the imprisonment. Fine will be minimum amount involved in the fraud.
Price.
It will be 3 times of the fraud. Sir, if the amount involved is less than 10 lakh, people, the difference between this and this, here it is 10 lakh and above. Here it is 9.999, 9,19,999.99. Anything less than that will come here. That's the difference. Agreed? Yes, sir. So, sir, till now they have not asked this, but if they ask, it's actually a good way of asking a question also, practical question. So they can give you a turnover of the company. They will say the turnover of the company is 500 crore and the fraud reported people is 5 lakh rupees. Now they are asking you what will be the penalty of this particular person under this particular scenario as per section 447. How will you calculate? Whether it will come under left or right, how will you calculate?
5 crore, sir.
1% of the turnover is
5 crore.
5 crore
Or 10 lakhs, whichever is less, that is 10 lakhs.
or 10 lakhs, whichever is less, that will be 10 lakh.
It is less than 10 lakhs.
So whatever is the penalty you guys did, now see whether it is coming under this, that is less than 10 lakh or more than 10 lakh. If it is less than 10 lakh, now come and apply here. Amount involved is, where is this? Less than 10 lakh, the penalty will be, where is it? Punishable with imprisonment up to 5 years or fine up to 50 lakh or it can be both. Sir, in this case, sir, imprisonment minimum of 6 months, but if at all public are the people who lost the money, then the minimum penalty will be for 3 years, maximum up to 10 years. Clear? Okay, sir. Next one is called as offer for sale. What do you mean by offer for sale, sir? Whenever I told you in the class also, generally when will Mama Earth case, Shilpa Shetty case. So Shilpa Shetty's case was actually good case where she got an opportunity, she sold it off. That's what we saw in the class. I'll give you one more example today. Patanjali. In the year 2019, at any given point of time, I told you one thing. In a listed company, how many minimum public shareholders has to be there? 25% has to be there, minimum. In Patanjali, in 2019, the minimum public shareholding had reached somewhere around 19%, if I'm not wrong, or 20%. But how much would be minimum? 25%. Now, they did not take any corrective measures. SEBI imposed of some punishment on the company and they had freezed the promoter shareholdings. So, Baba Ramdev could not sell his shares for a certain period of time in Patanjali because they did not satisfy the condition of minimum public shareholding. Immediately, Patanjali gave a notice. What is that? Mitro, hum OFS karna chahte hain. Meaning what? Because your shares are less, our shares are more. We decide to reduce our shares and increase your shares. OFS was done. 2019-20. Understood? So what is OFS? Nothing but existing shareholders, they offer their shares to the public. Generally, it will be at the time of incorporation, at the time of listing to get that listing gains or to meet this condition of minimum subscription. Clear? Yes, sir. Okay. Sir, however, whenever you are coming with OFS, sir, there are certain rules that is generally applicable to public offer. That rules will not be applicable here. What is that? Minimum subscription is not applicable. If you are going for a public offer, if your public offer is to be a hit, then minimum 90% has to be subscribed of the offer. Issue size. If I am issuing 100 crore, at least 90 crore has to be subscribed. OFS, it's not fresh issue. It's already existing people, so I am taking and giving. Then why minimum subscription? Not applicable. Next one, minimum application value. Not applicable. According to Companies Act, it is 5%. According to SEBI, it is 25%.
5% of the nominal value, 25% of the
issue offer. Now, sir, that is not applicable. Sir, third one, sir, statement to be made by both utilization of money. What do you mean by that, sir? Whenever you're going for a prospectus, how are you going to utilize that money? You need to give a declaration. That is not required here. Why? You are not going to utilize it at all, Noda. You are going to take the money from public. You are going to give it to the promoters. I mean, the people who are selling the shareholders. Generally, it will be promoters only. Next one, any other information which can be compelled and justified. You can take those informations. Clear? Then, okay. Next one is section 29, which says nothing but all the listed companies, if at all you are going to list, basically listed companies or public companies in the process of listing, you guys have to issue shares mandatorily in demat form. This is in section. There is a rule. There is a rule called 9. There is one more amendment there. Because it's in a rule, you guys don't have that rule now. Not that. Recently there is an amendment. To be very frank, major amendment. To be more precise, no, the way your dependencies are, it can be CA or CS, it will increase. You know why? Till today, private companies, they were dealing their securities in physical mode. The amendment says, now this section applies to even private companies as well. Going forward, you need to maintain your securities mandatorily in demat mode. Already rule is passed. Applicable. September amendment. Word, wonderful. Only exception is small companies. Wonderful amendment. You know why? Accountability will come. In demat mode, there is no physical thing, no cheating. Not possible. It's actually a good read. It is. Yes, you online no. You online no. Online no. Sir, allotment of securities. Now, whenever a company goes for an IPO, I had to allot a securities, provided you need to satisfy certain conditions before you allot. What are the conditions? First thing is that people, you need to make sure the minimum subscription is met. Minimum subscription is nothing but 90%. Technically, it is as given in prospectus, but according to SEBI, it is 90%. But what should we write? As given in prospectus, because SEBI is not there for us. Yes. Next one, what if it is not received, sir? Within 30 days, sir, you need to refund it within next 15 days. Sir, failure, sir, 15% interest has to be paid by the directors. Minimum application money according to Companies Act is 5% of nominal value. SEBI says 25%. Return of allotment, sir, whenever, whichever security, debenture, so equity or preference, or whenever you issue securities, you need to mandatorily inform ROC in one form called as TAS3 within 30 days of allotment. In this form, you have to prove that ROC, we have done all this, sir. How? You will give the list of allottees to whom and all you have allotted. Registered valuers report. How did you arrive at the price? Next one, sir, consideration other than cash. We will see when we are doing sweat equity and ESOP part. Next one, sir, penalty. Penalty, it's okay, ignore. Next one, sir, securities to be dealt within stock exchange. Whenever you guys are coming up with an IPO, that is whenever you're going for a listing, obviously your securities has to be listed at least on one stock exchange. Yes or no? So you have to make an application at least to one stock exchange to get listed. So it can be NSE or BSE. Here the important question is this part, rate of commission. Sir, now whenever I'm going for IPO, what is the maximum commission I can give? Why? Commission on whom are you giving? There are people called as underwriters. If at all my minimum subscription is not met, these people will come and buy those shares. So, sir, I'm giving some money to the underwriters. How much can I give? Maximum people depends upon the type of share it is. If it is any share, equity or preference, the maximum you can give is 5% of the issue price. Or in your articles, if you have given it as 4%, 5 or 4, whichever is less. Sir, if I am giving debenture, sir, then they say people 2.5% or given in articles, whichever is less. Exam point of view say important, that too it will sit in your MCQ. Clear? Yes, sir. Okay. Next one, sir. 41 da? GDR. 41 talks about GDR. What is GDR, sir? Whenever a company, Indian company wants to raise money from foreigners. Till today, this is what I was telling you. We had to do all circus only. I'll show you one circus. Example, there is one company called as Reliance. You guys know Reliance? Yes, sir. Ayo. Yen sir nivo. Okay, Reliance Industries shareholding pattern. Okay. You want to see? Sir, ಏನು ತಮಾಷೆ ಮಾಡ್ತೀರಾ? You want to see Akash Ambani, see here. Shareholders. Okay, Ambani, Nija Ambani, Ambani, KD Ambani. Yes, who is that KD? Hey, I'm showing you 100. Why that KD now you want? Yes, okay. Now, what is one thing which we have to see here? Custodian and all. How is the GDR issued? So there will be one custodian, there will be one depository. Remember, the custodian for us is the Bank of New York Mellon GDRs. Okay, it seems. How many GDRs have been issued? It is sir counting units 10, 100, 1000, 10,000. How much?
15 crore 97 lakh.
15 crore?
97 lakh 2000.
15 crore, 16 crore, 16 crore GDRs have been issued. That means what? Reliance has issued 16 crore worth shares. Now do 16 crore into 3,000 odd rupees. That is what they have raised. Allah, I'm just telling you. Yes, sir. That is what they have raised from the US market. New York it is. Got it, Yes, sir. So till today we were doing all this matlab. Now they have given you an option directly issue equity in New York market. Got the difference, Yes, sir. Okay, so that's your GDR part. I hope this is clear. Yes. Okay. And the next section is private placement. Before I go to private placement, randomly let us see off if we have offer follow-up series done now. 27 we have not done. 27 variation in terms of contract or object stated in prospectus. Okay, simple thing. This you can also read it with your change of object clause. Now, whenever you have raised, if you have issued prospectus to public, now Zomato, they said that they will be doing delivery business. That's why they raised 9,000 crores. Now they want to do, they 5,000 crores they have finished. They want to do hotel business now with that. Now, whenever you have stated a particular object and you have raised the money from public, you are supposed to utilize that money for that purpose only. You are not supposed to deviate. Sir, but there is no other way. There is a way, people. The way is section 27. What does it say? Whenever a company has issued prospectus and it has raised money, if you want to deviate from that, then you need to pass a special resolution. It is through postal ballot method. And remember one thing, what is that? Whenever you are calling them for a meeting, you have to clearly disclose people. What is the total amount you had raised? What is the amount you utilized for the purpose? And what is the new object you are proposing? How much money you want to spend there? Everything you need to disclose to the shareholders. And main thing, those shareholders who are not okay with this particular thing, you need to give them an exit opportunity to quit the company and go. Exit opportunity means you need to take their shares, pay them the money and send them out royally. It's clear, section 27. Okay. Offer for sale is done. 29 dematerialized form. 30 advertisement of prospectus. What is advertisement of prospectus? Simple. Whenever you are advertising prospectus, in that you have to mandatorily disclose your content of memorandum. Meaning all your 6 clauses you have to disclose. That's all. That is your section 30. 31 we did. Shelf. 32 we did. Abridged prospectus, summary form. Correct? Civil law, criminal we did. Okay. 36. Punishment for fraudulently inducing investors to persons to invest money. Nothing but people. If people are coming up with any fake schemes or however indirectly if you are inducing people to buy the shares of the company, then you will be liable under section 36. Section 36 also says you will be liable under section 447 only. Sir, when will that come into picture? Any agreement? See underwriting. So any agreement for with a view to acquiring, disposing, subscribing or underwriting securities. So you're cheating them and you're making them buy the shares. Or any agreement, the purpose of which is to secure a profit. So what is your main intention to cheat? To get a profit. I'll send you a message, sir, buy this share. Do you know? I don't know. You just buy, sir, I'll get commission. The third one, people, some companies, they will go and do it because they may get some loans from the bank. As an obligation, they may support them. So, sir, if you do any of these people, section 447, you will be liable. Class action suit, people, first time the need was felt in the case of Satyam. Class action suit is nothing but if at all there is any fraud in the prospectus, that means not only you, the entire public would have been cheated. So, in such case, everyone cannot come to the court. Instead, do one thing, all of you, you class, on behalf of all of you, send one person, that is only called as class action suit. So one representative will be sent on behalf of all of you. The first time ever this need was felt in the case of Satyam. That's how section 37 was introduced in Companies Act 2013. Okay, done. Punishment for personalization of the securities. Personalization means nothing but people, a person who is faking to be a shareholder, meaning fictitious name, benami. If at all you are giving any fake names or fraudulently, if you are telling the company to give you the shares, then they are telling you even for that also you will be liable under section 447. So 34, 35, 36, 37, 38, everything talks about penalties only. Clear? Yes, sir. Okay, 447 we saw, allotment of securities by company we saw, 40 we saw, 40 main thing that you need to remember is commission, GDRs we saw, agreed? People, my question to you, now Reliance you saw, Reliance has issued GDRs. How do they create GDRs? I believe I had told you, equity shares will be given to a domestic custodian. Based on the equity shares, they will create overseas, they will inform on depository. He will issue something called as GDR. How did they price the GDR? How is it determined? If the price of the equity goes up, this also goes up. Now my question to you, in Reliance, 16 crore worth of shares are held by GDR holders. Now my question to you, can these people vote?
After the tax rate, they will be given equity share. Because an agreement between the
So sir, remember, as long as it is GDRs, they will not have a right to vote. Then who will vote, sir? The depository will go and vote. Sir, then it is not fair, no sir. It all depends upon the agreement between these two. But from the company's point of view, my point of contact is you. I will not let all of them inside. So what will generally happen? He will give them an internal tool to vote. He will take their vote and he will vote accordingly. That's how generally it happens. Understood? Pakka na? So remember, if they ask you, I've just added as a questionable point. Okay, let's go to the last topic, sir. Private placement. Okay, now what is private placement, sir? Important topic. A private placement is nothing but people when a company decides to allot securities to a selected group of people is called as private placement. If you guys have seen Shark Tank, 4 people are there. I specifically give an offer. Hey, you Anupam, do you want to come and invest? Out of all this, I've identified you and I'm making an offer. No, this is called as private placement. A company can make a private placement maximum to how many people? Act says 50, rule says 200. You need to follow rule. So the maximum private placements you can make in a year is 200 people. Sir, 50, how many? 200 is for how many? That's very important, sir. In this 200 people, it is for each class of security. Meaning, in a year, give it to 200 equity holders, 200 preference, 200 debentures. Each class has 200 limit. Sir, what if at any given point of time I exceed this 200? That means your offer will be deemed to be a public offer. You need to follow the entire section 26. So, public offer, your prospectus, so all those things have to be followed. Sir, now in this limit, certain people are not counted. Since it's 200, QIBs are not counted. ESOPs, employees options are not counted. Yes, sir. Sir, whenever I need to give a private placement, then I need to mandatorily pass a special resolution. Each time I give it, should I have to pass a? Yes, each time you give it, you have to pass. except one category, QIB. Meaning, let us imagine, anytime if you pass it during the year, whatever are the further private placements you make it to QIBs, all the offers are counted. You need not pass again and again special resolution for all the private placements made during the year. Understood? Pakkana? QIBs are nothing but your mutual funds or banks, so big investors, qualified institutional buyers. Understood? Yes, sir. Okay, next one. Sir, private placement, how is it done, sir? In private placement, 3 documents are very important. One is called as PPOL. PPOL, private placement offer letter, PAS 4. So I have to clearly identify, I have to clearly number, I have to clearly write the name of the person who should apply in this offer. To his name only I have to send the offer letter. That is called as PPOL, PAS 4. Sir, to whomever I am giving the offer letters to, I have to maintain a record of all of that in the form PAS 5, record of private placement. Sir, once the private placement is completed, I need to intimate to ROC in PAS 3 within 15 days. Correct? Yes, sir. Sir, the offer has to be completed within how many days? 60 or 30? 60 days, sir. If within 60 days, if the offer is not complete, I need to refund the money within 15 days. If not, sir, penalty will start at the rate of 12%, and it will start from which day? 61st day. Understood, all of you? For certain companies, this particular restrictions and all is not applicable. Which company? NBFC, housing finance companies. The provision shall not apply to NBFCs and housing finance companies. That's all. You've got everything. People, how can you raise the money, people? Check, DD, bank, not by cash. Exam mein, they can ask you a question on cash part. They can ask you one more question. At any given point of time, 2 private placements cannot run simultaneously. You have to complete one and you need to start another. Simultaneously, 2 private placements cannot happen. Clear? Pakana? And you cannot utilize the money until PAS 3 is filed. Until ROC is informed about who has invested, how much he has invested, you cannot utilize that money for anything. The question can come there also. Pakkana. So in private placement, the questionable points are, they can give you a limit, each category. That can be one of the question. QIB and employee based, ESOP. That can be one of the question. Cash related. That can be one of the question. The return is not yet filed, but the company has utilized the money. Is it fair? That can be one of the question. And next one is, the company wants to, one offer is going on. The company wants to start another offer. That is one question. Either bit, yeah, they will not ask anything. Clear, all of you? Okay, done. Okay, that's all. So chapter 3 is completed. That's all. Okay, let's go for a break and come. Yes, sir. Good, sir. That's why we came, sir. They online. Able to understand online? They're already taking break. No, see, they're all there. 20 minutes? Sufficient? Oh, come at 6 o'clock. Okay, go. Come at 6 o'clock. We'll revise the further parts. I hope you guys are able to understand. The pace is fine. You want me to cover a little more faster? Or this is fine? Yes, people, let's start your next chapter. Easy chapter. In terms of the sections and all, in terms of important concepts, this definitely has more important concepts in the complete part 1 when compared to other part. I mean, other chapters, this has the maximum important topics. So we'll cover it accordingly. Yes, Sham. Okay. Yes, people. Okay. Online able to see it? Okay, done. Yes. So the next one we will easy one, simple one, chapter 4, share capital and debentures. In terms of weightage, as I was talking to you, there are more important concepts in this particular chapter. So from your exam point of view, important. So let's start your chapter from section 43. First things are share capital and debentures. So whenever a company wants to raise, how is even your chapter sequenced? So try to analyze. The first one, the previous chapter spoke about PAS, prospectus and allotment of securities, meaning they were talking about offer, completely public offer. Huh? What? Mic check. If we say that one, it will work, no? Okay. So the third chapter was completely revolving around a prospectus. Prospectus, that means nothing but public offer. The second chapter revolves around share capital and debentures. Other way of raising money from people other than public offer, whatever is left will come and sit in this particular chapter. That's the reason you will see preference shares will come here, bonus will come here, and your buyback related provisions will come here, debentures will come here, everything will sit in this particular chapter because the second way of raising money. The third way of raising money is your next chapter, deposits. Understood? That's how even your chapters are sequenced. Okay. Now the section 43 talks about different types of shares. So for a fact we know the different types of shares. The first thing is people, equity shares and preference shares. In equity shares, people I can further classify this into two categories. One is with the voting rights and differential voting rights. With the voting rights is nothing as usual, whatever you read throughout the chapters. With the differential voting rights, people, there is something more to learn. First of all, what do you mean by differential voting rights? Generally, it's an option given to that public. Basically, if you think, I do not want voting rights because I'm not able to make any significant impact in the company. What is the use of me holding these shares? So you will be compensated with the dividends. You will get more dividends when compared to voting rights. So generally in DVR, Tata Motors, if you hold 10 shares, you will get 1 vote. But when compared to normal shareholder, you will enjoy 5% more dividend. So one share, if he gets 100 rupees, you will get 105 rupees. That's how the differentiation is made. Is it clear? So Tata Motor was the first company in India to issue DVR. Now sir, can any company issue DVR? There are certain things you need to satisfy. Now what is that? First thing, it has to be authorized by your articles of association. The next one, you need to pass an ordinary resolution and postal ballot. The third category is very, very important. That is, what is the maximum DVRs a company can issue? The maximum is at any given point of time, your total voting power having DVR should not be more than 74%. So at any given point of time, take your entire vote. DVR should not be more than 74%. Voting power they are talking about. Yes, sir. Next ones are not defaulted. Yes, sir. If possible, people try to take a picture of this particular not defaulted. I have tried to categorize this. You will understand the significance after some time. Try to take a picture. You're not this TV this selfie, he'll do everything, he'll do. He is prepared properly, so he's chilling. Okay, so online you guys also take that. Yes, now not defaulted. Now what is this? You are not supposed to issue DVR. Technically, everything seems same. There are 3 categories if you go in detail. The first category says you shouldn't have made default at all. If you have made, that means in the 3 years you cannot go. What is that first one? Who cannot issue DVR? If at all you have failed to file your financial statements and your annual return in the 3 preceding financial years, I cannot go for a DVR. That means, people, let us imagine, I am going for issue of DVR in the year 24-25. Let us imagine in the year 23-24, I have not filed my financial statements. So when can I go and issue my DVR? You have to make sure my last 3 years there is no default. So until that, people, I cannot go and issue my DVR. Agreed? The next category comes people, no subsisting default. What do you mean by subsisting? Ongoing. As on today, meaning in the past you have done something, but today you have made it good. If that is the case, you are free. You can do it. You can issue DVR. That is the second category, no subsisting default. And when is that? Imagine you have declared dividend, but you did not pay. You took some time, but you paid. So you made a default, you made good the default. Done. You can go for the DVRs. Second one, repayment of deposits. Sir, repayment of deposits, maturity happened, you had not paid, there was a default, again you made a payment, after some time, default is done. So as on today, there is no default. Same thing, redemption of preference or debentures on the date of maturity. Payment of interest on deposits and debentures. There was a default, you made good the default. Next one, no default in payment of dividend on preference, payment of loan or interest taken from public financial institution, state level financial institutions or scheduled banks. If at all, this is state financial institutions, state financial institutions or scheduled banks. If you have taken any loan, you have made a default. First to make good the default and then we'll see what should happen. Is this clear? Okay. Next category, statutory payments to be paid to the employees, their PF or whatever their gratuity payments. You have made a default. First to make good the default. First to repay and then we'll see what should happen. Next one, crediting amount to IEPF. Dividends, you should have transferred 7 years. You have not yet transferred. First to transfer. We'll see what will happen. Sir, we had made a default, sir. First to make good the default. After the default is made good, DVR can be issued after 5 years of making good the default. That's why I categorized into 3 things. One, your 3 past years is clean. You can go and issue your DVR. Next one, no subsisting, meaning today there should not be default. Third category, you have done a default, 5 years cool off period is there. Understood? Meaning you did something today, you have to first make it good. After that 5 years you need to meet. 5 years from the day you make good the default. Is clear? 100%? Okay, done. Next one, sir. You should not be penalized in the last 3 years by RBI, SEBI, SACRA, FEMA. Next one is no conversion, meaning existing equity cannot be converted to DVR, DVR cannot be converted to existing equity. And rest of all the cases, sir, they will be treated as pari passu with the equity shares. Correct? Meaning, sir, even their names will be written in register of members. Even they are entitled for notices of the meetings. They will also get financial statements. Everything will remain as it is, right? So everything will happen. Is clear? Pakkana? Okay, done. Next one, sir. 43. Okay, so we were seeing about types of shares. Like that only will continue off. Preference share. Section 55. Remember, important. According to section 55, a company can issue preference share provided what is the maximum repayment period. A preference share cannot have a maximum. First thing, people, no company can issue irredeemable preference share. You can issue convertible or it has to be repaid. You can never issue irredeemable. It has to be repaid at one day or another. Okay, sir, what is the maximum maturity period? Maximum maturity period is, people, 20 years. Sir, subco 20 years. Few companies have exception. Who are the few companies? Everything with regards to infrastructure finance, infrastructure projects, infrastructure NBFCs. These people have an exception. They can go beyond 20 provided from the 21st year minimum of 10% has to be redeemed from the 21st year. Correct? Yes, sir. Okay. Now, sir, this is preference share. Convertible types of preference share is manageable. Okay, with regards to voting, first of all, what do you mean by preference share? Preference share enjoys a priority with regards to 2 things. At the time of repaying the capital, they will enjoy a priority. At the time of repaying dividend, they will enjoy a priority. And do the preference shareholders, do they have a right to vote? Generally, no, but they can vote in the matters that affect their interest and during the winding up of the company. They can vote. Agreed? And the next one, sir, if at all the preference dividend is not paid for 2 years, then preference shareholders will have a right to vote on all the resolution placed before the meeting, just like equity shareholders. Here, there is a little, blank space in law only. They did not say, or they have not stated until when will this particular thing continue. So imagine after some 4 years, they repaid the preference dividend. Now what will happen? They have not stated anything about it because law is only silent. So technically, how do we see? Once the default is made good, the voting rights will come to an end. But regarding that, there is no law. It's clear? Pakka na? Yes, sir. Okay. And that is what is given with regards to preference shares and preference dividend. Okay. Now, because we were doing about that, let us do of change in voting rights. Section variation in voting rights. Section
48.
voting rights we'll do, and then let's go to variation. Okay. First we'll do a 47 and we'll go to 48. 47 is where they say how much votes you have. Equity share capital obviously will be in proportion to whatever is their equity shares. Preference share, does he have a right to vote? Directly, whatever is affecting him and during the winding up of the company. And proportion of the voting rights people, it will be as per their equal paid up capital. Sir, non-payment of preference dividend, sir, for a period of 2 years can place right to vote on all the resolutions. Agreed? This is section 47. Now, sir, section 48. Connected topic, everything with regards to voting, I'm trying to do it together. Now, what does 48 talk about? 48 talk about variation in shareholder rights. Now, imagine, sir, we had issued preference shares for a period of 10 years. Now, we want to change this duration. From 10 years, we want to make it to 12 years. Why? Because of repayment issues. We do not have money as of now, liquidity issues. So, we are calling the shareholders for a meeting and we are saying we want to increase it to another 2 years. Are you guys okay with it? Now, are they fools to accept? Unless and until they get something, why will they accept? So a company comes up with another deal. What is that? You take it for 12 years. Till today we were paying 9% as preference dividend. If you guys agree to this, we will pay you 12% as preference dividend. Now obviously win-win situation. Now this is called as what people? Variation of shareholder rights. Whenever you want to change the terms of what you have given to the shareholder, now this is called as variation of shareholder rights. Now, first of all, if you want to change the shareholder rights, now let us imagine, okay, there are some restrictions. In certain cases, you cannot change the shareholder rights. When is that? Okay, and first of all, people, is it arbitrary? Can the company exercise variation of shareholder rights whenever they want? Should the power be given somewhere?
It's not restricted by any law right now. With consent of 3/4 of the party or special resolution.
Okay, so main thing, remember this, they have not asked, but I think it may be a important question. Now people, if you want to change the shares, how we will see? Provided the power should be given to the company. Where should the power be given? With the respect to such variation is contained in MOA or AOA of the company. You should have some power. Arbitrarily you cannot exercise. So let us take it this way. I have not put anything with regards to that in my MOA or AOA. Now can I not change it at all? The second thing says you can change it provided take a look at your prospectus. You shouldn't have promised them when you are issuing that we will not change your rights whatever happen. You shouldn't have promised them. If at all you have promised them anything in their offer letter or prospectus, so you cannot change the shareholders' rights at all. See here. In the absence of any such provisions in MOA, if such variation is not prohibited by the terms of issue of the shares of that class, means if you are prohibiting yourself when you issued, then you cannot change the shareholders' rights. Is clear? Yes, sir. Okay, this is the power. I got the power. Now, how do I change? Simple. Call the preference shareholders for a meeting. That particular shares for a meeting, that is preference share. Now, what do you allow? Call them for a meeting. Now, in the meeting, people, not less than 3/4 of issued shares of that class. Which class I'm talking about? Preference shares, or pass a special resolution in that meeting. Sir, now you are saying 75% of the people agreed. What about 25%? If 25% did not vote, we don't mind. If 25% said no, then problem, people. What are they saying? If at all these people want to do anything, they can go and appeal it in tribunal. At least 10% of the people thinks this should not go through, what they are doing is wrong. Then people, they can go and appeal it in tribunal. Now we need to wait for the order of the tribunal. Tribunal says go for it, you can go for it. Tribunal says you need to repay, you need to repay. You need to follow the tribunal's order. Is clear? Yes, sir. Now we have a problem. Now we increased 9 to 12%. One equity shareholder said, sir, dikkara. Why? Sir, because you are paying them 3% more, you said preference share means something which enjoys priority over equity share. After paying him 3% more, what I get is 3% less. Then why should I invest in your company? Already you pay me peanuts. Correct? So one person started saying dikkara. Now people, whenever one variation affects another person, that is another class of shareholder, it is your duty to take approval from that class as well. And how is that? Again, you will take 3/4 approval from the another class as well. Is clear? This is variation of shareholder rights. When you are trying to read this part, try to read 43 and try to read 47, 48, 49, 50, 51 together. 49, 50, 51, there is nothing. What is there in that? One is whenever you are making the calls has to be uniform. Meaning what? Let us imagine all of you are the equity shareholders of my company. I will tell, hey, you three, you guys have to pay completely the fully paid up shares. Hey, you three, you guys pay 5 rupees, it's okay. In the same class, I cannot make a differentiation. If there are different class, I can make a differentiation. That's the first rule. That is only section 49. Uniformly, you need to make a call. There should not be any difference with regards to the same class. That's all. 49 done. 50. Calls in advance, people. Now, whenever a person, let us imagine there are 3. Now, 3 people has paid entire amount, but I have not called entire amount. You have paid in advance. Now, you are asking for complete voting rights. So, does advance amount entitle you for voting rights? The answer is no. Even if articles provides, you cannot exercise. The next one is people 51. 51 says about dividend can be paid in proportion to the amount paid up. Called up, paid up. So you may get more dividend because you have paid more. So advances may entitle you for little more dividend. 51. That's all done. 49, 50, 51. So when you are reading, write down the sequence. 43, 47, 48, 49, 50, 51. Read it together. Clear? Yes, sir. After this, technically you should have read 55 also. Or you can put 55 here only. 43, DVR is done. You are reading preference share and then you are going to 47, 48, 49, 52. Done na? Pakka na? Okay, sir. So once this is done, sir. 49, 51 done na? Add of 52 also. Add of actually 53 also. Discount and premium. Nice, no? Okay, right off that, after that, 51, 52, 53. 52 anyways you guys know. What is 52? Issue of securities at premium. He is like, sir, right off, sir, enter Companies Act. You can't write 8 to 10 sections, sir. Okay. So people, what is that? Section 52. What is the issue of securities as premium? What can you utilize the securities premium for? Question will come. 5 purpose. Preliminary expense, buyback of shares. Right of preliminary expenses. Bonus shares. Redemption of preference share. Discount to issues of expenses involved with regards to shares or debentures and all of that. Agreed? Yes, sir. So securities premium can be utilized for 5 purpose. Remember, wherever there is utilization and source, important question. Correct? Source is also important. Utilization is also important. Where and all you will get source, bonus, buyback, important. Sir, application of securities premium account applied for fully paid bonus shares, BBA. You need to know BBA, buyback, bonus. Next, sir, you need to know Preliminary expenses are premium on redemption. So BBA, PPA. So preliminary expenses of the company, nothing but your incorporation expenses. Next one is your premium on redemption of preference share as well as debentures. And third one is writing of expenses of commission paid, discount allowed, any issue of shares or debentures. Meaning, you guys saw, no, what is that? Underwriting commission. Issue related only, no? 5%, 2.5%. That money you can take from premium. That is what they are telling you. Agreed? Yes, sir. Done. Okay. Provision on issue of share discount. Yes, sir, people. People, can I issue my equity shares at discount?
Under two circumstances.
Under two circumstances. Oh my God. Okay, what are the circumstances?
Converting loan into equity.
When you are converting, okay. One is ESOP or sweat equity.
Sweating equity, sir.
Okay. Sweat equity is one where you can issue shares at discount. Next one.
Loan into equity.
When you are converting loan into equity, that is also possible. Yes, sir. Remember, sweat equity you are earning. That's the reason you are allowed on discount. And always remember, discount is always on face value. That's the context. It's not on the market price. It's always on the face value. Yes, all of you. Okay. Now my first question, can you give discount on equity except those two scenarios? Can you give a no? Can you give discount on preference?
No, sir.
Can you give discount on preference share? Not possible. On debentures you can give. The law says, section says shares. So it includes equity also, preference also. Both cannot be issued on discounts. Debentures, yes, possible. You can issue on discount. It's clear, all of you? Yes. Okay. So remember that only a company cannot issue shares at discount except in the case of sweat equity. Any issue share discount shall be void. If you issue it, it is void. Another thing is that anything contained in subsection, a company may issue shares at discount to its creditors when its debt is converted into shares. I think I told you one scenario also. Imagine Kingfisher had taken loans from a bank. They are not able to repay the loan. Now they said, okay, sir, instead of loan, we will give it to you shares only. Now the loan, the bank will feel, instead of taking this way, I will only buy it. What is the advantage I am having? You need to prove them that it's okay, sir. Outsider, I will give it at 10 rupees. For you, I will give it at 5 rupees only, sir. So that's an advantage you have. You will get some discount. If at all, generally you see you will get 100 shares. Because I am giving you at 5 rupees, you will get 200 shares. That's the advantage you hold. Remember, this has to be read with one more section, and that section is 62.
1B.
What is 61B? ESOP. 62.3. You will read it with 62.3. 62.1C is preferential. 62.1A is rights. 62.1B is ESOP. 62.1C is preferential. Preferential, there is nothing. You need to read it with private placement. That is section 42. We'll do quiz of sections. Okay.
Sir, what is 62?
Conversion of debt into equity. How can I convert my debt into equity whenever I want? That's all. When you took the debt, that time only, you should have asked your shareholders' approval. You should have passed a special resolution at the time of taking the debt, not at the time of converting. But this condition is not applicable to one person. When? In the case of government converting it. We'll see when we are doing it. Clear? Yes, sir. Online? Understanding? Okay. Everything we have done now? Above? Everything above we have done? No, one section I have left, I believe. Share certificate I have not done, no? Certificate of shares. Okay, certificate of shares. Actually, there is nothing, people, because everything is now, even your private also is moving towards demat. So this has absolutely no significance at all, but we'll see. So if at all a company, prima facie evidence, who is this prima facie? Who is she? You know that? You don't know? Prima facie. What is prima facie, people? Prima facie means primarily, on the face of it. It is a title. That means it proves that this person is the owner. On the face of it, it says that he is the owner because it will be in your name. Okay. A certificate of shares is required when shares are issued in a physical form. So in demat, obviously it is not required. So a share certificate has to be signed because it is company's document. Who has to sign it? Depends on you have common seal or not. If you have common seal, you will prove under common seal. If common seal is not there, then two directors, wherever there is CS, one director and CS, same as Bills of exchange. Whatever you guys saw, basically negotiable instruments. Same thing will come here. Clear? Okay, sir. Sir, issue of duplicate certificate. If at all any person has lost it or destroyed, you can apply for the company. They will issue duplicate share certificates. Shares held in depository form. Then you do not need any share certificates. It is exempted, obviously. If at all anyone defrauds for duplicate share certificate, there is penalty. Penalty and all, it's okay. You want to study here? Sir, that time only we did study. Okay, DMAT mode, obviously this all is not applicable. Okay, I'm just leaving the penalty part alone. I hope it's okay. Sir, even if you discuss, we are not okay. Remember that. Okay, sir. Because you did share certificates, sir, there is one connected topic called as within how many days should I issue share certificates? Imagine I am going for first time incorporation. Within how many days should the company issue me share certificates? 1 month, 2 months, 6 months. Okay, debenture is 6 months. IPO is okay. This is again physical certificates. So IPO doesn't come. The allotment. 2 months. Memorandum, people, that is subscription to a Memorandum of Association, that is at the time of incorporation, it will be 2 months. And next one was what, people? You will see at the case of transfer or transmission. Imagine I have transferred my share to this person. Now he needs to get another share certificate. Within how many days should the company give share certificate to in the case of transfer? 1 month. That's the difference. Yes, sir. Remember, it is 2 months, 2 months and 1 month if you remember. In case of subscription to the MOA, 2 months. Incorporation, this is sir, what if private placement, rights issue? Again it is 2 months from the date of allotment. Next one, transfer transmission, 1 month. In the case of allotment of debentures, 6 months. Remember, this table may be important. 56. Marathon only. Sections. Correct. Sorry, I'm sorry. Manage shooting. Okay. Okay, rest of section 56 we'll see later. Okay, we'll see which other section. We will do a sweat equity. Sweat equity. Tell me what is sweat equity. It is shares issued at discount or for consideration other than cash for employees, directors for giving value addition, know-how or intellectual property rights. We are giving shares at discount or for consideration other than cash. Hey, what is this consideration other than cash? So, sir, employee is not giving us money. He has contributed something else, meaning he has given us an intellectual property. Now, this is valuable, it seems. So, sir, meaning people, he has given us a probably patent. In the pharmaceutical company case, imagine Aditya Music. Anirudh comes and gives a wonderful, yes, jailer. That's all. Got it, no? With that one song, he got one bench. They gave it or not? Sun TV. What is his name? I forgot. Kalanidhi Maran. He gave it, no? Sun TV, no? Sun Pictures, Kalanidhi Maran, Sir, I don't know, sir. We remember the daughter's name, but okay. Correct, no? Yes, sir. Now, people, I hope you guys have seen that video. Rajnikant gets one car. Anirudh gets one car. Why? Rajnikant gets okay, da. Why Anirudh got? Because we know the first hero of the movie is Anirudh. Sorry, da. No controversies. Correct, Rajnikant himself has said, I've seen this movie without recording, re-recording. It was like an average movie, but Anirudh has lived the movie. So he's given something to the company. I'm giving it back. Consideration other than cash. IP, copyright it is. Understood, Pakka. So, sir, did they charge for the car? No. So, sir, they gave car. If you want, you can give shares. It is allowed. Now, sir, you said something and all. In the company's balance sheet as a CA, how should I show it as? If he gives it cash, I know to pass journal entry. You're telling something consideration other than cash and all. How do I have to pass an entry? First of all, how should I treat it? If at all you have got an asset, if you got, he did not pay anything for this. Huh?
Depreciable asset on the balance sheet.
If it is a depreciable or amortizable asset, carry it to the balance sheet. If at all it is not depreciable or amortizable, then expense it. If at all there is a question, this will be the question. How do you treat consideration other than cash? If it is depreciable, meaning physical asset, amortizable, intangible asset, you use depreciable for physical asset, amortizable is for your intangible assets. If it is for that, then you have to treat it to balance sheet. Carry it to the balance sheet. If it is anything other than that, sweat, he worked hard, nothing he gave, but he worked hard. We are happy with that. You need to treat it as employee expenses. It will go to P&L. Expense it. This is clear? Pakana, 100%. Okay, what is the maximum sweat equity I can give?
Here it cannot exceed 15%.
Okay, let us imagine people. My company's paid up equity capital is 1 crore. Okay, my company's paid up equity capital is 1 crore. Now they are asking you what is the maximum I can pay.
At the stretch 15%, overall 25%, startup company 15%.
The 1 crore is my paid up capital. You tell me what is the maximum I can pay.
15% or 5 crore. 5 crore.
Okay, 15% or 5 crore. This is 1 crore rupees only. I'm not giving you shares. 1 crore rupees is a paid up capital. You tell me what is the maximum I can give. Now in this year, how much I can give? Da? So I need to take 15% of question number 1. Paid up equity. People, now look at the question. Da. Look at the people. I have 1 crore equity capital. I have 50 lakh preference capital. What is the maximum? Hey, don't look down. I'll hit you. What is the maximum I can give? 15 only. How many of you calculate 15% on 1.5 crore? How many of you calculate 15% on 1 crore? This is what I told you. You will remember 15%, but what 15? Equity. Remember, preference share is a kattappa for you in the exam. Literally kattappa. You will always regret that preference share. Why does it come down? You don't know where to take, where to leave. Yes, it is paid up equity, sweat equity. So you don't need another capital here. Only equity it is. So 15%, how much it is? 15 lakh or 5 crore, whichever is higher. Whichever is higher or lower? Higher. So how much I can give? 5 crore. Answer is wrong. Marathon may be wrong. In the exam only, sir. Yes, people. Remember, next condition is there. At any given point of time, sweat equity cannot be more than 25%. So if you give 5 crore means, it is going beyond your allowed thing. So at any given point of time, it cannot be more than 25%. But one company said, sir, 25% is not sufficient for me, sir. For a startup company, they have relaxed this, and for a startup, it is made 50% for 10 years from the date of incorporation. Remember, if a question is coming, it will come here. Clear, all of you? Look at the condition once. Limit on issue. It should not exceed one time 15% of paid up equity capital in a year it is. Every year you can make. So sir, every year you can make 15. Yes, you can make. Provided at any given point of time, overall, lifetime, it shall not exceed 25% of paid up equity capital at any given point of time. But in 1 year, 15% or 5 crore issue value, rupees it is. Whichever is higher. That's once in a year. Clear? Pakkana? I hope this entire thing is clear. Exceptions are startups are 15%, 50% and 10% from the date of incorporation. Clear, all of you? Lock-in period of 3 years from the date of allotment. People, once I got the allotment, I got the sweat equity. I cannot transfer it because what is the use? I give him, he sells and he goes. Then what is the purpose? Can I get a dividend on this? So remember, once you get sweat equity, you can enjoy dividend, you can enjoy notice, all the rights you guys can enjoy. But you cannot just transfer it for the next 3 years. Clear? Okay, next one, people. Price of issue is determined by the registered valuer. That is what price you are issuing. Treatment of non-cash consideration, depreciable, amortizable, balance sheet. If it is not A, meaning not amortizable, not depreciable, treat as an expense. All the details of these people, whomever you have given the sweat equity to, maintain their details in SH3. Remember, double of it. Double of it. Sweat equity. 2 no. Sweat equity. That's why SH3. Double of it. ESOP. 4 letters. That's why SH6. So register of ESOP is SH6. Register of sweat equity is SH3. Remember in exam, if possible, right, you will get some extra mark. Clear all of you? Yes. Okay. ESOP also are giving it to employees only. What is the difference? Here, consideration will always be there. Money will always be there because discount is not allowed. Here, there may be discount. And the issued terms will be different for him and issued terms is different for him. How? Ajagajantara Vityasa. One is in another room, one is in another room. Why? Here, day one you are allotting. There, you are showing him biscuit. Why biscuit? Grant of option. Amele vesting period, amele granting period. Correct? So there are difference in terms, even though it is employee. Agreed? Yes, sir. Okay, done. Agreed? Done. Next people, 54 is done, 55 is done, 56. Transfer and transmission of securities. If at all I want to transfer my securities, first thing it is not applicable to demand format. What I am showing is here physical format. How do I do a transfer? If he wants to transfer the shares to transferee, you will sign one form and that form is called as transfer deed. The format is people, you don't have to invent it. It is already given and the format is SH4. Once you sign this SH4, that is a transfer deed, you need to give it to the company to record the transfer. The company will take register of members. They will update the register of members within 7 days. Understood? We'll see that. Within 60 days of execution, you have to give it to the company. Yes, sir. Register of members has to be updated within 7 days. You will see that in register of members, 88. Clear, all of you? Yes, sir. Okay, sir. Sir, what if it's a partly paid share? You need a confirmation from the transferee. Transferor are paid only 5 rupees. Do you know about it? So confirm it to me because you have to pay me that. Remaining money. So you have to confirm people. We'll be giving him a time of 2 weeks. In 2 weeks, if he does not reply people, it is considered as deemed approval. Yes, sir. SH4. Sir, what if this instrument is lost, people? They may take an indemnity bond from you and they can still transfer the shares. Done, section 56. Next one, people, refusal of registration and appeal against refusal. Meaning, sir, I have given my transfer request, sir. Company did not register my name at all. Then what will I do? Sir, hamara ijjat. You'll go to tribunal. So, people in tribunal, people will go and cry. Then how many days I need to go, sir? So first, in the case of private company or public company, you will technically go and you will give your request for transfer or transmission to record. Now people, these people have 30 days time to reply to you whether we are recording it or we are not recording it. So within 30 days, they have to give you a reply. 60 and finally it is 90. But where it is at, we will see. I'll tell you where the change is. To reply, it is 30 days only. To reply, it is 30 days only. The next limit is, now imagine private company. They replied. They said we are not going to register or they said something or they did not reply at all. You have another 30 days time to go to the tribunal. So 30 days time is with the company. If they do not reply, you wait for 30 days. If they are not replying, from here you will have another 30 days to go to the tribunal. Agreed? In the case of public company, this is not 30, it is 60. 30, 60. Understood? Sir, if at all, okay. Yes, sir. Next one, sir. If no notice sent, then, sir, within 60 days of delivery of instrument with the company, in the case of public company, it is 90 days. Understood? Pakana? 100%? Any doubts? So it is 30, 60, and this people it is 60, 90. Remember that. Is this clear, all of you? So you need to go to the tribunal. You need to tell them, sir, this is what has happened, and tribunal will give you the accordingly. They will tell you to either dispose of the matter or to register this particular instruments. Okay. Yes, sir. Okay, next one, people. Section 58 is done, na?
59.
Okay. What do you mean by transmission, da? By the act of law. Examples of transmission, when and all it can happen? In the case of death, in the case of insolvency, in the case of lunacy, unsound mind. Agreed? Okay. And in the case of transfer, people always remember, someone forged my signature, he further transferred. Remember, forgery, in the first chapter, second chapter only we saw, whatever is the case of forgery, you will never get a right. Whoever is the initial shareholder, he will only enjoy the entire thing. Is clear? Yes, sir. But in the case of subsequent transfers, meaning someone forged, someone purchased, innocent person purchased, he further transferred. In such case, whoever is the innocent buyer, for him company will pay the compensation, and that has to be recovered by the company from that fraudulent person. Clear? In the case of transmission, sir, again, whenever a person dies or insolvency or lunacy, in that case, I'll become a shareholder. Okay. Next one is people, refusal of registration, we saw 58. And next one is people 59, rectification of register of members. What is people? Nothing but I will give an appeal to the tribunal. The tribunal will tell me when will this come into picture without sufficient reason. My name is entered in register of members. I should not be a shareholder, but they have written my name. Second scenario, I should have been a shareholder, but they have omitted my name. They have not written. Third scenario, they are taking lot of time to make an entry. In these scenarios, people, you can go and make an appeal with the tribunal to make the respective entry in the register of members. That is your section 59. That's all, huh? Should we go through 59 now? Okay, read once. Appeal by agreed person according to section 59 if the name of any person is without sufficient cause, without reason, entered, omitted, or delay takes place. Agreed? In such case, the person having become or ceased to be a member, then the person aggrieved, that is whosoever is name written, not written, or taking time, or any member or the company may appeal in such form as may be prescribed to the tribunal to a competent court outside India. Few people will have a doubt here. Why is the company itself appealing? Remember, people, a wrong entry made, registers cannot be just striked off as you want. Any entries made in the registers cannot be altered. To make that, you need tribunal's approval. That's the reason company itself is doing. Got the scenario na? Where you yourself realize that I've made a wrong entry. You have to go and correct it in the register. You do not have a right to do it yourself. You will go and do it after tribunal's approval. This is according to law and legally doing. But you tell what will you do? Sir, white na knack. You'll change off there only. That's what people will do. Well, how will you know that you changed? Yes or no? Okay. Order of the tribunal, it will either dismiss or it will tell to transfer or it will tell to rectify the register as the case may be. Yes, sir. The provision of section 59 shall not restrict the right of holder of securities to transfer such securities. Further, any person acquiring such securities shall be entitled to voting rights unless the voting rights have been suspended by any court. Court. Meaning what, sir? Just because your name has been mistakenly taken away by the company, it will not take away your right to transfer. You still enjoy the right to transfer. Okay. Alteration of securities. Okay, 61. Yes, people, tell me, how and all can a capital be altered? 5 ways. How and all? First one, increase of authorized capital. Second one, consolidate, subdivide. Meaning, sir, you will split the face value into lower denomination. Next one, higher denomination. One is your share split and one is consolidation. Next one is cancellation and conversion of share into stock, stock into share. I told you in Indian scenario, it is generally, it will not happen. Agreed? Yes, sir. So there are 5 scenarios. Whenever you read this section, section 61, connected section is people, section 64. Whenever there is alteration of capital or whenever there is redemption of preference shares, you need to intimate to ROC in one form. That form is called as SH7. Clear? You'll remember? Yes, sir. Reduction of capital. Yes, we'll see that. Is clear of you? This entire thing, any doubts? No. Okay, done. Next one, sir, is section 62. In section 62, I can further classify this into mainly, there are three aspects. The first thing is section 62, subsection 1. In this, I can further classify into three things. One is called as rights issue, next one is called as ESOP, next one is called as preferential issue. If this is nothing but they say, read it with 42. So you will follow 42, private placement, done. Next one is people rights issue. What is rights issue? A right given to the existing shareholder to acquire more. And it is always given in the proportion of your existing shares. Agreed? If you hold 10 shares, you will have a right to buy another 5 shares. That's how a rights issue is given. Unless otherwise prohibited, by default, every rights issue, letter of offer, has a right of renunciation. What do you mean by renunciation? If I do not want to buy the shares, I can give my opportunity to another person to buy the shares. That right is called as what, people? Renunciation. Unless otherwise prohibited, by default, you have a right to renunciation. Yes, sir. That is section 62, 1A. People, one more thing. What is an offer period? I give you a letter of offer. Rights issue has to be open for minimum how many days? They say, people, it is 15 days or such a lesser number of period as may be prescribed. That lesser number of period is 7 days. That is a minimum number of days the offer should be open. Sir, maximum can be kept open for 30 days. You cannot keep the offer open for beyond 30 days. And remember, if you get the offer letter today, you need to have at least 3 days of offer opening period. Meaning whenever the offer opens, you need to issue the letter of offer at least 3 days prior. Meaning if the offer is opening today, you cannot give the letter of offer to the person today. You need to at least give it 3 days prior. Agreed? Yes, sir. Okay. There is one criteria. A question can come here. One company comes and asks you, I cannot follow such bigger time period and all that. I want to follow lesser time period. Do I have any way out? You as a CA advise. Very good. In the case of private company, if 90% of the members it is voting shares value Allah, 90% of the members, whether in writing or in electronic mode, if they agree, people, whatever is the timelines given above, you can even follow the lesser time period as well. Meaning what? Any other company should have a minimum offer period for 7 days. Private company can even keep it open for 1 day also. If 90% of the people agree to it. Is this clear? Any doubts? That's your rights issue. The next one is called, people, ESOP. In ESOP, what will generally happen, people? ESOP is a right given to the shareholders employees to subscribe to the shares of the company. So in ESOP, I will further classify ESOP into 3 periods. The first is called as grant of option. Next one is called as vesting period, gestation period, or your waiting period. The third period is called as exercise period. Grant period means, people, it is a time where the company identifies the potential employees, searches their ID, sends them one offer letter. Macha, stay with us for at least next 1 year, because you will have waiting period. Stay at least for 1 year. Today I am giving you a word. After 1 year, I will give you shares of the company. Today I am giving you the grant of option. So people, grant of option will have name of the employee, predetermined price, predetermined quantity of shares. After 1 year, how many shares I can buy will be already given in my grant of option. Now the employee has to wait for 1 year. Now after 1 year, let us imagine, in my offer letter, they have told me that you can buy the shares of the company for 500 rupees. After 1 year, in the market, the shares have become 800. But with company, I can buy 500. So it's a beneficial thing for me. I will exercise the option. That's called as exercise period. After 1 year, in the market, the shares are available at 250. I will obviously say no to the option. I will let it lapse. I will buy it in the market because I will get it at 250. This is the reason it is called employee stock option. Agreed? Sir, whenever you have the waiting period, imagine they give you a grant of option today, the exercise happens 1 year. In between this period, will I have right to dividend? Will I have right to dividend? No, sir. Will I have right to vote? Can I sell? Can I pledge? Can I hypothecate? You cannot do anything, people, because you are not a shareholder. It's clear, Pakka? Yes. register ESOP, register of ESOP, you will maintain all the details in the form SH6. Clear all of you? Clear? Faster? Going properly now? Okay, good. So ESOP, grant of option, number of share, price of share. It's called as exercise price. Vesting period, gestation, waiting period. Minimum will be 1 year. Minimum according to Companies Act. A company is free to choose 2 years. It's fine. Option gets vested. Once the options are vested, it shall be exercised in the time. Okay. Public company, special restriction. Private company, authorization. Restriction. No vote, no dividend, no sale. No. People, yesterday 2 things we forgot. How can we forget? In 2 scenarios, the waiting period of 1 year will be automatically reduced. When is that? Whenever an employee dies, the family can exercise the share on that day only, on the date of death. Don't cry, come here and exercise. That's what they're saying. Oh my God. Next one is people, whenever an accident happens, not accident, permanent disability. In that case, on that day only, the exercise option will be given to the employee. Register of ESOP, yes, such 6. Online, is it clear? Online. Online. Okay, next one people, section 62(3). What is it? Section 62 shall not apply to increase of subscribed value of company, excess of an option attached to debenture issued or loan raised by the company to convert such debentures or loan into shares in the company, provided such an option have been approved before the issue of debentures by a special resolution. Correct? Where did you see this? Section 53, issue of shares at discount. That is what I told you, there will be cross reference. So what are they telling you? You can convert your debentures into equity, provided before that you should have passed a special resolution. However, according to section 62(4), this is what is a government, where any debentures have been issued or loan has been obtained from any government by a company. So I have taken from central government only loan. And if the government considers it necessary in the public interest, it may by order direct that the debentures will be converted to shares in the company. They will not ask you, they will only convert. As appears to the government to be reasonable. Sir, it's anyaya, no sir. That's why you guys can go and cry. Where? If the company is not okay with the terms of conversion, the company can go and cry in the tribunal. Where the government by an order made in a subsection 4 directed for conversion into shares and where no appeal has been preferred by the company, the MOU of such company where such order has been effected, understood? Meaning what, sir? In MOU, whatever is my capital clause, whenever government passes the order, by default the capital clause will stand altered to the amount we want to increase to. So if my capital was 5 crore, if the government is converting 2 crore worth loan into equity, now my revised capital clause will become 7 crore. Understood? Yes, sir. Done. Next one is bonus share. What is bonus share, sir? It's a share given for no consideration to the existing equity shareholders. What is the source of bonus? The free reserves, security premium, very, very important. The only purpose why you can use this account was for CRR. When will you create CRR? To fill the gap between capital. Generally, when will you do it? What will be the scenario? One is buyback, next one is redemption of preference shares. That two people, buyback or redemption, you will create CRR account only whenever you are using it out of the profits of the company. If you are doing buyback or if you are redeeming preference shares out of the fresh issue, then capital redemption is not required. However, CRR is created, sir. You can use that account to do the bonus issue. Okay, conditions, sir. How to make a bonus issue, people? Authorized by articles, recommendation on the board. You should have not made default in principal and interest. Not defaulted in payment of statutory dues of the employees. Partly paid up shares first has to be made fully paid up. The bonus share shall not be issued in the lieu of dividend. They can ask you a question here only. In the place of dividend, it has to be only dividend. You cannot replace it by bonus. Company which has once announced the decision of its board recommending a bonus shall not subsequently withdrawn. You cannot withdraw the decision. The reason is also, people, because the effect on the share market would have already happened. You cannot take it back. Yes, sir. Okay. Next one, people. Reduction of share. Okay. Bonus. There is one connected point. Restriction. Once again. Okay, we'll do a buyback and we'll come to this reduction, no? Or we'll do a reduction only. Okay, we'll do a reduction only. Reduction of share capital. What do you mean by reduction of share capital? Whatever is my capital, sir, I'm reducing my capital. What are the scenarios where you will reduce your capital, people? You will reduce your capital generally in 3 scenarios. When is that? First of all, whenever you're extinguishing the share capital not paid up. Meaning, sir, if it is 10 rupees face value, 8 rupees is paid up, 2 rupees is still uncalled, 8 rupees is called. You will say 2 rupees don't give me. One way of extinguishing your capital, reducing your capital. Next one is cancel the capital which is lost. This is happening generally in the case of losses. Where you have lost the business, asset sides have reduced, you have to reduce your liabilities also. The third one, sir, you have taken 10 rupees, entire 10 rupees is called up. You think it is excess, repay 2 rupees, reduce your face value. The third way of reducing the capital. How do I reduce the capital, sir? You need to apply to the tribunal. What will tribunal do? Tribunal will send your order to all the authorities like ROC, creditors, SEBI, government, and they will ask, this company wants to reduce its capital, it seems. Do you guys have any objection? If you guys have any objection, you can give the objection. If at all you guys do not respond within 3 months, it is treated as no objection. So deemed approval. Sir, once it is deemed approval, sir, that means your capital will stand reduced. So till today, if I was liable for 10 lakhs, my capital will now become 8 lakhs. So my liability will only be 8 lakhs. However, if any creditor can come and prove that his name has been omitted in the list of creditors, if he comes and appeal, people, whatever was my previous liability, that will only continue and the new liability will not be affected. So I will be liable until my previous limit, not according to the new limit. So until this limit, I will be liable. Is clear? Yes, sir. This is section 66. Next one, sir, section 68, buyback of securities. Buyback of securities, people, you need to technically remember these points. What is that? First one, sir, if you want to go for a buyback, you need money. What are the sources of buyback? The source of free reserves, securities premium, proceeds of fresh issue, but not of the same kind. If I am buying back equity, it has to be preference. Post debt equity ratio should not be more than 2:1. I hope in the class we have done a problem also on that. Next one, sir, all securities shall be fully paid up. Next one, no further buyback until 1 year. So nothing but cool off period. If you do it today, another buyback can happen only after 1 year. Company shall not issue same kind of securities within next 6 months. I have bought back equity today. I cannot issue equity only for the next 6 months. Then why did you buy back today? Correct? However, there are some exceptions. Exceptions are, people, bonus issue. Company decides to issue bonus. Okay, because you have capital redemption reserve. You can go for it. Fine. Next one is conversion. 5 years back I had issued convertible preference shares. The conversion is falling today. I can issue equity, allowed. Next one, sweat equity. I promised my employees last year. Now their conversion is happening. Or I'm identifying them today. No one will stop me because you have to retain them. Allowed. Okay. Register of buyback, sir. SH 10. Next one, sir. Extent of buyback. What is the maximum buyback I can do, sir? By passing board resolution, people, the maximum buyback you can do is 10% of the paid up equity share capital plus free reserves. If you pass special resolution, people, you can buy back 25% of the paid up share capital plus free reserves. If you are buying back equity, that means it is 25% of paid up equity share capital. Agreed? Yes, sir. Any other security can be your 25% of paid up share capital plus free reserves. Yes, sir. Declaration of solvency, meaning, sir, after buyback, sir, you are utilizing your excess money. You are telling we have extra and you are repaying the money back to the people. What if after repaying, you will end up in insolvency? Directors have to give a declaration. Don't worry, we have sufficient money. That is only called as declaration of solvency. We have money given by directors. That company will not become insolvent in the next 1 year. It is given in the format SH9. Important from exam point of view. Next one, sir, return of buyback SH11. Meaning once you have done the buyback, you need to intimate ROC in the case of unlisted. You will intimate ROC and SEBI in the case of listed. In the form SH11. Extinguishment of securities, meaning if it's a physical one, once you buy back, you need to destroy all the securities within 7 days. Then that is your buyback. Debentures, okay, prohibition. Section 69 was, we have already done. CRR account, capital redemption reserve account. One connected point is there. Okay, section 70, prohibition for buyback in certain circumstances. Meaning what, sir? Whenever you propose to do a buyback, people, you need to do it directly. You cannot do it indirectly. What do you mean by indirectly? I will give money to someone else. They will purchase our shares. That cannot be considered as a proper buyback. That is what they are telling you. The section of the Companies Act prohibits the company for buyback in certain circumstances. When the provision says that no company shall directly or indirectly purchase its own shares or other specified securities. How? Through any subsidiary company, including its own subsidiary. So subsidiary cannot buy its own shares. That is not possible. Through any investment company. Imagine venture capital funds or some private equity funds. They have invested. I cannot give money to them and I cannot tell them to buy. That is not allowed. Third one, if a default is made by the company in repayment of deposits or redemption or paying of interest or loan for financial institutions, provided you can do it after 3 years of making good the default. No company shall directly or indirectly purchase its own shares or other specified securities in certain scenarios if you have not complied with 92, 123, 127, 129. Clear? Yes, sir. There is one point. 1 second. 67 we have not yet done, no? Restriction on purchase of company or giving loans by it for purchase of its shares. What is section 67, sir? In certain scenarios, they are telling you indirectly you are not supposed to purchase. What do you mean by indirectly? They are telling you in certain scenarios you cannot buy the shares of the company. How is that, sir? First one. No company limited by shares or guarantee and having share capital shall have a power to buy its own share unless consequent reduction of share capital is effected. Meaning what? If you are doing the buyback, sir, the first thing you need to do is your capital is reduced. Indirectly, you know what this point is saying. A company cannot buy the shares of the company as an investment. Now, I know for a fact for the next 5 years I will grow. I will invest in my own company and I will keep it. This cannot happen. If you buy it, you have to subsequently reduce your capital. You cannot hold it as an investment. Not allowed. Understood? Huh? Okay. Second one, sir. No public company shall give by means of loan, guarantee or any other financial assistance for the purpose of purchase or subscription made by any person or any shares in the company or in the holding company. There is an exception. What is that? We'll say. A public company is not supposed to give a loan. And it cannot tell some other person to buy the shares of my company or my holding company. But exception is there. When is that? Imagine I'm a banking company. ICICI Bank. I took the loan from ICICI Bank. I invested in ICICI Bank only. Because that is my ordinary course of business, ICICI can't stop. Because as a customer of ICICI Bank, I have a right to take loan. I took it. I invested in their company only. They're telling me this restriction will not apply. And this restriction is only for public company. For private company, if you remember, there are some exceptions. Some conditions have to be satisfied. What is that? We'll see. Next one, the provision is made for purchase of. Now, what is this, sir? Now, imagine people, an employee is given an option to, where is it? See this point, C point. An employee is given an option to buy the shares of the company, ESOP or sweat equity. You imagine a person who is earning 40,000, 50,000. You are telling him to buy shares. And how much is the value of shares? It is coming to 5 lakhs. Where does he have money? As a company's policy, you can support him by giving a salary advance. As a loan, you can give it. Give a loan. But how much? Not exceeding 6 months of your salary. Oh, sir, super. A CFO came, CEO came, director came, asking for this opportunity. Will they be covered? Remember, they are not covered here. Other than director or KMP, employee can avail what people? He can avail salary advance, not exceeding 6 months of his salary. Next one, sir. The provision is made for the purchase or subscription or fully paid up shares in the company or its holding company. The purchase or subscription, the shares held by trust, blah, blah, blah. What is this, sir? Nothing but, if you remember in the class, I would have told you, if you want to do ESOP, there is something called as trust route. Meaning what, people? until the company allots shares to the employees, grant of option, vesting of option, and exercise period. In that 1 year, where will the shares be? So what will a company do? Company will create a trust. Now you see Reliance and all. Reliance and all gives around 1 crore, 2 crore shares to employees. Not one person, but under employee you can see so many shares. And every year they will identify new employees. So until there, where will all that shares be? Reliance will create a trust. Now what will the trust do? The truster will take the money, the trust will buy some shares, and the trust will accumulate the shares in the name of the trust. Whenever a right employee is identified, they will allot the shares. Technically, you are not supposed to give loan to anyone, no. But trust route it is allowed. Because for the benefit of the employees, you can give money to the trust. If you want, I can explain it in 2 minutes. If you want to understand this topic in detail, I should explain. Generally, there is something called as trust route people. Now imagine a company can implement ESOP in 2 ways. One, company only will keep a track of everything. Grant of option, vesting of option, exercise period. Everything company only will keep a track of it. Second one, once the company starts growing, it is difficult for the company only to take care of everything. So what will a company do? Company will say, I can't do this job, a truster, you do the job. And the company will give truster 1 crore rupees. We will give them the money. Now what will the truster do? The truster people, the company would have identified the employees. Now in this 1 year, after 1 year only, we have to give him a share. The trust will just keep on waiting. In the market, whenever the shares are falling, the trust has got money from the company, no? It will use the money and it will buy the shares from the market. Freshly, the company will not allot. Whatever is there in the market, that only I will buy, I will keep it with me. Again, it will fall, good opportunity. I will again buy it from the market. And the trust holds it. Now, sir, after 1 year, if an employee says, I want the share, the trust will transfer the shares to the employee, exercise, that is allotment takes place. Now, ESOP, correct? It will definitely be for a little lesser price, obviously, but not completely free. Yes, sir, because ESOP can never be given at discount. So, sir, he will pay the money. The trust will repay the money taken from the company. Understood? Technically, according to the section, a company can never give money to anyone to buy its own share. It is giving no here. Exception trust route. Sir, ivlo irka sir idre. Ante emra endo antunnada? Intunda sir dintlo. Now read. The provision is made for purchase or subscription for fully paid up shares in the company or its holding company, in the purchase or subscription for the shares held by trustee for the benefit of employees or such shares held by employee of the company. So basically, as a trustee, for the benefit of the employees, if the trust is holding, this is allowed. Understood? Pakka na? 100%. So this is your private company, sir. I told you this exception is for public company. So technically, public company cannot give money to anyone, but they are still allowed to give. What is the exception? One is banking company, ordinary course of business. Next one is salary, not exceeding 6 months. Next one is, in the case of trustee, for the benefit of the employees. This is for public company. What about private company, sir? Private company, this section will not apply provided all conditions are satisfied. What is that? In your company, no other body corporate should have invested. Meaning individuals are allowed. If a company, LLP, if they have invested people, then no, this exemption is not applicable for you. Next one, people, if the borrowing of a such company from banks or financial institutions or any body corporate is less than twice of its paid up share capital or 50 crore rupees, whichever is lower. Meaning what, people? The borrowings in the company should not exceed this number. Meaning take your paid up share capital, multiply it into 2. Imagine my capital is 1 crore. Multiply it into 2 crore or 50 crore rupees, whichever is low. So 2 crore, in my company, borrowings should not be more than 2 crores. Nothing but similar to the debt equities only. So next one, sir. Such a company is not in default of repayment of such borrowings subsisting at the time of making transaction. Meaning you should have not made any default. If made, you should have made good. As on today, there should not be any subsisting default. Clear? Yes, Pakana, done. Okay. All the important sections are done. The last sections are nothing but directly debentures. Yes, people, taka, tell me what and all are the provisions with regards to debentures. How long can a debentures be issued for? What is the timeline? A debenture cannot be issued for a period more than 10 years. Exception again, infrastructure companies. Yes, sir. Can a debentures be given a voting right? A interest is not paid for 2 years. No, no matter what, people, a debenture can never enjoy voting rights. Okay, if convertible debenture is to be issued, pass special resolution. Is it always special resolution, people? I think I told you something in the class. No, yes. Okay, always remember, people, whenever you are issuing convertible means it is getting converted to equity. Yes, you need to pass special resolution. Cross reference section 62 subsection 3. If you are giving debt today, if you want to convert it into equity tomorrow, you should have taken prior approval. Understood? Okay, sir. Next one, sir. What if it's non-convertible, sir? Non-convertible, people, acts as a debt. So, I think I would have given you an example in the class. There is something called a section 181C. This has a limit on the directors. Up to one limit, you guys can borrow without even asking us. If it is going beyond that limit, people, you need to take shareholders' approval. Yes, if it is up to one limit, you need not even take shareholders' approval. Same point even will come in deposits. Clear? Because it's a debt, it's not equity. So special resolution is not mandatory. When will special resolution come into picture? When the directors are going beyond their power. And the power is given in section 181C. Because it is not there in our syllabus, I am not taking you in detail there. Clear? Yes, he is like 181C. Okay. Class lo cheppinta adi kuda. Secured debenture can be issued. Sir, if I want to issue a secured debenture, sir, first thing you need to appoint a debenture trustee. You need to enter into debenture trust deed. The repayment period should not exceed 10 years. Infrastructure company can go up to 30 years. And next one, whenever you're creating secured debentures, you need to create a charge on this particular debentures in the favor of debenture trustee. And you need to appoint a debenture trustee before you issue the prospectus or letter of offer. When and all debenture trustees appointment becomes mandatory, people, when and all? More than 500. And whenever you are issuing a public, basically prospectus, you need to mandatorily issue, you mandatorily need to appoint a debenture trustee. Remember that. Okay. Debenture with voting rights cannot be issued at all. At the time of issue of letter of offer, you should have already appointed a debenture trustee. But it's okay, you can take the debenture trust deed even after issue also. That's what they're given. Within 60 days after allotment, enter into a debenture trust deed. SH12. Charge not required for government company where government amount is guaranteed by central government or state government. Okay. With regards to conditions, sir, exceptions, infrastructure, private company, finance, all these companies, they can go up to 30 years. Debentures, okay, they have two things, sir. One is debenture redemption reserve, debenture redemption fund. Yes, sir. Tell me first, debenture redemption reserve. How much I need to create? Debenture redemption reserve. Only one company has to create 10%. That also. If you remember the table, only DRRO, DRFO. Only one company has to create DRRO. And which is that? Unlisted companies. Apart from these companies, only see. You should not be all India financial institution. You should not be a bank. You should not be financial institutions. You should not be NBFCs and housing finance companies. Apart from that, Arivu, where will we come? We will come here only. Are we financial institution? No. Then we will come here only. Hotels, where will they come? They will come here only. Meghana's Biryani, where will they come? Zomato, sir, where else will they come? So people, I'm telling you, all of us will come here. Now, if we are issuing debentures, we have to create DRRs, and that is 10%. Understood? Huh? And how do I create this 10%? 10% is on what? 10% is on total outstanding debentures. Whatever is still not yet paid, on that you need to create 10%. Okay, DRR is on 10% of, I will write it as total outstanding debentures. I need to create DRR. Okay, now Lokesh asked, Gokul, you changed your name, what? Okay, ಅದು ತುಂಬಾ ದಿನ ಆಯ್ತಲ್ಲ. Okay, Gokul, yes people. Now, Gokul asked, sir, this 10% is waste, no sir. You're telling me to just keep it aside. I've kept it aside, but it's not giving me any money at all. Gokul, don't cry, da. This 10% may 15% invest in some places. Wow, sir, I'll invest in options, so futures, so I'll udayenge, sir, money. You udadenge, you will you'll just make a loss to the company. Da. You cannot invest wherever you want, people. Safe investments are okay. Like scheduled banks, government, unit trust of India, all these are allowed. Yes, sir. Sir, how much can I save, sir? 15%. 15% of what? 15% of debentures maturing during the year. Ade Guru. So, if I take a financial year, now let us imagine from 1st April 2024 to 31st March 2025, during this period, whatever the debentures that is going to mature, I need to deposit by 30th April of the year. I need to deposit in a separate account. Basically, whatever, wherever you want to make the investments for. Agreed? Yes, sir. Sir, what is the difference between DRR and DRF? DRF 15% is calculated on the debentures maturing during the year. Because in the lifespan of the company could have issued many debentures, or you would want to redeem the debentures in advance. However you want to, you do it. So in such cases, what you need to do, you need to create a reserve. You need to create one investment fund, and that is only called as debenture investment fund. Is clear? 100%? Okay, sir. So, and who needs to create DRF? In this table, as of now, I'm not going and doing who and all are not required to create. I'm just doing who are required to create. But remember, in one attempt, they have asked, because you know, we think we are bad. Institute is our dad. NBFC and HFCs, whichever is listed, they need to create DRF. Remaining listed companies, you need to create DRF. Yes, sir. Next one. Remaining unlisted companies, you need to create DRR also. You need to create DRF also. Two things in debentures. One more thing is there. One is who can be a debenture trustee. Disqualification is important. We'll see of that also, because it is investments where you can make that is important actually. Okay. See, debenture redemption fund, people. It shall be deposited by 30th April of each year. It shall be deposited in scheduled banks, unencumbered securities of government, unencumbered securities mentioned in Indian Trust, unencumbered bonds issued by company under Indian Trust Act. Such money shall not be used for any purpose other than redemption. DRR is always created out of profits of the company. Remember, you cannot use any other money. It is always created out of the profits of the company, which is available for distribution as dividends. From that money, you create DRR. From DRR, you create DRF. Here, not always, because DRR is not applicable to everyone also, no? Now, for example, if you see this companies, there is no DRR at all. So, not always, but if this is the case, yes, it is from DRR only you create DRF. Clear? Yes, sir. Okay, that's important, remember. And with regards to debentures, people, there is one thing. What is that important thing? Who cannot be a debenture trustee? Important. A person shall not be appointed a debenture trustee if he is a beneficial holder of shares. So basically, a shareholder cannot be a debenture trustee because he will be biased. A promoter, director, or KMP, or any other officer, or an employee of the company of holding subsidiary, correct now? beneficially entitled to money which are to be paid by the company otherwise than as remuneration. As a debenture trustee, you will get remuneration from the company. Other than that, if you are getting any money, example, imagine you are a debenture holder only. You will get interest, beneficially entitled, you cannot become. Indebted to the company, I've taken loan, ICICI Bank, I've taken loan from them. I want to become a debenture trustee of them only. Not possible. Has furnished any guarantee. Someone has taken loan. I have given guarantee. If he doesn't pay, I will pay. Again, not possible. Has any pecuniary relationship. Pecuniary means any other monetary relationship of a value 2% or more of its gross turnover, companies, or total income, or 50 lakh rupees, whichever is less. Correct? Next one. During the two immediately preceding financial year or current year, is a relative of any promoter or any person who is in the employment of the company as a director or KMP. So you cannot be a relative also. As an employee, okay. Director or KMP, not allowed. So next one, sir, casual vacancy people, the board only may fill the casual vacancy. However, if at all the casual vacancy is due to resignation, that means why will someone leave and go? Something should have happened. So, see, okay, next, sync. Okay. If such vacancy is caused by resignation, then majority of the debenture holders has to agree for it. Consent has to be given. Next one, can we remove? Can we remove a debenture trustee? Yes, possible. Provided 3/4 of the debenture holders value, in value, has to give a consent. Next one is, remember the meeting part. When will the meeting be conducted, people? Whenever a request is made by at least 1/10 of the debenture holders in value, or whenever there is a need. That is, imagine if they have not made a repayment, they have not repaid the interest on time, there is a breach or there is a default, you can call for a meeting. Next one, liability of debenture trustee, meaning in the trust deed, there cannot be a clause which says, if anything happens due to my negligence, you cannot hold me liable. Even if it is there, it will consider as void. It will not be effective. But is there a way where if I have made something, I can be excused of what I have done? Imagine I am liable technically. Can I be excused? Possible. How? The debenture holders 3/4 in value have to excuse such incident. If they excuse, then okay. But if just because it is there in the trust deed, you will not be allowed or you will not be excused. Clear? Yes, sir. Yes, sir. Done. So by this we complete your chapter 4. Okay, taka. Online. Yes, sir. Online there. Okay, we'll gear up here. Will not take much time. We'll try to finish a little early. Is it working, Ada? Okay. Okay, now. Okay. Yes, people. Online now? They are online now. Okay, yes, people, let us do acceptance of deposits by companies. First thing, sir, before we start acceptance of deposits, first thing we need to know is what is not a deposit. So, important definition they may ask you in the terms of, they will never ask you, almost never only, but I cannot assure and give it, but they can never ask you the complete deposit definition. They will ask you scenarios only. Whether this is considered as deposit or not. Yes, sir. Okay. What is not considered as deposit, people? The first one, any amount received from first government, that is your central government, state government, Guaranteed by government, local authority, statutory authorities. Local authorities can be your development authorities. For example, if I take Bangalore, BDA, Bangalore Development Authority, which takes care of land, BBMP, municipalities. So things like that. Statutory authorities is nothing but your regulators. Sir, any amount received from, one is Indian is covered, next one is foreign governments, foreign international banks, and multilateral financial institutions like your World Bank, etc. Loan received from any banking company. So bank is giving me a loan, it is coming considered as loan and not as a deposit. Loan or financial assistance from public financial institution. What do you mean by public financial institutions? As of now, only two are defined. One is called LIC, next one is called as IDFC. Only these two are defined under Companies Act only as public financial institutions. Or it can be any other, sorry, three are defined. UTI is also there. Specified company referred to in Unit Trust of India. So, PFI, sorry, what is it? LIC, IDFC and UTI. These three people are considered as public financial institutions or any other company as prescribed by central government. Next condition also same, prescribed by central government with consultation with RBI. These people can be called as PFI. So to become a PFI, what is the criteria? First thing, you should be a statutory company, meaning established by the act of the parliament or state legislature. Next one, people, minimum 51% of the shares should be held by the government. These two conditions has to be satisfied to become a public financial institutions. Clear? One more definition covered. Okay. Next one, any amount received against commercial paper. Why people you need to follow RBI guidelines. Next one, any amount received by a company from other company. This is generally called as intercorporate deposits. One company gives loan to another company will not be considered as deposit. Amount received and held towards subscription. Meaning what people? Share application money. You can keep it as share application money for a period of 60 days. 60 days if you are not making allotment, you need to refund it within 15 days. If in 15 days also you are not refunding, after that people it will be considered as deposits. Clear? Yes sir? Okay. Next one, people, any adjustment of amount for any person shall not be deducted. Okay. Any amount received from a director of the company or relative of the director of the private company. Meaning what, sir? If a director is giving me a money or director or relative of a director is giving money, people, in the case of private company, it is not considered as deposit provided he gives a declaration. The declaration is, people, sir, oh, hamara mehnat, hamara money, sir. I have not borrowed it from any place. It's my own money. Okay. Next one, amount raised by the issue of bonds or secured debentures. First thing, people, if it is secured, it has to be secured by first charge. Next one, it should be only on tangible assets. Intangible assets are not allowed. The third thing, people, that it is to be compulsorily converted into shares within 10 years. So what if it is not compulsorily converted? It will come here. Non-convertible. If it is non-convertible, you don't have a choice. It has to be mandatorily listed. So if it is convertible, that means you need to mandatorily have a security. Huh? If it is non-convertible, it has to be listed. I'm telling you, if it is convertible, then it is to be mandatorily having a security, first charge. If it is non-convertible, mandatorily listed. What I'm saying is convertible, security is mandatory. Non-convertible, listing is mandatory. Clear? Yes, sir. Sir, provided security. Remember, whatever is the market value of the asset you are creating as security, debentures value should not be more than that. Imagine the property. I'm giving land as security. Land value is 1 crore. Debentures value should be less than 1 crore. It cannot go beyond that. Clear? Okay, next one. Any amount raised by issue of non-convertible provided listed on recognized stock exchange. Amount received from an employee not exceeding his annuals annually. Provided should not be interest bearing. Generally, people security deposits. If you are taking any money from your employee as a security deposit, you can take, provided it should not go beyond his annual salary. If you take it and if you start giving interest, it will become FD. That's why it is non-interest bearing. Make sense, huh? Okay, next one. Any non-interest bearing amount received or held in trust. Basically, the trust thing. Any amount received in the course of or for the purpose of the business. So if a company is doing business, in the course of business, I am receiving money. Now your next list will start. What is that? Sir, we are Arivupro. We have taken classes from you. Sorry, you have taken classes from me. You have given money to me. Initially when you joined, you paid for both the modules. They are telling me if you have taken money in advance, the product or service has to be given to you within 365 days. Sir, there is a case going on between me and Gokul. Sir, what you did is not fair. We went to court. Now, because of the court proceedings, I was not able to deliver the product within 365 days. Because of that, if there is a delay, it is okay. That's an exception. Due to litigation, if there is a delay, that's an exception. Next one here. As an advance receipt in connection with immobile property. Whenever you take land and all, obviously, day one, no one will give you 2 crores. Token advance, so things like that will be there. Provided it is adjusted in the future amount you pay. So if you have taken 1 lakh today, in the future, if you are taking remaining amount, you can deduct it. As security deposit for the performance of the contractor. If people take money as a secure deposit for the performance of the contractor, that is also allowed. Next one, as advance received under long-term projects. Long-term projects are basically where, imagine the government also tells this. If I have to give you a tender, government takes some amount from you, provided they need to have a guarantee, no? What if you do not complete the project? So they will take money from the people whom we give the tender to. That can be the case. It is not considered as deposit. An advance for providing future services. An advance for providing future services. Security deposit performing the contract of supply goods. For example, I think we have told that Wonderla bounce bike or what is that? Yulu bike, Zoom cars and all. They take some advance amounts from you. That is allowed. Next one, sir. An advance for providing future services. What is this, people? Maintenance, warranty charges, annual maintenance services. Agreed, Pakka na. So they are telling me what is the maximum I can say, sir? It cannot exceed whatever the other competitors are following or 5 years, whichever is less. So if my competitors are following 3 years, 3 years or 5 years, whichever is less, 3 years, you cannot take maintenance charges for more than 3 years. If competitors are following 7 years, you are following, competitors following 7 years, 5 years, whichever is less, 5. You cannot go beyond 5. Advance received is allowed as a sectoral regulator. Try. Telecom industry only allows me to take. Who are you to say? Insurance, IRDA, allows me. Who are you to say? As an advance for subscription towards publication. What is this, sir? Week magazine. Your ICI magazines you guys will get. No, you guys will subscribe. Imagine because of any reason they are not able to give you the publication. They have to refund the money within 15 days. If at all they are not able to deliver the product, at least give back the money within 15 days. Any amount brought in by the promoters as stipulation by lending financial institution. What is that? I wanted to start one project. I went to a bank asking for 1 crore loan. Bank said I will give you 80 lakh rupees loan provided 20 lakhs you bring. If at all you don't have capacity to bring in 20 lakhs, how can I believe 80 lakhs on you? So if at all, this is nothing but down payment. Correct? Next one, any amount accepted by a Nidhi company. Nidhi company, that's their duty, that's their job. Chit fund. They are regulated by state acts, chit fund act. Any amount received by the company or any collective investment schemes. Collective investment schemes are any other schemes. For us, let us not get into that as of now. Nothing but your gold schemes, SARI schemes, Patre schemes, all of that will come there. Convertible note. Important, there will be a question here. A company raising money by issuing convertible note, it will not be considered as what, people? It will not be considered as deposits, provided the minimum amount you take should be 25 lakh rupees or more. Less than that is a deposit. It has to be converted or repaid within 10 years. And the 25 lakh rupees has to be collected in a single tranche from single person. And the amount has to be received by a startup company. So you need to satisfy all the conditions. Single tranche means single transaction. 25 lakhs அப்படியே money credited amount, message has to come. Yes, correct. So private company incorporate, this is a startup. Yes, DPIIT approval and all. If you take DPIIT approval, you'll get. Clear? Okay, any amount received from a company from alternate investment fund, domestic venture fund, correct? So if a mutual fund is investing in you, regulated by SEBI, REIT, why all this, sir? It is all coming under or regulated by SEBI. That's what they have given here. Correct? Yes, sir. In the class we had seen what is REITs, mutual funds, and all that. Yes, sir. So we had seen everything in one place. You guys want to revise this again or no? Done. Done, no? Okay. Next one, sir. Okay, let us do section 73. Okay. 1 second. Able to understand it, Online, able to understand it, Serving the purpose why you are here for. If that's not the case, it has no value. Okay. Acceptance of deposits, yes, sir. Okay. Section 73, sir. Okay. First of all, sir, this acceptance of deposits is entire provision. It says, section 73 simple. It says, prohibition of acceptance of deposits from public. Few companies are not allowed to accept deposits from public. Now, who are they, sir? First thing, eligible companies will be seeing that in the next section. In 73, it says, you're not supposed to take from public, then you can take it from members. But this restriction is not applicable to certain companies. Who are they? That is banking, NBFC, HFC, or other companies specified by central government. So they can ask you a question here. Remember to see the name properly. They will directly ask you, XYZ Housing Finance Company wants to accept deposits from public or from members. First of all, what is the procedure? The simple provision directly is people, it is not applicable at all. Because that is their everyday job. Banking company, that's their everyday job. I need not be eligible. Got the difference? So remember that is one way where they can ask you. Okay. Next one, sir. Sir, however, any company may accept deposits from its members, subject to the provisions will start. What is that? First of all, you need to pass a resolution. Why I have just put it as resolution? Depends upon how much money you are raising. If it is within the limits, then board resolution is also sufficient. If it is beyond the limit, special resolution has to come into picture. That's why we have put it as resolution. Understood? That is only 181C. Clear? Okay. Next one, sir. Circular. You need to give a circular. It's nothing but like a letter of offer. That is only called as DPT1. In this, what and all information should be there, sir? Issue circular to the members, inviting them for accepting or investing in the deposits. Okay. Financial position of the company, credit rating, and the total number of outstanding deposit as on today. If you guys have already accepted anything, as on today, how much you already have. Such circulars to be published in newspaper, English and vernacular. Remember, newspaper publication, if it's in the case of members, it is optional. In the case of public, it becomes mandatory. Sir, I give it in the newspaper. How long can I accept deposits from the public? It will come, technically this is more important for the next section, but we'll connect it here only. You can raise the deposits up to 6 months from the closure of financial year or 6 months from the closure of financial year or date of the AGM, whichever is earlier. Yes, sir. So imagine if I give my deposits circular in the newspaper on 1st January 2024. Then how long can I use this deposit? Using this circular, how long can I raise money? When will the financial year close? 31st March 24. From here 6 months. Or date of AGM, whichever is earlier. How many of you think? Anyways, both are same, no, sir? Anyone thinking like that? So remember, some listed companies, they can have 5 months also. AGM. They not every company is 6 months. What if few companies do the AGM little earlier? The last day is 6 months. They can do it in May also. Now that becomes May or 6 months, whichever is earlier. Understood? Okay. Next one, sir. 72B. So 72A talks about how to prepare circular. 72B, before you give it to the members, you need to first show it to one person. ROC has to approve. Then, sir, you have to at least give 30 days prior. Okay, once ROC approves, 32C talks about DRR. Same thing we saw now there, sir. There it was. Redemption reserve. Here it is deposit repayment reserve. It will be at the rate of 20% of deposits maturing during the financial year. Technically, the explanation is similar to DRF. There it is 15%, here it is 20%. It has to be created by 30th April of each year. Okay, 72E, sir. Company not defaulted in repayment of any deposit. You should have not made any default. If any default is made, then 5 years has to elapse. So 72A to E. A talks about circular. B talks about giving it to ROC 30 days prior to giving it to members. C talks about DRR. E talks about people. No default. If default, they should have been. You should have made a default. So what is that? You have made good the default. Correct? Now people. 72A to E. D is missing. D was once there. Now it is removed. D was people deposit insurance. Earlier it was there. Now it is removed. Now it is no longer there. Sir, if it is not there, then why will you tell? First of all, kutti chitti brain, sir. You know how much difficult it is to. Because in one attempt, they have asked one question: is the company required to take deposit insurance? After the amendment. Meaning what, people? Technically it is removed. You don't have a knowledge, you have not seen. So you should have written, no, it is not required. But you do not know it at all. Correct? Yes, sir. That's the reason I say. Clear? Okay. So 72A to E. So every company should follow this. Not every company, people. Some companies are exempted. Who are there? It is not applicable to a private company. So they can raise deposits without following 73A to E. Provided you have to satisfy these conditions. What is that? It accepts from members not exceeding 100% of the paid up share capital of the company plus free reserves plus securities premium account. If it is within that, people, then you can go without following this entire procedure. Next one, or registered startup for 5 years. This is the only place, Mahan Bhavs, they have just kept it as 5 years only. In rest of all the places it is 10 years. Or which fulfills all the conditions. What is that? You are not an associate or subsidiary of another company. Borrowing is less than twice of paid up share capital or rupees 50 crores, whichever is less. Similar to that, whatever we saw there, public and private. Next one, not defaulted in repayment. If you satisfy all this, then a private company need not have to follow 73A to E. Clear? Okay. Procedure for acceptance. How do we generally accept, sir? First, you need to pass a board meeting, general meeting, task resolution according to AOA or according to the limits. Draft circular DPT1, file it with ROC, and people will start applying for it. When you are taking the application, take a declaration also that is they are applying with their own money and not borrowed money. Collect the application. You need to issue deposit receipts within 21 days of receipt of money, CT, acknowledgement. You are giving share certificates there. Here you are giving deposit receipts. Sir, within 7 days of issuing deposit receipts, people, you need to make an entry in the register of deposits. Maintain deposit repayment reserve at the rate of 20%. Submit the return of deposits in form DPT3 by 30th June every year to ROC. What is the status? How much is outstanding? How much have you repaid? Keep on filing it to ROC. If company fails repayment, then you need to intimate it to tribunal. Maximum amount of deposits that can be accepted by non-eligible company. We'll see this, what is it, after a little while later. Clear? Okay. Exceptions are the maximum limit shall not apply in the following case of private company. That also we'll see later. We'll do of section 76. Okay. Okay, we'll do of this section only. So, sir, first of all, now we saw who can accept deposits from members. Now, who can accept deposit from public, sir? Who can accept deposit from public people? First of all, you need to be a eligible company. What is eligible company? It is given in rule 21E. What is eligible company? It's a public company having a net worth of minimum 100 crore or more, or turnover of 500 crore or more, or it is, remember, net worth it is, very rarely it comes up.
135 also.
Yes, clear, minimum of 500 crore or more, plus pass special resolution if within limits of 181 CA. Correct, Okay. That is all sufficient. Provided depends upon your AOA. Yes, sir. Okay, sir. Board meeting plus general meeting, as the case may be. MGT 14, you need to file with ROC. Not required, that's fine. Appointment of deposit trustee, because you are giving it to public. Because you are appointing a deposit trustee, you need to enter into a deposit trust deed. DPT 2. Correct? DPT 1 circular. DPT 2 trust deed. DPT 3 return of deposits filed with ROC by 30th June every year. Okay. Obtain credit rating. Important, I can ask you a question. When should we obtain a credit rating?
Every year.
You need to obtain the credit rating every year as long as the deposits are not repaid. As long as they are outstanding, you need to renew the deposit credit rating every year, and you need to disclose it to ROC. Clear? And the credit rating shall not be below minimum investment grade rating, that is in the industry. What is the minimum rating? So, for example, passing for you is 40. Like that, what is it for deposit? It should not be below that. Generally, it should not be below B. Yes, other specified credit rating for fixed deposits. For FDs, what is there? It should not be less than this or that. Okay, only eligible companies. Okay, next is same. Charge creation. Whenever you create a charge, obviously, you need to intimate it to ROC in the form CHG1. Issuance of circular in the form DPT1. English vernacular newspaper. Validity, website, how long they can apply, same thing will come into picture. Within 6 months of closure of financial year or due date of AGM. Whichever is earlier. Collect the signed application, same thing. Issue deposit receipt within 21 days. Not bad. Issue deposit receipt within 21 days. Make an entry in register of deposits within 7 days. And of course, maintain deposit repayment reserve by 30th April of each year. And maintain DRR and file DPT3 by 30th June every year. Is clear? All of you done. For with regards to deposit repayment, deposit rules, there are certain rules. What is it, sir? First of all, what is the minimum tenure a company can accept? The minimum tenure people cannot go below 6 months. So you can never accept deposits repayable on demand. Like savings account cannot be opened. However, on the need basis, you can open short-term requirements. You can up to 3 months. It cannot go below 3 months. Provided for the short-term requirements also, it shall not exceed 10% of the paid up share capital, free reserves, securities premium. It can be accepted to meet short-term requirements provided it cannot go less than 3 months. Clear? Yes, sir. Okay. Maximum tenure 36 months. Sir, premature repayment of deposits, sir, meaning I have taken my deposits for 2 years. Or I have taken the deposits for 3 years. I want the money within 3 years. Can I do it? Can I ask for it? Allowed, sir, provided whatever the rate of interest will be reduced by 1%. But this reduction of 1% will not be applicable in two cases. Case 1 people, to satisfy rule 3. What is rule 3? Rule 3 says what is the maximum deposits you can accept. What is the maximum deposit you can accept? Every company can accept one number, no. If you are a company other than eligible company, the maximum deposit you can accept is 35%. Now imagine company went for a buyback. The percentage will decrease. Hey, 35% of what? From members, how much you can accept? 35% of what? Paid up share capital, free reserves plus securities premium. When you do a buyback, what will happen?
35% will remain same, sir. The number will remain.
Hey, what I'm telling imagine your paid up share capital was 100 crore. Your free reserves was 50 crore. And your securities premium was another 50 crore. You add everything, it comes to 200 crore. On this, you have taken 35% as deposit. You are allowed, you have taken this. In the next year, company went for a buyback. You went, buyback, how many all you can do? Free reserves you can do, using free reserves you can do buyback. I bought back, imagine some 20 crore worth of shares. 20 crore reduced here also. How did you buy back? Using my free reserves. It went down here also. This became 80A, this became 30A, this became 50A. What is the total? 160A. Now 160 into 35%. You have accepted this amount. Now obviously it is going beyond this. So to correct it, what you will do? You have to repay. So if you are repaying for this, meeting the requirement, you need not reduce the interest by 1%, pay off everything. Sir, second reason, when will we reduce? When we will not reduce is 1%. If it is asked by army people, navy people, or military people at the time of emergency, if they are asking or their dependents are asking, you will give back the entire money without reducing any percentage of interest. These two are the exceptions. Clear? Yes, sir. Sir, whenever we are applying this limit of reducing 1%, I am asking for premature repayment. Now, sir, they are telling you to calculate this even months people, they have given you one criteria. What is that? Reduction of rate of interest payable. I can come and ask for premature, provided it should not be less than 6 months. It should be only after 6 months. Okay. Rate of interest shall be 1% less than what would be payable, provided less than 6 months to be ignored, 6 months or more to be considered as 1 year. Meaning what, people? Imagine if at all I have completed a tenure of 1 year, 7 months. You need to consider as, you need to round it up as 2 years. 1 year, 7 months. Remember 1 year, 6 months also. 6 is counted where? That's the reason I'm given you 6 months or more. You will round it off to next year only. Less than 6 months, you will treat it as people 1 year. That's 5 months, imagine. The 5 months will be ignored. So you will get the interest only for 1 year. How much you need to get? Whatever you are entitled to, it will be reduced by 1%. If I was entitled for 12%, I will reduce it by 1%. You will get 11%. Is clear? 100%? Pakkana? Okay. Sir, higher rate of interest. Sir, now you imagine this year they promised me to pay 10% rate of interest. Now, am I eligible for higher rate of interest? Yes, people, provided you renew your deposit. How much should I renew, sir? Imagine, people, I had taken my deposit for 36 months. Now 24 months is already done. Another 12 months is pending. Now you can go and you can ask the company for renewal. Provided whatever is a renewal period should be more than the unexpired period. Still 12 months is pending. Your renewal should be more than that. So that should be 24 months as the case may be. Understood? Pakkana? Then you will be eligible for higher rate of interest. Okay. Next one, sir. Quantum of deposits. What is the maximum deposits a company can accept, sir? It depends upon what type of company you are. There are 3 types of company. One is called as eligible company. Never say public or private and all. One is eligible company, other than eligible company, government company. If it is a other than eligible company, meaning if your net worth or your turnover is not coming in those limits, then people you can accept deposits of not more than 35% of paid up share capital plus free reserves plus securities premium account. If you are other than eligible, if you are eligible company means people, how much you can accept? 35% only, never write 35%. Write it as 25% from public, 10% from members. That's how. You cannot take entire 35% from members or entire 35% from public. That does not work. Next one, sir. If at all it is government company, maximum 35% from public. Clear? If company fails to repay deposits, they shall pay interest at the rate of 18% per annum. If company fails to repay the deposit, the depositor may file an application to tribunal. It may by order tell to repay or any loss or damage incurred. Increase, decrease, increase, increase, చెవున వస్తుందా? నీకే ఉంది రాదు, అందుకే ఐ లిఫ్ట్ ఇట్. వెయిట్, will increase. Yes, sir. Done. Okay. Anything else done in deposits, sir? Okay. Certain things were not allowed. What is it, sir? What is the maximum people I told you? 35% other than eligible companies, 10 and 25 eligible companies, 35 government companies. However, private companies, people, there is one exception which we said we will come back. What is that, people? The maximum limit shall not apply to the following class of private company. Technically, what is private company? Other than eligible company only, no? So technically, other than eligible company can maximum raise 35% from its members. But following private companies can go beyond 35%. Who? A private company which is a startup for 10 years, you can go beyond 35%. Understood? Sir, why is it 10 years here? Or I told you, in one place they have made it 10, one place it is still 5 only. Next one, private company which fulfills all conditions, whatever we saw above. It should not be associate or subsidiary of any company. Borrowings less than twice of its paid up share capital or 50 crore, whichever is less. Company has not defaulted in repayment of any borrowings. So if you satisfy these people, then you can go beyond 35%. Clear? Pakkana? Do not get confused between two exceptions. One exception is talking about how much deposits a private company can raise. That is this limit. Next one was exemption for following the procedure of raising deposits. 73A to E. Understood? Pakkana? So I believe this is your deposits chapter. Done? Okay. Let us do of registration of charges also. After this, we'll take a break. And after that, we will do what is that? Management. For today, let us finish it off. For tomorrow, we have less part only. If possible, we'll finish maximum. So the next day, let us keep it for maximum questions only. Because I'm just looking the content part, we'll finish it off. RTP will pakka do, and MTPs will do. That's all of you, pakka. And yes, questions. Okay. We'll do charges, Okay. First of all, we will next chapter we will registration of charge. Registration of charge, people. First of all, charge can be of two types. One is called as fixed charge. Next one is called as floating charge. What is the difference between fixed charge and floating charge? Fixed charge is fixed charge. Fixed charge is created on a specific asset, basically a fixed asset, where if you want to further sell it, you need to take the creditor's approval. If you want to further take any loan on it, you need to take the creditor's approval. Whereas in other case, there is something called as floating charge. What do you mean by floating charge, sir? Something which is not yet fixed. Generally, examples, you guys can take loan on stock in trade, on debtors, accounts receivable. On all this, you guys can go and take loan from the creditors. They are called as what, people? Floating charge. Floating charge remains floating. The creditor will not have any right on it as long as it is a floating charge. But a creditor will have a right on it when a floating charge becomes fixed charge. This process is called as crystallization. It's clear? Pakka na? Yes, okay. And when does a floating charge gets crystallized? Two are very simple. Three are very simple actually. First one is when company goes into liquidation. Then obviously I need to get back my money. Second one is company ceases to carry on business, stops doing the business. Third one, the creditor or debenture holder takes steps to enforce security. What is CHG 6? Day. Appointment of receiver or manager. What is that? Now imagine people, someone has not paid me loan on time. What will I do immediately? I'll appoint a person to go and take charge of that particular property. So that is the step where creditors or debenture holders takes steps to enforce the security interest. Appointing of receiver or manager. That is a force of, taking steps. Clear? Okay, next one, happening of any event specified in the deed. So in the deed, whatever is specified, according to that I can take an action. That is when the floating charge will get crystallized. That is your fixed charge. Okay, next one, sir, what if I do not register the charge? What is going to happen if you do not register the charge? There are two consequences. One is people void against the liquidator. Next one is void against the creditor. What do you mean by void against the liquidator? The liquidator can tell you, though you are a secured creditor, if the company goes into liquidation, I will tell you, don't stand in the secured creditor's queue, go and stand in the unsecured creditor's queue. So first the secured creditors will repay. If still money is there, we will repay it to you. Sir, what do you mean by void against a creditor? Imagine people, I have created a charge on the same property with two people. First I have created with HDFC Bank, next I have created with ICICI Bank. On HDFC I have created on 1st Jan 2024, on ICICI Bank I have created on say for example 1st Feb 2024. HDFC has not yet registered the charge, ICICI went and registered the charge. When they come for repayment people, ICICI will be given the first priority, next HDFC will be given the priority. Here Isham. Okay, void against the liquidator, void against the creditor. Okay, next one, sir. Duty to register the charge. Who will register the charge, people? First, the charge has to be registered by the company. It is the company's responsibility. If the company fails to register the charge, then it will be on the charge holder. So there are always two parties in the charge. One is called as charge holder. One is called as charge creator. Creator of charge or holder of charge. Creator of charge generally will be the borrower. Holder of the charge will generally be the lender. So next one more question. Imagine I have assets outside India. I have taken loan by giving those assets as mortgage. Should I even on that should I create a charge? Even for document for the property outside India also have to create a charge? Yes, people, wherever, irrespective of the place, you need to create a charge, whether on the assets in India or outside India. It's clear? Yes, okay. Provided who has to verify? Because someone has to sign. No, they're telling you. Remember, first of all, movable, immovable, tangible, intangible. Questionable points which I feel people, one is whether in or outside India. This is a questionable point. Next questionable points. Intangible assets also you can create a charge. On that also you can create a charge. Possible, you need to notify the registrar. That is also important. Yes, sir. Next one, to be verified by. If the property is situated outside India, the documents has to be signed or verified. Who will do it? Company seal. If a company has a common seal. If not, two directors or company secretary or authorized officer of the charge holder. Director or company secretary, authorized officer of the charge holder. Charge holder here is creditor. Some other person other than company who is interested in the mortgage. Who will this generally be, people? Imagine my interest will also be affected. Such person can also verify the document. Who can that be? Let us imagine we have taken this property on lease. Arivu will be the person who will be affected. So we can also verify the document. We can also verify the document because we have taken it on lease. We will be affected. Understood? Rent we will not be affected. Maximum. Lease you will be affected because long term, no? Okay. Property situated in India, 1 or 2. Third one will not come into picture. Yes, sir. Important question. They can ask you a question here also. Exactly where they'll ask? Here they'll ask. Outside India. Clear all of you? Yes, sir. They can split the question in this way. A company has property situated outside India. First of all, is charge possible? If yes, who needs to verify the document? Expected question. Next one, charge shall be registered with registrar within 30 days of creation of charge. So whenever you create a charge within 30 days, ideally you need to register the charge. However, if at all the charge was created, there was an amendment. If it was before amendment or is it after amendment? If it was before amendment, people, then we give 300 days additional time. Now imagine within 30 days you did not do it. 1st January 2019, within 30 days you did not do it. Then you need to go and touch the feet of central government. They will give you, okay done, don't worry, another 300 days time I will give you. Correct? This is called as condonation of delay. Condonation of delay is nothing but excusing your delay. To be filed with ROC by paying such additional fees. Sir, what if even within the 300 days I did not do? If you do not do it even within the 300 days, people, then on 1st January, 2nd November 2018, people, they finally introduced this amendment and they said one thing. What is that? Even on 2nd November 2018, if there are still some charges which you have not yet registered, one last time will be given to you, that is 6 months. That is 6 months. We need to take it as 2018, sorry. So 1st January 2018, within 30 days, within 300 days, plus 6 months. Sir, even within the 6 months, I did not register my charge, sir. Please show your feet, sir. I'll quickly touch it off. Don't show me feet, you turn, I'll kick. Correct? So people, if you miss this, people, you can never register a charge. Clear? Next one, sir, after amendment. So on or after, sir, that is 2nd November will be covered here. If it is before 1st November, it is coming under before amendment. 2nd or after, sir, will be covered in this place. Now what is the rule? First rule still remains the same. Within 30 days, you need to register the charge. How will you register the charge? Which form? CHG 1. You need to register within 30 days. Sir, within 30 days, I did not register. Now what will happen? If you did not register, people, then you will be given another 30 days time. Technically, it is 60 days from the date of creation of charge. But technically, you will be given extra 30 days only. But provided you need to pay some additional fees for it. Extra money has to be paid. Sir, even within the 60 days from the date of creation, I did not register the charge. Now what will happen? Another 60 days will be given to you. You need to register the charge within that days. Technically, it will come overall 120 days. Sir, for this extra 60 days, people, they will say you pay additional fee plus people you need to pay ad valorem fees. Nothing but something like a penalty. It's clear? Yes, sir. Sir, if you give CHG1, he will reply to you by giving you a certificate of registration in CHG 2. So CHG1 is you registering the instrument. If it is any security, CHG1. If it is debentures, secured debentures, you will file CHG9. CHG1 for any instrument, CHG9 for debenture. ROC will reply to you in CHG2. Now, sir, imagine, sir, we entered into a document, but for this document there are changes. What type of changes? Imagine there was Kingfisher. Kingfisher took loan from ICICI Bank by giving their UB City as a mortgage. Now, after some time, sir, the mortgage is still going on. The charge is still going on. One more company, let us take for example, there is Infosys. Infosys purchased this UB City from Kingfisher. Now, obviously, going forward, people, Infosys has purchased a property which is under a charge. This has to be intimated to ROC. How will we intimate, sir? This process is called as modification of charge. This is one way. Next way, imagine there is change in terms of the instrument, change in rate of interest, tenure, amount. That will also come as modification only. Modification will be given in CHG CHG1 only. Reply will be given by the registrar in CHG3. Biscuit ಹಾಕಿ ಹಂಗೆ ಟಾಪ್ ಅಂತ ಕಚ್ಬಿಡ್ತೀಯ. So 1 is creating charge. 2 reply for certificate of registration of charge. CHG3 is modification of charge. CHG9 debentures. Okay. So sir, what if the charge creator, that is the borrower, did not file the form? Now what to do? You don't worry, the charge holder, you will get the next power. If he has not created the charge within 30 days, now you come and file the charge documents. Sir, isn't it an unwanted expenses on me? Technically he should have done. Why should I do? You have a right to reimburse everything. Fees also, additional fees also if anything is incurred. Clear? Okay. If the company fails to register within 30 days, charge holder may apply to ROC for registration. ROC shall give notice to company, and if no objection is received within 14 days, it may allow such registration. Meaning what? Now imagine Kingfisher case only. ICICI Bank is coming and creating. ROC will check with the Kingfisher. Hey, he is telling that he is creating a charge. Is it true? Check and let me know once. If at all Kingfisher does not reply within 14 days, it is considered as deemed approval. Okay. Next one, sir. Company to report satisfaction. Section 82. What is satisfaction, sir? Simple. Whenever the amount is repaid, people, that also needs to be informed to ROC. You will inform it with inform. In which form you will intimate? CHG4. The company has to intimate the ROC in CHG4. ROC will reply to you in form CHG5. Satisfaction of charge. Report on satisfaction of charge. Memorandum of satisfaction of charge. Agreed? Yes, sir. Now people in this case, technically how will it happen? Now it will be ulta. What is that, sir? The company shall give intimation to ROC within 30 days. Yes, sir. Sir, what if within 30 days I did not intimate ROC that I have repaid the loan? I did not do it. Then same thing, people, within 300 days you can pay some additional fees and you can repay the loan and you can intimate the ROC. Sir, even within 300 days also I did not intimate ROC. Now what will happen, sir? The last section, people, section 87 will come into picture. According to section 87, people, rectification by central government in ROC. There you will again go and cry and you will say, sir, please show your feet. So remember, for creating a charge, there is no this unlimited period and all. But for satisfaction of charge, even after 300 days, central government can give you an approval. Clear? So technically for satisfaction, 30 plus 300 plus condonation of delay with central government, this is section 87. When else you will go to 87? Whenever whatever the details you have filed in the charge documents, if there is a mistake, if there is a omission, you have not disclosed something properly, you can go to ROC, again you can rectify those mistakes. That happens again in section 87. That's why you call it as condonation of delay. Rectification by central government in register of charges. An application can be made to central government in case of omission in giving intimation to ROC with regards to payment or satisfaction, or omission or misstatement in particulars filed with ROC. You can go to central government in these two cases. When you, which one? This one you have made the payment, you have not intimated. Here, whatever the details you have filed with ROC, there are mistakes in that, like the name, interest rate, date of repayment, particulars. You have not properly given. You can correct it. Sir, how now you are? How will we go and touch the feet, sir? Touching the feet? See, like this. CHG 8. 9 yaad guru. 100 times 9 is debenture. Okay, clear. Yes, if central government is satisfied that it was not intentional, it may direct extension of time if filing was not made within 300 days from satisfaction. This is not covered under registration. See, correct? Registration today is maximum 120 days. 60 plus 60 only. Additional add velarama. Here you have beyond 300 provided it is proven properly. direct for rectification of any particulars in filing previously recorded with ROC. Clear? Yes, sir. Okay, sir. And in satisfaction, sir, obviously, when company says that I've repaid the loan, just like when Kingfisher filed, when ICICI filed, they checked with Kingfisher. Hey, ICICI is telling that he has taken he has given a loan to you and you have created a charge. Is it true? He checked, no, 14 days. Now it will become ulta. When Kingfisher is coming and telling I have repaid the loan, ROC will check with ICICI. He is telling that he has repaid the loan. Is it true? You have 14 days. If you don't reply, deemed approval. Clear? Pakkana? 100%. Now tell me all the forms, sir. CHG1 creation of charge or modification of charge. CHG9 in the case of debentures. CHG2 is certificate of registration of charge. CHG3 is modification of charge given by ROC. CHG4 satisfaction of charge filed by the company to ROC. CHG5 ROC reply, memorandum of satisfaction. CHG6 now whenever imagine Kingfisher has taken loan from ICICI Bank, you did not repay the loan, ICICI Bank immediately appoint a manager and he will say go and take the custody of the UBCT. I need to intimate it to ROC within 30 days by filing a form called CHG6, appointment of receiver. Even when you appoint, you will intimate. Even when his appointment will come to an end also, you will intimate within 30 days. CHG6, all these details you will maintain in the form CHG7, that is called register of charge, maintained by the company permanently throughout the life of the company. You will maintain. Instrument creating the charge, meaning loan agreement, will be maintained for a period of 8 years from the date of satisfaction. Something understood? Meaning loan was taken in the year 2024. It was repaid in the year 2030. That loan agreement is there, no? You need to maintain it for 8 years from the date of repayment, 2030. What about CHG7? Throughout the life of the company, you need to maintain it. Sir, one person purchased one document, one property from the company, but the company never disclosed that they have taken this charge and all. They never disclosed. So a person is coming and filing a case in the court. Will his appeal stand? He can go and argue on that point? No. Because remember, whenever a charge is created, there is one more register that will be maintained by ROC, which is open for public domain. In the class, if you remember, we had seen Kingfisher charges created. That is only called as doctrine of constructive notice. Clear? If it is there in the public domain, it is considered as deemed approval. You have known it, you have seen it, deemed notice. Understood? 100%? Pakkana? Yes. And remember people, whenever any banking company, if they take any loan from RBI, you guys would have studied about repo rate, reverse repo rate and all. If a banking company takes any loan from RBI, obviously loan is created, no? You need not have to create any charge. They are exempted. Clear up? Yes, sir. Only RBI part. Clear all of you? See once if we have covered everything. If there is anything which you want me to cover, we'll again cover. Huh? We have covered everything, huh? Sure? Pakka? No, we covered everything. Anything else we need to cover? Da? See from the book. Da? I believe I have covered every point. We didn't see all the forms. Now only I said, no, da. I didn't cover everything. CHG7, sorry, CHG8 people is condonation of delay. You go and touch the central government, no, section 87. Basically, where you repaid the loan, satisfaction was not intimated within 300 days. You went and touched the loan, no, I draw feet also, no, CHG8. Okay. Sorry, monitoring. Okay. Done, nada? Everything is covered in charge. 100%. Modification also I told you. There is one place where you guys may get confused. I don't know. I've covered only. Wherein they say if there is any document which is purchased, which is subjected to charge. And one more thing, people. Registrar has a power. If registrar only gets to know through any information or it's on his own that the loan is repaid, without even intimation, registrar can take his register and he can write it as the charge is satisfied, and he will issue a notice to both the parties accordingly. That is one point that will also be there. Agreed? Huh? Okay, let us quickly see it of floating charge. Duty to register, section 77 we saw. 77 not to apply to certain charges, shall not be made to certain charges which are prescribed on the resolution RBI, correct? Huh? Consequence of non-registration, we saw no. Void against liquidator and all, we saw that. Application for registration of charge by charge holder, if he fails, he will come. Section 78. Acquisition of property subject to charge and modification of charge. What is this? If any person purchases, Infosys purchases a property which is subjected to charge from Kingfisher, UBCT. Infosys has to intimate to ROC in CHG1 that there is a modification in charge. Section 79. Read it. Acquisition by a company of any property that is already subjected to charge. Infosys is buying a property from Kingfisher. Kingfisher has taken a loan on UBCT. I am buying that only. Now parties will change. That's the reason you are intimating ROC. Or in the case of modification, what you will do? You need to intimate ROC. Modification examples are the deemed notice. Date of notice of charge, section 80, nothing but constructive notice. Company to report satisfaction, we saw the table, 30, 300, if not 87. Hey, am I telling something, what is happening? I am telling something, 30, 300 and all, you are thinking ML. Hey, 90 ML. Cough syrup. Hey, okay, power of registrar to make entries of satisfaction and release in absence of intimation from company. That is what I just told you. If you guys didn't intimate, I only got to know on my inspection or someone intimated. I can mark it as released. I can intimate to both the parties. Intimation of appointment of receiver, correct? Within 30 days. Appointment also, seizing also. CHG 6. Punishment for contravention. You want no? Out of syllabus only, sir. So all the forms we had seen in the last, correct? Yes, for people watching online, you guys can take picture of it. Okay, of this we complete your chat chapter. You want break? Go for a break and come. Ritha. Technically, how many? 1 second. Yes, people. So let's start with, we are done with chapter 6. We are going to start with chapter 7. Online, audible, I hope you are clear. Okay, so the question I asked is any questions in the previous topics? No questions, previous chapters, you guys went home and revised? You guys did? No, sir. What we did in the class only is revision, no, sir. Why should we go home and again revise? What's the use? Okay, correct, makes sense. You have to save time. Re-revision. Yes, sir. Okay. So, let us start with chapter 7. Chapter 7, people talks about management and administration. So, in management and administration, the first topic, everything starts with section 88. Section 88 talks about what, people? Register of members. So, first of all, should every company maintain register of members or is there any exception? Like private companies, OPC, small companies, is there any exception? Yes, sir. Who should maintain? Any exception is there? Or every company has to maintain? Every company, huh? Yes, sir. Huh?
Every company.
Every company, huh? Starting question, bouncer. Huh? Okay, so sir, all the companies has to maintain register of members. So register of members, sir, members yesterday only we saw members, both the shareholders will be called as members only. When I say both the shareholders, who and all is included? Equity as well as preference. What is the register of members format? MGT 1. Preference shareholders, what is the format? MGT 1 only, not MGT 2. Not MGT 2. Okay, what is the format of debenture holders? MGT 2. How long will you maintain the register of members for? Permanently. How long will you maintain the register of debenture holders or any other security holders?
Date of
8 years from the date of redemption. Okay. So, sir, registers people, the first thing, register of members, equity as well as preference. How do I maintain it, sir? Format is form MGT1. Few people will be asking me whether should we write it. If you write it, you will definitely have that extra weightage in your exam. Next one, sir, register of debenture holders will be maintained in the form MGT2. Other security holders will be maintained in the form MGT2. Now, whenever I am talking about these registers and all, registers will generally be open for inspection. Technically, what and all the details that will be mentioned in the register of members, the person's name, nationality, the date of becoming a member, number of securities held by the person, date of cessation, if at all he has left. If at all a body corporate is a member, then you will also maintain SIN and details like that. However, when we are doing inspection, we will see that. So MGT1 will be maintained permanently, and debenture holders, that is any other security holders, will be maintaining for 8 years from the date of redemption. Now that's the reason if you see other security holders and register of deposits, technically both are maintained for a period of 8 years only. So register of deposits, even when you say register of deposits, more or less the format will be similar to other security holders only. Yes, sir, that you will be maintaining for a period of 8 years from the date of last entry made. Correct? Okay. Sir, place. Where is the register of members kept, people? Register of members will be maintained at the registered office of the company. But sir, no sir, I want to keep it somewhere else, sir. I want the fancy thing, sir. You can keep it somewhere else, people, provided there are two things you need to remember. What is that? First one, if you can pass a special resolution, you can keep anywhere, but within the same city, within the same town, or within the same village. No sir, हमको हमारा city नहीं चाहिए. Go and keep wherever you want in India. India na sir, yes, provided at least 1/10, where more than 1/10 of the people reside. In that place, you guys can go and maintain your members. Correct? There's a complete provision. Okay. Next one, index. What do you mean by index, sir? Nothing but your serial number, the first page, opening page. In which page, whose details are there? Which shareholders' details are there? Now, should every company maintain register of index? If at all the number of members are less than 50, then not required. What about 50?
Required.
Exact 50.
Required.
Remember, this is where your exam question will come. Less than 50 not required. 50 members, so index will be required. Foreign register, people. What do you mean by foreign register? First the question will come like this only. Should every company maintaining a foreign register? Is it mandatory on the company? No. Is it mandatory? Optional on the part of the company. Second one, what is the format of the foreign register? Similar to whatever is the principal register. If you are maintaining MGT1, it will be MGT1. Other security holders, MGT2. Okay, whenever I open a foreign register, immediately I need to intimate to ROC in form MGT3. Within how many days will you intimate? Adu gottilla. Within
3 days.
7 days, 15 days, 30 days.
30 days.
Within 30 days. Register of members, how many days will you make the entry in the register of members? Imagine I become a shareholder. Within how many days will I make an entry in the register of members? You need to maintain it in the period of register of members is 7 days. Whenever you want to make an entry in the register of members, you make an entry within 7 days. Sir, can I close the foreign register whenever I want? Can I close it off? You can discontinue the foreign registers whenever you want. There is no timelines for the foreign register. Just that you need to transfer all the entries to the principal registers before closing it. There's a complete provision with regards to foreign register. Remember, agreed? Yes, sir. Transmitted within 15 days of the change. Intimate ROC within 30 days. Opening and discontinuing is allowed. That is what is the maximum questions they can ask you with regards to foreign register. Yes, sir. Next one, sir. Closure of registers, sir. Section 91. Section 91 talks about closure of registers. Why will a company even close the registers? The reason of closure is whenever they want to declare dividends, bonus. So to know the entitlement, they will close the registers. Whenever the registers are closed, you need to intimate the shareholders because Generally, the shareholders will come to the company to inspect the registers. You need to intimate them, it is closed now, please don't come. How will I intimate, sir? You need to intimate by giving at least 7 days notice. If you are a listed company or in the process of listing, you need to give it in a newspaper. If at all you are a private company, you can give a personal email. That is absolutely fine. Understood? 100%. Sir, what is the maximum time I can close my registers? The maximum time you can close is, people, 45 days in the year, 30 days at once. Aggregate is 45 days. At any given point of time at once, you cannot close it for more than 30 days. That is what with regards to your register of members and closure of registers. Okay. So reason no maximum period of notice of closure. Okay. 91, 94 we will do of. Okay. What is 94?
Places of register. Place.
Inspection now. Now, sir, declaration 89 will do, 90 will do. We'll first finish off the register related and then we'll again come. Okay. Sir, place of keeping and inspection of registers and returns, sir. Section 94 talks about the registers and returns, which we saw this, which we already seen also, where you need to keep it. You generally need to keep it in the registered office only. You can keep it provided more than 10% reside, wherever they reside. The registers, indices and returns shall be open for inspection. Correct? Anyone can come and inspect. That's the reason you saw section 91 also. Who and all can come and inspect? Member, debenture holder, other security holder or beneficiary holder. Now these people can come and check anytime during the business hours without paying any fees. But if at all you are any other person, then you need to pay a fees not exceeding rupees 50 to come and inspect the books. The time period for inspection shall not be less than 2 hours in every working day. Agreed? Sir, whenever I come, can I take a copy? Can I take an extract? You can make a note of it. Any such member, debenture holder, other security holder, beneficiary holder or any other person, technically everyone mentioned above, they can take extract from register. They can copy, absolutely fine, without paying any fees. But if at all you need a copy of it, the company will charge some money for you. How much? Not exceeding rupees 10 per page. Clear? Default, I am not getting into it. This is an amendment. What is it, sir? Sir, section 94 talks about inspection also, where people are coming and checking the documents. Sir, in the register of members, there is my personal details and all mentioned. What if Siddhartha will come and take some girl's name and start messaging her? So people, because of that, they stopped giving certain information to members. Correct? Sir, what is that, sir? This is an amendment, people. Certain details will not be available for the people coming and checking while inspecting. What are the details, sir? First one, address will not be disclosed. Second one, email IDs will not be disclosed. Third one, any other unique identification numbers. Imagine I take Aadhars, I take any other number, that will not be allowed. Imagine if you are a foreign citizen, I might take any number according to your country, that will not be disclosed. Fourth one, PAN numbers will not be disclosed. These will be confidential. Is it clear, all of you? Okay, done. Period of retention. Okay. Period of preservation, sir. We saw custody. No, custody will be in the custody of company secretary. Period of 8 years. No. Okay, done. Okay. Registers to be evidence. Section 95. People will be asking me, sir, what is section 93? 93 is not there. 93 is removed. Sir, the registers, their indices, copies of annual returns maintained under section 88 and 94 shall be prima facie evidence of any matter directed or authorized to be inserted. What do you mean by that, sir? At any given point of time, if anyone wants to know who is the owner, open the register of member, whosoever name is there, he is the owner. Who says? It says prima facie evidence. What do you mean by prima facie? I have told you in the class. Primarily, on the face of it, that's the evidence. But remember, that's not the final evidence. The second evidence is called as conclusive evidence. Prima facie means whatever is written on the first page, that's all. I will not dig deeper. But if I dig deeper, if I get to know something else, that will be called as conclusive evidence. Clear? Yes, sir. So on the face of it, whosoever name is written, he is the owner. He will get the dividend, he will get the rights, he will get the bonus. Clear? Done. Okay. Then we'll do up section 89. In 89 there is an amendment. I believe there will be a question also there. Okay, section 89, sir. What is section 89, sir? Declaration in respect of beneficial interest in shares, section 89. What is beneficial interest, sir? Simple. Let us imagine, Benami transaction. I am the actual shareholder, but I don't invest in my name. I give money to my driver. My driver will go and invest in the company. So section 89 was targeting those people. Now I should also go and disclose. Even my driver should also go and disclose to the company that my driver will disclose, you guys have registered the shares in my name, but the benefits it will not come to me, it will go to my owner. I will disclose that you guys have registered my driver as your owner, the benefits will come to me. Both of us have to disclose. And what will the company do? Company will take this information, company will put it in one envelope, they will give it to ROC. It is the responsibility of the company to make sure it is communicated to ROC. It's clear? Yes, sir. So what are the forms now? We'll see. Okay, declaration to be filed by registered holder, driver of shares and not a beneficial owner. So he is a registered owner, but he does not get any benefits. He will disclose in form MGT4 within 30 days of entering his name. He needs to tell that I am not the owner, he is the actual owner. Sir, next one, sir. Person holding beneficial interest, that is the owner, me. I will tell that I am the person who gets the benefits, but you have registered in his name. I will disclose his details and my details. Again, within 30 days in form MGT 5. So MGT 4, who will disclose? Driver will disclose. MGT 5, owner will disclose. So 30 days. Even if there is a change also, you need to disclose within 30 days. Meaning, I was the owner, I gave it to you now. Now you will become a beneficial owner. Possible, na? Yes, sir. Now all this information will be taken by the company. MGT 4, MGT 5. Company will collate it and company will send it in MGT 6 within 30 days of receiving the declaration to ROC. Now the question was, you are telling company after making a note of such declaration, you need to give it to ROC. My question is, who is responsible to give this information to ROC? Someone has to be responsible, no? When I say company means who? That's what is the amendment. There is an amendment in this particular provision. Now what is the amendment, sir? See here. They have added something here. Section 89. Okay. Now in your books, there will be something till 8 only. Agreed? Page number. 1 second. They online able to see here. 7.7. You will have only till 8th number. Correct? From 9th is an amendment. Yes, sir. So, if you guys want, you'll take a picture once. Online. Online. Audible ada? Online. Okay. Then so now what is the amendment, people? See here. Every company shall designate a person who shall be responsible for furnishing and extending cooperation for providing information to the registrar. You nominate one person who is extending the cooperation to ROC, who is giving all these details. A company should nominate itself. Okay, who will that be, sir? See here. With respect to the beneficial interest in shares of the company, for the purpose of sub rule 4, the company may designate. Whom will the company will designate? Company will designate CS wherever a CS is appointed. Sir, what if a CS is appointed only on the, now imagine, if a company has a paid up share capital of more than 10 crores, appointment of CS is mandatory. That's what the law says. The paid up share capital has to be more than 10 crore. What if the capital is less than 10 crore? The company will have CS. The answer is no. Then in such case, who will be doing it? They're telling if CS is not there, then any KMP. Who is the KMP? CEO, whole-time director, managing director, manager, CEO, CFO, CS. All these people will come. Of course, one level below the board also. Yes, sir. Now, any of these people can be appointed as a person for cooperating with the ROC. Understood? Sir, what if KMP is also not nominated? In such case, people, you people, you are neglecting my order. Every director will be liable under this particular section or responsible under this particular section when there is no CS or KMP. Understood? KMP also same people. Companies having more than 10 crore paid up capital, you need to appoint a full-time KMP. That's the complete provision. That is not there in our syllabus. So even less than 10 crore, KMP appointment is not mandatory. Understood? So they will not have. In such case, what will happen? They are telling every director. Got this scenario? Yes, sir. Sir, now we have a doubt. What? You introduced the amendment today. We have not yet appointed. Now what to do? Until a person is designated, the following person will be deemed to be a designated person. So this is an amendment. No. Until you appoint, who will be this particular person? They are telling you until you appoint. Same thing from upper take bound. I mean, same thing will repeat. What is that? If a company has CSR, then CSR. Sir, what if a company does not have CSR? Then managing director or manager, not KMP. Managing director or manager. Sir, what if, sir, they are not there, sir? Then every director. So if I take above says CSO, KMP, every director. Below it says CSO, managing director or manager or every director. The first one says you may nominate these people. Second one says until someone is nominated, this will be the order. Now you guys can have a doubt. Everyone, sir, Allah, every condition is or. It will be CS or. And remember, if a company has CS, that is the first priority. CS, if there is a requirement of appointment. If CS is there, you cannot appoint a managing director. So be prepared for such question. Got this? Okay. Next one. Every company, now how will we know that who is this person nominated? Every company shall disclose this person's details in annual return. Sir, what if I have nominated a CS today? Can I change this person? I have nominated a MD today. He resigned. Can I change this person? Possible, people. How? You need to intimate ROC in the form GNL2. That's the complete provision. Any doubts, sir? Correct. Any doubts here? No? Pakka? Sure? Simple? Okay, done. So, sir, MGT 6, consequence of non-filing, the right with respect to such share shall not be enforceable, penalty. Minimum 50, no. I'm not getting into penalties. Okay. Next one, sir, SBO. SBO provision, when will SBO provision come into picture, people? What do you mean by SBO? SBO means significant beneficial owner. First of all, when will you see this, people? Two main conditions are to be satisfied. What is that? First one. What is SPO? Let us imagine there is a company called as company in our class. What would you have seen? Kingfisher, Okay, Kingfisher company. Imagine there is a company called as Kingfisher. Now Kingfisher has an obligation to report everything to ROC. Now for us, we will call Kingfisher as a reporting company. Agreed? This is called as reporting company. Now what should Kingfisher report? Kingfisher has to report in my company who and all are the shareholders. Sir, everyone's details have to report. Not everyone details. I'm concerned about if there is a directly individual who is investing, then we don't have a problem because in his name he is investing. We don't have a problem. We have a problem when in Kingfisher, Queenfisher has invested. Sir, why, sir? Why do you have a problem? Because, people, this can be a case of money laundering also. Someone is hiding behind the company. Agreed? So, sir, now what should Kingfisher do? Kingfisher should ask the Queenfisher, hey, in my company you have invested. In your company, who has invested? Queenfisher will say, Sunfisher. Dave, how long it is going to? It can go up to any level until you find the ultimate individual who is hiding behind the companies. Understood? SBO will come into this picture. So remember, if at all directly a person is investing more than 10%, SBO is not applicable at all. Our concern will be only when the person is investing indirectly. Also, directly plus indirectly also you need to take it into consideration. What do you mean by that, sir? Let us imagine this person has invested 5%. Sir, and Queenfisher company has invested 6%. Sir, in Queenfisher, Sunfisher, who is a shareholder? Same person is a shareholder. Now this becomes direct plus indirect shareholding. You need to take it as 5 plus 6. It becomes 11%. That means it is a significant person. Agreed? Pakka na? So sir, let us look at that provision only once. What does it say? Every individual acting alone or together through one or more person it is. So everyone is included. HUF, trust, your partnership, LLP, company, however you are investing, I need to disclose everything. Okay. When will I have to disclose? Whenever. Who is a SBO according to our provision? In relation to a reporting company, meaning for Kingfisher, it means an individual referred above who possesses one or more of the following rights. So who will be called as a SBO? If at all a person holds, see here, indirectly is in Kingfisher, Queenfisher is holding 6%. In Queen is Sun, in Sun one individual. So that became indirectly 6%. Directly also I am holding 5%. More than, not less than 10% of the shares. So mine is becoming 11% here. So I will be called as significant beneficial owner. Understood? Akana? Okay. Next one, sir. One is holding the shares. Second one, people indirectly or directly holding not less than 10% of voting rights. Sir, what is the difference? Here they are telling you 10% of the shares, preference or equity, everything is considered here. Here they are talking about voting rights, 10%. The main concern here is if at all you are holding DVRs, you might hold less number of shares. You might hold more number of shares. Your voting will be lesser. So that's the difference. Got it? Next one, sir. Has right to receive not less than 10% of the total distributable dividend. Now DVR will come into picture. Comparatively, you get more dividend, no? Yes, sir. So, out of the total 100 rupees declared by the company, this person only is getting 10 rupees. You will be called as a SBO. The next one, a person who has a significant influence on the company, meaning a person who can take policy decisions. He is called as a significant influencer. Now, all these four people or anyone also is called as what people? Significant beneficial owner. Yes, sir. Pakkana. 100%. Sir. There is Kingfisher. In Kingfisher, Queenfisher. In Queenfisher, individual holds 20% of the shares. Queenfisher in Kingfisher holds 6%. Directly also he holds 5%. Is SBO provision applicable? No, 6 plus 5.
25%. It should be 25%.
Queenfisher holds only 6%. Okay. Now directly is holding 5%.
That individual should hold 25%. The individual doesn't have significant influence over.
That's the main word, sir. I need to check the second condition here, people. This person should have a significant influence over this company. Now, what do you mean by significant influence? 50% should be held. Technically, more than 50%. If it's a body corporate, then I'll call this company. Now imagine it's a company. A shareholder should have at least 51% shareholding. Then it is in your control. Then this provision will apply. For 20% not apply. Next one, imagine this person, Queenfisher is not a company. Let us imagine Queenfisher is a HUF. Okay, who is this person? This person is a co-partner. Is this SBO provision applicable? Not applicable. HUF is not under the control of co-partners. It is under the control of Karta. That is when SBO provision will apply. That's how you need to see the entire provision. Dartha, understood? Okay, done now. Here, that was a complete thing which we saw in the class also. Okay, sir, now if I am a SBO, what should I do? If you are a SBO, you need to disclose your details in the form Ben 1. Correct? Yes, sir.
Registered on
You need to disclose. No. There is only one form here. I mean, Ben, there is. No, I will also not disclose, and he will also not disclose. Only one disclosure will come into. Correct. We'll see that. Ben 2 will come into picture when company files details. Okay, so people, this person will disclose everything. Who is disclosing? That individual is disclosing in Ben 1. The company will take the details, forward it to ROC in the form Ben 2. And simultaneously, they will maintain a record of this entire thing in the Ben 3. So now I have a problem. What? Sir, is this person one, what is that? Honest person, Buddha, will he give all the details? No, he will not give. Now what will happen, people? Kingfisher will start reverse hunting. You don't disclose, I will ask. If I ask people, you have to disclose. How will I ask people? I will ask by giving you a notice of disclosure. You will give a notice in the form Ben 4. Here, Ben 4. So Ben 4, you will give it to the person that can be SBO. Whoever you think is SBO, you will give it. You think whoever has a knowledge of SBO, you will give it. You think this person was a SPO in the last 3 years? You can give them also. Asking for the disclosure. Sir, once they get the notice, these people have to reply within 30 days. In case if they do not reply people within 15 days, or if they reply but you are not satisfied, what will the company do? Company will appeal for tribunal. Sir, ye kaisa aadmi hai sir? You will go to the tribunal and you will say, sir, please take an action against this person, sir. Now what will a tribunal do? Tribunal will give you an opportunity of being heard. Within 60 days of application, after giving an opportunity of being heard, the tribunal shall pass an order accordingly. Now I can say within this many days you have to come and give me the further disclosure. You need to give a proof, everything. Now you have 1 year time. The individual have 1 year time. In 1 year, if you go and prove that yes, everything is fair, tribunal will take back the order. If within 1 year, if you do not prove anything, people, then the last ultimate thing is all the shares, whatever is freezed, will be transferred to IEPF account. Agreed? Yes, sir. Pakana. Done. Penalty? You want? No, sir. Humko nahi chahiye hai. It's clear, all of you? I believe from the exam point of view, important. Okay, done. Next one, sir. 94, 95. 96, okay, we'll talk 96. What is 96, people? 96 is the annual general meeting. Yes, people, tell me, how many meetings? Technically, there are 2 types of meeting. One is called as AGM, one is called as EGM. AGM, people, first of all, every company, mandatorily, once in a year, every company it is, they have to conduct AGM. One company need not conduct exams. OPC. A company which has to conduct AGM. First AGM of a company will be conducted within 9 months from the closure of financial year. I have discussed in the class how do you consider closure of financial year. If at all your company is registered on or before 31st December any year, then your financial year will end in the next year only. If your company is registered anytime on or after 1st January that year, then your financial year will end the next year, not immediately. Giving you an example, if my company was registered on 31st December 2023, my company's financial year will end on 31st March 2024. If at all my company was registered on 1st January 2024, my financial year will end on 31st March 2025. So, if at all it is the first year of my company, the first AGM will be held on within 9 months from the closure of financial year. That is, you can hold it any time within 9 months. That is 31st December is what is 9 months. You can hold it any time before that. That is only first AGM. Sir, second or subsequent AGM, you can hold it within 6 months of closure of financial year. Because of any reason, if you are not able to hold, you can ask for one-time extension of 3 months from ROC. It will be only applicable once. Yes, sir. Next one. You need to keep one thing in mind. At any given point of time, the gap between 2 AGMs should not exceed 15 months. You need to keep every provision in mind. Is this clear? Okay. Sir, AGM can be called anytime during the business hours. That is nothing but 9 to 6. AGM section is 96. Agreed? We had seen every provision regarding that also. The first AGM is within 9 months. The second subsequent is 96 again. 6 months. Gap between 2 meetings. 9 plus 6 again 15 months. 9 to 6 is the AGM timings. So try to remember this. You will remember everything. And one time extension of 3 months. Agreed? Yes, sir. Okay. And not only that, people, if your top 100 listed companies, your AGM has to be conducted within 5 months from the closure of financial year. And this listed companies, people, they need to intimate ROC that they conducted AGM on time. That is only called as report on AGM. That section is called report on AGM. What is report on AGM? 121. What is report on AGM? Report on AGM is nothing but some listed companies will tell to ROC, you told us to conduct AGM. We conducted AGM. What time you conducted, how many people attended, what and all were passed. You will give a clear notice to the ROC. That is only called as report on AGM. Okay. Where can I conduct the AGM? The registered office of the company. Can I conduct it in any other place?
If you are a foreign company, foreign.
No, AGM, can I conduct it in any other place? You first thing, people, you have to conduct it within the same registered office. The next condition is, people, you can conduct it in the same city or town or village. The third thing is, people, if at all you are an unlisted company, you can conduct it anywhere in India. Correct? This is what you had seen. This is a complete provision. Yes, place, registered office, city, town, village, unlisted company can do anywhere in the India, provided all the members agree to it. Date, you can conduct it any day other than national holiday. What are the national holidays? 3 days. Republic Day, 15th August, Gandhi Jayanti. September ಏನೋ ಅಂದೆ, ಟೀಚರ್ಸ್ ಡೇ ಅಂತ ತಾನೇ ನೀನು. Okay. Next one, we will report of AGM, section 121, to be listed, to be filed by listed company with ROC within 30 days of conclusion of AGM. You will give a disclosure on whether you have conducted the AGM or not. Clear? Okay, the next type of meeting is called as, people, EGM. EGM, people, section 100. When and all you will conduct a EGM, first one, whenever the board wants to do it, they will conduct a EGM. Whenever they want, they can call. EGM can be conducted in any place in India. If it is a wholly owned subsidiary of a foreign company, EGM can be even conducted outside India. Remember, AGM can never be conducted outside India. It has to be in India. Is clear? Pakana? Okay. Next one. By board on requisition by members. What is this? The second condition is where the company is conducting the EGM. When will they conduct? If at all the shareholders have made a request, they have asked the company to conduct a EGM, they can conduct a EGM. Provided certain people have to make a request. How many people? It depends upon the company has share capital or it does not have share capital. If a company has share capital, minimum members holding not less than 1/10 of the total paid up share capital. On the other hand, 1/10 of the total voting power. If they give a notice, people, then within 21 days, you need to take steps to conduct a meeting. You have to conduct the meeting within 45 days. Here you need to take steps, so here you need to conduct the meeting. Taking steps is like at least giving a notice of a meeting. Okay, sir. Sir, within 45 days also, if they don't conduct, whoever made a request, they can only conduct a meeting within 3 months. Provided you need to remember certain things there. What is that? Whenever
Company should hand over all the details.
company should hand over all the details, the expenses has to be reimbursed, and that money will be collected or deducted from directors' remuneration. Sir, and remember one thing, sir, in the EGM conducted by the requisitionist, if at all there is no quorum present, the meeting will stand cancelled. Correct? Yes, sir. Okay. There can be a question here. What if there is an accidental omission of giving a notice to any of the shareholder? What will happen to the validity of the meeting? Is the meeting valid or invalid? Valid, sir. Accidental omission does not invalidate the proceedings of the meeting. Remember, you can expect a question there. That is your 96 and 100. What is 97 and 98? 97 talks about
AGM by tribunal, 98 EGM by tribunal.
Correct, top 100. 97 talks about what, people? 97 talks about AGM, which is which is ordered by tribunal. 98 talks about any meeting, class meeting, EGMs ordered by the tribunal. So remember, tribunal can pass an order. Tribunal can tell you to conduct a AGM or EGM as the case may be. If at all, people, AGM, if at all tribunal wants, tribunal can add one order also in that particular thing. What is that? It can say even proxy can also be counted as quorum, or
Proxy cannot be counted.
proxy can, I can even reduce the quorum requirement also. Even one person personally present can also be made as a quorum. Correct? Yes, sir.
With whom will they talk?
Huh?
With whom will they talk?
No, when you're going to AGM, when you're going to the tribunal asking for the AGM, that means the matter is to be passed immediately. So we don't have time for discussion. It is about the decision. Generally, when will we go? Imagine the company does not have any of the directors. You need to appoint the directors. So in such cases, you can go. Okay, power of tribunal to call AGM, power of tribunal to call EGM. If at all, sir, anything above is not properly done, sir, section 99 will be the penalty. What is section 99? If there is a default in 96 to 98, AGM, tribunal's order to conduct AGM or tribunal's order to conduct EGM, if it is not followed, people, in such case, 1 lakh rupees in the case of continuing default with a further fine which may extend to 5,000 rupees for every day if you fail to conduct the AGM or EGM, as the case may be. Clear? Done. There is one section we have missed, that is section 92, annual return. What is annual return, people? What is the form you will file the annual return in?
MGT 7, MGT 7.
First of all, what is annual return, people? Annual return is a non-financial disclosure filed by every company with the ROC. Every company, sir, yes, sir. What is the format you will file? Depends upon what type of company you are. If you are a small company or a OPC, you will file all the disclosures in MGT 7A. If at all you are any other type of company, you will file it in form MGT 7. And when will you file this details, sir? You will file it within 60 days of closure of or completion of your AGM or the due date of the AGM, as the case may be. Correct? If you are a foreign company, the same details you will file it in the form FC4. Yes, and annual return, people, has to be certified by who? A company secretary. And if in the case of CS, if a company does not have a CS, you need to get it certified by PCS. In the case of OPC, a director alone can sign the document. CS signature is not mandatory. It's clear? Yes, sir. That's all.
Annual return of company having paid up share capital of 10 crore.
10 crore, you need to get MGT 8. So certification. Okay. Additional compliance, sir. A listed company or company having paid up share capital of 10 crore or more, or a company having turnover of 50 crore or more, in addition to just a signature, you need to get one certificate also that they have prepared the annual return according to the law. And that certificate given by the practicing company secretary will be in the format MGT 8. Sir, annual return will also be maintained for a period of 8 years only. Remember that. Here, yes, sir. Okay, done. 9, done. Okay, Takaragattal of 101, window of notice. Okay, notice of a general meeting, people. Notice of a general meeting. You have to give a notice of general meeting, people, within 20 prior 21 clear days, sir. What do you mean by 21 clear days? The clear stands here, people. You need to give it. Exclude the day of giving the notice and day of the meeting. Excluding that, you need to give 21 days notice. If at all you are giving it by post, you need to add another 48 hours. That is nothing but technically you need to add another 2 days. So you can expect a question on this topic also. Correct? Yes, sir. Okay. And notice of a meeting will be given to whom and all? Whom and all will you give it a notice of the meeting?
Legal representative.
You will give it to every member, legal representative. Legal representative comes in the case of a person passed away, deceased person. The assignee of an insolvent member appointed by the court. Basically, you can imagine like a liquidator. The next one, the auditor or the auditors of the company. Auditors also you need to give a notice of general meeting. Yes, sir. Sir, what if I am busy? I am not able to attend. I am the auditor of the company. I am busy. I am not able to attend. What to do? You can send a representative. Can I send my intern? He has knowledge. You don't have knowledge. Perfect, you have. You can go. You know, no, people, there will be CA dropouts, but they will be called as tax consultants. They have equal knowledge because of work experience. Now I am 35-year-old. Imagine there is a person, 35-year-old tax practitioner. Can I send him on my behalf? Remember, even the person whom you are sending also should be a chartered accountant. Even that person should also be auditor. Important, you can expect a question there. MCQ. Here, yes, okay. Every auditor, every director of the company, accidental omission, same thing, will not invalidate the meeting. You will be giving it to every member. Member includes equity as well as preference. You will give it. They will attend, but they will not have a right to vote in the meeting. Okay. Next one, people. Can a meeting be held at a shorter notice? Important from exam point of view. Can you hold a meeting in a shorter notice? Possible? Yes. Depend upon what type of meeting you are conducting. If at all you are conducting a AGM, then people, you need to take a prior consent from the members that you are okay with not giving 21 days clear notice. They will give it less than that. You should be okay with it. You take a prior consent and give a lesser days also, it is allowed. So lesser means how much? You can give even 1 day also. You can give even 2 days also. Absolutely fine. Provided, how many of them have to agree? 95% of the members entitled to vote. So who are entitled to vote? Equity. But it may so happen at times preference may also have a right to vote. Agreed? Yes, sir. There at. Second one, sir. In case it is any other general meeting, imagine if it's a EGM. You want to call it on a shorter notice. Then people, by members of the company, if it is company having share capital, then it is very important provision here. MCQ can expect here. Majority in number of members entitled to vote and who represent not less than 95% of the paid up share capital. What do you mean by this, sir? Imagine if you take example of Adani. Gautam Adani holds 63% of its share of his company. 63% he only holds. So, some 2-3 people, if they give a consent, they can hold off a shorter notice. They said not possible. You need a majority in number of members also. Number of people. Now imagine my company, there are 10. 6 people also have to agree and 95% in value also you need to agree. That's the reason it is and. In AGM, it is only 95% of the members entitled to vote it is. Here it is majority number as well as value. That's the difference. Here, okay, sir. If the company has no share capital, 95% of the total voting power. Done. Authority to call a meeting, it is generally all the board of directors. Contents of the notice, I can generally give what is the number of the meeting, date of the meeting, etc. Section 101. Next one, section 102. What is 102? Explanatory statement. What is explanatory statement, sir? Explanatory statement is basically nothing but in a company there are 2 types of business. One is called as ordinary business. Next one is called as special business. Ordinary business means anything which happens routinely in a company, and that is what we call it as adda. What is adda, sir? Approval of accounts, declaration of dividend, appointment of director, appointment of auditor will be considered as adda. These are called as ordinary business. Explanatory statement is not required for adda. Anything other than adda, you need, it is called as special business. You need to give an explanatory statement. In exam, they may ask you to give certain examples of special business also. You write down from first chapter to this chapter, everything is valid. Meaning, charges, deposits, shifting of registered officer, object clause, name clause, everything will come here. Agreed? Yes, sir. Special business requires explanatory statement. Explanatory statement is what, sir? Technically, you are informing the shareholders why you are calling them for a meeting, what is going to be discussed. All the details about the resolution will be disclosed here. Agreed? Yes, sir. Okay, sir. In that specifically, contents, sir. What will you disclose? The nature of concern or interest. Basically, if at all your directors or your KMP, if at all they are getting benefited from any transaction, any meeting, resolution, you need to disclose what is the benefit they are deriving. That is what they are telling you. Every director and the manager, every other KMP and relatives of them, if they are getting any benefit, whether financial or any other benefit, you need to disclose. If you pass this resolution to shareholders, these people will get benefited. You need to be aware of. Next one, sir. Whatever is the resolution we are passing, this does not directly benefit us, but it will benefit some other company. And in that company, if my people are holding shares, how much? 2%. If they are holding minimum 2%, you need to give a disclosure about that also. What do you mean by that, sir? Other information and facts. Okay. If special business to be transacted at a meeting of the company relates to any other company in which the extent of shareholding of every promoter, director, manager, KMP shall be disclosed if shareholding is 2% or more of that other company. Meaning what? Imagine my promoter has 3% of shares in other company. We are entering into a contract with them. Here he does not have any benefit, but that company's share price will go up. That company's dividends will go up. He will be benefited. I need to disclose it in my meetings. That is your explanatory statement. Done now? Sir, what if I fail to disclose people? Whatever is the benefit you made, that has to be compensated to the company. You need to hold it in trust. Basically, you need to keep it for yourself and you need to return it to the company. Any benefit made. Is this clear? Pakkana? Okay, done. Next one, sir. Quorum, sir. What is the quorum, people? Quorum depends upon what type of company you are, whether you are a public or a private. But first thing, always remember, Companies Act also says quorum, but you have a power to increase your quorum as well by giving it in your Articles of Association. So it is always Companies Act or Articles of Association, whichever is higher, that will prevail. So, sir, for a public company, depends upon how many members are there. If at all the number of members is not more than 1000, up to 1000, sir, number of members that has to be present for the quorum is 5. Remember, it is personally present. So, proxy is not counted in the quorum. Next one, sir, if my number of members are more than 1000, up to 5000 people, then the number of members personally to be present is 15. More than 5000, 30 members should be present. In the case of private company people, 2 members personally present only will be the quorum. If at all AOA prescribes more, you need to follow that. It's clear? Pakkana? Okay. Okay, body corporator, that we'll see. Okay, quorum we were doing the. We'll do of 112 and 113 now. Okay, what is the 112 people? Of course, there are a few people who are extremely busy, like a president of India and governor of a state. If they are shareholders, obviously they cannot come and attend the shareholders meetings. So what they will do on behalf of them, they will send someone else to attend the meeting. The people whom they are sending to attend, they will be called as what people? Authorized representatives. They will be counted for the purpose of quorum. They will not be treated as a proxy. The next person is, in the case of body corporates, imagine LLP has invested, company has invested, they cannot personally come. They will also send an authorized representative only. They are covered in section 113. So even they are also considered as authorized representative. Even they can also be present. He will be considered as personally present for the purpose of quorum. 112, 113. Clear? Yes, sir.
If the quorum is not present within half an hour, meetings will stand cancelled.
We'll go to that adjourned meeting. We'll do. Adjourned meeting is okay, yes, sir. Next one, sir. Quorum. Consequences of no quorum. We'll do adjournment also. Okay, consequences of no quorum, people, within half an hour, if at all the quorum is not present, then the meeting will stand automatically adjourned to the next week, same day, same time, same place, or as decided by the board. You need to make sure if you're adjourning the meeting, then you need to give another notice, not less than at least 3 days notice has to be given. If at all individually you think it is not possible, you can give it people by publishing it in the advertisement, as well as if you have a website, you can publish it on your website as well. It's clear? Pakkana? Sir, in the adjourned meeting also, if the quorum is not present?
Present members. Present.
Then whoever are the members present, they shall form the quorum. But I told you something more also here in the class. What was that? This is what the act says. But I told you, whenever you are conducting meetings, there are 2 standards that is applicable. One is called Secretarial Standards SS1, SS2. SS2 governs general meeting. According to Secretarial Standards, it says number of members in the adjourned meeting. Whoever is present, they only will be quorum, provided at least 2 people should be there. That is what is given in the standards. Clear? All of you? Okay, done. Representation is done now. Okay, 104. Chairman of the meeting. Chairman of the meeting is elected by the members present. Every meeting they will elect, or you just nominate one person as a chairman, he will be the chairman. Agreed? Next one, sir. The chairman will always have a note, it seems. What is that vote? The chairman will have one vote is called as casting vote, also called as second vote. Why is it called as casting vote or second vote? Technically, imagine chairman obviously will also be a shareholder. As a shareholder, I also have a right to vote. Now imagine if at all there is equality of votes, 50-50. Yes also 50, no also 50. the chairman will be given a second vote. That's the reason it is called as casting vote or a second vote. Clear? Done. Next one, sir. Okay, we'll see this point in poll when we're doing the poll part. Next one, sir, proxy. Okay, with regards to proxy, first thing, tell all the rules, sir. First of all, what are the things a proxy cannot do? A proxy cannot vote on show of hands. A proxy people cannot speak in the meeting. Next one, people, a proxy will not be counted for the purpose of quorum. Next one, what an all proxy can do? Proxy can demand for a poll. Proxy can vote on a poll. Next one. What is the maximum people a proxy can represent? The maximum people a proxy can represent is 50. Provided this is 15 number of members. He can represent 50 people at once. Or the total voting cannot be more than 10%. I mean, total share capital he represents, it will not be more than 10%. So, what if I want to represent someone who is holding more than 10%? Then, in such case, you can appoint only one proxy. That person cannot act proxy. That person cannot act as a proxy for any other person. Sir, next question. Should the proxy be a shareholder? The answer is no. But one company says, yes, my proxy has to be a shareholder. And that company is Section 8 company. Section 8 company proxy should also be a shareholder. Clear? Pakkana. So if a proxy form is to be valid, you need to deposit the proxy form at least 48 hours before the meeting. Remember, if at all I am giving two proxy forms, whichever form is given later will prevail. If at all the proxy form is not dated, not signed, not stamped, the proxy will be considered as invalid. Imagine if a proxy as well as a shareholder, both of them attend the meeting, proxy will automatically stand cancelled. The person's meeting or the person's voting will go forward. That will be considered as final. It's clear? Next one, sir. Can you inspect proxy forms? Inspection of proxy forms. Okay, importance here. Every member entitled to vote, meaning what? Equity shareholder. At a meeting of the company or any resolution to be moved thereat shall be entitled during the period beginning 24 hours before the commencement of the meeting. What do you mean by that? Let us imagine the meeting is on 8th April 2024 is the date of the meeting. At what time? The meeting is, let us imagine, at 1 p.m. Clear? So 24 hours before means, people, 7th April 2024 at 1 p.m. Now what are they trying to tell here? 24 hours before the commencement of the meeting and ending with the conclusion of the meeting, meaning the meeting is from 1 p.m. to 4 p.m. Yes, sir. So from 7th April 1 p.m. to 8th April 4 p.m. you have some right, it seems. What is that right? To inspect the proxies lodged, meaning a shareholder, equity shareholder can go and check who and all is coming personally, who and all is being represented through a proxy. You can go and check all the proxy forms. Provided you have to intimate the company that you want to come and inspect. Sir, how many days notice I have to give to the company, informing them that I'll be coming and inspecting the proxy forms? How many days in advance should I tell? You need to tell at least not less than 3 days notice in writing, giving your intention to inspect. Understood? So in short, equity shareholder can go and inspect all the proxy forms. Who and all are coming and representing through proxy, I can represent it, I can go and check it. This is the duration. So you can start checking it from 1 p.m. You have a right to check until 4 p.m. Provided you need to intimate the company that you will be coming and checking. Remember, that is important. You can expect a question here. Clear? Done. That's a proxy. Okay, next one, people. 106. Okay, voting is also important. First of all, right to vote. Can a company restrict the right to vote of any person? Is it possible? A person has not completely paid his calls. So the company restricted his voting right. Can a company do it? But its articles of association is silent. Can a company still restrict? Yes or no? Wait, sir. We'll see, sir. We'll see and say, sir. Here, the articles of a company may, meaning what, people? Articles, if it does not provide, people, in such case, people, you cannot restrict. That's what I had given to you guys in the questionable point. Meaning articles has to restrict. If articles does not restrict, then you cannot restrict a person from voting. It's clear? Yes, sir. Now, on what grounds can a company restrict a person from voting? You can restrict on two grounds. First one, if a person has not paid any calls. Second one, people, if at all he has taken any sum from the company and he has not repaid. So it is call money or any other sum payable. Let us imagine ICICI Bank have borrowed some loan. Have not repaid. ICICI Bank can restrict my voting right. Sir, on any other ground can I restrict a sir? Or in regard to which the company has exercised right of lien, on any other ground they cannot restrict the voting right. So it can be calls or it can be this. But you need to give a power to the company in the articles of association. If articles is silent, you cannot restrict the voting right. Is clear? 106 is done. Feeling cold, huh? I think that is also on that's the reason. You want to turn off that?
Manually it turned. This also got turned.
No.
Turned off, sir.
Ilva. Kai idenge. Off ada?
Off ಆಯ್ತು sir. ಅದಕ್ಕೆ ಅದನ್ನ manual ಆಗಿ turn off ಮಾಡಿ ಇದನ್ನ on ಮಾಡ್ಕೊಂಡು.
Wait, now. No, wait, it will turn on.
Off.
Wait, it will come. Rajkumar, wait. Okay, done now. Okay, done. Now, okay, 107, voting by show of hands. Whenever you want to vote people, a company can conduct its voting people. Technically, in the voting, I can put in 4 heads. One is called as voting by show of hands, e-voting, poll, postal ballot. In show of hands, it is always considered 1 share is equal to 1 vote. By default, unless otherwise a poll is demanded, everything will be conducted by show of hands. But if a company demands for a poll, then only poll will be taken. If not, it is always voting by show of hands. In any other case, 1 share is equal to 1 vote. In show of hands, 1 person is equal to 1 vote. Okay. Demand for a poll. Okay, let us start from poll only. Okay, who can demand for a poll? First one, chairman on his own, he can demand for a poll. He can say, let us conduct this matter by poll. Next one, by chairman on demand made by the company. How many people should make a demand? If at all, it depends upon you have a share capital, you don't have share capital. If you have share capital, any member or proxy, because proxy can also demand for a poll, holding at least 1/10 of the total voting power or 5 lakh or more paid up capital. Remember, whichever is less, so whichever is more, nothing is given. So it is 1/10 or 5 lakh rupees. Okay. Next one, any other company holding 1/10 of the total voting power. This will be in the case of generally company not having share capital. Okay. Sir, when can the poll be demanded? Important question again. A poll can be demanded even before the declaration of results by show of hands. After the declaration of results by show of hands, a poll can be demanded. Next question, again an important question from MCQ point of view. Once the poll is demanded, can we withdraw the demand? Yes, the poll can be withdrawn by the people whoever demanded it. Clear? That's your poll. Poll to be taken forthwith. Hey, this is very important. When should the poll be taken? Poll should be taken immediately or within 48 hours. Immediately when you are deciding 2 matters. What is that? Appointment of a chairman or adjournment of a meeting. If it is for this, you are asking for a poll, it has to be taken immediately, forthwith. If it is for any other matter, it has to be taken within 48 hours. Okay, polling paper will be in the format MGT12. Scrutinizer shall count and report on the result. The report to be scrutinized in form MGT13. It will be submitted to the chairman within 7 days of taking the poll. Correct? Okay. Voting through electronic means e-voting. What is e-voting, sir? Again, it was majorly with regards to the companies which is having more shareholders, so that more and more participation can happen through meetings. Applicability. Every listed company having 1,000 or more members. Listed company, 1,000 or more members they need to mandatorily give its shareholders an option to vote through electronic means. Even if you are not able to travel to the physical place, you need to give them an option to vote. So for a private company and all, obviously this option won't be there. Physical meeting will happen. E-voting and all will not be available. Non-applicability, sir, these provisions will not apply to Nidhi companies or institutional investors. Notice of meeting can be sent directly, website, newspaper, advertisement. Content of the notice, you will clearly say in the notice, people, two things are very important. One is login ID and password, and how long will the e-voting be open, sir? The e-voting will be open for a minimum period of 3 days. It has to mandatorily close on the previous day at 5 o'clock before the date of the meeting. If my meeting is on Tuesday, people, on Monday 5 o'clock it has to close. If the meeting is on Monday, Sunday 5 o'clock your e-voting has to close. Clear? Sir, appointment of a scrutinizer. Who is a scrutinizer? Technically, scrutinizer is a person nothing but like a magician. In the meeting also he comes with a closed dabba. He will say there are no votes in it. He locks it and people will start voting in a physical place. If it's in an electronic form, everything will happen in a software. Who will be a scrutinizer technically? He'll be an CS, CSO, CMA, advocate. So is it only Asa? Technically it can be any person other than the employee of the company. But unfortunately, we guys have ruled this market. Because obviously imagine, if a CA comes, you will take at least 50-60,000. Imagine a normal BCom person has taken this. Imagine a normal engineer. For him even 15-20,000 can be more. But it is a overly, because this other part is very small. It doesn't, you cannot notice it at all. But any person can become a scrutinizer. Remember that. He gets the access to all the details of the company. Scrutinizer report to be prepared not later than 3 days of the conclusion of the meeting. Results should be disclosed on the company as well as the agency giving this facility as well as the stock exchange if the company is listed. Okay, next one, sir. Postal ballot. People, proposed resolution through e-voting shall not be withdrawn. Poll can be withdrawn. E-voting cannot be withdrawn. What is a postal ballot, sir? Postal ballot is nothing but, people, an option on the company to conduct or to pass a resolution without having to conduct a physical meeting. So these things, you have an option to skip the physical meeting. You can conduct it only you can give an option for the shareholders to just vote from remote place instead of coming physically. That's the beauty of postal ballot. Section 110. What does it say? Postal ballot is mandatory. We'll see that. Postal ballot can be used for following business. Cannot be used for following business. What is that? First of all, ordinary. Adda you cannot use it because AGM, mandatory. And next one, any business where directors or auditors have to be heard. Section 115, special notice, removal of directors and auditors, where they have something to express. You cannot conduct them by postal ballot because physical meeting becomes mandatory. Next one, sir, exemption of postal ballot, for them it is not applicable. It seems. Who is that, sir? OPC or any company having up to 200 members. So that means which company they are talking about? Allah kano, all the companies. Public company can also have 100 members. Noda? Okay. Following items in main class also you fail. Now also exam. Okay. Following items shall be discussed only in the postal ballot. What is that? Throughout you have seen so many places. Postal ballot, postal ballot, postal ballot. So what is that, sir? Alteration of object clause. Section 27 was there. What is that? Change in objects and having unutilized money. DVR. Issue of DVR. Postal ballot, there also you saw. Next one was buyback. Sir, variation of rights of securities. Small shareholder director, that is not there. No. This is not there in our syllabus, so don't worry much. Alteration of private company. Basically, if you want to convert AOA into public, private company into public, public into private. Shifting of registered office outside the local limits. Correct? Yes, sir. So these things you need to mandatorily do it by postal ballot. Scrutinizer's appointment, same thing. Whatever we saw, same thing will apply. Just keep an eye on the days. 7 days. Results to be declared on the website of the scrutinizer report. Okay, done. Next one, sir, section 111, circulation of members resolution. What is this, sir? Nothing but a company is conducting a meeting as a shareholder, even I have something to discuss. Can you add my agenda also to the company's meeting? Is it possible, sir? That is what is called as people circulation of members resolution. Members can propose resolution for consideration which may be circulated to other members if the company deems fit. So they can propose. Who can propose, sir? If a company having share capital, members having 1/10 of the paid up share capital carrying voting rights. So equity. Company not having share capital, 1/10 the total voting power. Sir, conditions, sir, such requisition shall be signed by all the people making a request, and you need to give sufficient money for taking care of the expenses of distribution of your notice. Sir, within what time I need to give? You can expect a question here. You're telling me to give a request, no sir, to add your resolution to the notice of the meeting. Imagine company wants to discuss 4 things. You want to add one more thing to this notice. Within how many days you want me to give this request? They're telling me, people, you need to give a request. Depends upon what is the item you want to discuss. Is that item something where you need to pass a shareholder's approval for it, or no approval and all, sir? I just want to present some data. I want to give one PPT presentation now in the meeting. Can I give a? They're telling you it depends upon what it is. If at all you want to pass a resolution, in that case, people, you need to give it minimum 6 weeks before the meeting. 6 weeks before the meeting, which is the meeting which is so obvious that you know it is going to happen. They're referring here to AGM. Yes, sir. Sir, if it is PPT, nothing to pass a resolution, you need to give at least 2 weeks before the meeting. Sir, Achucho, now you know what happened. Sir, I thought to do 30th September is the date of the meeting. I thought to do. But because of 30th September, I gave the notice on 15th August to the company, 6 weeks before. But after giving notice, sir, those people called the meeting on 15th September only. Now, I did not satisfy 6 weeks criteria. They said after you give a request to the company, if they call a AGM before the day, it is still okay. Your notice is considered as properly given. Clear? Done? That is your 111. Next one, sir, 115. Resolution requiring special notice. When is it required? Generally, people, whenever you want to appoint an auditor, हमको ये auditor नहीं चाहिए, हमको दूसरा auditor चाहिए. So you are telling current auditor we don't want, sir. Please appoint some other auditor. So in that case, or retiring auditor not to be reappointed, you appoint whomever you want, sir. But ये बंदा हमको नहीं चाहिए. Sir, remove director before expiry of tenure. Sir, remove him, sir. Remove him, sir. Hey, hero, we have appointed him for 5 years, kano. Hey, remove, sir. Appoint another director in the place of remote director. Clear? In all these cases, you need to give a special notice. So this is nothing but what is happening here, people. A group of shareholders feel that the auditor or the director are not up to the mark. You have a right to remove them before the completion of tenure. What is the right you have? You have a right to give a special notice to the company. Sir, we are not satisfied with their performance. And that is what you are doing under section 115. Clear? Okay. Sir, how many people should give, sir? How many people should give, sir? Can one person give?
Not holding them 1% or 5 lakh.
Individually possible. Group is not required. It is not plural. If one person holds 1% of the total voting power, possible. That is also sufficient. Or shares which minimum 5 lakh is paid up. They are telling you, people, then this person's request will be valid. Sir, within how many time I have to give, sir? Sending notice to the company to be sent not earlier than 3 months before the date of the meeting, not later than, not to be sent at least 14 days before the meeting. What do you mean by that? Let us imagine our date of the meeting is on 30th September. You need to send it at least 14 days before the meeting. Can I take that as 16 September? Huh? 16th. Let us take 14. 14 September. I have to give it at least by 14 September. Okay, I will give it in January only. Macha, in January what and all can happen now? They are telling you, you cannot give before 3 months. That's the maximum. And when will that come to? August 30, July 30, June 30. Clear days. I'm just taking it as June 30, or you need to take actually the date of the meeting and all, you need to leave. Correct? So I'm not supposed to give before this, I'm not supposed to give after this. Clear? Yes, done. Company, you will give notice to the company. What will company do? Company will further forward it to the shareholders. How many days, sir? At least 7 days before the meeting. Sir, individually now it is too late, sir, to give. Okay, give it in newspaper. Check technically if a company is listed, they will also give it in the website of the company. Clear, Adana? That's all. Hey, other sections, okay, other sections. 114. Ordinary and special resolution. Ordinary means ordinary resolution. Special means special resolution.
Where the votes casted in favor of the business transacted in the meeting is twice.
Oh, yeah, yesterday English. Okay. So generally people, what do they say? Ordinary resolution means simple majority. Special resolution means the vote cast in the favor of resolution should be at least 3 times the vote cast against the resolution. The number of people saying no is 5. If the resolution is to be called a special resolution, the number of votes for should be at least 3 times the votes cast against. So the 15 people, this is called as special resolution. Remember, the total number of shareholder is irrespective to consider special resolution. The total number of members attended the meeting, irrespective. The number of people who did not vote, don't count. Nota, none of the above. They did not vote properly. All this is not at all to be considered while you are calculating special resolution. From your exam point of view, they may ask, remember. Clear? Yes, sir. 115 done, 114 done, 116 we have to do. Nothing but resolution passed at adjourned meeting. What is adjourned meeting? Sir, this week quorum was not there. We postponed our meeting to next week. So, when you are taking the day of passing the resolution, what is the day? Is it previous week or the adjourned week? Remember, you can expect a question here. If at all a meeting gets adjourned, the date of passing the resolution will start on the actual date of adjournment, not on the previous day. You can expect a question there. Yes, resolutions and agreement to be filed. Section 117, there is nothing but people. There are some very important decisions that are taken in the company which are mandatorily to be discussed with ROC. You have to file it. How should I file it, sir? In one form called as MGT 14. You have to disclose it to ROC. Sir, what are those important decisions? Wherever you have passed special resolution, it is very important. You need to disclose it to ROC. Wherever you have written special resolution, you have to disclose it to ROC. In form MGT 14. Sir, you know what? Law has said special resolution, but we passed unanimous. They still lawmakers said special resolution only, no? You passed unanimous, still it has to be filed. Understood? Okay, see here, special resolutions, which is written as special resolution, but all the members agreed. Next one, resolutions appointing or renewal of managing directors. MD, if at all you are appointing, their agreements are very valid. For us, it is not important, but for you, it is not important. Earlier, it was CA final. CA final, it was around 8 to 9 hours topic. Managing director was a very important topic. Now, it's not there. It's okay. Rest in peace. Resolutions agreed by any class of members with a specified majority. Meaning, I'm talking about equity shares. That's why I said special resolution. With preference, with any specified majority, even that also has to be intimated. Next one, resolutions requiring a company to be wound up voluntarily. Winding up people, very big decision. You need to intimate to ROC. Resolution passed in pursuance of section 177(3). What is this, sir? Nothing but we have given our board of directors certain powers. Without asking shareholders, you can do so many things, it seems. Without asking shareholders, if you have done anything like that, you need to intimate to ROC. MGTA 14. Other resolutions or agreement as may be prescribed. As of now, nothing else is prescribed. Next one, people, section 118. What is 118, people? 118 is nothing but minutes of the meeting. Remember, you need to prepare a minutes of the meeting separately for every type of the meeting. Board separate, committee separate, general meeting separate. Minutes of the meeting should be maintained permanently. Minutes of the meeting should be signed by town. Who should sign the minutes of the meeting? The chairperson of the meeting has to sign the minutes of the meeting. Technically, the minutes of the meeting will be prepared. Draft will be prepared within 15 days. It has to be finalized and written in the minutes of the meeting within 30 days of the completion of the meeting. The chairman of the meeting should sign the minutes by when? Within 30 days of the minutes of the meeting, you need to sign the meeting. But because of some reason, if the chairman met with an accident, rest in peace, passed away, now who will sign?
Give the board meeting, which shall be the next, chairperson of the next meeting.
Correct. Very good, sir. Remember, it depends upon what type of meeting it is. If it is a board meeting, then the minutes will be signed by the chairperson of the next meeting. If at all it is a general meeting, AGM or EGM, the next meeting you don't know when it is going to happen. So this will be signed by the person authorized by the board of directors to sign. They will sign. Important exam point of view. Exam question will be there. Clear? Signing of the minutes. Remember. Correct? Yes, chairman of the next succeeding meeting. Okay. Next one, people. Important. People, can a chairman delete any content from the minutes of the meeting? Can I delete any content? Okay, in the draft only. Whatever was discussed in the meeting, from that can I delete anything? If it is anything detrimental, defamatory, three things you need to remember. Correct. Detrimental, defamatory, irrelevant, that will be deleted. It can be excluded in the opinion of the chairperson. Correct. People remember here, they will ask something and all. Should the chairperson consult the directors? Should the chairperson call President of India? Something and all they will say. Nothing. In his opinion, if at all he feels this is the case, he can eliminate. Clear? Important from your exam point of view. Secretarial standards, I told you. SS2, correct? Signing provision we saw. Default. Okay, inspection of books, section 119. The minutes, whatever you have maintained. Remember, board meetings minutes can never be inspected. General meeting minutes can be inspected. To be kept at the registered office, minutes will be kept at the registered office systems. It will be open during business hours and you can go and inspect without any charges. Every day it will be open at least for a period of 2 hours. Any member shall be entitled within 7 days after he has made a request in that behalf to the company and payment of such fees with a copy of any minutes. If I ask for any copy printouts, I need to give it within 7 days. If at all someone refuses it, in case of any refusal, the tribunal may, in addition to 3, basically it's nothing but if any inspection is refused. Imagine I wanted to inspect a company's minutes, the company refused it. So a person whose request is refused, what he can do? They're telling, if any copy required under subsection 2 is not furnished within time, the company shall be liable to penalty of 25,000 every of the company. In the case of any such refusal, the tribunal may, in addition to 3 by order, direct an immediate inspection. Because that is my entire thing. I want to inspect, the tribunal will pass an order for you to inspect. Done. Maintenance of records, whatever this inspection or whatever the company has to maintain. You guys can maintain it in physical form also, electronic form also. Electronic form is also allowed, but for certain companies it is, electronic form has to be there. What is that, sir? Every listed company having not less than 1,000 shareholders, debenture holders, other security holders may maintain its records in electronic form. Provided that the records are maintained in the same format, the information are required adequately recorded, meaning whatever you are maintaining in electronic form, it should not be altered and it should be legible, it should be properly visible. Whenever you want, you should be able to take it, retrievable. Whenever you want, you should be able to print it, reproducible accordingly. Clear? Okay. Report on AGM, which we saw. Last one, applicability of section 122. Sir, AGM, is it applicable to OPC? The answer is no. Then how will a meeting take place in the case of OPC? How will he pass a resolution? He will not pass a resolution at all. Then what will he do? He will directly take the minutes book. He will directly enter whatever he wants. That is only considered as resolution passed. And also remember people, certain sections, section 101, 2, 107 and 109 is not applicable to private company. If at all they want to follow it, they may follow it. But section 101 to 109 and 101 to 107 and 109 is not applicable to private companies. Some section 101 to almost 120 is not applicable to OPC. Correct? Certain sections are not applicable. What are sections, sir? Sir, 98 to 100 to 111 shall not apply to OPC. So basically, there is no concept of notice, quorum, proxy, nothing, because obviously there is only one person. Agreed? Yes, sir. So by this we complete your chapter 7. We saw every section, huh? We saw every section or not? Okay, taka we'll do of dividends, huh? After that we can take a break. Okay. Accounts of companies, Allah. Dividends. Where did dividends go? Okay. Declaration and payments of dividends. Easy chapter, ano? Huh? Small chapter, ano? Everything is small, ano? Okay, we'll start now. So next chapter we will declaration and payment of dividends. Okay. First thing, sir, there are two types of dividend systems. One is called as final dividend. Next one is called as interim dividend. What do you mean by final dividend? Final dividend means anything which is declared in AGM. Interim dividend means people anything which is declared in between two AGMs. But remember people, final dividend is proposed by board of directors, approved by shareholders. Question number 1, can the shareholders demand higher dividend? Not possible. Can the shareholders request for a lower dividend? Possible. So you cannot request for a higher dividend, you can request for a lower dividend. Dividend is always paid on face value. Interim dividend, sir, is always approved, proposed both by board of directors. Remember, you can expect a question here. Done? Okay, done. Sir, now how and all I can pay my final dividend, sir? Declaration of dividend section 123. First of all, sir, sources of dividend, from how and all I can pay, you can pay out of the profits of the current year, you can pay out of the profits of previous year. That is nothing but your free reserves. Remember, interim dividend, that is not how it is. You cannot do it by free reserves. Agreed? You'll see when we are doing that. Or both, or if at all, any money is provided by central or state government, you can declare it even out of that as well. Okay. Free reserve does not include statutory or revaluation reserve. I hope you guys know this is throughout, wherever, whichever concept you see, that is always there. Before declaration of any dividend, the following should be deducted. What is that? Previous year losses as well as depreciation. Transfer of money is not mandatory. This is very important. What is it, sir? Is there any fixed percentage that a company has to transfer every year to general reserve? Is it something like that? No. If I want, sir, this year if I earn 100 crores, entire 100 crores I can declare as dividend. There is nothing like a percentage has to be saved. It's clear? Pakana? Okay, done. Next one, sir. Rule 3. Declaration of dividend out of profits of previous year or where there is inadequacy of profits or absence of profits. Meaning, I want to declare dividend. This year, my profits are less or there is no profits at all. So what I will do? I will take money from my free reserves and I will declare dividends. In that case, you need to satisfy 3 rules. All 3 rules has to be satisfied. First rule talks about what is the maximum rate of dividend you guys can pay. The maximum rate cannot exceed the average rate of dividend paid in the last preceding 3 years. Average it is. Take all 3 years divided by 3. Sir, what if I don't have 3 years, sir? Then this condition will not apply. That is what you saw here. Keep it as a note. Next one, sir. Maximum amount that can be drawn. Sir, second condition. What is the maximum amount I can take from my free reserves? The maximum you can take is 1/10 of the paid up share capital plus free reserves. Remember one thing. Now imagine 1/10 came to 10 crore. Okay, in the current year, you have 1 crore losses. You need to set off that. 9 crore can be utilized to pay dividends. Sir, the third one, sir, balance in reserve. After I take money, how much is still left in my reserve? That is your third condition. After such withdrawal from reserve, the balance shall not fall below 15% of the paid up share capital. So you need to satisfy all three conditions. Clear? Yes, sir. Okay. Payment of dividends, sir. How long I can make the payment? I can make the payment. Dividends will be payable only to registered shareholders or to his order. If I tell don't pay to me, pay to him, you can pay it to him, or to his banker. This happens only in the case of, everything will happen now in the case of this only. NEFT, that's how the dividends are transferred. Dividend can be paid only in the cash and not in kind. Cash here means I'm not telling physical cash, I'm talking about bank transfer, check, DD, or electronic mode. Dividend shall not be paid if company has not complied with section 73, nothing but you cannot take acceptance of deposits from public. 74, repayment before whatever you have taken before the act. Section 8, company is prohibited from paying dividends. Interim dividend people can be paid out of three things. What is that? First one is surplus in P&L account. What is surplus in P&L account? Last year profits, I have not transferred it to my reserves. It is still reflecting in my P&L. I'll call it as surplus in P&L. Wantedly, the directors will save some amount here. This is money that can be utilized by directors to declare dividend without asking shareholders. Anything goes to free reserves, I need to take a permission, not something in surplus. Then now, that's the logic. Next one, sir, profits of current financial year. Imagine I'm declaring dividends in the last quarter. So in the full year, how much did you? Q1, Q2, Q3, Q4. How much have you earned? Financial year has not yet completed. I'm declaring now. Whatever is the amount you have, you can declare. Last one. Profits generated in the financial year till quarter preceding the date of declaration. Imagine I want to declare dividend in the month of October. Then take the data till September. From April to September, how much ever is your profits, you can declare dividend in the month of October using this profits. So three things. Understood? Clear? Okay. Restriction during the loss of current financial year up to end of immediately preceding quarter. Meaning what, sir? If I'm using my surplus, that means in the current year I am having losses. Then only one condition will come into picture. What is that? The rate of interim dividend shall not exceed average rate of dividend declared in the last 3 financial years. Clear? Yes, sir. Why does the company generally have this condition? They can stop the company from paying dividend at all. Simple condition is that why will not we have this condition of paying from free reserves. There are some companies, for them it will be a tradition of paying dividends every year. I can give you examples like Reliance, I can give you example like ITC. They have never broken the record. From the last 15-20 years, they have been giving dividend. Now 1 year you can have a COVID. Can I break the record? Not allowed, because the market will take this news in a negative way. Now imagine you as a shareholder, or imagine you are an employee. 1 year, every year I'll give you increment, but 1 year I'll not give you increment. As an employee, what will be your moral? So to avoid that, we have an option to take it from free reserves, but provided you cannot empty the bank also. That's why conditions are there. Hope that clears. Okay, next one, sir. Dividend declared, section 124. We also called it as timeline. Whenever a company declares dividend, then you need to follow certain things within some time period. What is that? If I declare a dividend today, then within 5 days, I have to first separate that amount from my current account. So open a separate account, deposit the dividend into that account within 5 days from the date of declaration. Once you put it into that account, within 30 days of declaration, you need to make the payment to the shareholders. Sir, within 30 days, if you are not able to pay, then within next 7 days, sir, open one more account. This account will be called as unpaid dividend account, UDA. You need to transfer all this money into that account within 7 days from the date of expiry of 30 days. So 30 days is done. After that, within 7 days, you need to transfer the money into UDA. Sir, in this UDA, it is there, sir. No shareholder came to claim it. Keep the money there only for a period of 7 years. In 7 years also, if no one comes, people, which does not belong to anyone, belongs to me, says government. Transfer everything to IEPF. Correct? Remember, within 7 years, if you want money, you need to go and deposit. You need to go and request it with the company. After 7 years, can you get back your shares? Yes, provided you need to go and speak to IEPF. You have to apply to IEPF. Sir, what and all will be transferred to IEPF? Your shares will be transferred. Your unpaid dividend will be transferred. Any interest accumulated will also be transferred. Clear? Done. Next one, sir. IEPF account, sir. You can expect a question here. How will they ask you a question? They will clearly give it to you in MCQ. What are the purpose the IEPF can be used for? They will give you a list of this. One item will not be there. They'll give you a list like that. I hope you got the question. They may not tell you to write the entire thing. They will give you it in the form of MCQ only. Clear? Yes, sir. Sir, what if they give off? That's why I'm explaining. Funds is credited with the IEPF, which is created by government. How will it will receive the money? It will receive the money by any grants given by central government, by any donations, or any general revenue account given by central government. First three things is all given by government only. Fourth one, amount in IEPF. In Companies Act 1996, whatever was there, when Companies Act 2013 came, all that amount was transferred to this particular act. That is what they have given reference. Today's date is no longer there also. Interest or income received from investment made out of the fund. Generally, they will invest in government securities. Money is there. That will also be credited. Next one, disgorgement order money is it. What is disgorgement order? Kitna English. Disgorgement order is nothing but if there is any person who has made illegal gains, government will pass an order. Hey, give it, everything will be taken back. That is called as disgorgement order. Money which is collected back, illegal money. So that and all government only will take. They will take. You would have taken it from some person, no? Illegal money, no? That means you have taken it from some other person. It will be given back to that person only. That is what you will see under fifth, distribution of disgorgement amount to the person who suffered the loss. The best example I can give is in the case of Satyam, Ramalinga Raju. He had illegal gains, we gave it to the person who suffered the loss. It is nothing but investors. Okay, next one, unpaid dividend account, obviously, share application money. Correct? Someone has applied, you never allotted. No one came to ask also. Yes, mature deposits, mature debentures, preference shares, interest accrued on all of this, SBO shares.
Section 90.
Whatever 1 year that person does not disclose, no, transferred, no, that is coming here. Okay, next one. Funds is debited with what and all I can use this money for. You can utilize the IEPF for refund, obviously. If they are coming back, you need to pay. You can't say, hey, Goda. You have to give. Promotion of awareness amongst investors. Promote. Obviously, no. Nowadays, IPL, if you see, RBI is coming up with promotional activities. Don't click on this. No? Not seeing IPL and all?
Everyone who is IPL.
Okay. They are coming with advertisements. RBI, SEBI, RBI, to every day you will see that. I don't know how you are seeing. I am that free person. I am seeing in Jio Cinemas. RBI is coming, Noda. They will come up with one advertisement which says you will keep getting messages. Don't click on the links which you do not know. Dhoni, that's all. These advertisements all entadu illa. Sir, advertisements when it comes, we will take a break, sir. We will not see advertisements and all. Okay. Educating investors, protection of interest of investors, disgorgement, reimburse legal expense under class action suit. 37. Authority to administer the fund. Authority is created. Who will take care of it? Ex officio, ex ipsums. Ex officio. What is ex officio? So because of your designation in one place, you will become a chairperson of this particular IEPF. Sir, because of designation in one place means what? Whoever is a secretary of MCA will become a chairperson of IEPF. If they change there, you will change here also. Understood? You will see secretary MCA in one more place. Where? Constitution people 6 members. Maximum limit is 7. Sir, CEO shall be the convener of the authority. Where will you see it? secretary of MCA. Auditor, reporting of fraud. If at all the amount is 1 crore or more, you will give it in sealed envelope and all, no? Whom will you give it to? Secretary MCA only. Oh, sir, Secretary MCA. I thought I'll give it to him. Where will I give? Okay. Power of authority. Yes, sir. Then, power of authority. What and all they can do? Administer the fund, maintain separate account to spend amount. Okay, nothing. Any authority created by government. All the audit of the authority has to be made by CAG. Whether it is authority of the government or it is government company, their audits has to be done by CAG. Now what will CAG do? The CAG, their audit report, they will give it to the central government. Central government will lay these audit reports in both the houses of parliament. So in the parliament, it will be discussed. Then that is your IPF annual report. Okay. Dividend to be held in abeyance. Who is this abeyance, sir? Abeyance is nothing but people keep it aside. What do you mean by keep it aside? If at all the dividends you are declaring, whatever the shares, if that shares are undergoing any dispute, meaning what, sir? It may so happen a transferor signed SH4 and gave it to the company to register the transfer. The company has 30 days to register the transfer. Within 15 days, they declared a dividend. So technically, if you say, I gave a request to transfer, I know that I have to give it to another person. But within this time, the company declared dividend also. Technically, according to this, transferee should get the dividend because they have given up the request. Now, whom should the company give it to? Because in register of members, transferor name is there. But in my hand, transfer request is also there. So, what do they say? First thing, you can add in your transfer form only any dividend declared after giving the transfer. You can give it to the transferee. You can disclose this in your transfer form, SH4. If that is not disclosed, company will see, they will call the parties, they will sort it out. Only after that the dividend will be paid. Until that, sir, it will be kept aside. That keeping aside only is called as people kept in abeyance. Clear? 124. Sorry, 126. 127, sir, punishment for failure to distribute dividend within 30 days. Important exam point of view. What is that, sir? If at all the company has declared a dividend but they did not pay the dividend, in such cases, people, they will be liable, provided if at all there should not be a liability, then it should fall under this exemption. In these cases, company will not be liable. When is that? Due to operation of law, like death to insolvency or because of any other matter, even after declaring I am not able to pay the dividend, it's not my fault. So I will not be liable. Second one, sir, shareholders' direction of payment could not be complied. He told me to credit a specific bank account, but he has given account number as wrong. The digits are wrong. So in this case, what will happen, sir? The same has to be, now I tried crediting to that account, but obviously the number is wrong. I will not be able to credit, but your liability will still not come to an end until you communicate this fact to the shareholder. Here you can expect a question. If not communicated, the liability will be there. Adjusted against some due from shareholder, meaning call amount. If you have not paid, I can take it from the dividend. Dispute to receive right of dividend, abeyance. Non-payment is not due to the default of company, etc. Anything, but it should not be the default of the company. In such case, people, they are telling you, company won't be held liable. If at all it is held liable, company will be liable to pay interest at the rate of 18% per annum. And who will be liable, sir? Directors, they are liable to be imprisoned for maximum 2 years, fine 1,000 rupees per day of default. Note, dividend once declared cannot be taken back. It becomes a debt to the company. Yes, sir? Okay. We'll go for a break and come, huh? Go for a break and come. Yes, people, let's quickly revise your chapter 9, accounts of companies. Easy chapter, nothing to worry. We'll see where the questions can also be expected. Accounts of companies, people, section 128 talks about books of accounts to be kept by the company. In the books of accounts also, they have clearly defined what is books of accounts. Books or paper, books and paper, and financial statements. This and this, okay definition for us. But this is more important for us. Sir, with regards to financial statements, what is considered as financial statements, sir? Financial statements includes people, balance sheet, P&L account. In the case of Section 8 companies, you call it as income and expenditure account. Cash flow statement, statement of changes in equity, explanatory note. All this is considered as financial statements. One important question here, which you guys expect from your exam point of view, is that certain companies are exempted from maintaining cash flow statements. Who are they? One is OPC, small company, dormant company, startup. These companies are exempted from maintaining their cash flow statement in financial statements. So this can be an important question from an exam point of view. Remember, online able to see here? Okay, next one. General requirements in preparation of turned off. यहाँ आके रिमोट लेके टर्न ऑफ करके कौन रहे वो माइनर माइनर ओके if people general requirements in case of preparation of books of accounts, it has to be true and fair view. It has to be maintained for every financial year. Explain the transactions of registered office as well as branch office. Accounts must be kept in the accrual basis on double entry system. Place of maintenance, people, it will be maintained in the registered office of the company or any other place after passing the board resolution. Remember, important, after passing the board resolution. You also need to intimate ROC in the form AOC 5 within 7 days of such decision. Note, books of branch office, whether in India or outside India, the books shall be kept at the branch office itself, provided a summarized return shall be sent to the registered office quarterly basis. Clear? Yes, sir. Okay. Inspection by directors. If at all a director wants to inspect any of the books, he can do it during the business hours. He can inspect books of subsidiary also only after an authorization given by the board of directors. It is like allowing you to go and check it. This is important. Imagine, sir, I need some information of a company which is outside. Financial information maintained outside India can be requested by a director. Imagine I have a branch office outside India. Can I go and check the financials of the branch office? They are telling you why, simply Qatar Airways you will go, Emirates you will go, you will have some food there, expense only noda. They are telling you avoid that. Rather you can ask them only to send it. So they will send it to you people. It shall be provided in 15 days. This is more important. You have to make a request on your own, not through any intermediary, like an agent should not be involved, because I'm talking about sensitive information. Okay, sir. Next one, sir, period of preservation. Now, you will maintain it for a period of 8 financial years. However, if a central government tells you to maintain it for a period more than that, you will maintain it for more than that. Where will you see the reference?
131.
Wherever you are reopening or restatement of accounts. If at all central government tells you to maintain, you will maintain. You can reopen even beyond 8 years. If company incorporated newly, then such period as maybe as the time of existence. People. Okay. This 8 years preceding financial year, I hope we had discussed in the class on how to count it. Imagine if the current financial year is 2024-25. Do not count this year. Here the financial year will start from 23-24. This will be your first year. Like this, go see which is the 8th year. Wherever the 8th number is coming, that accounts you need to maintain until 24-25. Now imagine you go to the next year, 25-26. This, whatever you got as 8th year, this can be destroyed. Very important question from exam point of view. Where they will ask you, what is the last year that the government authorities can reopen or restate the financial statements? They can ask you. This is a very important thing, how to count. 24-25, the current financial year, you are excluded. Take it from 23-24, that will be your first year. 22-23 will be your second year. Like that, go. Like that you will go until 8th year. Whichever year you are writing as 8, that is the year you will maintain it in 24-25. Next you go to 25-26, that years you can destroy. That's how it is. Clear? Pakkana? I hope you guys got it. You want me to write or something? It's clear? All of you done. Okay. Next one, sir. Hey, online now. Next one, sir. That's the important thing. person responsible to maintain the books of accounts, important exam point of view, it may come in your MCQ. Who and all are responsible, that is related to you, the books of accounts, so it will come. Who is that, sir? Everyone related to management only. One is managing director, whole-time director in charge of finance, CFO, or such other person authorized by the board. Important. Clear? Next one, sir. Financial statements, section 129. How to maintain the financial statements? Obviously, true and fair view. You have to comply with accounting standards. Exam may important. If at all, first of all, people, you have to follow accounting standards. Sir, no, sir, I was not able to follow. I don't have a way out. You have an alternative. What is the alternative? You have to disclose what is that you have not followed. Second thing, what is the deviation? What did you follow? Third thing, what is the effect of such deviation on your financials? You need to disclose these three. Agreed? Deviation, reason, and what will be the financial effect? Yes, sir. Okay. Shall be in the format Schedule 3 of Companies Act. What is that? That is nothing but they are talking about financial statements formats. Balance sheet and all will be as per your Schedule 3 of Companies Act. Non-applicability, this format to all this is not applicable to the insurance companies, banking companies, and companies which are engaged in supply and generation of electricity, or any other company which financial statements are specified. Board shall lay following documents in AGM, which and also financial statements of my company. Now, if I take Infosys, I'll lay the financials of Infosys and consolidated financial statements of all my subsidiary companies and associate companies. Consolidated, I'll add everything. So this also I'll have to lay in front of my general meeting to be prepared as per the accounting standards. Sir, so everyone should present consolidated financial statements. Technically, generally, yes. However, there is an exemption for a few people. So see, these people are exempted from giving consolidated financial statements. How is that example we had seen? Let us think there is a company called as Walmart. There is a company called as Flipkart. There is a company called as PhonePe or Myntra. Now this is a holding company, this is a holding company, this is a subsidiary company. That is how the chain is made. Agreed? Now that asking you, whenever I am preparing a consolidated financial statements, just for the sake of example I am taking, let us imagine Walmart is an Indian company. Let us imagine. Now Walmart has already prepared one financial statements for them. One is done. The second financial statement will be a consolidated one. They have already prepared. So they have already prepared for Flipkart as well as for PhonePe. Now you tell me, should Flipkart again prepare for them? Not required. That is what is an exemption. Agreed? Like this, there are some exemptions. Yes,
The ultimate holding company.
Ultimate holding company or intermediary.
Members intimate us to not.
They give a no objection. They are absolutely fine. Next one, it is unlisted or not in the process of listing. Yes, sir. So who are exempted, sir? It is unlisted company or not in the process of listing, whether in or outside India. You are, I think, the first 2-3 items and all, they will not get into outside India. Someday, possibility is there. Clear? They may ask you, it is listed there. What do you think? They can ask. Clear? It's ultimate or intermediary holding company files a CFS. So Walmart has already done. Or imagine Flipkart has done. Again, Walmart need not do. Next one. It is a wholly or partly owned subsidiary of another company, and all its members have given no objection on non-presentment of CFS. What do you mean by that, sir? Let us imagine, sir, there is a Walmart, Flipkart, PhonePe. What they are telling, sir, it's a wholly or a partly owned subsidiary of another company, and all its members have given no objection. Let us take Flipkart example only. Sir, Flipkart shareholders only are telling, we don't want CFS, we don't have any objection. They are giving a no objection. Then in such case, you need not prepare CFS. Simple, yes, sir. Possible question, mark it there also. Next one, sir, exemption by central government to comply with section 129. They can ask you a question like this, sir. Is every company liable to follow section 129? First thing you will write is certain companies are exempted. Correct? And on the case-to-case basis, central government also has a right to exempt any company on an application made or so moto. They can ask you a question like that also. Remember, important exam may you can expect a question. Done na, 129 is done. Next one, sir, reopening of accounts. What is that? Let us imagine, sir, Satyam case exactly that is what has happened. In 2008, there was some financial manipulation. They had shown some inflated financials, sales and all. They had shown some inflated sales and all, by which their balance sheet is obviously inflated. So after 2-3 years, they got to know that for the last 3-4 years, that Satyam has been doing it repeatedly. Now, when Satyam accepted that yes, this has been happening, the IT authorities wanted to go back and see what these people have done for all these years. So in such case, sir, current year is going on. Can I go back in the past? Can I reopen the accounts? And can I prove that whatever they have written is wrong in these accounts? Can I prove that? Yes, that is what is the section called as section 130. 130 comes when the authorities want to reopen and recast the statements. 131 is when you voluntarily want to change it. Agreed? Okay. 130 people, how is it done? Sir, the authorities, can they do it whenever they want? They can do it, people, provided they need to make an application. How is it? To reopen and recast its financial statements, you need to file an application. Who has to file an application? Application has to be filed by central government, SEBI, income tax, statutory authority, any other person. Statutory authority can be IRDA, your PFRDA, as the case may be, or TRAI, Telecom Regulatory Authority of India, as the case may be. They are filing an application to competent court or tribunal. You guys know tribunal. What is this competent court? What if a company is not situated in India? The company is situated outside India. Can we still do inspection investigation? Yes, you can do. Provided that time the jurisdiction will not be with us, the jurisdiction will be outside. Vijay Mallya, case, your person only. Are you able to get him back? No, because he is in the jurisdiction of another country. That time tribunal will not work. So what will you do? You will go and enter into a treaty with the outside court. That is outside government. That is when competent court will come into picture. Clear? Okay. Before passing the order, it shall give notice to any. So now tribunal have filed an application. What will tribunal do? Tribunal, let us imagine, IT authorities or SEBI has taken this step on Satyam. Now, tribunal will say, a central government, a IT authority, SEBI is telling Satyam has done fraud since for all these days. They are inflating their sales and showing. Now, do you guys have a problem? IT authorities will definitely have a problem because they have already paid tax on the inflated amount. So, IT authority will definitely say, objection, your honor. In this case, what is going to happen? There will be a hearing. Obviously, just because you lose tax, you cannot say whatever they did is right. Wrong is wrong only. So in this case, there will be a hearing that will be held. Sir, what are the reasons why we can reopen? The reasons can be two things, people. One, if at all we know that the accounts were prepared in a fraudulent manner, or, sir, the directors are frauds, sir. When they are only fraud, accounts also will be fraud. Because they only have manipulated. Example, sir, Kingfisher. Satyam, management as a whole did not receive the first, tomato. The first tomato was hit on the financials directly. In the case of Kingfisher, the tomato was hit directly on Vijay Mallya. And then financials came into picture. Understood? Yes, sir. So, when the mismanagement has happened, obviously the financials will also have an impact. Okay. Sir, note, what is the maximum time you can reopen? 8 years. This is where the question will be important. However, if central government has ordered to maintain for more than 8, you can open for everything. The accounts once revised shall be final. Important exam point of view, remember. Next one, people, section 131. What does it say? Whenever a company has prepared its financial statements and board's report, there are two sections which talks about it. Section 129 and section 134. 129 talks about your financial statements, 134 talks about your board's report. If a company, they have clearly given you a format also. If a company has not followed the format properly, whatever are the disclosures the company should make according to 129 and 134, they have not made it accordingly, then what you will do? Imagine, people, last year I only found that we have not made certain things properly. Board's report, we did not disclose certain things properly. Financial statements, we have not taken one input properly. Now company only realized. Now can I do anything? Hey, what is doing, sir? Take and correct it, whitener. What else you will do? That's all. No. people, this section for here it is very easy. In reality, people, very must money making procedure for you guys. Very must making procedure. Why people? You have to go to a professional. The company will come to you guys. You guys will go to the tribunal and you need to take the tribunal's approval to go back, take the accounts, change it and again refile it. Because look at it people, once the accounts are filed, how many people would have already read the accounts? How many people would have already believed in that accounts? So it is not like so easily you guys can change it off. It is not so easy also. So what is the procedure? Again people, tribunal only will be allowed and you can change the financials after making an application to the tribunal. If tribunal agrees for it, you guys can change an account. How long can I go back and open, sir? Obviously 8 years, no? No, sir. The maximum you can go back and open is for 3 preceding financial years. Ide, Raukala, again Raukala came. Huh? Vaida, dosha ide ee class alli. Quickly. Can you call Shankar or someone? No? Prayer also didn't work? Okay. Yeah, black magic, huh? You called it black magic? Okay. That only I'll be telling. Then let them come. Okay. So, sir, when to do, sir, if board thinks that the financial statements or board report has not been prepared according to 110 another day, maximum duration people 3 years, sir. How people write an application to tribunal? Tribunal will obviously give it to other authorities also. Example, SEBI, central government, IT, etc. Once you get the tribunal's order, tribunal will conduct a hearing. The tribunal's order you have to go and give it to ROC. ROC will unfreeze the financial statements you have filed. Now you can take it back, make the changes, again file it. Once filed is final. Clear? It can be reopened only once in a financial year. Reason for revision to be disclosed in the board's report. Every year a company prepares board's report. In that you need to clearly disclose what was the reason why you guys had to revise. Because it is an intimation you are giving it to the shareholders. Last one, sir. Limit of revision. Can I do whatever changes I want, sir? No. If you have already given it to ROC, if it is already adopted in AGM, if you have already given it to the shareholders, the copy is already given. Now, your limit of revision cannot go beyond. Pen work ಆಗ್ತಿಲ್ಲ Shankar. Work ಆಗ್ತಿದೆ, sorry. ಯಾವುದು ಇದು? How can they do it? People, you also saw. See, when it comes, just like the doctor, when you go to hospital, your illness would have gone. Right, no? When you wouldn't have copied is when you will get caught. When you copy, you won't get caught. That will happen. There. Limit of revision. If such previous financial statements has been sent to members delivered later, then revision shall be confined to whatever is missing according to section 129, 134, add that. For example, CSR says you need to give a disclosure on committee. You have not given. According to 134, you have to give. You have not given. Add it. Huh?
CSR 132.
CSR 135 kano, 134 mein you have to give a disclosure on CSR committee board's report. So you have not given. So I have to comply with that. You can comply. Next one, making consequential alteration. What is consequential alteration? Consequential alteration means, people, let us imagine in the 2022-23, I changed my financials. It changed opening balance or closing balance. Opening balance changes. Oh, that's sir. That's what noda. In 22-23, if numbers change, what goes to the next year will also obviously change. But you have taken our previous number. It will change now. You have to change now. That's what they're saying. Okay, na? Logic irukuda. Okay. Next one, people, NFRA. What is this NAFRA? NAFRA हमको NAFRA करता है. What is this NAFRA है? National Financial Reporting Authority. First of all, three things we need to know about it. It governs the quality of the professional. Next one, they take care of your accounting and auditing standards. Discussing with ICAI, they will release your accounting and auditing standards. Sir, until NAFRA was formed, there was Vikas sir, Nakas, Nakas that was there. Correct? Yes, sir. Next one, sir. Chairperson of NAFRA, who is eminent person having experience in accounts, audit, finance, law, they were only. He has experience in everything. Chairperson and members shall declare to central government to no lack of confidence and conflict of interest appointment, sir. Meaning, people, you should be a person who does not have any conflict of interest. What do you mean by conflict of interest? When you are appointed in NAFRA, people, you cannot work in any audit firm until your tenure. Even after you leave, for the next 2 years also, you cannot be associated with any of the audit firms. Clear? Next one, such part-time and full-time members not exceeding 15. Functions of NAFRA: make recommendation on auditing and accounting standards, monitor and enforcement, oversee the quality of service of professionals, and suggest change to improve quality. No, you are not doing it right, do it like this. Perform such other functions. Okay, sir, first of all, will the NAFRA look at the quality of all the professionals? It is basically concerning CAs. Sir, all the CAs CAs of only big companies. Chota companies, ROC will take care. Big companies, NAFRA will take care. Yes, sir. So big companies means what? Big companies means if you are a CA of a listed company, whether the company is listed in India or outside India, if you are an auditor of that company, then you will come under NAFRA. Company won't come under NAFRA. You will come under NAFRA. That means when you are auditing, how you audited, NAFRA will check. That's the meaning. Yeah. I saw one answer the other day. People started writing that these people are regulated by NAFRA, not these people. The auditors of these people are regulated by NAFRA. Clear? Okay. Unlisted public companies having paid up capital of minimum 500 crores or turnover 1000 crores or aggregate, meaning everything put together minimum 500 crores. Now they will also be regulated by NAFRA. Next one, insurance company, banking, electricity, special act. All these companies will also be governed under NAFRA. Body corporate or company on a reference made by central government in public interest to NAFRA. Central government will say, on a request made, they will say, can you add one more person also to this list? Till today it is 3. Can you add one more person? Add LLP also. They are also growing today's data. Okay, LLP will also be taken care. Like that I am telling you. Yes, sir. Body corporate registered outside India. Body corporate registered outside India, which is subsidiary or associate of 1 to 4. Subsidiary or associate of 1, 2, 3, 4. So 2 conditions we saw. A body corporate registered outside India, and that is a subsidiary or an associate of any of these companies. Yes, sir. And you are an auditor of that. And that is such a big company. You are a subsidiary or associate of 1 to 4 and its income or net worth exceeds 20% of net worth of such company or what is the banking company?
Consolidated income or
consolidated income it is. I'm just writing at a CFS. You guys can understand. Sir, in short, what I'm telling you, sir, imagine there is Tata Motors and Jaguar, or Tata Motors and Range Rover. Now, if I look at total Tata Motors income, if I look at Tata Motors total net worth, how much of it is contributed by Jaguar? Sir, out of 100 crore, imagine 25 crore is coming from Jaguar only. Incorporated outside India. Subsidiary of a company registered here. Tata Motors listed. So you are satisfying all the condition. Auditor of that person will come under NAFRA. That's the meaning. Understood? Sir, once you are auditor covered under this rule, sir, once applicable, it is applicable for 3 years. Meaning what? Imagine I am coming under this unlisted public company. My paid up capital is 500 crore. Turnover is 1000 crore. Sales can fluctuate. This year it was 1000 crore. Next year it can be 980 crore. then NAFRA won't be applicable to me. Once applicable, 3 years applicable. So for 3 consecutive years, you did not touch the limit, people, then NAFRA will not apply to you. Clear? Same thing for all the companies. Imagine I was listed. I became delisted. After delisting also for 3 years it will be applicable. Clear? Yes, once you are governed under NAFRA, you need to intimate NAFRA who your auditor is. You will intimate in the form called as NAFRA 1. Within how many days? Within 15 days of appointment. 30 days, people, when this rules came into picture. Going forward, it is 15 days. When the rules was commenced, it is 30 days. That is what you would have seen there as 30 days. Sir, if you are an auditor of big company, it is NAFRA 1. If you are an auditor of other companies, then, meaning not big company, any other company, you need to intimate the appointment in ADT 1. Remember, both are important. Clear? Yes, sir? Any confusions? No? Okay, done. NAFRA. Okay, penalties are important for you. Remember this penalty. On such investigation, imagine if a professional misconduct was proven, then NAFRA shall impose a penalty. It depends upon who you are. If you are an individual or if you are a firm. If you are an individual, the penalty will be minimum 1 lakh. It may extend to maximum of 5 times of the fees you received. If in case you are a firm, minimum is 5 lakh. It may extend to 10 times of the fees you received. If you at all you are aggrieved, you guys can go for an appeal with the tribunal. Debar the member from doing your service. So not only that, people, you can also be debarred from being an auditor, internal auditor, undertaking any audit, and even valuation services for minimum 6 months, maximum 10 years. Sir, again, audit and annual report, same thing. It's a government created body. So you will prepare an annual report. It will be sent to central government. Central government will lay both in front of both houses of parliament. Obviously, because it is a government created body, it will be audited by CAG. Clear? Done. Next one, financial statements, board report, section 134. What is section 134? What is exactly board's report? Board's report is nothing but a love letter written by directors to the shareholders. What is that, sir? I will clearly say what we did in the last 1 year. Detail, financial or non-financial, in a summary way. I will express everything. Everything. Yes, sir. If at all it is a public, it's a private company, small company, you will call it as board report. If at all it's a listed company, you generally call this only as annual report. In annual report, board's report is one part. I am telling you a summary. Annual report will generally go for 400-500 pages. Yes, sir. Okay. So financial statements, in that certain things are very important. Try to remember these things specifically. Who will sign the financial statements or authentication of financial statements? Exam point of view, financial statements, anything important for you. Who will sign, sir? Chairperson if authorized by the board. No, sir, we did not authorize the chairperson. So, or 2 directors. If at all you have appointed a MD, managing director, it will be 1 director, 1 MD. If MD is appointed, he has to mandatorily sign. Next one, CEO, CF and CFO and CS. So, it is any one only, right? All of them have to sign. If everyone are there, everyone have to sign. Clear? Last one, sir, if it is OPC, 1 director you signed up, more than sufficient. Contents of board's report, there are so many things, basically all non-financial matters. You guys can simply remember all the topics, write it off here. What and all, imagine people, number of meetings conducted, you will disclose it here. I'm just telling you what and all you have seen. Sweat equity shares issued, you will give it here. DVRs issued, you will give it here. Changes of restatement, 131. Reason for changing, you will give it here. Auditing standards not followed. Deviation from auditing standards. Give it here. Correct? So whatever you have seen, that only will come again here. Agreed? What else will come? Fraud done by a company less than 1 crore. What will be the scenario? There is a fraud. The fraud is less than 1 crore.
Auditor will intimate to board of directors.
Auditor has to intimate to the board of directors 3 things. Nature, amount, and parties involved in the fraud. The directors have to give a reply to that, saying remedial action taken. That is also coming under board's report only. Yes, sir. Something and all, sir. You put something like this in air. What will it sit? Correct. Okay. See, it is what? Fraud reported under 143 subsection 12. Okay, next one. Director's responsibility statement. What is director's responsibility statement? In the director's report, one column will be there. Director, sir, will put one pinky promise and say, sir, we have done everything properly. Business mein mismanagement nahi hai. You can trust us, sir. Ye dil mange more. You can give the trust to us, sir. So how is this promise made? They will make promise 6 times. What and all they will make? They will make a promise covering the 6 promises. First one, they have prepared the annual accounts following the applicable accounting standards. If not followed, reason. Directors have selected accounting policies which will show true and fair view of the financial statements. Third one, maintenance of adequate accounting records. We have maintained it, sir. 8 years and all you are telling, no, books and all. Maintained, sir. Fourth one, accounts prepared on going concern basis. Fifth one, sufficient internal financial controls are in place in this company. Promise. Sixth one, sir, we are following all the applicable laws on the company. We are following. You don't have to worry. There is no problem from any company, any lawmaker. We are following everything. You give a promise. Complying with all those 6 things. There is one more thing also, people. Imagine the financial statements end on 31st March. Let us imagine 2024. Financials have been prepared. The director's report, let us imagine, will be given on, say for example, 30th August 2024. Sir, financials are prepared here. Director's report is prepared here. They are telling you, director's report will also have to include one thing. What is that? If at all there is any material transactions or changes that has taken place between this period, between the closure of financial year and the board's report, if any material transaction has taken place, that also you need to disclose. Clear? That is important. That's one thing you need to remember. Okay, the last part, sir, section 135, CSR. Okay, in CSR, sir, first thing, people, applicability. First to tell me, for whom and all CSR is applicable? First one is listed company. Listed company.
And company having net worth of 500 crores, turnover of 1000 crores, net profit of 5 crores.
Absolutely wrong, people. It is applicable to Yabbari company. Yes, sir. It is applicable to Yabbari company. Minor, a question to you. Imagine Flipkart, for them CSR is applicable. They spent also. They spent money. They have a subsidiary called PhonePe. Now, should they also spend money on CSR? Should they spend? Even a subsidiary company? After a holding company spent also, I have to spend? Sir, it is. Wait. Holding company, subsidiary company is also covered. Okay, small company, CSR applicable? Small company. So technically, the limits might not allow you to cross that. Agreed? Yes, sir. The next one, for a foreign company, is CSR applicable?
Yes.
Foreign company. Allah, the company which is situated outside India. So whatever is a place of business in India, you need to consider that branch or that project. If that is counting towards your limits, then yes, CSR is applicable. You should not take the entire accounts of the foreign company. You should only take that is what is there in India, that branch. If yes, even for them also it is applicable. So what are the limits, people? Applicability of CSR. It is applicable to companies, every company having net worth of 500 crore or more, turnover of 1000 crore or more, net profit of 5 crore or more. Should I satisfy all conditions or any one? Any one condition. So if once the company has to, the applicability comes into picture, I have to form a CSR committee. CSR committee consists of what, people? It consists of 3 or more directors, in which one shall be an independent directors. Care to be taken here, it is not 3 plus 1, 3 including one director, that is independent director. Sir, IIO, in a private company there is no independent director A. In foreign company there is no independent director A. You guys can make it, you can form a committee with 2 directors only, 2 members only. But remember, in case of foreign company, at least one person should be resident in India, because then only you will know where to spend. Agreed? So sir, formation of CSR committee. When and all you will form CSR committee? You will form CSR committee, people. First of all, based on applicability. Second one, whenever you have unspent CSR in your balance, meaning carry forward. From last year, you have carried forward some balance this year. You need to form CSR committee. There was an amendment here. What was that, sir? Earlier, once CSR is applicable, for the next 3 years, CSR was applicable. Now they have removed that. You need to check this condition every year now. Meaning your net worth, turnover, profit, you need to check every year. Earlier, once in 3 years, you used to check. Agreed? Sir, when is CSR committee not applicable? If at all the amount that we need to spend, if it does not exceed rupees 50 lakhs, meaning the CSR expenditure is not exceeding 50 lakhs, the 2% what we calculate, if it is not going beyond 50 lakhs, then you need not have a CSR committee. Done? Okay, done. Next one, sir. Composition. We did. Okay. CSR expenditure. What is the amount I need to spend, sir? You need to spend people minimum 2% of average profits of the company in the preceding 3 financial years. Agreed? Sir, whenever I'm calculating the average profits of the 3 preceding financial year, certain things has to be excluded. What is that certain things, sir? Whatever you have received from overseas branch. Now imagine Infosys as a branch outside India. You have received some profits from there. You should not include it here. Why? Logically think. If you are situated somewhere else, according to that country law also CSR will be applicable. That is what you are making here for foreign company. So it is not included in your profits of Indian company. Second one more thing has to be excluded. What is that? Any profits received from another company who has also followed CSR. Meaning any dividends received from any company who has already followed with CSR. Let us imagine, sir, Infosys has invested some money in Reliance. Is CSR applicable on Reliance? Yes. After spending money only, they paid dividend to Infosys. On that money, already CSR is made. Just like your GST, it's already paid. Tax on tax. We should not do it like that. Because on that profit, they have already spent on society. So when you are arriving at Infosys profits, you need to exclude a dividend which is received from any company which is already complied with CSR. Okay, that is CSR done. Sir, what to do with excess of CSR spent? You can carry forward for a maximum period of 3 years. Remember, next one, sir. What are the activities not considered as CSR? Can I spend outside India? Can you spend money outside India? Generally not possible. For training of the Indian sports person, then it is allowed. Or generally you cannot spend. Next one, people, it should not be ordinary course of business. Exception, research and development. During COVID, there was a relaxation given up to 3 years. Only for research and development. That too towards COVID, co-vaccine. Provided you need to do it with collaboration with the organizations mentioned in Schedule 7. We had seen Bharat Biotech, co-vaccine. Third one, what else is not considered as CSR? Anything done to employees and employees' families, not considered as CSR. But you do anything to the society, it is considered as CSR. Next one, what else is not considered as CSR? Political contribution, not considered as CSR. Next one, people, anything you spend according to statutory obligations, meaning certain companies, some laws tell you to follow certain things. Now, say for example, leather industry, before you emit any water out of your company, factory, you have to treat that water first. That's why they have set up some water plants, treatment plants. Can I claim this as CSR expenditure? Not possible. Next one, sir. What else is not considered as CSR? Any charitable things, any sponsorship shows, any TV advertisements, marathon, that running.
Marketing thing.
Marathon also, noda. Someone sponsor marathon, it's not.
Anything for marketing, if it has led to marketing.
Or anything which leads to marketing where the company derives any benefit is not CSR, correct? Yes, okay. Do you enjoy any tax exemption? No, there is no tax exemption on CSR. Okay, done. Next one, certain activities were added during COVID. What are the recent activities? Anything you spend towards COVID related, vaccine, makeshift hospitals, Har Ghar Tiranga,
Yes, sir.
Azadi Ka Amrit Mahotsav.
Yes, sir.
Sir, what is all this, sir?
Plate meeting.
Correct, plate meeting. Sir, 75th year people, we said every girl, every every house has to host Har Ghar Tiranga. So for that you need production. Anyone who supports that will also be considered as CSR. Correct?
Yes, sir.
And what else? Vaccination, makeshift hospital, Har Ghar Tiranga, ventilator, oxygen concentrators, everything were added during the time of COVID. Okay, done. Next one, sir. There is something called as unspent CSR. A CSR can be of two types. One is called as ongoing project or a not ongoing project. I can call it as multi-year project also. If at all it is a multi-year project. First of all, what do you mean by multi-year project? Any project that goes on for a period of not exceeding 3 years, excluding the year in which it started. So imagine if a project started in the year 24-25, don't count it. Excluding that, take 25, 26, 26, 27, 27, 28. So you have a timeline of actually doing it for 4 years, but when you're writing, you need to write it this way. Excluding the year it started, that is not counted. So sir, any project which is done for a multiple years, example is construction will come here, very big projects can come here. What is that person? Akash Ambani, Bantara, elephant jacuzzi, elephant food, that big. 1 year we cannot do all that, no? So it takes some time. So for all of that, so if you have seen there, he says that construction is still happening there. One more thing is being planning there. Why? It cannot happen within 1 year. Agreed? Yes or no? Okay. Yes, sir. Sir, what if it's a multiple project, sir? Simple. In the year, whichever the CSR is applicable, you started that particular project. In that year, people, if at all you were not able to spend the entire amount, obviously because it's a multi-year project, within 30 days from the end of the financial year, you need to transfer the entire amount to a different account and you need to name it as unspent CSR. Once unspent CSR is there, CSR committee is mandatory. Yes, sir. Sir, now in this 3 years also, I was not able to spend the amount. What will you do? From 2028, from the 30 days of the financial year end, you are still having some amount left in your unspent CSR. Transfer to any fund that is given under Schedule 7. Example is PM CARES.
Yes, sir.
Anything?
Yes, sir.
Hello?
Yes, sir.
Hello? Okay. Sir, what if it's a single year project, people? Single year project, if at all I am not able to implement everything, sir, then after the closure of financial year, within 6 months from the closure of financial year, we need to transfer everything to a fund specified in Schedule 7. Okay, done now. Non-compliance penalty I'm not touching. Okay, yeah? I want to see here. Non-compliance is okay, yeah? Okay, one more important thing is CSR reporting. Okay, CSR reporting, people, report on CSR. What and all you guys have done. You guys have to disclose this, people, in a format called CSR2. This has to be attached to your financial statements, that is AOC4 or AOC4 XBRL, as the case may be. You need to disclose it every year to ROC in the format called CSR2. This is CSR reporting. Apart from that, sir, in your board's report, you need to clearly disclose what is the CSR undertaken, what is the composition of CSR committee, and the report on CSR. You guys will also disclose it in board's report. Website of the company also. Next one is website disclosure, composition of CSR committee, as well as CSR policy and the projects that are covered and approved, that will also be disclosed. So technically, I'm saying there are completely 4 disclosures. One is called CSR2, filed along with your financial statements. Next one is board's report. Whatever is CSR committee, CSR expenditure. Next one is website disclosure. And the 4th one is, people, your impact assessment. Now, what do you mean by impact assessment report, people? Impact assessment report means, people, whenever a company having a average CSR obligation, I'll take it as okay, I cannot write as expenditure, I can write as obligation only. Any companies for the last 3 preceding financial years, my average CSR obligation has come to rupees 10 crore or more. In such case, sir,
impact assessment report concept will be applicable to me. Now, what do you mean by impact assessment, sir? Wherever, now let us imagine, I have to spend rupees 20 crore on a project. Actually, let us take 10 crore only. It is 10 crore or more. Now, whenever I have to spend 10 crore, now this 10 crore I can spend on multiple projects. Vantara, Mantara, Avantara, Kantara. So there are so many things you guys can spend it on. So Vantara took people 5 crores. Mantara took people another 5 crores. Avantara is a okay 50 lakh rupees. Kantara took everything else 9.5.
Another 10 crore.
10. Why do you will do this to me? Let us imagine just 20 crore. Okay, done now. Now what are you saying, people? You need to give a report on how is Vantara doing, how is Mantara doing, how is Avantara doing, how is Kantara doing. Kantara, they are not okay. They have did. I'm talking about Kantara too. So technically, what they are telling you, people, tell me, people, should Vantara give impact assessment report or not? Should they give it or not?
ACD 3 years average.
No, 5 crore. I'm telling no. So remember, CSR outlay of 1 crore only, but the first year people, it is not applicable. Meaning the year it started, the project it started, that year it is not applicable. What do you mean by impact assessment report? What is the change that your project made to the society? You have to give that. 1 year only, what change will it make? 2 elephants were there. 1 elephant went that side only, even if he is calling. Correct? Huh? So what impact did it make? Yes or no? No, that went no. You didn't see the video? Okay. So that's what they're telling. In 1 year, you cannot do anything. So the first year impact assessment report is not applicable because nothing you would have made. So impact assessment will be applicable from the year next to it. So that's the reason you would have written which has completed 1 year, minimum 1 year. Agreed? Sir, now whenever I have to take this impact assessment report, who will give me this report? It will be done by an independent agency. So they will also have to charge something. They will also take some money from us. How much they can charge? It cannot exceed, it shall be 2% of CSR expenditure, how much ever you have spent, or rupees 50 lakh, whichever is, write down whichever is higher, amendment. How can they make of lower to higher? Amendment.
What was the reason for this amendment, sir?
Because as the time passed by, now let us imagine 2%. There are companies, now imagine for whom if I am having a profit of 5 crore, is CSR applicable to me?
Net profit.
Now how much I have to spend? 2%. See how much 2% is coming to? 10% comes to 50 lakhs. 1% comes to 5 lakh. 2% is 10 lakh. Yes, sir. Now my project thing is coming to 10 lakh. And now if at all someone is coming and assessing it, for him this whichever is less makes sense. Now take Reliance. For Reliance, the CSR expenditure comes to around 1100 crores. He has made projects from Kashmir to Kanyakumari. Even if I come in one scooty which is having full mileage, that mileage only will take off my impact assessment report cost. So it is not covering. So they have said you can take whichever is higher. Here there's an amendment, remember. Here.
For independent agency of land big companies, it's helpful for them.
Correct, yes. Here, yes, sir. I hope I have covered everything on CSR. Yes?
Yes, sir.
Okay, done. So with this we complete your accounts chapter. Accounts of companies completed.
38.
Declaration is done, no?
Internal audit.
Oh, internal audit we have done, not done, no?
137, okay, sir. 36, 30.
Will do. Okay. 136, sir. Right of members to copies of audited financial statements. Meaning what, sir? The shareholders have a right to get the audited financial statement. That's a right of you. When will you get people? Whenever a company sends notice of general meeting, along with that, even the audited financial statements will also be sent. That is what they're telling you. What to be sent? Financial statements, including CFS, along with the audit report. Sir, whom shall it be sent to people? Every member, preference of equity, every trustee for the debenture holders, and to all other persons so entitled. If you have promised to some other person, even they will also get it. Timelines are not less than 21 days. Why? I told you, it will be sent along with the notice of the meeting only. Yes, sir. Okay. They shall be deemed to have been duly sent if it is so agreed by members holding. What is it, sir? If the copies of the documents are sent less than 21 days before the date of the meeting, they shall be deemed to have been duly sent. If the members holding, the company having share capital, basically people, the shorter notice thing only. What is that? Technically, they have to send me 21 days before. But imagine, shorter notice. 95% of the people agree for a shorter notice. Then I'll send it along with that only. No. That's why cut copy paste provision has been put here also. So if 95% of the people agree, I can send it lesser than 21 days also. Okay. In the case of listed company, sir, the company shall place the financial statements and CFS on its website also. Not only that, sir, the every listed company, along with its financial statement, they have to put each of its subsidiary companies' financial statement also on its website. Yes, sir. If at all the financial company is the listed company has a subsidiary company which is incorporated outside India. Now, in that case, what happens, sir? Where is it? Okay, basically what happens, sir, they're telling you people, if I'm a listed company, I have to place my financial statements on the website. Okay. If I have any subsidiary company, that also has to be posted on my website. Imagine if I have a subsidiary which is situated outside India. Even that company's financial statements also I need to post on website. But all these financial statements has to be audited. But imagine this subsidiary company is coming from a country where audit is not required. In such case, you can place unaudited financial statements only on the website. Clear? However, if it is not in English, it has to be translated into an English copy. Okay, done. Inspection, every member or trustee or the holders of debenture trustee can come and inspect the financial statements during the business hours. Manner of circulation of financial statements, how will you give it, sir? In case of all listed companies and such public companies which have a net worth of 1 crore and turnover of 10 crore, the financial statements may be sent by electronic mode for people who are holding it in DMAT format. Otherwise than in DMAT format, imagine I'm holding it in physical format, I'll ask them, is it okay? If yes, I'll send it in electronic mode only. If not, it will be sent in physical copy, provided I'll be collecting the money from them. Okay. Non-compliance, I'm not getting into it. Copy of financial statements to be filed with registrar, section 137. What is it, sir? Filing of financial statements. First of all, what is the format, people? In which format you will be filing it? You will be filing it, people, in form AOC 4. If at all, if it is consolidated financial statements, you will be filing it in AOC 4, CFS. If it is XBRL applicable to you, you will be filing it in AOC 4, XBRL format. XBRL is applicable on whom and all, people? Companies which are listed with stock exchanges in India and all their Indian subsidiaries. Probably not immediately, but somewhere down the line, December or next June or other next June, question can come there also. Companies having paid up capital of 5 crore or more, companies having turnover of 100 crore or more, all companies which are required to prepare their financial statements according to Ind AS. So for them it is applicable. Clear? Provided once once XBRL, always XBRL. Once you file it, going forward you have to file it, even if you fall below this limits as well. But certain companies are exempted. Who are they? NBFCs, HFCs, and companies engaged in banking and insurance sector. So 4 companies are exempted: NBFC, banking or insurance or HFC. Whenever they are asking you a question here, remember one thing. Remember carefully to read the name of the company. Because various places, the name of the company makes a lot of difference. HFC, NBFCs, as the case may be. Here, yes, okay. Okay, financial statements adopted, unadopted. What is this, people? Technically, when should I file my financial statements? You need to file it within 30 days of completion of your AGM. What if AGM is not conducted? You need to file it within 30 days of due date of AGM. Sir, what should I file? You have to file adopted financial statements. Sir, what if my shareholders did not agree? You have to file a provisional financial statements. The registrar will also be taking it as provisional only. Later on, you have to file a final financial statements. So that is what is the complete provision. Agreed? You have to file it within 30 days. We have written now. Okay, that is 137. OPC people, obviously AGM is not there. So directly it is 180 days of completion of financial year. In the case of OPC. Okay. 138. Internal auditor. Into 2, into 2, into 2, into 2. Something we had done. What is that, sir? D, SO, Yellow, T. DSLT, sir. For whom is the internal audit applicable, people? All the listed companies mandatory. If you are an unlisted public company having deposits of 25 crore, having a paid up share capital of 50 crore or more, having a loan of 100 crore or more, having a turnover of 200 crore or more. So multiply by 2 everything, it is applicable. What if it's a private company, sir? Just to take L&T. Yes, L&T Private Limited. Remember like that. Who can be an internal auditor? Who done? That accountant, cost accountant, or correct? No, done. That's all. Okay, done. That's it, chapter. Everything is cleared, covered. Okay, done. Accounts done. Next is your auditor. Taka will start off. Audit and auditors. Hold. We'll increase it. Come. Huh? Off it. You off it, sir. We'll die together. Yo. Oh, see, I offed. I offed. This how can that Mitsubishi से Blue Star कई सारे operate होता है? Okay, we do one thing. You come front. Let us turn on that AC. Oh, that will come there, huh? Okay. So someone should die today. Okay. Then back all of you. Let's start chapter 10 now. Chapter 10 is auditor and auditors. Audit and auditors. Okay. Okay, audit and auditors, people. Let us start. First of all, section 139, appointment of auditors. So, sir, whenever I have to appoint my auditors, I can classify the auditors into 3 categories. One is called as, in the case of first auditors, in the case of subsequent auditors, and in the case of government companies. For them, there is a little different provisions. Okay, in the case of first auditors, let us first start with government company only. In a government company, once the company is incorporated, within 60 days of incorporation, Controller and Auditor General of India shall appoint the first auditor. If at all CAG fails, sir, once they fail, within next 30 days, the Board of Directors shall appoint the auditor. Even if Board of Directors fail, people, 60 days, the shareholders members shall appoint. Even if they dies. Okay. Next one, sir, any other company, in the case of private or public or all other companies, once a company is registered, after 30 days of, within 30 days of incorporation, you need to appoint a first auditor. If they fail, sir, if board of the directors fails, within 90 days, people, the members have to appoint the first auditors. Clear? So this is the first auditor. Subsequent auditor. Now imagine the first auditor, his appointment will be valid until the first AGM. In the first AGM, his appointment will come to an end. From the first AGM, the next auditor will come into picture. So the subsequent auditor is always appointed for a period of 5 years. So how is this person appointed, sir? Procedure, technically, whenever there is an audit committee will propose it to the board will pass on this information to the shareholders. So the auditor is always appointed in the general meeting, AGM, because it is adda, appointment of auditors. It's clear? Pakana. The person appointed here will be valid for a period of 5 years. If at all a company does not have audit committee, directors only will directly propose it to the shareholders. Shareholders will appoint the auditor. It's clear all of you? Yes? Okay, done. Next one, sir. Whenever you are being appointed, you will give your auditor consent and you will clearly say you are not disqualified, and as the case may be. NAFRA 1, other auditors, ADT 1. Okay. Next one, sir. Tenure or rotation of the auditor, sir. Applicability. First of all, can I appoint an auditor for 20 years, 40 years, 100 years? No, sir. There is something called as tenure and rotation. Same auditor cannot continue on the company forever. But is it applicable for all the companies? Now, for example, Arivu's auditor is the auditor for, I don't know for how long. He is only the auditor. For a very long time. Can we have such things? That's why, sir, rotation and all this is applicable to only these companies. If you are not here, you can have the same auditor, Jigri. You can have him only forever also. Listed company, you have to rotate. Unlisted public company, having a paid up share capital of 10 crore or more, you have to rotate. Private company, having a paid up capital of 50 crore or more, you have to rotate. All companies having outstanding borrowings from financial institutions or public deposits of 50 crore or more. For all these people, 4 people, tenure also will apply, rotation also will apply. Tenure is 5 years. Rotation is same person cannot be appointed. Cool off is there, no, we'll see that. Sir, manner of rotation, individual, maximum you can appoint him is for 5 years. After that, sir?
5 years. Cooling period.
After one term, what you will do?
Leave him off.
Leave him off. You have something called as cool off period, people, 5 years. So maximum he can be appointed as for 5 years, one term. After that, there has to be 5 years cool off period, and after that you can reappoint him again. Whereas it is a firm people, you can appoint them for a period of 5 years for 2 terms. After that, again they will also have a cool off period of 5 years. And always remember, a firm with a common partner shall not be appointed for 5 years. I also told you a loophole also here. When you are appointing a partnership firm, you cannot have a common partner. What if after appointing a partner joins? The law is silent on it. So if you go with, that's what you would have studied, no? Letter of law and spirit of law. Spirit, sir? Spirit andre kandoddu. Spirit means, people, law, if you look at the rule, it says, whoever has already served, you cannot join another firm. If you join, the firm will also be disqualified. But technically, according to the letter of the law, that is not how it is interpreted.
Can we write an email to MCS?
Right. Okay. Then the existing company shall comply with these provisions within 3 years of commencement. Not applicable. It was there. Okay. Casual vacancy, people. Whenever a auditor resigns, dies, as the case may be, in his place, what you will do? You need to appoint one more auditor. If it's a government company, who will appoint people? In the case of government company, CAG will appoint within 30 days of casual vacancy. If at all CAG fails, people, within 30 days, board shall appoint. Sir, in case of any other company, within 30 days, board only will appoint. Remember, if the casual vacancy is due to resignation, that means something has happened in the company. That's the reason members should also approve the appointment within 3 months of appointing by the board of directors. Clear? Pakka na? 100%. Sir, subsequent auditor, we saw the case where shareholders will directly appoint in AGM for a period of 5 years. What is the case of government company? In the government company, every year CAG only will appoint. Yearly ones, 5 year or tenure, every year. And when will we appoint? Within 180 days of your financial year, you will appoint. Clear? Technically it will come to time of AGM only. Yes, sir. It's clear? Next one, sir. Reappointment of retiring auditor. What is this, sir? Now, whenever a auditor is completing his 5 years, now what happens, sir? Who will be the next auditor? If you have reappointed someone else, then absolutely fine. If you have not reappointed anyone else, then what will you do? Whoever is a retiring auditor, he only will be reappointed unless he said he does not want to continue, or he is not disqualified, not given his unwillingness. If he has given unwillingness, he cannot continue. He cannot be reappointed. A special resolution is passed, special notice that we do not want him to continue. Next one, no auditor is appointed or reappointed, the existing auditor shall continue to be the auditor. Clear? Yes, sir.
Retiring auditor ki rotation auditor.
Retiring auditor is nothing but a person who is completing his tenure and going away. Rotation is nothing but you cannot be reappointed, someone else has to come in your place.
Sir, మరి రిటైరింగ్ ఆడిటర్ 10 year అయిపోయిన తర్వాత కూల్ ఆఫ్ పీరియడ్ ఉంటుంది కదా సార్.
Correct. But is this applicable for all the companies? Rotation, is it applicable for all the companies? Small company? No. Private company? No. Public company less than 10 crore? No. So for them, this is the law. Understood? Yes, sir. Done. Okay. Next one, sir. 148 sims. Removal, resignation of auditor and giving out special notice. Technically, nothing is there if you have read 115. Correct? Special notice. 115. What was that? You are giving a notice. Sir, humko ye auditor nahi chahiye. So you are giving a notice. No. So what will a company do? It will take a notice from you. It will give it to the shareholders. Correct? It will also give it to the auditor. Auditor will give his reply. That reply will be forwarded to the shareholders. But if at all anyone feels this reply should not be forwarded, you can go to the authorities, you can stop this reply from being forwarded. It's clear? Yes, sir. Okay, see here. Removal of auditor. Should I ask any person before I remove? You need to consult someone. Central government's approval is mandatory. So removal of auditor, people, if you want to remove before the expiry of his tenure, then you have to first pass a board resolution. Within 30 days of passing board resolution, you need to take central government approval in form ADT2. ADT1 appointment, ADT2 application to central government. Within 60 days of approval, you need to pass special resolution. See special notice. I've just given you that order. Yes, sir. Resignation by auditor, sir. Can he resign? Yes, possible. Why not? Within 30 days of his resignation, he need to give this letter to company, ROC, CAJ. ROC and all, how will be intimate? You will basically resign in the form ADT3. So ADT1 appointment, ADT2 central government approval, ADT3 resignation, ADT4 reporting of fraud to MCA, secretary of MCA, secret envelope. 143.12. So sir, special notice, company will forward the notice to retiring auditor. He will give a representation to the company. The company will forward the representation to the members. However, any company or person may apply for tribunal to stop forwarding the representation. If not possible, auditor may request it to be read out at the meeting. Meaning, I gave my reply. It is not possible to give it to the members. I can tell it to read it out in the meeting only. Okay, next one, sir. Section 141, eligibility, qualification and disqualification. Mahishmati, saas le lo. Okay. Yes, sir. Eligibility, qualification and disqualification. Yes, people, who can be an auditor? Eligibility. Who is qualified as a chartered accountant can become a and practicing the
and holds a valid certificate of practice.
Yes, sir. Simple people. First of all, you need to be a CA. If at all you are a CA firm, majority of the partners has to be a CA. But provided when you are signing the returns, CA only has to sign. Disqualification, following people cannot become a CA, it seems. Kaun rahe wo? Body corporate. Obviously, company form of business is not possible. LLP is an exception. Next one, officer or employee of the company. If you are already working in the company, you cannot be an auditor. Partner or employment of officer or employee of the company. Meaning what? Let us imagine there is a company called as, say for example, Reliance. For Reliance, I want to appoint a person as an auditor. Now, in this Reliance, let us imagine there is one employee, or in this Reliance, there is one officer. Imagine senior level person, KMP or any person. Now, these two people, let us imagine they have a partnership firm. They have a partnership firm, or they have their own company, or any other thing. In that company, in this partnership firm, with our employee, this employee or officer is there, no? Let us take this employee is Ranbir Kapoor. Let us imagine this officer is Yash. Now, in this Ranbir Kapoor's partnership or in this Yash's partnership or a company, there is Hemant who is a partner here. Hemant is also an employee here, as the case may be. Hemant cannot be a partner of this Reliance. Hemant cannot be a, what did I say? Partner. Yes, sir, you cannot be a partner, auditor of Reliance. Clear? Pakana? Yes, sir. Online, if you want, you guys can take a pick. So this person not possible, this person not possible. Okay, done. Next one, person who renders certain services under section 144 आनो. Section 144 आनो. 144 में क्या है? Auditors not to render certain services. What and all is there? Bookkeeping, accounts, actuary services, investment related services, few services, some services. Correct? Basically, investment banking, investment advisory, actuary, and all that. Okay, accounting and bookkeeping, internal audit. You should not be an internal auditor. Design and implementation of financial information system, actuarial, risk related, valuation related, investment advisory. Sir, इस stock में डालो. Investment banking services, underwriting, or merger and acquisitions, rendering outsourced financial services, payroll, HR, management services, any other management services, any other kind of services as prescribed. As of now, nothing else is prescribed. Whether you are doing this directly or indirectly, you cannot be appointed as an auditor. Clear? Okay. Sir, next one, sir. Person or firm has direct or indirect business relationship with a company, associate, subsidiary, holding company. However, this business relationship does not include professional services, meaning if you are appointing me as an auditor, I will be giving you some services, right? That is excluded. Ordinary course of business. You are appointing me as a auditor of Reliance. I obviously have Geo connection. I watch IPL. For that, you will disqualify me. Provided, how much are you collecting from an outsider? You should collect the same thing from him also. Sir, for him also free, for you also free. It's okay. Imagine once you start charging, how much ever you charge for an outsider, the same thing you need to charge for him. That is only called as arm's length price. If that is the case, it is an exception. Clear? Clear? Okay, next one, sir. A person, his relative or a partner, a person is relative or partner, if he has any security in cash, cash here is company, associate, subsidiary, holding company, they cannot invest in any securities. However, there is an exception. Relatives can hold up to rupees 1 lakh. Remember, people, a few people have been asking a question here, recorded videos. Sir, is it, now imagine, sir, a person has two wives, imagine a person has wife and a son, sir. They both invest 80,000 and 80,000. Is the auditor disqualified? 80,000, 80,000. Remember, they have not given here as an aggregate. So, each relative can hold up to 1 lakh because nowhere they have given the word aggregate. It's clear? Okay. Indebted to cash, meaning I have taken money from company, associate, subsidiary or holding company. ICICI Bank, I have taken loan. I have to repay. I cannot be an auditor. My relatives have taken. I cannot be an auditor. In my partnership firm, my partner has taken. Even I cannot be an auditor. How much, sir? In excess of 5 lakh. Up to 5 lakh is absolutely allowed. Remember the limits and go in the exam. When disqualified, when not disqualified. Up to 5 allowed. Up to 1 allowed. If you have given guarantee, people, again, if someone has taken the loan from company, associate, subsidiary, holding, You have given a guarantee. If he doesn't pay, I will pay. Up to 1 lakh rupees people allowed. Beyond people disqualified. Sir, person whose relative is a director or KMP. Person whose relative is a director or KMP. What type of question will come? They will directly give you a scenario. This person, can he be an auditor or not? You can expect a question here. Sir, why? Imagine people, a person is proposed to be appointed as a auditor of the company. Imagine a lady has been proposed to be a CEO of a company. Her husband is a software engineer there. Is this person disqualified to be an auditor in that company? Yes or no?
Provided that husband has some professional qualification.
Proper husband is the husband of this auditor. Huh? They're telling you simple, as long as they are not director or KMP, absolutely allowed. Software engineer director, software engineer KMP, no. So if a husband is a KMP, husband is a software engineer, wife can be appointed as what people? As an auditor. Person or partner holding, each person, how many firms or how many companies he can audit? Maximum 20 assignments. More than that you cannot do. That's all, sir. Only 20, sir. हमारा इतना साल का मेहनत, only 20 companies. In this 20, certain companies are not counted. Which and all? Dormant OPC, small company, private company having paid up share capital less than 100 crore. Oh my God, less than 100 crore. 100 crore. 100 crore is not covered here, but for you, they will not go there. It's okay. They will not ask that point. What if they ask, sir? I have thought.
Sir,
but they will not ask.
The limit is for statutory audit.
Statutory audit. Sir, one more thing, sir. Imagine we are a firm. 3 auditors are there. For the firm, what is the limit? 60. It is a 20 per auditor. So it will be 60. Clear? Okay. Vacation of office. If an auditor incurs any disqualification after appointment, if you come under any of these things, you have to leave and go. See, here they have given a clarity. Common partner, they have never given a clarity. Got it? This is what I was telling. Okay, done. Sir, reporting of fraud by the auditors, section 143, subsection 12. If fraud is people, 1 crore or more, how will I report the fraud? Directly, people. Within 2 days of you getting to know about the fraud, you need to first intimate to the audit committee or the directors. If audit committee is not there, they will give their reply within 45 days. Whether they reply or if they do not reply also, you can file it within 15 days to central government. His report, reply. If they have not replied, the fact that they have not replied, you will give it to Secretary of MCA. You will file it in email also. You will also give a postal envelope also. And the format is people ADT4. Sir, what if the fraud is less than 1 crore? Remember here, 1 crore or more. Exact one, no? Exam mein bouncer. Because procedure only will change off. Agreed, huh? Sir, this also they will not ask. This they will ask. Huh? Okay. Within 2 days, the same thing. So now I'll ask the board of directors, they this is the nature of fraud. This is the amount involved. You know who and all did it? Parties. Now board of directors will take it when they are filing their financial statements and when they are giving the board of directors report. In that they need to reply to this point. What is the remedial action taken? Clear? Yes, sir. That is 143, subsection 12. Next one, sir. Before we go there, there are some important things, sir. In certain cases, auditors to attend general meeting 146 we covered. No, if you cannot come, you can send someone else also, provided he should be a qualified auditor. Punishment, I'm not going into it. There is one more important thing, Noda. Audit of government company is important. Powers, we need to start from here. They are important, correct? I'm sorry. No, sorry. Sorry. Okay. Remuneration of auditors, people. The remuneration of the auditors of a company should be fixed in general meeting. In the case of first auditors, it will be fixed by the board. The remuneration mentioned shall be in addition to. People, remember this. Important. Why? The remuneration mentioned aforesaid shall be in addition. Include the expenses if any. Meaning, In the MCQ, they can ask you that the company claims the maximum remuneration approved includes all the other expenses given by the auditor. It is both different. MCQ may they may ask you. Because it is auditors related, I am telling you, go line by line. Clear? Yes, sir. So remuneration is different, expenses is different. What are they saying? The remuneration mentioned above shall in addition, include the expenses, if any, incurred by the auditor in connection with the audit of the company and any facility extended to him. But the remuneration does not include any remuneration paid to him for any other services rendered by him at the request of the company. Meaning what? If there is any other thing which is given by him, that is excess. He will get more for that. Is clear all of you? Yes. Provided you need to make sure the other thing he has given, it is not falling under 144. Giving moral support. It can be, companies planning. I can give you any other plan. Now, whatever you saw under 144, everything was with regards to finance. So you can give something else also. Correct? Okay. Powers of auditor, you can go to all the branches, you can take all the books of accounts, vouchers, you can go and inspect, provided it should be in the business hours. Auditor of a holding company, you need to make sure you prepare consolidated financial statements also. Duties of the auditor, whether loans and advances has been properly shown, transaction of the company which represented by merely book entries, no proper vouchers are there, check that. Whether loans and advances, have you shown it as a deposits, check that. Whether personal expenses, oh my god, directors have gone to abroad and they're saying it is company's trip. No, check that. Where it is stated in the books and documents of the company that any shares have been allotted for cash, whether it has been actually paid by them or not. Allotments have happened. That's all. The auditor shall make a report to the members of the company. Okay. The auditor's report shall state he has taken all the information, explanation that is required for him to prepare this audit. Proper books of accounts, have they maintained or not? Whether the report on the accounts of any branch office of the company audited by a person other than a company's auditor, has it been sent to him or not? We saw no branch account on a quarterly basis, summarized returns has to be sent. Next one, whether the company's balance sheet and profit accounts, whether are they in agreement with the books of accounts or not? Here one amount, there one amount, like your trial balances. Whether in his opinion, the financial statements comply with accounting standards, the observation or comments of the auditors or financial statements or matters which have any adverse effect. Correct? You guys give a comment. Whether any director is disqualified, whether the company has adequate internal financial controls. Same thing. Director's responsibility statement. Sufficient internal financial controls have been maintained. Pinky promise. Directors made no. Who is Pinky? Sir. Okay. Auditors' report shall also include their views and comments on what are the pending litigations, whether the company has made any provisions for any material foreseeable losses, whether all the amounts to be transferred to IEPF is transferred or not. Correct? Audit of government company, important. Imagine people, whenever an auditor has made an audit and he gives it to CAG. Now CAG can do three things, people. On this audit report, he can pass any comments. He can also, if he wants, make a test audit, randomly pick one item and check whether audit is proper. If he is not satisfied, he can get it again audited by a different person called as a supplement audit. Whenever, because of all of this, if there are any changes, again it will be forwarded to the shareholders of the company. Clear? Yes, sir. Okay. Commenter, cost, test auditor, supplementary auditor. Okay. Next one, reporting of frauds we did. Yes, sir. Audit of accounts of branch office. It can be audited by whom and all? Company's auditor, by the accountant, or let us imagine my company is in US. In US, CPA can be an auditor. I can take an audit report given by a CPA, allowed. Correct? The branch auditor shall prepare a report and give it to the auditor of the company, which we have seen again and again. Agreed? Okay, 144. 145 auditors to sign audit reports. Obviously, Noda, it shall be open for inspection also. Payment of auditors, liability of audit firm. People in this entire thing, that is punishment for contravention. 147. Penalty on company, it's okay. Penalty have to pay for it. Liability of the audit firm, people, 447. But one thing you need to remember, in audit firm, whenever there is a penalty, let us imagine there are 3 auditors. Whenever there is a penalty, fine has to be paid by all 3. But imprisonment will only be on the auditor who did the mistake. Criminal liability, that is important. Cost audit, okay. Under cost audit, sir, what is one thing you guys remember? First of all, cost record. Who will have to maintain cost record, sir? If you remember whatever we written in the book, follow that only. Don't depend on that for the module. Whatever is written in the book, more than sufficient. Okay, cost record, people. First thing you need to remember 3 things here. One is cost record, cost records, cost audit, and cost audit report. Remember these 3 headings. Cost record, people, who and all should maintain? First of all, it is mandatory only on the companies. CG has passed an order. I will tell you to follow, you need to follow. But who and all, completely in depth, we didn't go. Correct? You written as may be prescribed. In your book, what we have given? Give me your book once again. And 48. You didn't write, huh?
Yes, sir.
That's all. Okay. Everything is as may be prescribed. We did not go in detail. Not we. It's not there. Rules are not there, so we did not go in detail. So cost records has to be maintained by those companies. Central government's orders to maintain, you have to maintain. Sir, when you say cost record, what should we maintain? We have to maintain utilization of the material, utilization of the labor, other items of cost. You will maintain it in your cost records. Technically, I have given you examples of those companies on whom this cost record will also be applicable, like telecom, electricity, etc. Cost audit mandatory only if the companies, that is CG, passes an order, only on them this particular cost audit is applicable. And how will it be considered? Based upon the turnover or net worth of the company. Cost record and cost audit is different. Records is like maintaining the records. Audit is like a person coming and auditing. Who will do it, sir? Cost auditor, the cost accountant, as per the Board of Cost and Management Accounts of India. Next one, sir. Appointment of cost auditor. Who will appoint? Remember, Board of Directors only will appoint. Remuneration will be fixed in the general meeting. Clear? Yes, sir. Okay. Next one is cost audit report, sir. It will be filed in the format CRA 4. The cost auditor will submit his report to Board of Directors. The Board of Directors, within 30 days, they will forward it to central government. It is it is filed in the format CRA 4 XBR. Correct? Yes, sir. That is what you have seen? Yes, sir.
Yes, sir. Yes, sir.
Now, that's all. Who shall be cost auditor? I think that is what we have seen. Anything else? That's sufficient. What is to be maintained? Cost auditor, appointment of cost auditor. That's all, no? Yes, sir. So by this we complete your accounts of audit and auditors. Agreed? Okay. Next we'll start with incorporate outside India. Na? You want break? Okay. Go for a break and come. Go for a break and come. We'll take up after the break. Sir, companies incorporated outside India, also popularly we call it as foreign companies. Section 379 to 393 governs around foreign companies. Now, whenever we need to know what is a foreign company, there is one thing, of course, people first thing this chapter is important. You can expect a question because first time it has been added to your CA Inter. Now, with regards to our topic, what is a foreign company? Every company just registered outside India, by default for this Companies Act won't become a foreign company. Then what is a foreign company, sir? Which is registered outside India. Three conditions are to be satisfied. It has to be registered outside India. It has to have a place of business in India. It should carry on some business activity in India. If all three conditions are satisfied, you will be called as a foreign company. So, sir, it means any company or body corporate incorporated outside India has a place of business in India and conducts any business activity in India, it is called as a foreign company. And whether how they are conducting a business in India, sir, it can be people directly or it can be indirectly also, that is agent or through them only directly. They can even be doing it as a physical office or they can even be present electronically. That will also be considered as what people, that will be considered as foreign company only. It will be considered as doing business activity. Sir, there has been one explanation given people under foreign company thing. What do you mean by place of business? Two people specifically have been included for the place of business. What is that? Registrar, basically registration and share transfer office, both are considered as what people? It is considered as place of business in India only. They may ask you a question here. Chances are 80 to 85%. They will say there is a company called Google which is incorporated outside India. They have a share registration office or share transfer agents working in India. Why? Because of economical, they have given that department outsourced to a person in India. Now this activity is happening in India. It will be considered as place of business. So whether now this company is called as foreign company or not. No, people. Where did I talk about business activity? Place of business is different. Business activity is different. So all three conditions are to be satisfied. When you're writing an answer, you need to write it with an assumption. Just because they have given you share transfer agent, by default, do not assume the place of business is there. Business activity, don't assume. So when you're writing the answer, assume and write. Assuming the company does not have a place of, the company is not conducting business activity in India, it will be considered, it will not be considered as foreign company. Or assuming the company has a business activity in India, it will be considered as foreign company. Write with an assumption. Is clear? Okay. Sir, what if I'm a foreign company, sir? If you are a foreign company, people, then this particular chapter will be applicable to you. Where is this definition defined, sir? Section 2, clause 42. Okay, sir. Now, section 379 says something. What is that, sir? Now, whenever there is a foreign company, let us imagine there is Google. Now, in that foreign company, 50% or more of the paid up share capital, whether equity or preference, partly equity, partly preference, if it is held by Indian citizens, whether one or more, or Indian body corporates or combination people, then that foreign company with regards to Companies Act is concerned, it will be deemed to be called as an Indian company only. So what, sir? Not 379 to 393. For them people, the entire company law will apply. Is clear? Okay, sir. What if it is less than 50%, sir? Then people, they have to comply with only 379 to 393. Is this clear? Pakkana? Okay, in exam, do not get confused. Imagine there is a foreign company. The foreign company opens a subsidiary company in India. Now, is this subsidiary company, what is this called? Is it a foreign company or not? They are doing business in India. Indian company or foreign company? So remember people, if you are directly registering a company in India, it is an Indian company only, it is not a foreign company. I am speaking about a term where Apple comes. Apple does not get registered here, but they open a store. They start doing business in India. Physical presence is there. Business is also done. Now this will call as foreign company. Now I will take this outlets sales for my CSRO and as the case may be. Understood? Pakkana? 100%. Let us imagine there is a company which is incorporated in India called as Company X. 100% shareholders are foreigners. What type of company it is? Indian company only. Okay. Next one, sir. Section 380. Documents to be delivered to registrar by foreign companies. You can expect a question here also. What does it say? First of all, whenever a company is coming and opening their office in India, project office, registrar office, whatever you are opening, within 30 days of opening your office in India, you need to intimate ROC, sir, present sir, I have come to India. You have to intimate, sir. How will I intimate? What and all I will intimate? You need to file one form, and that form is called as people FC1. You need to file it within 30 days of establishing business in India. Agreed? Sir, I will file FC1. Along with it, you need any other details. Obviously, I need your details. Whose details? I need the parent detail. That is the main principal business details. What and all? The charter documents, MOA, AOA. Sir, I come from China, French, Russia. Translate it to English. Address of the principal office. Where you are situated there. List of directors and secretary and their details. Names or details or address. So everything will be taken. Names and address of the authorized person in India. One person has to be authorized in India who would take care of the business in India. If you remember CSR should have minimum 2 members. One person in India, this person can be that person. Sir, you will see one more section also where I want to file any case against this foreign company. They have cheated us. They have cheated the contract. Whom should I send the notice to? You send the notice to this person. That means you have sent it to the foreign company. That's the significance of this person. Here, okay. Address office of company in India, where you are in India. Give the details of that also. Particulars of previous opening and closing of business in India. In previous years, had you come? If yes, give the details about those arrivals as well. Declaration that director or authorized representative is not debarred from forming or management of company. Whichever law. You should not have not been prohibited. Approval from RBI on FEMA guidelines. Because foreign dollars, everything is coming into picture. RBI comes into picture. Okay, sir. Next one, you will give all the details in FC1. Any changes in the information, people, you need to file it in FC2 within 30 days of alteration. It can be like address, details, name, the person, anything. Where to file, sir? You will obviously file with important thing. They can ask you a question. I'm telling you, within 30 days of coming and registering or opening a place of business in India, you need to file all the details to ROC. People will think the ROC of the state where you are coming. No, it will be for the ROC New Delhi center. Every document will go there. Important again from your exam point of view. Is it clear all of you? Yes? Okay. Next one, sir. 381. Accounts of foreign company. Sir, should we also prepare accounts? Yes, obviously. Whom should we give it to? You have to give it to ROC. What and all you need to give it, we'll see. Sir, every foreign company within 6 months of closure of financial year, similar to OPC, na?
Yes, sir. 6 months.
180 days only, no? Of foreign company, you need to file it to registrar. Sir, I am not able to give it, sir. One time extension of 3 months will be given, provided you need to make an application to ROC. Balance sheet and P&L account will be filed. Okay. Of what? Should I give it for the entire company, sir? You will give it for its Indian operation. Obviously, you will also give it of CFS also. Of the parent company also, you will be giving it. In accordance with Schedule 3. So, you are also expected to prepare your accounts, your balance sheet, P&L according to Schedule 3 of Companies Act. Consolidated financial statements of parent company also should be given. Your parent company's thing also should be there. A list of all places of business established by such foreign company in India in form FC3. What is it, sir? Where and all you are located. The details of all the offices should be disclosed in FC3. Next one, sir. Statement of related party transactions. Meaning if you have done any transaction with the related people, any business. Repatriation of profits. You have invested. Have you taken any money back to your country? Give the disclosure about that also. Repatriation means taking back. Have invested. I made profit. Have you taken back anything? Give a disclosure on that. Next one, sir. Transfer of funds. Transfer of funds. Have you invested any more capital? Have you taken back any capital back? All those things have to be disclosed. Accounts of such foreign company shall be audited by a Indian CA. This is also a good point. Correct? Okay, remember. Everything is given to the registrar. Okay. Next one is sections or provisions applicable to foreign company in addition to this chapter. So, sir, what and all is applicable to the foreign company, sir? I told you certain companies, that is, certain sections are applicable. Certain sections we saw here. 379 to 393 is applicable. That's all, sir. Allah, stay. That's all. No other sections applicable. Addition to this, there are some more sections also are applicable. What is that? It is given under section 384. What is the additional section now? Section 71 shall mutandis apply. Meaning what, people? Debentures. Section 92. What is that? Annual return. There only we saw FC4. That is also applicable now. Next one now. Section 135. We saw.
Yes, sir.
Applicable now for foreign unit. 2 officers.
One should be Indian.
One shall be Indian. 128. Books of accounts. Schedule 3. These people also have to follow. Register of charges. Chapter 6. Whether in India or outside India. Next one. Chapter 14. Inspection, inquiry, investigation. Basically, what is this? Not there in our syllabus. If ROC people technically, if you are doing something wrong, central government, RD, if you guys are doing something wrong, they have a right to come and inspect your books. They have a right to come and inspect your physical office. Same rights are applicable even to foreign companies branch also. I can come and I can inspect that as well. Okay. Sir, in general, section 26 also is applicable. Section 34 to 36 also is applicable. Chapter 20 is also applicable. Meaning what, sir? When will this come into picture? Whenever a company wants to raise money from Indian market, then these things will come into picture. This we will see when we are doing prospectus part. Completed.
Chapter
Here also prospectus is there. Da. Iruda, yaruda ni, yavadra nuvo, inta talented ga unnavo. Okay. Accounts of foreign companies we have seen. People, simple section, we'll finish up. Section 382, display of name, etc. of foreign company. What is this etc.? Simple people, the foreign company whichever has set up the place of business in India, they have to disclose their name and they have to disclose which country they are registered in 3 things. Where and all? In front of my office, big board. You have to disclose. Second thing, people, whatever your letterheads are, bill heads are, invoices, you need to disclose. Third one, whenever you want to raise panam, money from the Indian market, you will be issuing a document called as prospectus. In the prospectus also you need to disclose. What? The name, country where you are registered. Clear? Yes, and whenever you are disclosing it in front of the officer, you also have to make sure you need to disclose in the language in the general use in the locality also. Of late, you know, they are doing that, what is that?
60%.
60% Kannada thing. So that's the reason you need to post it now in Kannada. Till now, I told you in the class also, this is such a vague statement. Now in this line, in Kormangla, generally used language is English only or any other language. So I will post it only in English. That is, I can say, no, if registrar comes and says, I'll say, sir, this is the general language here. Correct? No. Vernacular language, general languages, there is a lot of difference. Vernacular is your local language. Correct? Okay. So you need to disclose all these 3. Correct? Okay. Prospectus, bill head, letterhead, invoices, and in front of the company in the billboards. Next one, sir. Debentures, annual return, registration charges. We saw 384. Which and all is applicable? Correct? Fee of registration 385. There is some certain fees payable according to the same. Indians, whatever are the rules we follow, same thing is applicable to them also. whenever they are filing some forms, some fees will be involved. They should also pay. You saw no additional fees, ad valorem fees, written on will be applicable here also. Interpretation, place of business, very, very important. Place of business includes share transfer and registration office also. Agreed? On this, I expect a question for place of business. Here, dating of prospectus and particulars to be. Okay. For this, I prepared one note now. We'll see in this note. I don't know if it is visible or not. Visible? Okay. So read these sections together. 387, 388, 389, 391. Now what does it say? 387 talks about prospectus. So whenever a company wants to raise any money from Indian market, which company? Two types of companies can raise its funds. Who are they? A company incorporated outside India or to be incorporated, or whether it has a place of business in India or not. What do you mean by that? According to our definition, you might be a foreign company or not. In section 23, you added section 23 subsection 3 and 4. What was the impact of that amendment? You can't come in Kantara and ask about Robert.
We have to take care that.
Take care of
CSR.
CSR.
CSU or KMP or an appoint money.
Section 23.
And these are kinds of.
That was beneficial interest. 89. Okay. I said only 3 amendments. The first amendment was only one. Sections are iru sir. Vandache. What is the amendment?
Public offer and private placement.
Public offer and private placement. A company need not issue GDR and all people. They can directly go and list your normal shares only. When you can go without establishing anything, why can't they come? Can come or not? That is what is this provision. Understood? A company incorporated outside India, whether or not it has a place of business in India. If you have also, you can raise. If you don't have also, you can raise. Understood? Okay. How will you raise, sir? Directly give prospectus to public. Before I gave it to public, one person came and hit. Who is he? Registrar. Registrar says, hum usko dekhna chahte hai. So first people, registrar will check everything. Before you issue it to the public, there is prospectus and application. The first person you need to give it to is registrar. Sir, now in this prospectus, what and all it includes, sir? The prospectus includes, next section also I am covering here only. So sir, first thing people, it will include one statement. What is the statement? First one, instrument defining the constitution. How are you registered? I mean, what type of company you are? Body corporate, statutory company, enactment under which you are incorporated. India Companies Act, according to which law are you registered? Give that details. Address in India where instrument can be inspected. At any given point of time, I want to go and check it. Can I come and check it? Where? Give the details. Whether company has established place of business in India or not. If yes, give it. Date and country in which company is incorporated. Where, which country you are from. Give all those details. Next one, sir. This particular thing shall be signed by chairperson of the company and 2 other directors. So the prospectus has to be signed by chairperson of the company and 2 other directors. Plus, you need to give certain supporting documents. So you need to give certain supporting documents to the ROC. What are those supporting documents, sir? The supporting documents are people, any consent to issue of the prospectus required from any person as an expert. Expert statement, if at all you have given, you need to disclose. Yes, sir. Next one. What you need to disclose? When I am giving it to ROC, I need to give the consent which expert has given. That consent form is very much required. Whoever is telling us to go and invest, that form is required. Next one. Copy of contracts for appointment of managing director or manager. Whatever you have appointed, MDs and all, their contracts we need to see. Next one, copy of any other material contracts not entered in the ordinary course of business. This is not your usual business, but it is still something which is very important you have done. Give me the contracts of that. For how long? For preceding 2 years. Copy of underwriting agreement, if any, if you have entered. Copy of power of attorney. Why power of attorney will come? If prospectus is signed through duly authorized agent. Why is this? We saw who has to sign the document. We have said chairperson and 2 other directors. They were not available. We gave our power to someone else. Okay, what is the guarantee they had a power to sign? You have to give a power of attorney. That has to be given to the registrar to cross check. Understood? Okay. Where did this go? Okay. Yes, sir. Now, so all this has to be given. In addition to that, expert statement. So we have seen 387, 389, now 388. What is the expert statement, sir? Now, whenever you need to give an expert statement, can I give an expert statement? Yes, you can give. In your prospectus, you can include, provided in certain cases you are not supposed to give. When the first one, no person shall issue in India any prospectus offering for subscription in securities, whether a company is incorporated outside India, whether it has place of business in India or not, if where the prospectus includes a statement purporting, meaning claiming to be made by an expert, your prospectus should not have an expert statement. If he has not given the consent or has before delivery of the prospectus withdrawn his consent, meaning what? In short, they are telling you, your prospectus may have an expert statement, provided you should have given a written consent. Second thing, before giving the prospectus, you should have not withdrawn that consent. Clear on this one now? Pakkana. That is what is given in 388. Understood? Try to understand the flow. Understanding? See, 387 spoke about dating of prospectus and giving it to the registrar. 388 spoke about your expert statement. 389 spoke about who should sign and registration of prospectus. And what and all I have to give it to the registrar. That is what we saw in 389. And next one is 391. What is 391, sir? Application of sections 34 to 36 and chapter 20 as the case may be. 34 criminal liability, 35 civil liability, 36 inducing whatever you are doing. Underwriting that loan thing, you are fraudulently inducing other person. Technically 37, everything is fraud only. They are telling 34 to 36, mutatis mutandis will apply. Chapter 20 is nothing but winding up. All these provisions will as it is apply. Agreed? Yes, sir. So indirectly, what are they saying? In your prospectus also, if there is something wrong, you will be liable, just like our Indian companies. Civil liability, just like same thing, cut copy paste. Understood? That's the reason we saw 387, 388, 389, 391 together. It's clear, all of you? Okay. Next one, sir. 387 shall not apply. What is it, sir? Generally, people, whenever you are giving a prospectus for the public has to apply to your company shares. What and all you will give? You will give prospectus and application. You need to give both application form and prospectus. However, in 2 scenarios, you need not give prospectus, it seems. You can directly give application form. When will that be? If you remember, same thing you had seen in 26 also. Whenever it's rights issue, that is you have given it to the existing debenture holders, or if it is uniform, same thing. Issue to the existing members or debenture holders. Then why again prospectus? Yesterday I told you. For first model you will give introduction. Second model, why do you need introduction? Correct, no? Next one. Issue is uniform in all respect with the previous issue. We have already done it. It's the same. So again I will not give you prospectus. Simple. Yes, sir. So 387, 388, 389, 391. Beats mein, which beats, sir? 390 is missing, sir. What is 390, sir? 390 talks about IDR. Now, sir, what is IDR, sir? GDR ka ulta. That's all. No, what is IDR, people? Whatever we saw in GDR generally what happens, people, there will be a Indian company who will go and give their shares to Indian custodian bank, that is domestic custodian. Domestic custodian, he will cooperate with overseas depository. He will issue GDR. Ulta karo arrow mark ko. there will be a foreign company, he will go to domestic custodian, he will coordinate with overseas custodian, he will coordinate with domestic custodian for us, and this person will issue IDR. Sir, any company was issued, sir. This company was the first company, Standard Chartered Bank. They issued around 3,000 odd crores as their IDR. Today's date, they have even discontinued as well because of the cost of listing. Obviously, it is high. Once you are listed, you need to pay the listing fees. That's a very high amount. Agreed? Yes. See, end of the day, if you are taking the benefit of it, it's okay. If not, it's unnecessary expenditure, no? Correct? Correct? By company incorporated. According to the companies, no company shall make IDR. So you need to follow this provision also. In addition to that, you need to follow SEBI also and anything issued by RBI also. Why dollars to Indian rupee conversion will be involved? SEBI ICDR is a person who completely deals with listing procedures. ICDR. If a company has to get listed, one complete chapter is people ICDR. That is the main chapter. How you guys can get listed. ICDR. Clear? Pakkana? 391 we saw na. Punishment for contravention. You want punishment? No. No, sir. Company's failure to comply with provision of this chapter not to affect validity of contract. My God. Important question, people. What does it say? People, let us imagine there is a person who came to India. He's a foreign company, but he did not follow this chapter. Meaning he did not intimate our ROC or he did not intimate some parts of this chapter. Then people, he has entered into any contract with our Indian company. It will not have any effect on the contracts. Contracts will still continue. But sir, if he does any mistake, you guys, Indians can file a case on the foreign company. Sir, can he also file? Until this chapter is complied, you are disqualified from filing a case back. You cannot file a case. You cannot claim a set-off, counter-claim. All this is not possible. Set-off means I gave money to him, he also gave some money. I did not repay. He's telling, sir, adjust, sir, adjustment and all not happens. Pay everything back. That is the meaning of set-off or counter-claim. Clear? Yes, sir. Important, remember. 393. I expect a question to come there. Rule 12. I think MCQ question they may ask you also. Rule 12 of companies registration of foreign company. What is this? Okay. This is nothing but people. If any person improperly, even if he is not, if he claims as a foreign company, then a registrar can conduct an inspection, inquiry, investigation according to section 210. Investigation can happen. Exemptions under this chapter. Central government people had a power. What is that? If at all central government wants, central government could have exempted any company from following certain sections under this chapter. It is central government's discretion. Now central government utilized this power and central government said certain companies are exempted from following certain sections. Not everything. Not all. 379 to 393. Not all. Certain sections are exempted. What is that? See here. MCA, they introduced a new section called as 393A, and according to which the central government hereby exempts from the provisions of 387 to 392 the following. Who and all? Foreign companies, they are not supposed, they are not, they need not have to follow 387 to 392. And companies incorporated or to be incorporated, whether having a place of business in India or not, they may be exempted, it seems, from what people? 387 to 392. Sir, okay, you are telling you are exempting them. What are you exempting them from? You are exempting them from these sections if they are doing these activities. What activities? If at all they are coming and offering the securities. Offering for subscription in the securities. Next one, requirements related to the prospectus. I am exempting you. Meaning, disclosure, exempting. Whatever is to be stated in prospectus, exempting. That is what they are telling you. All matters incidental thereto in IFSC. What is IFSC? When we are doing definitions, we will do International Financial Service Center. Sir, what is 387 to 392? 387, dating of prospectus and particulars to be contained therein. What is that? Whatever we saw together, all the sections, that is exempted. 388, provisions as to experts content. 389, registration of prospectus with registrar. 390, offer of IDR. 391, application of section 34 to 36. 392, punishment for contravention. So they have exempted from a section called 393A. It's clear?
They may exempt, or else have the government.
Government hereby exempts.
They have exempt.
Yes. Clear? Is clear? Okay. Will we complete your foreign companies?
If they have exempted all foreign companies or the companies for whom it's applicable.
So they are telling you. I'm not telling don't follow everything. Only with regards to these three aspects it is exempted. Meaning, as far as it is concerning offering for subscription in the securities, requirements related to prospectus and IFSC. Only these three matters, if it is related, it is exempted. Anything else, it will be covered. Understood? Okay. Let's do of definitions. Any doubts in foreign company? No. We'll do of definitions so that you will have that flow. LLP. Let's do definitions. We have covered most of it. No, any important definitions we have exceeded? Anything we have to cover it? So today I think we will complete of the definitions part. Tomorrow we'll keep LLP and other laws.
LLP is already included in other laws. No.
No, it is corporate laws.
70 marks.
70 marks. Yep. Enna question the last day. Okay. People, let us do chapter 1 definitions. First of all, applicability of Companies Act, section 1. To whom and all Companies Act is applicable? To all the companies registered under this law or any previous law. Insurance company, banking company, company engaged in electricity or statutory companies, such other body corporates as central government may prescribe. Is it important, sir? It may be important from your MCQ point of view. Why is that? Whenever there is a conflict between Special Act and Companies Act, imagine there is an insurance company, IRDA Act is also applicable. Now, between insurance companies, now if there is a conflict between Companies Act and Insurance Act will prevail. From that point of view, from MCQ point of view, it may be important, remember. Yes, sir. Next one, definitions are abridged prospectus means what, people? Summary of a prospectus. Accounting standards, NAFRA, until NAFRA, NACAS. Consultations and recommend, okay. I'm not getting into detail there. Alteration, addition, deletion, submission. Article means articles of association. Altered from time to time, everything. Associate company, we did not do. Correct, we did not do. Associate company means what, people? A company in which other company has a significant influence. What do you mean by significant influence? Significant influence means, people, more than a minimum. Which holds not less than 20% or more. 20% is called as associate company. Is clear? But does not include 20% or more. 20% is associate company. Sir, 20 minimum 20 is associate company, but does not include a subsidiary company. What do you mean by that? 20 to 50%. If one company has invested in another company, it will be called as an associate company of another company. Yes, 51 becomes subsidiary. Always remember, associate company definition includes joint venture. A joint venture company is also considered as associate company. Examination question can come here. Is clear? At least 20% of the total voting power or control of or participation in business decision under an agreement. Joint venture. Agreed? What do you mean by a body corporate? It includes a company incorporated outside India, but does not include cooperative society or any other body corporate as defined by central government. Chartered accountant, ICAI. Company incorporated under this law or any previous law. Control the right to appoint majority of the directors or to control management or policy decisions by virtue of shareholding or management rights or voting agreements. You know why this control word is required? Now, whenever I say significant control means this. Understood? Meaning SBO provision, there it will be helpful. Expert, who is an expert? Engineer, valuer, CA, CS, CMA, any other person who has the power of authority to issue a certificate under any law. Government company, what do you mean by government company? A company in which minimum, basically not less than 51% of paid up share capital is held by government, central government, state governments, central government and state government. Remember, subsidiary of a government company will be a deemed government company. Listed company, what do you mean by listed company? People, important. What do you mean by listed company? Okay. Sir, what is listed company is not our scope of understanding. What is not a listed company is our scope of understanding. These are not considered as listed companies citizens. Who are there? Public companies which have not listed their equity. So if you have listed equity or listed company, if you have not listed your equity on a recognized stock exchange, but you have listed your what? Non-convertible debt securities, that too issued on a private placement basis, or non-convertible redeemable preference shares issued on a private placement basis. Meaning what? If you have issued convertible preference shares, convertible debentures, and if you have listed them on the stock exchange, you will be considered as listed company. So I have issued non-convertible debentures only, but on a public offer, you will be considered as listed company. According to me, if a question comes from definitions, this is macha extra gole, pakka important. Clear? Next one, private companies which have listed their non-convertible debt securities on private placement basis, not considered as listed company. Public companies which has listed their equity only, equity, but not in Indian jurisdiction, in a foreign jurisdiction. Correct? But remember the words, equity shares listed on a recognized stock exchange, but whose equities are listed in a jurisdiction specified according to section 23, subsection 3. Corrected? You're not listing here, no. You're going and listing outside, no. That's what they're saying. Correct, Noda? Amendment, Noda?
Yes, sir.
Okay. MD, Managing Director, he has a substantial power to affix the common seal. This is. He has a substantial power of the company. The substantial power does not include the routine nature, like drawing the check, endorsing the check, or affixing the common seal. All this will not be considered as substantial power. These are routine administrative jobs. Okay. Next one, member people, the subscriber to MOA. Every person who agrees, technically people, who is a member? A person can be a member people in 3 ways. How is that? First one, during the incorporation. That's why they have written subscriber to MOA. So technically they are talking about a promoter. Next person is every other person who agrees in writing to become a member of the, whose name is entered in the register of members. Basically, you are buying the more shares at the time of allotment. It can be private placement, it can be FPO, it can be rights issue. You can become a member. Third one, people, you will be a member if at all your name is written as a beneficial owner. If you remember depository model. Correct? Registered owner, beneficial owner, depository model. Okay, officer who is in default, they may not get into detail. You want to go in detail in officer who is in default? We'll just randomly go through. Okay, officer default, wherever we have said this person will be liable for penalty. Who is that officer? The officer is people, whole time director, KMP, where there is no KMP, then such a director or director as specified by the board. We won't specify at all, then all the directors. Yes, sir. Okay. Any person who under the immediate authority of the board or any KMP charged with any responsibility including maintenance. Every place you will write no or such person authorized by the board. That person will be called as officer. Any person in whose advice we are in any person in accordance with whose advice we are accustomed to act. Meaning what people? A person controlling you. Correct? A port. Every director, but does not include professional capacity. Meaning you guys are not included here. If you give any professional advice, you are not controlling the company. You are just giving a professional advice. Control here includes, if I have to tell you the Shark Tank, 1% you will invest, but you want that 1% person to come inside because of the value he holds. You are ready to do whatever he tells you to do. He is covered here. Clear? Yes, sir. Next one. In respect of the issuer or transfer of any shares of a company, the share transfer agent, registrar and merchant banker. Meaning what? The person gave a share transfer request, but the company has outsourced everything to share registrar agents, registrar and share transfer agents. We saw even in the foreign company case also. Company has outsourced it to them. They are telling you in that case. In respect of issue or transfer of any shares, the share transfer agents registered to the issuer, such person will be responsible. Clear? Next one, who is a promoter? Promoter means a person who has been named as such in the prospectus. In the prospectus, if you have been written as a promoter, you are a promoter. Who has control over the affairs of the company, whether as a shareholder, as a director or otherwise. If you are controlling, you are called as a promoter. The third person, in accordance with whose advice or directions the directors are accustomed to act. I am telling you how to do, you are doing accordingly. Even that person is also called as promoter. Registrar is ROC. Related party. Related party is that big definition. If you remember that circle,
Yes, sir.
I made you guys write one circle. Correct? That blue and red and all we have written. Just this one thing I am skipping the, because if I just read, it not makes any sense. Agreed? Okay, what is relative, sir? Father, mother, stepfather or stepmother, brother or sister, stepbrother or stepsister, spouse or children, son or daughter, stepson or stepdaughter not there. Partiality. Stepdaughter alone is not there. And next, son's wife and daughter's husband. Everything's step. And small company we saw, subsidiary company we saw. That's all. So by this we complete your Companies Act, and LLP alone is pending. Tomorrow let's complete of LLP also. Not much of the part is pending. LLP won't take much time. FEMA will take some time because it will be important from an exam point of view. The rest too is manageable. We'll do it off. Clear?
LLP has come for 18 marks in MTP.
It's important. LLP, FEMA, foreign companies. Important from your exam point of view. Pakka. New chapters. Absolutely unexplored areas. Yes, sir. Chalo. Let's meet tomorrow. Thank you so much. See you guys. Bye-bye. Online able to see here? Yes, people. Let's start your next chapter. LLP Act, quick summary. Okay, first of all, what do you mean by LLP? LLP name itself says what? There are three words that is there in LLP. One is Siddhartha, one is... yes, people. LLP has two basic characters in it. One is called as limited liability and one is called as partnership. That's the reason LLP is called as a hybrid instrument. Hybrid means certain characteristics from company has been taken, certain characteristics from partnership has been taken. Together they have put in a mixie and they've girded grr and finally one product came and that product is called as people LLP ano. Yes, sir.
So with this only I'm covering two other topics also. Difference between LLP and partnership, difference between LLP and company. Let us see the characteristics of LLP. So we will also be covering at the characteristics of LLP also. So what is that? First of all, what are the natures of LLP? I told you certain characteristics are taken. First nature is people. Let us start with limited liability only. The partners won't be unlimitedly liable unlike a partnership firm. Your liability will be limited only to the extent of the capital you contributed. Just like company. Once that capital is done, your liability comes to an end. Okay, first nature. Second one, people. Just like company, there is perpetual succession. There is perpetual succession. But remember, in a partnership form, there is always one nature. If a person dies, in his place, another person will come. He will have a right to take the share in the profits. He will get the dividend. I mean, whatever is the interest given, no, all that you will be eligible. However, you will not be treated just like the existing partners. Meaning, with regards to what are the rights you enjoy, you will not enjoy the same rights. That is there always. Yes, sir. Okay, that is your perpetual succession. Even after death, the LLP will continue. Next one is people. It's a body corporate, artificial legal person. It has a separate legal entity from that of its partners. Partners are different, LLP is different. Meaning you can enter into a contract in the name of the LLP. LLP can possess contracts. They can hold properties in its name, liabilities. Someone can sue and even LLP can sue the others. Okay, next one is that people. It also can have a common seal. And people, just like a company, even LLP also has to communicate everything with ROC. The documents become public. Just like company, where ROC can do some inspection, here also inspection is possible. Yes, sir. Sir, and what else, sir? Okay, in LLP, what is the minimum number of partners required to start a LLP? Minimum number of partners required. There are minimum 2 partners required. What is the maximum number of partners? So unlimited. So this is one character taken from public company concept. Technically, if you see partnership, the maximum limit on partnership is 50. You cannot have more than 50 partners. Here they are telling you they are allowing up to unlimited. Sir, there is one called as partner. There is one more person specifically called as display picker, designated partner. What do you mean by designated partner, sir? Is designated partner having a crown? He is nowhere different from a normal partner. With regards to the business per se, he has no other extra, scope when compared to a normal partner. Whatever normal partner can do, DP also can do the same thing. In exam, don't write off DP is like a director and all. Because in a company, the administration is with director. Designated partner is not his duty. What is designated partner's duty? Only extra work we have given you is go and coordinate with all different authorities. You will be the point of contact. So if lawmakers want to contact the LLP, they will only get in touch with you. And you are your designated person. So amongst all the partners, we have nominated one. That's the reason we are calling him as designated partner. For what? If IT authorities have a problem, they will send a notice to the designated partner. If ROC have a problem, they will send a notice to the designated partner. Understood? 100%. In a company, how many designated partners has to be there? Minimum. Sorry, in a LLP, how many should be there? Minimum 2 designated partners. So overall, how many partners has to be there? 2 plus 2? 2. So it is not like 2 partners or 2 designated partners. So 2 partners only can become designated partners also. So those 2 designated partners, who can be a designated partner? Who can be? Is it only an individual or even a body corporate can become? Remember people, technically designated partners has to be individuals only. But there was an amendment. Now they said even body corporates can also. When 2 body corporates started one LLP. Imagine 2 partners are body corporates only. Infosys and TCS, they came together. They started one LLP. Where are individuals? Both of them are artificial persons only. Now who will become a designated partner? In this case, they will have to nominate a person, authorized representative. This person will become a designated partner. Infosys will nominate one person and TCS will nominate one person. Now they will act as a designated partner. Earlier that was not the case. An individual should be a partner.
Now they are not a partners. They are just a authorized representatives. That's an amendment. That's the difference. I hope you guys understood. Sir, just like foreign company, there is a concept of foreign LLP also. What do you mean by foreign LLP? Place of Anna. Clear? So people, anything which is, any LLP which is registered outside India has a place of business in India. Business activity in India is called as foreign LLP. Okay. Designated partner. Okay, done. We discussed all that, na? Difference. People, one main thing, what do you mean by mutual agency? Mutual agency means in a partnership firm, one partner can go and bind all the partners. Imagine I go and sign. If the contract ends up in a loss, the entire partnership firm will be liable. So a partnership firm does not have money. Every partner will be liable. But that is not the case with LLP. In LLP people, a partner cannot bind the partners. Then what can a partner bind? A partner can just bind a LLP. A partner can just bind a LLP. Remember that. What do you mean by that? Imagine I entered into a contract for worth 15 lakhs. The LLP has a capital of 10 lakhs. If that contract ends up in a soup, only 10 lakhs will go. 5 lakh people, the partners won't be liable. Understood? Pakkana, 100. You guys can ask one more question. Sir, what will be the 5 lakh? What will happen to the 5 lakh? This partner has to pay. He will pay only if it is a fraudulent transaction. If he genuinely did a business, if it's a genuine business loss, even this partner also won't be liable. That's the whole concept of limited liability partnership. No. Yes or no? Okay, done. That was the basics. So remember, mutual agency also is important concept. Okay. Minimum number of partners. People important. Small LLP ano. Small LLP. My suspicion is that there might be a question on small LLP means what? People from age immemorial, small company they have been asking. I'm not saying they won't ask. They will ask. But when compared, both are similar concepts. So small LLP has some weightage. Especially, especially in MCQ. Okay, so what is a small LLP? It is a LLP only, it seems. They got encouraged by Companies Act. Just like them, here also they have designated one LLP as a small LLP, and they will in the future give them some benefits. So as on today, what do you mean by a small LLP, sir, which satisfies two conditions? Both the conditions are to be satisfied. What is that? In company, it was paid up share capital. Here, capital will be called as contribution. So contribution not exceeding 25 lakh rupees and turnover not exceeding 40 lakh rupees will be termed as what, people? Small LLP. Important. Next one, sir. In your book, people, financial year definition is not there. According to me, this will be an important question. Alva, aduda jalak, aduda magic. People, according to the Companies Act, what do you mean by financial year of a company? If a company is registered on 31st December of a particular year, when will your 31st March? 31st March. Now people see here, in the Companies Act, we had a end date as 31st December. If you are getting registered after that, then your LLP will have, your company will have a financial year next year. Yes, sir. So whatever is 31st December in the Companies Act, in LLP Act will be 30th September. Not 31st December. Remember that, important. Okay, now read the complete provision. In relation to LLP means a period from 1st day of April to 31st day of March. You do not have, you just write it down. Provided that in case of LLP, partnership incorporated after 30th day of March, 30th day of September of year, the financial year may end on the 31st day of March of the next following that year. So for us to understand, just write down this example. You guys may understand. So the example is, people, let us imagine a LLP is getting incorporated on 1st October 2024. LLP got incorporated on 1st October 2024. The financial year will end on 31st March 2024. 26. Huh? You said 26 only, yeah. Sir, if at all the LLP gets registered on, write down both the scenarios. Second scenario is even more important. If I get registered exactly on 30th September 2024, then my financial year will end on 31st March 2025. Is clear? Pakka na? 100%. Why this differentiation also? The reason is people in LLP, the transactions will be less when compared to a company form of business. So there 3 months might have some reasonable transactions. Here the 3 months is very much negligible. That's the reason they added another 3 months to it. Understood? Because LLP per se from a business point of view is a small person. So even if they are registering on November, in a LLP's point of view, for 4 months also there won't be much transactions. So for 5 months also there won't be much transactions. In company, generally they say for 3 months there might not be any transaction. That 3 months equality in LLP is 6 months. There won't be much transactions. Understood the logic? Exam point of view, important. Clear? 100%. Okay, designated partner we saw na. A designated partner, how many designated partners should be there? 2. Anyone should be there in India? 1. There should be a resident in India, meaning people, he should put cement and city. How long should he be there? He should have present in 20 na 18 na? 120 days in? During the financial year. Very good, sir. Don't get confused between OPC and this. OPC is preceding financial year. LLP is during the financial year. That's the difference. Clear? Yes, sir. Okay. Next one, sir. Who will be the designated partners? You can specifically nominate who will be the designated partners. If you are specifically not nominating, you can also say time to time all of us will take turns as designated partners. In that case, every year the designated partners can also change. That can also happen. Sir, in a company, sir, a director should mandatorily have DIN, director identification number. In a LLP, sir, a designated partner should mandatorily have DPIN. Agreed? Okay. Change in designated partner. Okay. First, we'll see from the chart, and if there is anything missing, we'll just see here. Okay, partners, minimum 2 partners. Okay. Sir, at any given point of time, a LLP should have minimum 2 partners. What if it goes below the minimum 2 partners? What if it goes less than 2 partners? You will be given people 6 months time to increase it. What if you do not increase within 6 months, sir? The same thing will happen here also. What is that? The continuing partners, whoever is aware of the scenario that we are continuing with less than minimum partners will be unlimitedly liable after that 6 months. Not only that, if at all you are continuing the LLP with less than minimum number of partners for more than 6 months, that is also one of the grounds for dissolution. So if you look at the grounds for dissolution, this also will come there. Agreed?
Minimum number of partners is reduced. How will the other one not have the knowledge of
No, see, it may so happen that this one person, whoever is other partner, he may become a lunatic. He may die. Whether legal representative is there, I'm not saying it is always. Might happen. Agreed? Yes, sir. Okay, next one, sir. Designated partners, minimum 2, there is an authorized to take care of legal compliances. So one designated partner should be resident in India 120 days. Correct? Okay. Feeling cold, Okay, I've increased it. Okay, next one, sir. Incorporation of LLP. How to incorporate LLP, sir? There is one form here. The form you need to file here is called as Form Philip. Philip means people form for incorporating limited liability partnership. Form Philip. Form for incorporating limited liability partnership. What is the procedure, sir? You will first reserve your name people similar to company only. It should not be undesirable. It should not be similar. It should not be similar to your company's LLPs as well as any registered trademarks. And you should mandatorily add the word LLP to your name. Okay. Next one, sir. Philip. In this, you will give the details of LLP partners, designated partners, address of LLP, objective, contribution, and it shall be certified by CA, CS, CMA, advocate, and registration of LLP is mandatory. Submitted to the ROC. If everything is proper, certificate of registration will be given. You remember, just like Companies Act, you get SIN. In LLP, you will get a LL PIN, LLP identification number. In certificate of registration or incorporation, the date of registration will be given, LLP identification number will be given. Again, a recent amendment, not there in our amendment or not there in our syllabus also. Even LLP nowadays will also get PAN. Just like company. Till today, the integration had not happened. Recently, they have amended this also. Even PAN number also you will get along with your certificate of registration only. Earlier, we used to apply it separately. Now, this is also one of the integrated thing. Clear? Sir, once the form is done, sir, within 30 days, you will file something called as LLP deed. What is this? Similar to partnership deed in partnership firm. So, all your rights, duties, and obligations of partner, remuneration, everything can be decided by you only. LLP Act is silent on it. So duties, rights, liabilities, obligations, everything will be decided by your LLP deed. And LLP deed will be in the format Form 3. It has to be filed within 30 days of incorporation. Clear? Done? Okay. Sir, registration of changes in partners. What do you mean by that, sir? Let us imagine partner or designated partner. Partner or designated partner. I think we had seen in the example. What is that? I think the name change I had given astrology or something. I don't know. Okay, forget, sir. There is a partner, sir. The partner, whatever details he has given to the company, at later point of time, if those details change, like name, address, who will change the name? Possible, no? Change of name will happen, no? Especially in Telugu industry. So many heroes have changed. Yes or no? Nitin has changed, according to me. Sandeep Kishan has also changed. Nitin, I think THIN, generally Nitin, I think his name is NITIN. So they follow astrology. They do it. Will they change, sir? Yes, they will change. Yes, sir. So, sir, if at all there is a change, now if at all this person is a partner, you need to intimate it to the LLP. LLP will further forward it to the company within 30 days of such a change. So LLP will take that information within 30 days of the change. They need to intimate it to LLP. ROC. Sir, what else will LLP have to intimate to ROC? People, any change within 30 days of the change, you need to intimate to ROC. Change can be change in your details of the partners. It can be change of partners also, meaning admission, you have to intimate. Omission, retirement, removal, resignation, you need to intimate within 30 days of the change. So, sir, it can be incoming or it can be outgoing. Outgoing can happen in 3 cases. One is insolvency, one is death by notice. Whenever a partner ceases, he will always be entitled to 2 things. One is his capital, one is goodwill. What is the share of the partnership? Okay, sir. Sir, if at any given point of time, I believe I have communicated the change to the LLP, but I think LLP might not intimate to ROC. You can also personally intimate to ROC. You can expect a question here. Clear? So, sir, if partner believes that LLP shall not forward to ROC, he can directly forward to ROC within, to ROC. ROC shall confirm with LLP and give 15 days to respond. Failure to reply will be deemed approval. What do you mean by that? Partner has applied to ROC directly. Sir, this is the change. Now, what will the ROC do? ROC will check with the LLP. Your partner is telling that this person is leaving the company. Is it true? Do you know? 50 days time is there. If you do not reply within 15 days, it is considered as deemed approval. Done. Okay, next one, sir. Conversion of firm or private company, unlisted public company into LLP. They can ask you a direct question here only. Can an existing firm, partnership firm, private company, listed company, can they convert? Remember, sir, it has to be unlisted. A listed company cannot convert into anything. You have to first become unlisted. Here, yes, okay. Sir, can they convert into LLP? Yes, it seems possible. It seems. Next one, sir. How? File prescribed form with ROC. What is that form and all? Not in a syllabus. Don't even bother. What is the effect? Once you get converted people, you will get a new certificate of registration. Going forward, till today your company, you are following Companies Act. Going forward, you will follow LLP Act, and you need to intimate your ex also. I mean, you need to intimate your previous regulator also. You will intimate if you are a partnership firm, you will intimate Register of Partners. If at all you are a company, obviously you will intimate ROC only, but a different authority wherever you are. Now imagine if you are in Karnataka, if you shifted to some other state, you need to intimate the authority of the previous state. So you need to intimate that you have converted. Clear?
What if the partnership was unregistered?
Then no, nothing. Nothing is there. No ground at all. Yes, sir. So next one, sir. Financial disclosures. Should LLP do any financial disclosures? Yes, people, cut, copy, paste. Whatever you did there in the form of AOC 4 and MGT 7, same thing will apply here also in the form of statements of accounts and solvency and annual returns. Same thing will come here also. And within how many days, sir? Timelines important from my point of view. If LLP, MCQ mein examination question can come here. If LLP shall, first of all, it has to maintain proper books of accounts. Okay. They have to file statements of accounts and solvency. When should we file? They say within 30 days from 6 months from closure of financial year. Let us go in ulta. Closure of financial year is 31st March 2024. 6 months from here, I will take 30th September 2024. Within 30 days from here, so I will take 30th October 24. Understood? So 30th October 24 is my last day to file my financial statements. It is called as statements of accounts and solvency. Sir, my annual return, sir, it has to be filed within 60 days of closure of financial year. That is nothing but May 30th. Clear? Pakkana? Yes, sir. Exam point of view, very important. Remember, winding up at dissolution. Let's go. First, we'll see the other parts here. Characteristics, body corporate, separating on mutual entity, LLP agreement, artificial legal person, common seal, LLP, limited liability, conversion into LLP. We saw no. People, important, LLP cannot be done as a Section 8 company. It has to be for profit, not possible. Remember, somewhere here and there, not for your attempt, someday it can be important. Management of business is done by only who manages the business of LLP? Partners, so LLP, don't write off as designated partners. So investigation possible, e-filing has to be done. Foreign LLP, outside India, place of business in India, business activity in India. Incorporation of visa, Filippo, okay, done. Certificate of incorporation, okay. Once you are incorporated, sue capacity, so incorporation of registration. Registered office of LLP and changes, same thing. Registered office also has to be communicated to LLP. Can you change it anytime? Yes, you can change it anytime. That is also possible. Okay. Name people, cut, copy, paste, whatever you saw in Companies Act. Meaning what? Can you change the name of the LLP? Yes, sir. How? Voluntary, mandatory. Mandatory cut, copy, paste. Meaning what? Within 3 years of a dummy, duplicate LLP getting registered, the original LLP has to go and file it with central government. Within 3 years of registration, within 3 years, central government, if at all deems fit, yes, what you are saying is right. Central government may pass an order for the LLP to change its name. Once the order is passed, within 3 months, you need to effect the change. You need to change the name. If at all you do not change the name on your own, then in such case, central government himself will allot you a name like RD's order, not not complied, year and date of the order, everything will be given in your name. Can I further change it, sir? Yes, you can further change it. Done. Rectification of name, that's what we saw. Partners and their relation, eligibility, everyone can be a partner. Relation of partners, it is all defined by your LLP agreement. Any changes has to be also filed with registrar. How will you file it? Nothing but your form 3 only. LLP deed, no. Cessation of partnership, we saw how and all. Death to declared on insolvency, correct? No. And whenever he goes out, what he gets? Agreed? Yes or no? Consequence of cessation. Okay, this might be important here. Consequence of cessation of a partner. Cessation means what, people? A particular partner's appointment is coming to an end. Correct? Now, where a person has ceased to be a partner, the former partner is a person who is leaving, is to be regarded as still being a partner of the LLP. Oh my God, they're telling he retired, it seems. He resigned, it seems. But still he will be considered as a partner only, it seems. Oh my God. Until when? When he was a partner, you will be still liable. And until you give ROC intimation, you are still liable. Because outsiders, how will they know you left? So let us imagine there is a partner who resigned from the LLP. He left, but still entered into a contract with some person. Now, whether the outsider, can he hold the LLP liable for this contract? The answer is, if the resignation is not yet communicated to ROC, and the third party, I will ask you one question. Whoever entered into a contract with my partner, I will ask you one question. Macha, only one question. Did you know? Sir, did you know means what? Did you know that this person is no longer a partner? Did you know? Sir, no sir. Humko nahi pata hai sir. If you don't know, then we will protect you only. Who? The third party. LLP will be liable for the third party. Sir, no sir. I did not know sir. The next question. Hey LLP, he did not know it seems. So you have to pay the money. LLP will say, hey, go sir. I have given it to ROC. Doctrine of constructive notice. If you have given to ROC means you have given it to the world only. Now third party will be liable. You will not get the money. That's what is given in this both contexts. Clear? According to me, might be important someday, not immediately. Sir, someday why are you telling it now, sir? Not for you people. Someone watching video. Someone. I don't know. The cessation of a partner does not discharge. Correct? Whatever he did when he was a partner. So even after he left, whatever was done, for that he will be liable. For the new contracts, he will not be liable. Where a partner of LLP ceases to be a partner, the former partner or a person entitled to his share in consequence of death or insolvency shall be entitled to receive from the LLP amount capital or accumulated profits, which we saw. A former partner or person entitled to his consequence of death or insolvency shall not have any right to interfere in the management of the LLP. This is what I told you. Imagine I left. In my name, someone else came and joined. He will get the profits. He will get the share of benefits. By default, you cannot interfere in the management. You will not be treated just like other partners. This is according to the law. Now imagine a new person is coming in. I will tell, hey, you will not be treated equally with us. Will he come? So that's what it is. So mutually, if you agree only, he will come. If not, if you say we will not treat you at par with us, then why will he come? So it is like a lock only. Understood? No, it is for the legal representative, for the person, that is, imagine children, or imagine wife, or imagine parents. It can be any person, no? Yeah. See, technically speaking, what happens here, when we are doing business, or when we are doing partnership, you personally believe that person for a particular skill, and you trusted. Whether that skill will be there in the children. Now, imagine there can be a wonderful batsman, Sachin Tendulkar. Everyone can in the family be a Sachin Tendulkar. Now imagine, you particularly, let us imagine you took a partner because he is very popular. Now, not every person in the family will be as popular as that celebrity. Correct? You cannot replace his shoes. So you cannot be put in the exact shoes. But yes, this is absolutely left to your discretion. If partners agree, then we don't have a problem. Okay, done. Registration of changes in partners, which we saw now, 15 days or 30 days of change, you need to communicate to ROC. Extent and limitation of liability of LLP and partnership, no mutual agency. We saw this, no. There is no mutual agency. You cannot hold or you cannot bind the partner personally. You can only bind the LLP. And for anything done fraudulently, people, you will be unlimitedly liable. But if you are doing everything within the authority, then LLP will be liable for it. If you are doing anything out of the authority, LLP will not be liable for it. Agreed? Extent of liability of partner, not personally liable. Agreed? Yes. However, it will not affect if he has done anything wrongfully. But a partner shall be personally liable for the wrongful act or omission of any other partner of the LLP. Agreed? What does it say? Read. This section shall not affect the personal liability of a partner for his own wrongful act. What is a first statement? It says a partner will not be personally liable. Personally means once I have put in my capital amount, that amount is gone. That's all. Rest of the amount I will not pay from my pockets. However, this rule will not apply to in the second case, it seems. When if you did something wrongful, if you only did a wrongful act, then you will be personally liable. We cannot save you. But a partner shall not be personally liable for the wrongful act of any other partner. That is what I told. That partner who did the mistake will be liable, not all the partners. Agreed? Okay, doctrine of holding out. What do you mean by that? Imagine people, there are three partners. In the partnership firm, there is one manager also. The partners introduce this manager to the ICICI bank as a partner only. Even though he is a manager, they introduce him as a partner. So according to the ICICI manager's eyes, this person is a partner only. Now, this person, Mr. T, had an opportunity to say, no, sir, these three people are lying. I'm not a partner there. I'm a manager there. But he said he did not agree. He also went with the flow. He also said, yes, sir, I'm a partner only there. Now, imagine people, if anything happens to this contract, remember, whether this contract ends up in loss, you will be liable. Whether this contract ends up in profit, you will be liable for that also. Meaning you will get that money also. And remember, sir, there was one more bank called HDFC. With them also they did a contract. Whether was this person introduced as a partner with HDFC? The answer is no. You were introduced only with ICICI. Sir, HDFC's contract, you earned a profit here also. Will D get a profit there? The answer is no. Wherever you are introduced, only you are entitled for profits coming from that place. Agreed? Yes, sir. Done. That is your doctrine of holding out. Unlimited liability in the case of fraud. We have seen if you do fraud, you are unlimited liable. So there is no limited liability after that. Agreed? Whistleblowing mechanism. What is a whistleblowing mechanism? Whistleblowing mechanism is nothing but, imagine you see some unusual activity. You means who, sir? A partner can see, an employee working in LLP can see, or any other person can see that there is a mistake that is happening. So you guys can go and intimate to the courts or to the tribunals, and you can go and report that, sir, you know what, this partner did fraud, sir, I saw, this is the evidence, take. People, after you giving the evidence, if it is proven that yes, this partner or this LLP has been doing some fraudulent activities, now this process, whatever you told, meaning you intimated others know, you drew their attention, you made sure that they are seeing at this scenario. This process is called as whistleblowing. Whistleblowing is nothing but getting the awareness, or you are telling the other people to look at the scenario, what is happening. So now we have a fear. Imagine an employee went and reported against the partner. Now you will remove this person, you will demote this person, you will put him in the night shift. No, so remember people, this is called as safeguarding against the victimization. Meaning you cannot do anything which is harmful for him. Meaning like suspend, demotion, reducing his salary, threaten him, all this cannot be done. You cannot harass him, things like that. Understood? This entire concept is called as what people? Whistleblowing. Contribution is nothing but capital only. Whatever you guys are bringing in, you guys can bring in you can bring in money, you can bring in movable property, you can bring in immovable property, everything. You can be bringing tangible, you can bring intangible, anything. Okay, financial disclosure we saw now. Annual returns. So penalty you guys want? Sir, power of registrar to obtain information. It's nothing but people at any given point of time. Registrar thinks that he needs some information. He can take the information from the partner or the designated partner or the employee of the LLP. If at all any summon is given to you, it is your duty to coordinate and cooperate. Correct? That is what is completely given here. You want to see one, sir? That's all. Should we go in detail? Okay. Next one is people, compounding of offences. Important from my point of view, you can expect a question here. What do you mean by compounding of offence? First of all, people, an offence can be classified into two things. One is called as people, civil offence. Next one is called as criminal offence. Civil offence means something which deals with only fine. Criminal offence, people, will be fine and jail, that is imprisonment, or it will be only jail. Basically, where going to jail will be mandatory. Those offences, now there are two types of offence. One is called as fine, that is only civil, and next one is criminal, where you are going to jail. So, whenever you know that you have done something wrong, now what is the complete procedure? The court or tribunal will start the investigation. They will prove that you have done the wrongdoing. After being proved, then you will be liable. Sir, if you know you have done a mistake, you can only go and accept, that you have done a mistake, where you are only going and touching the feet and you are saying, sir, money cheating is, sir, I only did everything. You are accepting everything with evidence. In such case, people, court will appreciate you. Sabash da. Why, sir? You are saving court's time. Why else? People, you are saving court's money also. They also have to pay to the public prosecutor. Money has to be paid. No, you are saving everything. No, the benefit will be given to you only. Now, this is only called as what people? Compounding. Compounding means people compromising. A LLP can go and compromise their offences with the courts. They can go and accept the mistakes. Sir, I did a mistake in January. I went and accepted. I did a mistake in March. I went and accepted. May. Day, atte mane nenadu. Whenever you want, you'll come. Can it possible? They're telling you, Macha, remember, if you do it once for the next 3 years, you cannot go and compound. There is a cool off period. Once you compound your offense, people, for the next 3 years, you cannot go and compound. What if I'm doing another after 3 years, sir? We will appreciate you. Once in 3 years, it's okay. So once in 3 years, you can come and go. So once in 3 years, you come. Next 3 years, again, if you do any mistake, it will be treated as a fresh offense. You can compound it. Clear? Accounting to me, important, remember. Nothing contained subsection shall apply to an offense committed by LLP or its partner or designated partner within a period of 3 years from the date on which similar offense committed by him or was compounded under this section. After that, people shall be made to the registrar. Where is it? Second or subsequent offence after the expiry of period of 3 years from the date on which the offence was previously compounded shall be deemed to be the first offence. 3 years will start from the date of order passed by the authority, compounding order. From that, 3 years will start. It's not from the date of committing the offence. Clear? You can do. Same offense, you can do. You can try section 2 this year, section 3 next year. Where any offense is compounded before institution of any prosecution. Simple, people. Imagine you went and compounded before the ROC or any authority even started the proceedings. If you went and compounded, then people, they will not start the proceedings at all. If at all you went and compounded after the initiation of proceedings, then people, they will drop the proceedings. Clear? Yes, sir? Pakkana? See, where the compounding of any offence is made after the institution of any prosecution, such compounding shall be brought by the registrar in writing to the notice of the court in which prosecution is pending, and on such notice of the compounding offence being given, the offender in relation to which the offence is compounded shall be discharged. Clear? Yes, sir? You need to intimate to the registrar once the compounding order is received. You need to intimate within 7 days. That is there. Within a period of 7 days from the date of offence, so compounded. Okay. Next one is okay. Assignment and transfer of partnership rights. What is this, sir? Whether can you transfer your share to someone else? Possible. No one can stop you. So wholly or in part, you are free to do. No one will stop you. Clear? Next one, conversion we saw na. Foreign LLP. Compromise arrangements and or reconstruction of LLP. What is compromise arrangements and reconstruction? Compromise arrangements, people, simple. Let us imagine a LLP has taken some loan from a creditor. We are not able to repay. Now in this case, what happens, people? We took 10 lakh loan from them. We are not able to repay. You will call them and you will make them understand the scenario. Macha, there is one very tight scenario. What is that? We have taken loan, no, that we are not able to repay. Now what to do? Creditors can do two things. One, get angry. And they will say, hey, come to court, I will look at your thing there, come, I will not leave you. Obviously, that is how they will get irritated. Correct? Next one, creditors will understand. Even if I go to court, nothing will change. Because business loss is a business loss. I cannot recover. So second scenario, the creditors will try to understand what the LLP is trying to say. They will say, see, totally you have given us 10 lakh rupees. You have to let go. You have to write off 2 lakh. In our balance sheets going forward, we will show it as only 8 lakh. Now with this, it's a presentable balance sheet. We will go to some banks. We will go to few investors. We will raise money. Let us try to build the business. If you don't agree, the only way you have is go and file a case on us. Let us wind up. Whatever you will get, you will get. You might not get even 1 rupee also. This is the only option available to you. If creditors understand this game, they may agree to this, and this is only called as what people compromise or arrangement. Sir, how many people should agree, sir? Important majority number 3/4 in value. The same thing can happen also with regards to partners also. You might have taken money from partners. You have to reduce the amount taken from partners also. Same thing will apply there also. 3/4 in value, majority in number. What is the majority number? Imagine totally there are 10 creditors. 6 creditors have to agree. And imagine total 10 creditors. Totally they have 10 lakh rupees. That is what you need to pay. 3/4 in value. At least 7.5 lakh worth people have to agree. So 6 people holding 7.5 lakh worth people, you need to get the majority. Why is this? To avoid one strong holder taking the decision. Imagine in this one bank only had given 8 lakhs. Possible, yes, sir. To avoid such scenarios, we say majority number also. Clear? Understood? Okay. So once you pass that order, say you are accepting the order, that is accepting compromise or arrangement. Technically, what you will do, people, compromise or arrangement. First, technically, what will happen? Any LLP, any creditor or any partner, you guys will file any LLP, creditor, partner, or if the LLP is in the stage of liquidation, then liquidator, they will file an application to NCLT. Sir, this is the case, we need to compromise or we need to make an arrangement. NCLT will tell you to conduct a meeting. You will conduct a meeting of either creditors or partners. In the meeting, if at all the decisions has to go through, you need to make sure you get a majority in number plus 3/4 in value. Once the meeting decision is taken, you need to forward the outcome to NCLT. Once you get the order from NCLT, now this you will forward it to ROC. Agreed? This is the complete thing. Sir, now ROC, NCLT has agreed to whatever we have done. So he has passed the compromise or arrangement order. In the next section, NCLT has a right or he has a power to supervise his entire provision. At any given point of time, NCLT feels your compromise or arrangement is not happening according to the order I passed. NCLT may pass an order of winding up. Or I might even make modifications to the plan as well. I hope you guys understood the complete scenario. Is this clear? Pakkana? 100%? Okay. Power of tribunal to enforce compromiser. You have a power to supervisor and you may make any modification. If it is not working out, then you may also pass an order for winding up. The next section 62 people talks about reconstruction or amalgamation. Meaning, sir, let us imagine 2 LLPs want to come together, they want to merge. Or let us take one bank had given a loan to another LLP. LLP is not able to repay the loan. Now people, one bank wants to take over the LLP. Now again there is an amalgamation happening. Now in this case, people, the third section will come into picture. The third section is only called as section 62. Now in section 62, what happens? Which one? 1 second. Only an audible, Ada? Audible? Yes, okay, done. Sir, in section 62, what happens, people? Imagine an application is made for amalgamation of 2 LLPs. And where are you making an application? You are making an application to NCLT only again. Now you are making an application for amalgamation. Now NCLT, after considering the entire scenario, people, NCLT will pass the following orders. What is the orders? Now let us imagine there was old LLP and it is getting merged to new LLP. In the order passed by NCLT, in the order, it will make provision for all of this. What is that? All the assets of the old LLP will become the assets of new LLP. All the liabilities of old LLP, new LLP. Whatever are the pending cases or litigations, everything will continue in the name of new LLP. Agreed? Majorly these things were there, and after everything is passed, you may wind up the old LLP as well without dissolution. Meaning no liquidation process happens. After you transferred everything, then what is pending? Dissolution without winding up. Basically, I'm telling you, there is no liquidation that happens because there is nothing present. You have transferred everything. Agreed? Yes, sir. Okay, done. Winding up and dissolution. Okay, winding up and dissolution, that's your almost technically the last part. Winding up and dissolution of a LLP can happen in two ways. One is voluntary. Whenever you want, you do it. Next one is by tribunal's order. How will it happen in tribunal's order? If at all the LLP goes and decides based upon the majority, you guys go and appeal it in tribunal. Tribunal may pass a winding up and dissolution order. People will have a question, what is the difference between voluntary and LLP decides? Voluntary, if all of you agree, very smooth, don't go to NCLT at all. But what if there are 5 partners, 3 are okay, 2 are not okay, you guys may come under this part. So next one, sir, number of partners reduced below 2. We have seen this, 6 months. Beyond that, unlimited liability as well as this. LLP is unable to pay its debts. Basically, perpetual. LLP acted against integrity and sovereignty of India. Default in filing statement of accounts or annual returns for 5 consecutive days. Just an equitable grounds. Just an equitable grounds, nothing but any other ground which NCLT feels right. Agreed? Applications of provisions of Companies Act, nothing but we can make sure whatever the central government may by notification official gazette direct that any of the provisions of Companies Act shall apply to LLP as well. They can make a order and they can make a provision. Not there in our syllabus, people, they have actually made a provision also. Now beneficial ownership and SBO provisions are also implemented to LLP as well. Recent amendment in December 23 they made. Not directly in our syllabus, but remember, it is there. Clear? Ben 1, Ben 2, Ben 3, Ben 4. You remember? Ben 1, Ben 2, Ben 3, Ben 4. Provision, even the words also won't change. Same thing. Now it is called LLP Ben 1. LLP Ben 2, LLP Ben 3, LLP Ben 4. Same thing. Clear? Yes, same thing. Everything is being implemented. Payment of additional fees. What is this, sir? Now in the act, if at all they have said you have to file certain form within some time. If you do not file it within that time, they may give you a provision to file it beyond that also by taking some additional fees from you. The additional fees may be different for different class of companies. Meaning small LLP, it might be less. Big LLP might be more. Enhanced punishment, meaning whatever, wherever it says penalty and punishment, first time we have a discretion of giving you lesser penalty also. But if you are coming again and again like Attemane, second or subsequent offense, even the penalty can also be twice the amount of penalty mentioned in the section as well. Yes, sir. Whether we complete your LLP. Any doubts, sir? No? Okay. Any doubts, sir? Okay, so after this, people, let us come to your next one. Let us do FEMA. Okay. Let us start with FEMA. Yes, all of you. Then now, according to me, sir, why everything according to you? Legally challenging it will become. Residential status, promise on you, there will be a question. And pakka means pakka, there will be a question. Residential status. Current account transactions, there may be a question. Which one? Current account transactions. Prohibited transactions, so Nepal, Bhutan, somewhere there, lottery, somewhere there, pay more attention, there may be a question. And current account transactions only, wherever we have seen donations made by other than individuals. Other than individuals, LRS limits. There also there can be a question. We'll see when we are doing that. Clear? Yes, sir. Okay, once again. Okay, we'll start. So, sir, foreign exchange management people, very important from your exam point of view. I expect the maximum questions to come here also. So, what is Foreign Exchange Management Act, sir? We wanted an act which could revolve around the foreign exchange transactions that are involved and any transactions that happen between two countries. It can be exports, it can be imports, it can be various monetary transactions, you investing abroad or you buying securities abroad. Everything will be covered under your FEMA transactions. Now, in FEMA transactions, sir, the first thing you need to understand is okay, extent and application, person, resident India, definitions. Okay, we'll start with definitions. Okay, first thing, sir, authorized person. Who is an authorized person? Simple. Now we are in India. You are in India. You want to get your dollars. Now, whenever you need dollars, people, you cannot go and get the dollars from wherever you want. You can get the dollars only from few people. And who are the few people? RBI says, I call these few people as authorized persons. Why are we calling them as authorized person? Because RBI has authorized them to deal with foreign exchange. And who and all can deal with this foreign exchange, sir? The authorized person can be of three types. One is called as people, authorized dealers, money changers, offshore banking units. What do you mean by authorized dealers? Technically, authorized dealers will be, generally it will be banks. Always, sir, for us, most of the cases it is banks. Next one is called as people money changers. Who are these money changers? You will see these private companies. If you go to any malls, posh roads and all, you will see a board put up. Foreign exchange will be done. You guys can give and there will be one scrolling LED will be going on. Today, $1 is equal to 82 rupees. One scrolling will be going on. They are called as what people? Money changers. Offshore banking unit means people nothing but an authorized person which is set up in SCZ. If at all offshore banking unit is nothing but people, an authorized person which is being set up in SCZ will be called as what people? Offshore banking unit. It's end of the day bank only. Agreed? Capital account, current account, currency, current account transaction we'll see. Currency includes everything. Foreign currency. What is foreign exchange, sir? Foreign exchange means foreign currency and includes. So foreign exchange. FEMA, no, Foreign Exchange Management Act. What and all will come under foreign exchange? They're telling currency will come, obviously. Foreign means foreign currency and it includes. Hey, if you remember your interpretation of statutes, means and includes. What do you know means? Means is people restrictive definition. If at all includes is there people, you guys can extend. Agreed? Means and includes both are there. Means and includes both are there, no? You need to treat it as restrictive only. You cannot add more to it wherever means is given. Once means is there, that's all. Clear, huh? Okay. Sir, it includes what and all? Any deposits made. From here, you're opening a, what is that? Foreign currency account. A foreigner opens an Indian bank account. It is still coming under FEMA only. Okay, next, credits. Basically, loans taken. Balance payable in any foreign currencies. Next one, drafts, traveler check. I told you what is traveler check. You go and you give Indian money. Now, for example, certain people carry money only, converted bills. To be more safe, you get something like a checkbook. You know, for example, I will go to Indian Bank, ICICI Bank. I will go and deposit some 1 lakh rupees. He will give me an equivalent checkbook, which I can just tear it and pay in the outside country, not in India, because it will be denominated in dollars. But how am I getting? I am getting it by giving rupees. So I am getting a checkbook here, which I can go and spend there. The checkbook you are getting is called as traveler's check. Letter of credit, your transactions, bill of exchange. I hereby promise solemnly that I will pay you money, Mr. Ninganna, next 3 months after sight, whatever you are saying. That is called bill of exchange. Promissory notes, checks can come here. Expressed or drawn in Indian currency but payable in foreign currency. Drafts, traveler check, letter of credit, same thing. Bill of exchange, drawn by banks, institutions or person outside India but payable in Indian currency. What do you mean by that, sir? I've given Indian currency, I've purchased this, but you can encash it by giving it in outside India. So basically you are getting the book by giving Indian currency, but you can actually pay it for dollars. So if you are giving one currency and getting another currency book, same thing happens there also. Imagine a person, tourist is coming to India. He will buy one traveler's check from US. He gives dollars and buys one book which is valid in India. That is also called as foreign exchange only. Understood, all of you? That's what is mean. What is the meaning of this? See, expressed or drawn in Indian currency but payable in foreign currency. So it is expressed in Indian currency, but how did he pay? It is paid in foreign currency. Correct? Huh? Okay, some practice questions we have seen. Foreign security is nothing but anything which is given by out of India. Person resident out of India. Person includes a big repatriation. Okay, let us directly go to residential status. Huh? Okay, residential status people. Now try to understand people. To understand what is a residential status, first of all, you need to know there are two kinds of people, increaser, decreaser. There are two types of people. The two types of people are people. There is one person called as PRI, the other person is called as PROI. A person resident in India, a person resident outside India. Who will be called as a person resident in India? There is a condition that is satisfied. If you satisfy this condition, you will be called as a PRI. If not, you will be called as a PROI. Now, what is that condition? Straight away, first one condition is there. Condition number one. Who will be called as a PRI? The person who has stayed in India for a period of more than 182 days will be called as a person resident in India for the current financial year. Again, I repeat, if I have to decide a residential status on a normal basis of any person, the first criteria is a person should have stayed in India in the previous financial year for more than 182 days. So straight away directly think as 183 only. He should have stayed at least for more than 182. So 183 I'm just taking it. So if he has stayed for more than 182 in the current financial year, his status will be called as PRI. The second thing people, when you are solving this residential status, try to make sure this has nothing to do with residential status. From where you are, meaning which citizen you are, is nothing to do with residential status. A Indian citizen can be called as PROI also. A foreign citizen can be called as PRI also. Both are possible, both are allowed. Agreed? Pakkana? Okay. Third condition, sir. Sir, who is called as PRI? We clearly saw a person who has stayed in India for more than 182 days in the previous financial year is called as PRI. But from this definition, they are excluding certain categories. Correct? Now, people, I'll tell you one thing. When you look at the normal law, if you directly look at Bare Act, people, nowhere it is written that preceding financial year, current financial year, this and all, nowhere it is written. This is just the interpretation, IOS, interpretation of statutes. If you look at it, entire industry has followed this, that's all. But if I show you the Bare Act, it is not written. Previous year, current year, it is not written. Agreed? Okay, understood? Yes, okay. Now, simple people, try to concentrate. Now, in the PRI definition, if at all a person has stayed for more than 182 days, in the current financial year, we were calling him as what people? PRI. However, let us imagine whether he has satisfied or he has not satisfied. Whether he has satisfied or he has not satisfied. But in the current year, if at all he has done any of these things, what is that? In the current year, people, if he has gone out of India, meaning what, people? Let us take in the year 2023-24, this person has stayed for 190 days in India. But in the year 24-25, in the year 24-25, a person who has stayed for more than 182 days in India in the last year, but in this year, people, he is leaving India and going. If he is leaving India and going, now the first question they will ask you, what? Why is he leaving India and going? For what purpose he is leaving India going? If he is going for these three purposes, what are those three? Is he going for employment? Is he going for any business or vocation? Any special skills? you're learning some artist, you're going for such thing, or you're going for any other purpose. The intention of stay, you do not know. How long you are going to stay, you do not know. Are you going for these three purposes? Then people, they are telling you will be excluded from the definition of PRI. You will be considered as PROI. Understood? Pakkana. What do you mean by that, sir? In the year 24-25, he will be considered as PROI if he is going out of India for those three purposes. If you are going out of India for any purpose other than these three, you will be considered as PRI. Why? What does the definition say? From the PRI definition, the following people are excluded. Who? The people who have gone out of India for this purpose. What if you have gone out of India for any other purpose? You are not coming under the list. So you are included in PRI definition. For you, only thing, if this is not understood, just to remember this in short. For the above purpose, if you have gone out, you are a PROI. If you have gone out for any other purpose, you are a PRI. Now, sir, there is one more question that can come in the exam. When, sir, Namudga, will he go directly on 1st April 2024? He may go out of India on 1st August 2024. Now, in this case, what do you want me to do? Remember, in the previous year, he has satisfied the condition. So, from 1st April 2024 to 1st August 2024, he is still in India. He has satisfied previous year condition. He will be considered as PRI. He is leaving India when? 1st August 24. Remember, this is your ICAI interpretation. According to your institute's interpretation, they say the day you leave India, you need to consider him as he has stayed in India on that day. So your flight is going on 1st August. You're in aeroplane, you're still under India ke under hai. They're telling you 1st August is still considered as PRI only. So you left it today, next day from 2nd August you will be considered as PROI. That too when? If it is for those three purposes. Now people will be asking me for, can you give an example, sir, for anything other than these three? Anything other than these three. You went for trip, casual trip, you will come for any other. Then you will be considered as PRI only. Example, there is a person who was working in Infosys, say for example India. He got a promotion. He got an opportunity to work for Infosys New York. He left India on 1st August 2024 for employment. From 2nd August 24, for what purpose he has gone? For these three purposes if he has gone. Employment, no. He is excluded from the definition of PRI. So this person will be considered as PROI. Say whether you understood or not. Pakka macha, promise on me there will be a question. Yes. There is one RBI circular only. What is that? People started asking, what if people have gone out of India for educational purpose? What if they have gone for educational purpose? Then remember, there is a RBI circular. RBI consider it as people who go abroad, they will also work abroad. Condition number one. Second one, people who go abroad, immediately finishing their studies today, tomorrow they will ange bandbittare. No, they won't come. They want to earn something and come back. That's the reason on these two grounds, the person who have travelled outside India for education, RBI circular and clarification says he is considered as PROI. When they're asking you a question on a student traveling abroad, you will write it as RBI clarification. You guys can have a question now. You will ask also, what if a foreign student is coming to India? Unfortunately, RBI has not given any clarification on this. Then you need to apply these three rules only. Is this clear? The left side is clear? Okay, right side, sir. Person who has come to stay in India not for taking employment to do business or occasion. So people, you saw first PRI definition. In the PRI definition, they are telling following people are excluded. Who are the following people? They are telling a person who has come to India not for this is excluded. If you have come to this, If you have come for this purpose, you are included in the PRI definition. Wonderful. Understood? Again, I'll repeat. What have they said? From PRI definition, two people are excluded. Now I'm looking at the second category. If you have come to India otherwise than for these three purposes, if you have come to India for any other purpose other than these three, they are excluded. Other than these three are excluded. If you have come for these three, included. In what? PRI definition. If that is confusing, directly go to in short. For the above purpose, if you have come, you are a PRI. If you have come for any other purpose, PROI. Other way to remember, if our person is going for employment, we have treated him as PROI. That means Goda, you belong there. In the same way, when they are coming here, we tell you belong here. Understood? PRI, pakka na. That is called PRI, PROI. Is clear? 100%. Correct. Yes, any doubts here? No doubts. Okay. Now, people, one more thing, people, concentrate on this part. What is that? Your book has this chart. In this, there is one good information. What is that? Let us try to see what is given by your institute material only. No, that is not there. Just take one picture if you want. It is there in your ICA module. Just take one picture. Say material only. Yes, Now see this interpretation. Let us try to answer whether what we have done is correct or not. Yes, Now imagine, people, during the relevant previous year, did he reside in India for more than 182 days? Let us imagine yes. Did he go out or stay outside India during the current year? The answer is yes. Let us imagine he has gone out of India. Now I'll ask you, for what has he gone? Has he gone out for these three purposes? If the answer is yes, so he is excluded from our category. He'll be called as PROI. He has gone for three purposes. Yes, PROI. Has he gone for those three purposes? No. Then he is called as PRI. Sir, in the current year, has he gone out at all? Answer is no. Then he is considered as PRI only. Done? Simple. Okay. Now see, this is very good. Sir, the person has not stayed in India for more than 182 days. But in the current year, sir, did he come to stay in India? The answer is yes. Why did he come to stay in India, sir? Did he come to for those three purposes? The answer is yes. The person will be called as PRI. If at all the person is coming to India for any other purpose other than three, it will be considered as no, PROI. Sir, did he come or stay in India during the current year? The answer is no. He'll be considered as PROI. Sir, what is that? You said it is peculiar here. This condition is peculiar. What do you mean by that, sir? Technically, what do we see, people? In the preceding financial year, if he has stayed for more than 183 days, in current financial year, if at all he is coming to stay in India for those three purposes, then we were calling him as PRI. Correct? Agreed? Yes, but this interpretation of what it says, whether he has stayed in the previous year or not, this is applicable for a foreigner even coming to India for the very first time. Let us imagine, sir, try to understand, very important, in the year 2023-24, I repeat, in the year 2023-24, a person who is a citizen of US is coming to India on 1st April 2023 for employment purpose for a very first time to India. Previous year he has not come. But why is he coming, people? He is coming for employment purpose. Previous year condition is not satisfied. He has satisfied current year, coming for employment purpose. He will be considered as PRI. Understood is one thing. What is that, sir? Just to make sure to understand is one thing. When a person is coming from abroad to India, if he is coming for those three purposes, don't even check the preceding year whether he was there in India or not. Understood? Got this understanding? All of you? Pakka? I hope online this is clear. Yes, all of you? Yes, that is one thing. This is the peculiar interpretation. All of you? Understood? Let me know if you want, I can repeat also. Is there any doubts? Again, I'll repeat. Technically, I will consider this way. There are two types of people. The person who has always stayed in India, the person who has stayed outside India. The person who has stayed in India, now this person obviously will be satisfying 182 days previous year condition. And in the current year, if he is going abroad for those three purposes, he will be treated as PROI. If at all, I mean, if he is going for three purpose, PROI. Any other purpose, he is PRI. Now let us imagine there is a foreign citizen. If the foreign citizen is coming to India for a very first time, and he is coming for those three purposes, they are telling you even if the preceding year condition is not satisfied, he will still be considered as PRI only. Understood? 100%? Pakka na? Okay. That's all. That's one thing which you guys had to remember. Okay. Next one, sir. There is a residential status of other than individuals may come. Meaning, if at all I have to decide a residential status of companies, branches, how do I decide a residential status, sir? It depends upon if any person, body corporate, is incorporated in India, meaning LLP company directly registered under Companies Act. By default, you are a PRI only. So there can be another scenario. A company is, we'll see that, an office or branch or agencies in India which is owned or controlled by PROI. Meaning what, people? There is a company which is situated outside India. They have an office, they have a branch, they have an agency in India. Like our foreign company definition. The foreign branch will be considered as what, people? PRIA. Correct? PRI only we are seeing, no? Next one, sir. Office, branch, agency outside India, owned or controlled by PRI. A person in India is controlling something outside India for our purpose. Even that is also considered as PRI only. Understood? Pakana. So a body corporate or a company registered in India, you are a PRI. A company registered outside India, they have a branch in India. Who controls, who owns, forget. You have a branch in India, you are a PRI. Sir, registered office, everything outside India, meaning the office, branch, agency, everything outside India, but the control is from India. Then even the company, office, branch, agency, whatever is situated outside India will also be called as PRI only. It's clear? Pakkana, 100%. Okay, done. Remember that. Just an example. Imagine a company is incorporated in Australia. The branch is in Canada. Is it a PRI or PROI? Obviously PROI, because control also outside, agency is also outside. Company registered in Australia, the branch is there in Mumbai. Office, agency or anything in India, controlled by PROI, will be considered as PRI only. Chennai, PRI only. Clear? Done. Next one, sir. There are two types of transactions. Okay, before that, let us do the first section of Emana. Resident but not permanently resident, the person who has come to India and stays for not more than 3 years. Sir, there is something called as resident but not permanently resident. Who is that person? A person resident in India. He has come and residing in India, it seems. For what has he come? He has come for employment or job or any assignment. But this person stays in India for not more than 3 years. This person will be called as resident only, but not permanent resident. What is the significance? In one place it will see what is the maximum amount he can send abroad. For us, LRS limit is there. For this person, LRS limit does not apply. He can send his entire salary because his family will be staying abroad. Except if he is not resident of, citizen of Pakistan. Correct? Okay. Yes, okay. There is one important section. Not sure whether directly if they ask you for the very first time. Dealing in foreign exchange. Section 3. Section 3 is very important, sir. They say, if at all you are dealing in foreign exchange, certain things, they have given some peculiar things. What is that? No person shall deal in or transfer any foreign exchange or foreign security to any person not being an authorized person. What do you mean by that, sir? Imagine people, just now, Siddhartha, he came from US. He finished his, he went for a trip. Where are you going to? Thailand. Bangkok? Okay. So people, Siddharth just came from Bangkok, it seems. Now Siddharth has having people still $1,000. Siddharth was explaining his experience to Gokul. Macha, I just came from Bangkok. Gokul said, hey, attempt matta bata, I'll go to Bangkok. Now Gokul also wants to go to Bangkok. Now Gokul knows that he has to pay everything in dollars in Bangkok. Where will he get dollars from? Siddharth says, hey, I will only sell Kamda. RBI people came and hit Siddharth's hand like this. Why? Because of section 3. What does it say? No person shall deal or transfer any foreign exchange to any person not being an authorized person. Is Siddharth an authorized person? Sorry, is Gokul an authorized person? No. You have $1,000 left. If you want to go and exchange it, you need to go to authorized person, banks, money changers. Give it, get the money back. I told you in the class also logic. Why? Now Siddhartha might charge some commission. Today's date can be $1 is equal to 80. He will say, hey, you need to go there in auto, cab will not come first, second, third time. Oh, I'm reducing so much tension in your life. Give me 82 rupees, da. Give me 82 rupees. Instead of 80, give me 82. If I let this happen, people, you are only increasing the inflation. $1 at least is now 80. You are making it 82 by creating a black market. Not in a good favor of the country. That's the reason it is not allowed. Clear? Done. Next one. Make any payment to for the credit of PROI in any manner. Meaning what, people? Let us imagine Siddharth is in Bangkok. Siddharth has to pay some payments in India. What is that? Imagine he wants to pay that CA admission fees. Now Siddharth was opening his website and he was using his International American Express card. India was getting dollars. It was about to get Gokul called. Hey Siddharth, I am there now. Why are you paying? I will pay on behalf of you. RBI came and slapped. Why? When dollars as it is coming in India, why are you stopping the? Meaning what? You are not supposed to spend anything on behalf of a PROI. Because it's a gateway. We are getting in dollars. Don't stop it. That's what is the second one. Third one. Receive otherwise than through an authorized person. First one we saw from Siddharth's point of view. Second one you are seeing from Gokul's point of view. If you want to receive any money, you cannot receive money from any other person. You have to receive only from authorized person. He cannot sell it to any person other than authorized person. Same thing. Agreed? Agreed? Enter into any financial transaction in India as consideration for in association with acquisition or creation or transfer of right as otherwise provided. As general or special permission. What is this? Enter into any financial transaction for or in association with acquisition or creation of transfer of right to acquire any asset outside India. The above transaction, this is nothing but people in the class I had given you a big example. This is nothing but people called as Hawala transaction. In example, we had seen Shivaji. What is this, people? You cannot give anything in India and you cannot get something in US. This is not allowed. Meaning lawfully convert it into dollar. You should not do, like for example, imagine Siddharth wants some dollars. People do it. I'm still telling it will not happen. Siddharth has relatives abroad. Siddharth's uncle has settled abroad. Now Siddharth's uncle has settled abroad. Correct? Siddharth's uncle. Gokul wants to travel abroad. Technically Gokul wants dollars. How should he get dollars? He has to go to authorized person, convert and take it. Instead, what is Gokul doing? Gokul is telling Siddharth, Macha, take da, I'm giving you 10 lakh rupees here. I will go and convert this money, your uncle, tell your uncle to give 10 lakh divided by 80 rupees. How much ever it comes, let him give me dollars. So I'm giving it here, I'm taking the money there. This much is Hawala transaction. If they get to know, slap alla kicko. Illegal it is. Understood? Pakkana. All the examples was given here. Agreed? Okay, done. Next one, sir. Holding of foreign exchange, meaning except as provided in this act. Meaning this entire act says how to buy, how to sell, how to convert currencies. If you do anything apart from how it is given in the act, it is not allowed. If you want to do according to the act. That's all. Done. That's your section 4. Section 5. Currency, current account transactions. Okay, people. Transactions in foreign exchange can be of two types. One is called as current account transaction, one is called as capital account transaction. What do you mean by current account transactions? Current account transactions means, people, it means those transactions other than capital transaction and includes payments for. Imagine if you are importing something, you will pay foreign trade. Short term banking will come here. Long term will go to capital account transaction. Remember that. Short term is anything less than 6 months. Interest on loan. Loan is a capital account transaction. Interest on it is a current account transaction. Income on investments. You made investments in equity. Netflix. They are giving dividend. Current account transaction. Investment. Capital account transaction. Correct, Noda? Remittance for expenses of parents. Your parents, spouse, children, bank girlfriend. So all of them staying abroad, you're taking care from here, no? So they're telling all these expenses are also considered as current account transaction. Foreign travel expenses, you go, no? Education, medical expense, taking care of children, no, parents, so everything will be considered as current account transaction. So our current account transaction, people, to understand better, we need to know 4 things, people, under current account transaction. What are these 4 things? One is called as Rule 3 of current account transactions, Schedule 1, Schedule 2, Schedule 3. These 4 things is very important. Very, very important. Exam may promise one question will be there. Okay. Now, what do you mean by current account transaction rules? Rule 3 of current account transaction rules 2000. Yes, sir. Now, what does it say? Sir, Rule 3, Schedule 1, Schedule 2, Schedule 3. Correct? Rule 3 and Schedule 1 talks about the same. What is that? Prohibited current account transaction. You are not supposed to make it. What are those transactions? You cannot take foreign currencies for these purposes. What is that? First, Rule 3 says, if you are traveling to Nepal, Bhutan, you are not supposed to take foreign currency. Why, sir? Because Indian currency is accepted in Nepal and Bhutan. Next one is transactions in Nepal and Bhutan. One is for travel, bus ticket, air ticket, you can pay in Indian currency only. Next one is, you want lace packet there. Lace, chips, kurkure. You should not pay in dollars, mujhko 10 rupees note kadi. Meaning 10 rupee note is accepted there. 10 rupee note only can be allowed because it is accepted. It's clear? So you cannot take dollars for these purpose. Exam may, I think they may ask you from this only, Nepal or Bhutan. Next one, people, Schedule 1 now. Now, Schedule 1 we are coming to. Rule 3 said Nepal and Bhutan. Next one is your Schedule 1. Schedule 1, you cannot take foreign currencies, cannot come also, cannot go also. So, our Schedule 1 says, first of all, lottery winnings. What is lottery winnings, sir? If at all you come to India, you scratch a lottery ticket, you got lottery, you cannot take the money abroad. Understood? Yes, sir. I think lottery is also one of a very good possibility of asking a question. Remittance of income from racing or riding it. Yes, sir. MotoGP, F1, no. They, whatever you earn. End of the day, what they are telling you, people, imagine there is horse race transactions. Imagine there is any ridings, if there is any racings. If you win any money out of it, I am not telling you earning is illegal. I am telling you, you earn. Imagine Faf du Plessis came to India. When anyways he is there for a year, for 2 years, he took one lottery ticket. He won lottery. How much? 1 crore. Is it illegal? I am not saying illegal. But Faf Anna, please spend it here Anna. You are not supposed to take 1 crore to your country. Why? Earned here. Bitty money. I told you how we started FEMA. For us, foreign currency, hundi. Very, very important. You cannot just for this and all, you cannot reduce the hundi. Agreed? Okay. Next one. Remittance of purchase of lottery tickets. Okay, sir. I'll do one thing. Now, our Ranna, King Kohli, Virat Kohli says, can I buy lottery ticket abroad? Give me some money. No. You cannot take money from RBI to invest in lottery tickets abroad. You cannot take money from RBI to invest in sweepstakes, football pools. What is football pool? IPL for football. Yes, sir. So sweepstakes, gambling only. Nothing but gambling only. Casinos. Sweepstakes in our country, there no Bhagyalakshmi bumper draw. Same thing in their country is called sweepstakes. Yes, sir. They dream big. Clear? Now people, what they're telling you, why? Logically think. If I'm allowing you to take money to invest into a gamble, Pakka you will win. Cup only we will not win. That and all we will win. Yes, sir. First, what is certain we will win. And then we will think about, sorry, sir, no. Controversy la. Namge cup isala cup namde. Yes, people. Next, so understood this one. Gambling activities, what we are seeing, money is not given by RBI to you to go and invest abroad. Next one, people, remittance of interest income on funds held in NRSRE account. What is non-resident special rupee scheme account, people? Simple. The first two letters says everything. Non-resident. Let us imagine, people, there can be a scenario. Siddhartha, now he became a CA, very renowned CA. He got an opportunity to work in Singapore. He went. Now, till today, whatever he has earned, he has 1 lakh, 5 lakh, 10 lakh rupees. According to the law of the country, if you go abroad, you cannot continue to hold your savings account. You need to go and inform your banker that, sir, I am no longer in India. I have become NRI. You'll not say Maga Macha, you'll say Maya Macha. You will change your tone and all, no, for 1 year only. Next year you'll go and say Macha Vada, signal problem. Correct? You'll say no, yes or no? What they are saying, you people, they are saying is, you need to go and inform your banker. You need to convert your existing savings account into another account called as non-resident special rupee scheme account. Machan, whatever is the money, imagine he has done a FDA. On that he will get interest. Born and brought up here. Money here. Interest, why will we give it there? You have to spend it in India only. That is the scheme. Understood? 100%. Nothing but interest on your account has to be spent here. Next one, sir. Payment of commission on exports made. What was this, sir? There was Rocky Bhai. Rocky Bhai sold some gold. He wanted to sell. Rocky Bhai is from India. Rocky Bhai is a gold merchant. So he is looking for some international transaction. So there is a person called as Mr. A. Mr. A is an agent. Where does he stay? He stays in Dubai. He gives a contact of one person, Inayat Khalil. He says, hey Rocky Bhai, I am giving you the contact of Inayat Khalil. He is willing to buy your gold. Okay, very good. Now Inayat Khalil people purchased the gold. He was about to pay the money. But Rocky Bhai said, hey, humko kya chahiye? Dunya. Correct, no? So what do you want? I want to become a CEO of what? Your company also. Meaning, whatever your company, do one thing, make me also a partner. Give me 50% of the stake of your company. Are you serious? Yes. He went into KGF to he became a partner. He became a CEO. Basically, this company became a subsidiary company of Rocky Bhai. Agreed, Now, what is the problem? It's your personal thing. No problem for us. Rocky Bhai came back to India and said, hey, RBI, this A is there, no? He's asking for some commission, because he is the person who gave me Inayat Khalil's number. He's asking me for some commission. So can you please give me some $1,000? RBI said, hey, Rocky Bhai, why will I give you, You had an opportunity to earn dollars and get back to India. You did not earn dollars. Instead, what did you do? You converted the money into equity ownership in that company. You did not get rupees, you did not get dollars back to India. If that is the case, we will not allow you to pay anything as commission also abroad. You did not earn dollars. You want to pay dollars. We won't allow you. That's what is given here. See, payment of commission to A on exports made by Rocky Bhai. Made towards, what did you get in return? You gave gold, equity investment in joint venture or wholly owned subsidiary abroad of Indian company. Understood? Okay. Next one. Payment of commission under rupee state credit route. In the exam I told, in the class we had seen, rupee state credit route is nothing but India has certain tie-ups with certain countries. Instead of exchanging foreign currencies, we have a right to settle it in our own currency. So the contract which we have entered, that route is called as rupee state credit route. Instead of exchanging dollars, you can accept the money in your Indian rupee only. The other way also, you can make the payment in their currency only. So that is how it works. Now that is route is called as rupee state credit route. Example, we have entered into such contract with Russia. So if at all you are exporting anything there, you will not get dollars, you will get rupees only. When you are getting rupees, imagine someone helped you to connect to that person in Russia. For commission also, people, we will not allow you. Payment of commission under rupee state credit route. You earn rupees, the commission also we will not allow you. It is your headache. Understood? But however, there is two exemptions. What is that one exemption? One is pufu pufu. Pufu pufu without tea is not a good combination. So they say pufu pufu and tea are an exception for payment of commission. Shubha, what and all we are teaching. I'm just giving example, da. Dhumapana, Madhyapana, except up to 10% of commission on invoice of export of tea and tobacco. I think this can also be an exception. I mean, they can ask you an exam question. What is that? Whatever is the value you guys got for selling tea or tobacco, on that 10% you can pay as a commission, it is allowed. Even if you got rupee, you can still go to RBI. You can get up to 10% as a commission from the RBI. That is dollars. Next one is payment related to callback services of telephone. I told you what is that callback service of telephone, wherein you give the nothing what people imagine. Foreigners are calling you. You will tell no sir, we will only call you back. Instead of we getting money, we are spending money back. This is not allowed. Or what you will do? At times what happens for us, ISD calls are very expensive. 18 rupees per minute, 20 rupees per minute. So what do we do? If we are doing now, for example, call centers, BPOs, if at all there are so many calls you need to do from India to abroad, it is becoming 20 rupees per minute. So what do? We do something called as bridge calls. So there are some countries, let us take for example Mauritius, Chile or Switzerland. So we will identify some country where the call rates are very cheap and we will outsource our department to this country. And from that country, what they will do, it's like a conference call. They will call us also, they will call the US country also, they will connect. And we will have to pay this country. It will not be as expensive as you paying US. Instead of you paying 20 rupees per minute, here it will be some 6 rupees per minute. They're telling we will not allow you to pay the 6 rupees also. Why? Macha, 18 rupees, directly you could have paid in Indian rupee. You will pay to Airtel. 6 rupees, you're still paying to Switzerland. It is still dollar. It might be good for your company, not for the country. Understood? Done. Schedule 1, Rule 3. Any doubts? Any doubts? No. Now very less only, no? Because of internet, online calls only happens. Sir, any other doubts, sir? No, sir. Now people, next one is Schedule 3. Schedule 2 will do C. Next. Sir, Schedule 3, sir, there are two people, individuals other than individuals. Sir, for individuals, under FEMA, there is one thing given people, that one thing is called as people LRS. What is LRS people? Liberalized Remittance Scheme. What is that? As a person resident in India, you guys enjoy one right. What is that? Up to, I mean, in 1 year, you guys are free to take $250,000 from RBI. You can use it for whatever you want. If you want to go and buy property outside India, if you want to go and buy shares outside India, if you want, you can take it and go for foreign trips also outside India. And this is valid for 1 year. Next year again it will renew. So every year as a person in India, you have a right to take $250,000 every year. It's clear, Pakkana, 100%. Okay, sir. Even a minor can also get $250,000. Remember that. Sir, they can avail up to $250,000. Sir, I want more, sir. Now, for example, when we go, $250,000 is a very good deal. If Shah Rukh Khan goes, now imagine our celebrities were going for Maldives. Their 1 day stay on only around 80 lakhs, 90 lakhs. They go for 1 week, 10 week to Maldives. Where is $250,000 even sufficient for them? They will come under RBI approval. Clear now? Okay. Sir, now using this, what I can do, you can travel, I told you, except Nepal and Bhutan, you can take the money for that. Gift or donation, someone is staying abroad, you can give it as a gift or donation. Going abroad for employment, when you want to you have to travel, no, you can take some money and go. Immigration is what? Shifting your residence, you're permanently going abroad. You need some money, you can take maintenance of close relatives abroad. Your children are staying there, someone is staying there. You need to take care of their education, living expenses. You can do it. Business travel, meaning conferences and all. Next one, medical attendant, medical expenses, everything is covered there only. Medical treatment, anything for our celebrities will be going, no. Cosmetic surgeries, people will be going for heart related issues, everything will come there only. Next one is studies and any other thing you can spend $250,000. However, remember, if you are going for 4, that is immigration, no. If you are going for medical treatment, if you are going for studies, sir, $250,000 today, where is it sufficient for my studies, sir? I want to do MBBS, sir. Sir, not sufficient, sir. If you can get a quotation from the foreign university, sir, heart, sir, I have a problem, sir. Where is $250,000 sufficient, sir? Get a quotation from that medical university. If you can get a letter of representation, Now imagine if you want to emigrate, if you can get a letter of approval from the foreign country, embassy of that country, that $250,000 according to our country is not sufficient, then you can go even beyond $250,000 also. Understood? Yes, sir. For these three purposes, 4, 7, 8. Okay. Next one, sir. This is for individuals. LRS is only for individuals. Companies won't enjoy LRS limit. Sir, what if I'm a company? I'm Infosys. Can I also spend some dollars? Yes, people. Up to the limit, no approval needed. Beyond the limit, you need RBI approval. I think a question can come here also. Sir, what is that? Imagine people, a company wants to do a donation. How much can I donate, sir? You can donate people 1% of 3 previous years forex earnings. Last 3 years, how much you have earned? On that people, you can take 1%, or people $50 lakh, whichever is less. You can give it as a donation. Where can I give, sir? You can give it to people creating chairs, bench, desk. What is chairs? Chair is not what we sit at. Is basically companies, they try to reserve some seats for their employees. I told you also some examples where I can fund my employees to go and study from a particular university. For that I can donate. Reserve 5 seats for my company employees. That is possible. Next one, sir. Funds promoted by educational institute. Next one, sir. For technical institute in the field of donor company. Meaning, imagine I'm into pharmaceutical company. If you are a research and development in pharmaceutical, I can give a donation for you because I'll have a long-term benefit. If the research works, what will I get? Patented, good for your country only, no? That's what they're saying. Understood? Everything will have a reason, people. Without logic, nothing is written in FEMA. Clear? Next one, people. Commission per transaction to agents for sale of residential or commercial plot in India. Imagine people, an agent is abroad, Dubai, Sheikh. He is selling properties in India. Will this happen? Yes, it will happen. Very popular. They will sell properties in India. Now the agent, will he get commission? Now the company in India. Now imagine Prestige Brigade. They have appointed an agent in Middle East. Now from there, he got some investment from someone. I can pay him some commission. How much? Per transaction, I can pay $25,000 or 5% of inward remittance, whichever is more. Donation, people, you're not earning anything immediately. That's why whichever is lesser. You're earning something here. That's the reason whichever is more. 5% of inward remittance. Inward remittance means, people, what he has got it. The value of the plot of that 5% or $25,000, whichever is more. Next one, third one, remittance of consultancy services. Meaning, you think the abroad country is very good in certain aspects. Let us take, for example, in my company, I want to implement some software. Imagine Windows. I want to install it in all my computers. So I am entering into a consultancy project with some abroad person. So, sir, for what is that you are entering into a contract for? If it is infrastructure related, the maximum commission you can pay people, remittance, is up to $10 million. 1 million means 10 lakh. 10 million means 1 crore. 1 crore dollar. If it is any other consultancy, software or educational, any other consultancy will come here up to $1 million. That is your $10 lakh. Next one, remittance by entity in India, pre-incorporation, preliminary expenses. Before setting up the company, whatever they got in, they can obviously take it back. They can transfer into the company's name. And how much they can take back, sir? Up to 5% of whatever investment you guys got in, or $1 lakh, whichever is higher. Understood? All of you, Pakkana. This is what was given in Schedule 3. Any doubts here? Pakkana. So we have covered Rule 3, Schedule 1, Schedule 3. In Schedule 3, we have seen for individuals other than individuals. Half of the people will not understand where it is coming. So try to remember that first. Clear? Now we are seeing Schedule 2. In Schedule 2, sir, what does it say? A certain people, if they have to do certain transactions, you can do it only after taking prior approval of RBI. You have to do prior approval of government. Which government, sir? That specific ministry. Agreed? Okay, what is it, sir? Okay, Schedule 2, current account transactions, which require prior approval. Even one, they would have given limits, sir. If you are going beyond that, sir, you have to do it only after taking the central government's approval. With central government, I cannot directly go to Narendra Modi ji. For each ministry, they have appointed a designated, each department has a designated ministry. You need to go to that ministry. Example, first one, cultural tools, or Saima awards, or whatever, concerts, music concerts, film festivals. If you want to go abroad, first you need to take you need to take approval from Ministry of Human Resource Development. If they're asking from Schedule 2, I think chances are less only, but if they're asking, cultural tools is one of the important thing. Next one, sir, advertisement in foreign print media for the purpose other than promotion of tourism, foreign investment and international bidding by a state government and public sector undertaking. Now there are three things you need to read here. What is that? First of all, I will categorize the people into two. Now you are spending abroad for advertisement, it seems. Who, if at all you are state government, or if you are public sector undertakings, or you are none of them, you are others. If others are spending people, this section is silent. So you are free to spend whatever you want. Now this one, state government or public sector undertakings. Now my question is, what are you advertising? If you are advertising people, anything with regards to tourism, anything with regards to foreign investments, and anything with regards to international bidding, I'm calling people to come and invest in India. If at all the advertisements are given for these three purposes, then there is no limit at all. So if it is any other purpose, sir, then maximum you can give advertisement is $10,000. If it is going beyond this, you need to take central government approval. With central government, sir, Ministry of Finance, Department of Economic Affairs. Understood this entire flow na? Pakka na? Okay. The third one, sir, remittance of freight of vessel chartered by PSU, meaning public sector undertaking, they are importing something and they are paying freight charges. Freight means people, the cost of transportation. Simple, you being a public sector undertaking, if you are taking dollars to pay, that means you have taken the service of a foreign person. Why couldn't you take a service of Indian person? Being a public sector undertaking, you cannot do it outrightly. You have to take first a central government approval. Which one? Ministry of Surface Transport. Next one, sir, again payment of import through ocean by government department or a public sector undertaking. You are taking again import. Who? Government department or a public sector undertaking. They are importing. On what basis? You are importing on CIF basis, not on FOB basis. In the class I told you what is FOB. FOB is nothing but a cost involved. Let us imagine you are importing something from Dubai to India. Now the Dubai factory is here. The port is here. The cost involved of getting the product from your factory to the port is called freight on board. FOB. Your loading charges, coolie charges, local transportation charges, everything adds up to the cost of your product. This is called FOB. Yes, sir. You did not buy the product on FOB basis. You bought the product on CIF basis. What do you mean by that? You could have done one thing. You could have purchased it on FOB. From here, you could have taken an Indian vessel. Indian vessel means Indian ship. What did you do? You said, no, you come and give me the product here only. Until it reaches here, it is your responsibility. So what does he do? Okay, I will send it in my ship. I will take insurance from my country, not your country. So what happened? The cost of travel and insurance on the product is taken from US. That is the outside country, not your country. You could have avoided. If you just had paid FOB, you could have given the contract to our Indian ship. If you only do not trust us that we will sail, who else will trust? You could have given the insurance contract to our ICICI. Why did you give it abroad? They're telling not allowed. If you want to do it, surface transport. Understood? Yes, sir. Multimodal transport operators making remittance to their agents abroad. Nothing but imagine if there are multiple modal transports. Meaning, if at all you want to travel abroad, people, there is not one way you will travel. You might have to travel in air, and in some places you might have to travel in train. From some places you need to travel in cab. All the places you need to make the payments. Now that is what is called as what, people? Multimodal transport. So if at all a person in India has hired so many people, When he is making the payments to all those people, then you need to take the approval of registration certificate from the Director General of Shipping. It's clear? Next one, this I don't think they may not ask. Chances very less. Remittance of hiring charges or transponder charges. I told you. Imagine BBC, Netflix, everything is coming and being telecasted in India. You need to make the payments. You can make the payments. The approval is Ministry of Information. If it is internet, then Ministry of Communication and IT, Information Technology, respectively. Clear? Next one, remittance of container detention charges. I told you. Imagine there is a company, BMW. They imported some cars from abroad. They are bringing it through ship, and from the port they will put this into one big containers. You would see in movies, big containers will be there in the port. They will put this car in the port, in that container. That container will go from the port, it will reach your factory. Now what about this container? Who will invest in this? On the container people, they charge rent. There will be no rent for a period of 7 days. But in 7 days, you have to ship it to your factory, unload it and ship it back to the port. If you do not do it within time, people, there will be some penalty charges. If penalties charged people, that is not included. You need to take central government's approval. Understood? That's what is given here. Detention charges exceeding the rate prescribed by the Director General of Shipping. Up to what is prescribed is allowed. If it is going beyond that, you need to take the central government approval. Next one, remittance of prize money or sponsorship of a sponsor. I think exam point of view this is important. What is it, sir? Sir, you are conducting a sports activity abroad, or whoever won, you are giving a prize money abroad. Who is giving it? Two people can give it. One, any national body or any international body or any state level sports body. If they are giving it or they are organizing it, this will not apply. Who is organizing it? Sir, a private person is organizing it. This condition will apply. Sir, simplify it, sir. BCCI in COVID, they conducted IPL in Dubai. BCCI is the international sports body. Agreed? Now this condition won't apply for them. Sir, you will see this, what is that? Byju's Cricket Cup, Paytm Triangular Series. I think last year or something they paid. You will be seeing, no, that one sponsor would have sponsored one cup. Correct? They do it. Now, Paytm what? Is he a national level or sports or state level? Nothing. Private. He will come here. Now, what are they saying here? Remittance of prize money or sponsorship of what? Sports activity abroad by a person other than. How much, sir? If the amount exceeds $1 lakh. Yes, up to $1 lakh, even the private person also does not have to take. Beyond people, they have to take. Is it clear? Okay, next one, sir. Remittance for membership of P&I club. P&I club is again nothing but something which acts like an insurance. I told you in the class how does that thing work. Yes, sir. So this is what people schedule 2. So we saw 4 things. Rule 3 we saw Nepal, Bhutan, and schedule 1 we saw all the prohibited transactions. Schedule 2 was for people who needs to take prior approval of CJ. Schedule 3, 2 things. Individual, LRS, other than individuals, companies, 4 things are their limits. Yes, sir. In this case, sir, wherever there is a person who is what? A resident but not permanently resident. Who is he? Who has come to India for, say, for example, employment. He has been in India but not for more than 3 years. Being a foreign citizen, he is a foreign citizen, he is coming into India, but he should not be a Pakistani. Or you are a citizen of India, but you are working on deputation to India. For example, there is one of my relative. He has gone to US way long back, but he has not yet got green card. It's been 13 years or 11 years. So last 2 years, people, when his mother was not feeling well, he came to India just to be with the mother. Now mother passed away, he again went back. Technically, he is a citizen of India only. He has not yet got the green card, but he has been staying abroad. Family, children, everything is there. Mother only is staying alone here. He came to India, but his salary, he need not spend here. His salary should go to pay his children's fees. His salary should go to take care of the house rent. Agreed? Citizen of India settled abroad. They are only in our terms called as NRIs. Agreed? They are telling, Macha, you can remit your entire salary. No LRS limit. If he's earning $1 crore also, he can take it back because it belongs there. Understood? Pakkana? Yesha? Okay. Last thing we'll see of capital account transactions. So the last thing, sir, capital account transaction. What do you mean by capital account transaction, sir? CIF full form, cost, insurance, freight. Capital account transactions are a transaction which alters assets or liabilities of a PRI outside India, PROI in India, with very big attention. Concentrate. PRI, when he is in India, he opens any FD outside India. My assets outside India is going up. This is called as capital account transaction. Agreed? Imagine people, a person resident in India, he imports a machinery, plant and machinery. What is plant and machinery? Asset. So I am importing, I am buying a plant and machinery into India. What type of transaction is this? Cash basis. So it is a current account transaction, sir, because I am buying something there, but the asset is coming to India only. So PRI, my assets in India is being altered, not outside India. Let us look at second scenario. I got plant and machinery on loan. I have to repay it within 2 years. Now my loan is created outside. Now this becomes capital account transaction. Less than 6 months. Current account transaction. Short term creditor. My gut feeling says somewhere there a question will be there. Remember that. Clear? Pakkana. In exam, in class we had seen a big list. I don't know if you guys remember that or not. Okay. Yesha. Next one, people. Section 6. Any other example? Now imagine I buy some shares outside India. My assets are getting created outside India. Netflix shares. Now that is called as a current capital account transaction. A person resident outside India buys a land. De Villiers, AB De Villiers has purchased one mansion itself in India. Abroad. Assets in India is getting altered. It will be called as capital account transaction. Clear? Okay. Now what does it say? Section 6, people, it says FEMA permissible capital account transaction. Now permissible transactions are classified into two things, Schedule 1 and Schedule 2. One is for PRI, one is for PROI. Now sir, let us look at a prohibited transaction first. Or let us finish off Schedule 1 and Schedule 2 only. Okay, let us see of first permissible transactions. For PRI, what and all is allowed. For PROI, what and all is allowed. Sir, for PRI and PROI, nothing but people, if you remember your balance sheet, same items come people, nothing else will come. Agreed? If you remember, loan, deposits, creating accounts, assets, security, guarantee, borrowing, right from here to there, that's all, everything is covered. See here, sir, Schedule 1, PRI, Schedule 1 talks about permissible capital account transactions for person resident India. He can take anything outside India. Investments by PRI, Netflix, foreign currency loans, being in India, I am taking loan from Standard Chartered Bank outside India. Transfer of immovable property outside India. I am buying a land outside India, property outside India. I am a person resident in India. I am buying outside India. Guarantee in favor of PROI. Someone has taken loan outside. I am giving a guarantee on behalf of him. If he doesn't, I will pay. Export, import and holding of currency notes. I always told you, currency notes is always called as capital account transaction. Agreed? Logic also I told you. Why? Correct. The dollar, now imagine what they are telling you. Export, import and holding of currency notes. I am Indian. I am holding dollars. It is technically a valid currency of outside India, not in India. So this currency holds value outside, not inside. So currency will be considered as capital account transaction notes. Clear? Okay. Next one, loans and overdrafts by a PRI from PROI. Loan, which we discussed. Maintaining foreign currency accounts, FDA savings account, NRE accounts, whatever you say. Taking out insurance policy, same only no. Contingent liability. Today it is not there, but tomorrow you might have to get money. Loans and overdrafts by a person resident in India to, from. I hope you got the difference. Here it is from. Here it is to. You gave loan, you took loan. Indian bank gave loan to a PROI. Other way, you took a loan. Both way it is covered. Next one, remittance outside India, capital assets of a person resident in India. Capital assets. Agreed? Undertake derivative contracts. whatever is your derivatives, options, futures, hedging, all that can be done. So schedule 2, same thing people opposite. Whatever PRI was allowed to do outside, now PROI will be allowed to do inside. Same thing. See, invest in any security of a body corporate in India. He can invest in a LLP. He can invest in a proprietary concern. Capital only, no? Yes or no? He can buy immovable property. Guarantee in favor of PRIA. Currency notes, deposits, foreign currency accounts, FDA. A person, De Villiers is coming and opening a FD in India. For him, it's an Indian asset only, no? Remittance outside India of capital assets, undertake derivative contracts. I hope you are understanding what is happening. If a person is in India, if any asset or liability is getting altered, meaning increase or decrease, I had a property, I'm selling it also, it's a capital account transaction. Same way, PROI is there, his assets are getting altered in India. I took a loan gets created, no, here. I hope you're getting it. Okay, then schedule 1, schedule 2. So next important thing is prohibited transactions. Very, very important. I think question can come here. Now, sir, they're telling whenever you are doing a capital account transaction, you are not supposed to do these things. It's prohibited. A prohibited sector for investments from PROI. Now, people, just now you saw ABD Villiers can invest into Indian companies' capital, can invest into LLP, can invest into some sole proprietor. Whatever they are doing, you can invest, provided if the company, LLP, proprietor, if they are doing these business, you cannot invest. I'm not telling you cannot invest into the direct thing. I'm telling you cannot hold the ownership of the company doing these activities. You can invest into the activity, not into the company. Understanding? To explain more, I'll tell you. For example, you cannot control a company which is doing chit funds, meaning Shriram chit funds. If you want, you buy one chit. You also invest in chits. They're telling you cannot run chits. You cannot invest into Shriram chit company. You cannot buy shares of Shriram chit funds. Understood? Next one. Exception NRI can with prior approval of register of chits. NRI means Indian only. Staying abroad. Okay. Nidhi company. You cannot run a Nidhi company. Nidhi company is what, people? For mutual benefit. That cannot be owned by a foreigner. Basically PROI. Third one, agricultural plantation activities. Understood? I'm not telling you cannot buy land. I'm telling you, you cannot buy a company running the land. Getting the difference? Next one, real estate or construction of farmhouse. See, I'm not telling you cannot buy a land. I'm telling you cannot run a real estate company. You cannot run a construction of farmhouse. Okay. Exception in the real estate definition, these things are not included. What is that? Development of townships. Imagine brigade, prestige, mantri. They are developing. They are not owning it. You are free to do. You are allowed. Meaning you can come and set up such companies in India. Second one, construction of residential or commercial. That also you can do. Allowed. Third one, roads or bridges. We are only getting developed. Allowed. Fourth one, REITs. Real estate investment trusts. Allowed. Trading in TDR. TDR, I told you, transferable development rights. Imagine I had a land here. There was a metro that was coming. They had to acquire my land. Government gives me one certificate saying that whatever you can construct here, you can go and construct it somewhere else also. So they give me a right to construct. Sir, why? If I have a land, I can only construct. Why do I need a right? This right is given because in India, after a particular level, you cannot construct. Now, say for example, if at all in India, if you have a particular size site, imagine 30-40, that's a size site. You cannot go beyond 3 floors. 4th floor is considered as illegal construction. But if the same person has a TDR, he has a right to construct the 4th floor. Understood? Now, sir, I don't want to construct. It's okay. You give it to a person who wants to construct. That is only called as trading of transferable development rights. You can trade. In such companies, you cannot invest. Next one, other prohibited transactions for PRI. PRI, there are some transactions. What is that? Simple, don't do anything with Kim Anna. What is Kim Anna, sir? Democratic People's Republic of Korea, nothing but North Korea. He shall not make any capital account transaction with citizen or resident or entity of North Korea. Clear? Simple? Yes, sir. Sir, exemptions of applicability of these rules, the capital or current or whatever these sections, it is not applicable to a PRI. A PRI may hold, own, transfer, invest, foreign currency, foreign security, immovable property when he was a PROI or inherited from PROI. What do you mean by this, sir? Siddharth went abroad. Nicely he earned. He purchased some 2 lands there. He came back to India. Now he still has lands there. He became a PRI after some 3-4 years here. He still has a land abroad. Is this considered as capital account transaction? PRI having an asset outside India. Is it a capital account transaction? That is what is the exemption. What? Exemptions of applicability. If PRI may hold, own, transfer, you can hold what? Anything which you acquired when you were a PROI. When you are outside India, you acquired. Continue to hold. I don't have a problem. Exemptions. Next one, inherited from PROI. Imagine A went, A died. His children are here. Now, because of that, they got. They are not acquiring it. Again, these provisions will not apply. They are free. Exemptions. Next one, other way around. PROI. When he came to India, he earned here. He invested. ABD Villiers. When he came, he stayed in India for some 2 years. He purchased the land. Now he went back. Even after going back, he can continue to hold. Understanding? Any doubts? I hope it's clear. Next one, sir, inherited from PRI. Same thing. A person dies here, it goes. Clear? Yes, sir. Then you guys can ask, sir, then when will this chapter apply? Being in India only, I'm telling you, I only have shares of Netflix, sir. I have Netflix shares. Now what I'm doing is a capital account transaction. Understood? Being in India, being a PRI, I'm acquiring shares outside India, no? That's how we need to see. Clear? Yes, sir. Most of it is covered. Oh, everything is covered. Not bad. Okay. Let's go for break income. Yes, sir. Yo, my God, sir. Time nodi gottagata. Manvatva ilva. Humanity ne illa. Okay, go for a break income. We are almost done. We have some childre pulre chapters. Go for a break income. Yes, people. Let's start your next chapter. Interpretation of statutes. And the chapter next to it, the only chapter, last 2 chapters left, General Clause Act. Exam point of view, one question from interpretation of statutes, pakka will be there, 100%. Weightage can be anywhere between 4 to 5, but interpretation of statutes, why it is important also I'll tell you. Directly they'll give you a principle and they'll ask you to interpret it. That's all, directly. There will be no case-based scenario. 99% of the times that there will be no case-based scenario. It will be a direct question. So in interpretation of statutes, they'll always tell you one thing. What? The difficult part is to prepare. In other chapters, difficult part is writing. Exam is difficult. Interpretation of statutes, if you put effort in your home, you will pakka get that 5 marks. There you don't know. What will you put effort? If you are not able to understand the question, it's nothing in your hands. iOS is in your hands. That's why I always say, pay more attention for iOS and general clause because it is in your hands. It's clear? At least general clauses here and there, they will ask you a case-based scenario. But iOS, most of the times, maximum number of the times, it will be a direct question. Directly they will ask you, what is harmonious construction? What is existim generis? Directly it will be there. That is how directly will ask. Clear? Yes, sir. Okay, let's start with interpretation of statutes. Okay, done. First of all, sir, before I get into interpretation of statutes, first of all, let us understand why do we need iOS. iOS is required because they say no lawmaker is perfect. Meaning a lawmaker will make a mistakes. In law, there will be some mistakes involved. In such cases, what happens? Imagine a dispute happens. There will be a fight. The problem won't be here. The problem will happen in the court. When the judiciary judge is reading the law, he will understand, oh my God, what did the lawmaker make? He has messed up this provision. Now what to do, eh? Now in this case, people, I cannot sit here and blame the lawmaker because you need to give a verdict. Now, whatever the judge does in the court is called as IOS, interpretation of statutes. That's the reason, remember, IOS is maximum number of times done by the judiciary, not the lawmaker. And why do we do it? Because of the legislature. Because the law is not perfect. Meaning, sir, the law might be drafted with some flaws. There will be some mistake. Now, when the case is there in the court, some things will come for the judge's help. And these things can be categorized into two things. One is called as statutory help. One is called as non-statutory help. When I'm reading a law, I might have a doubt in understanding one word. So the first thing I will seek is statutory help. Now in Companies Act, I don't know what you mean by the word called associate. I don't know the meaning of company, financial year. Now see, technically you guys know what is financial year, but financial year definition was different in LLP Act and Companies Act. Now what do the lawmakers say? Refer that definition, you will understand what did the lawmaker meant. The judge will go, refer section 2, he will understand, oh, ida, I thought something else. So this acts as a statutory help. Next one, sir, what if the definition is silent? The next statutory help is called as General Clauses Act. That's also an act only, no? So the next thing where we will go to General Clauses Act. Sir, both of it did not help me. Next to what comes is called as non-statutory. Non-statutory is nothing but IOS. Understood? Now, sir, when you are trying to understand IOS, you need to get two things. One is called as interpretation. One is called as construction. What do you mean by the word interpretation? Interpretation means, people, I'll ask you, what do you mean by plant? You will say, hey, plant andre answer. Plant means something which will have brown below, green up. That is called as plant. Correct? Understood? Sir, now this is called as plant. Now, if I say, hey, Noda, in accounts, they have mentioned something as plant and machinery. Sir, you have to tell the context, no. Now, according to that, plant means you're trying to derive a meaning. Now, that is called as construction. Construction, technically it is not so easy. Interpretation means, people, the word if you search, there will be a meaning within it. Construction, within it there is no meaning. You will have to derive the meaning based upon scenario and circumstance. Example, sir. I think I gave you some case laws. Orange. What do you mean by orange? Does the word, is it so clear? What is orange? Depends upon where you are referring it to. That is only called as construction. Based upon the scenario, you are going to derive the meaning. Understood? Pakkana? Okay, sir. Now, sir, let us get into the book. What does it say? They have, okay, first we'll start with classification of interpretation. Classification of interpretation. Interpretation can be classified into two things. One is called as legal, one is called as doctrinal. The first thing I'll ask you guys only. You want me to go in detail, you want me to go on face of it? Taka tell me up. That also don't think. Okay. Maximum 15 minutes difference will be there. When I say in detail, face of it means I'll just explain the scenario. In detail, I'll give an example for again each of the scenario. You tell me whatever you want. Extreme, sir. Okay, classification of interpretation. Now, whenever I'm trying to interpret people, interpretation can be classified into two things. One is called as legal, one is called as doctrinal. What do you mean by legal, sir? Legal is nothing but, people, what the lawmaker himself meant. A legal interpretation can be further classified into two things. Where there is an actual rule of law, meaning when the lawmaker himself has clearly written subsidiary company means, hey judge, don't do interpretation or construction, follow the rule of law. It binds the judge. So, legal rule can be further classified into authentic and usual. What do you mean by authentic, people? Authentic is nothing but whatever is said by legislator himself. So, C's definition, he would have interpreted something, follow that. That is the first way of legal rule, under that authentic. Understood? Next one is called as, people, usual. Usual means what, people? Usual means something which has already happened, or customs. So this is nothing but people judicial precedents, nothing but people case laws. Earlier it has happened. You can take that as a help and you can interpret. That's the legal way. Agreed, huh? Which is there in the books. Next one, sir, is called as doctrinal. Doctrinal people can be further classified into two things, sir. One is called as people grammatical, one is called as logical. Grammatical means, people, nothing but your general rules of speech, your general English. Generally, what does it mean? Sir, if that is not giving you the meaning, then you will go to logical. Logical means, people, nothing but construction. You are trying to discover the meaning. I'll tell you, in class we had seen one example called beetle leaf. Correct? Huh? So that is what we are going to see. Yes. So we'll see when we start the rules. Sir, why do we need interpretation? I told you, statutory, non-statutory, everything we saw. Okay. Rules of interpretation or construction. There are two types of rules, sir. One is called as primary rules, one is called as secondary rules. Primary rules, sir, the first rule is called as, people, rule of literal construction. That means nothing but absolute sententia expositor non-indigent. Absolute sententia expositor non-indigent. Do not try to mug up. Try to understand the maxim. Absolute sententia. When the sentence is absolute, you do not need a interpretator. If your law book, sir, was like a very good movie book, you know, like a movie only, everything seen cut, then you can literally understand everything. Will you come to the class? Will you come? No. That's what is the meaning. When the law is so simple, you don't need a teacher. When the law is simple, you do not need a interpretator. In Latin, that interpretator is called as expositor. Understood? So, absolute sententia. When the sentence is absolute, macha, don't interpret. That's the reason the first rule, one easy, 1 mark. 2 marks I'll give you, like this only, easily. It's the first rule of internal interpretation of statutes. Because when the law is clear, we don't need any interpretation. Read it as it is. Agreed? That's the reason it is called as heart of the interpretation of statutes. That's why you write it as cardinal principle. That's the main. The first interpretation is given to the lawmaker himself. Got 2 marks, Done, yes, Okay. Now, sir, that's what they say. When the language is plain, then the language of statute is plain and unambiguous. There is no confusion. No question of construction arises at all. Agreed? But sir, when we have a question, what? Whenever there is a word which has 2 interpretations, which one is narrower, one is wider, you need to choose a word in a wider sense, not in a narrower sense. For example, in explanatory statement, we saw that the director, the KMP, you need to give a disclosure of any financial interest and other interest. Other interest means what? So, financial interest I will disclose. Other interest means, they're telling you when there is a word which can give you a narrower meaning and a wider meaning. Wider meaning, people, imagine because of this contract, I might not be benefited. My children might be benefited. It can be my relatives that can be benefited. Anything, it can be financial, or let us imagine, if I get into this contract, my son will get a job. He will be appointed as a director in that company. If you have any type of benefit, you need to disclose that. So one is a narrower meaning, shorter. Next one is a wider meaning. Even though the rule is clear, try to take a wider meaning. Next one, sir, words are to be understood in a natural and popular sense. Meaning, people, beetle leaves. I told you in the case of beetle leaves. In Kerala, there was a scenario where, according to the Sales Act, the vegetables, there is no sales tax on it. One seller of the beetle leaves, he said, even I am also selling a vegetable, I will not pay sales tax on it. The government filed a case on him, saying that, hey, how can you not pay tax? You have to pay. He said, hey, vegetable, even this is also eaten. You eat no beetle leaves. Now people, we were confused. The case was filed in the court that the Commissioner of Income Tax is telling him to pay the tax. But this person is telling, I am a vegetable. It is eaten. It is edible. So you need not pay tax on it. Matter went to court. Judge opened the book. It is written that on vegetables there is no sales tax. Now you tell da, what is vegetable da? First of all, I ask you one question. What is tomato da? All our childhood is mosa. Have they cheated us? They said tomato is a vegetable, but now they are telling fruit. Once you grow up, you are getting to know so many things. Tomato is a fruit, it seems. Now is it covered there? Now judge, hey, when you tell da, when we were born, there were maximum 5 fruits: orange, mosambi, apple, grapes, watermelon. Season bandre banana, mango. People today, lychee, gitchi, kiwi, yaar kiwi, avocado, and dragon fruit. If now can the person, now Siddharth is telling, sir, they can just add up the names of the vegetables in the act only, no sir. How can you add the hybrid to nati, farm? How many? Can you get it? Will it ever end? So people, the lawmaker had to interpret the law now. What to do? Now what is the first thing? Sir, beetle leaves. You told me to take interpretation of statutes. No, I googled it. What is beetle leaves? It gave me a meaning. What? The beetle Piper Bethel is a species of flowering plant in the pepper family. Piper raceae, native to South Asia, it is an evergreen. Now people, judging the court said, hey, my meaning only was cleared. The grammatical meaning is confusing me even more. So macha, let us do one thing. How do you know beetle leaf as? What do you know it as? Do you use it in cooking? Popularly, is it known for cooking? So in a popular sense, how is this word used? Beetle leaf is used post your lunch or food. Correct? As a digestion thing. Correct? Pan bida. Agreed? Based on that, people, a interpretation was made saying that in a popular sense, beetle leaf do not have to give a, what is that, grammatical interpretation. You need not Google it. You need not use a dictionary meaning for it. Use a meaning which is popularly used amongst the people. So whenever you are confused between words, which is the word is there. Now I do not know how to interpret. Should I do a dictionary for this, or should I use it in a popular way? They are telling you if a word has a popular way or a popular meaning in a natural way, however it is used, it follow that. Now don't tell me, sir, in my place, sir, they do one dish from beetle leaf. Macha, one dish is different. Entire India is different. Agreed? Based on that, I cannot give an interpretation as people. People in India, ice cream say they are doing vadada. Ice cream bonda is coming. No, I can't say ice cream is also vegetable. Huh? Dairy milk is also okay. Da. Ice cream, how can a bhaji happen? Da? Bhaji is hot. Ice cream is cold. They are doing it. Huh? No, what I can't. That's what I'm saying.
Sir, but what about songs, sir?
Somf.
Uttanantane sir.
Ah.
So adike tax sir.
Okay. Technical words to be used in technical sense. Meaning what, sir? Hey, what kind of person you are, da? Hey, you only, da. Now, sir, when I say person, what am I telling it as? Person has two meanings. Popular and normal sense means person means we know. Income tax says every person is liable to pay tax. Oh, person means we are. Technical meanings, if it is there, you need to interpret in technical sense. Here, person means what, people? It includes HUFO, it includes LLP, it includes company. Everyone are included. Understood? Done? This is only called as a first rule of interpretation, literal construction. Any doubts? Pakka na? Next one, sir. Rule of reasonable construction. Nothing but maxim. Utras majis valium quoth paryat. Correct? Sir, what is this, people? Simple. It says, whenever the first principle fails, you need to construct the meaning. I'm not able to understand anything with the word. The second thing that comes into picture is a second maxim that is only called as reasonable construction. Now, what does it say? Statute must be interpreted as to lead to a sensible meaning. When the plain or grammatical meaning does not give a sensible meaning, this maxim is to be followed. If court finds meaning defeats the law, It is a duty of the court to depart from dictionary meaning and adopt construction which will suppress the mischief and advance the remedy. Mischief means whatever is the problem. Imagine I am not able to understand one word properly. The court, instead of directly applying a dictionary meaning, I will try to construct it based upon a scenario. Correct? Huh? Yes, sir. And that's what they are telling you here. For example, what is the definition of a member? Tell me. Class action suit can be filed by all the members. Yesterday we saw how to become member. By subscribing to MOA, by agreeing at the time of allotment, or if your name is written as beneficial owner in depository model. In all these three cases, you can become member. Have I ever told you who and all are called as members? Everywhere by default I am telling you, member is shareholder, shareholder is equity plus preference. Now there came a case where whenever there is a class action suit, can a preference shareholder file a class action suit? Because nowhere it is written. Where is it written? Now I open a LADA, it says members have a right to file class action suit. Is preference shareholder involved? If I go with the meaning, it is silent. Constructions are equity or preference. When something wrong happens, they also have a right. They also have a right. That is what is construction. Understood? Pakkana. So sir, second one, simple thing. If they are asking you what is a maxim, try to write the legal maxim. If they are directly giving you a maxim, try to write the English meaning. Understood? Next one, when will reasonable construction come into picture? When the first one fails. And try to write the meaning. Whenever you do not lead to a direct meaning, you try to construct the law. When the plain meaning does not give you any sense, you try to construct the law. You can give an example. My request to you, try to give examples for interpretation of statutes, whatever we have seen in the class. That's fine. Clear? Okay, next one, sir. Rule of harmonious construction. What do you mean by harmony? We live in harmony. Harmony means what, people? Together. We'll see that now. Sir, a rule of harmonious construction mean what, people? Whenever you're reading a law, you need to read the law as a whole. You cannot read first part, second part, third part separately. That is not possible. Everything is one. Sir, okay, who said no? That's what even the lawmaker is telling. Harmonious construction means, people, you need to read the law as one. You cannot split and read it. You need to read it together. So the problem is not that if at all there is any conflict in the law. What do you mean by conflict, sir? One part says one thing, another part says one thing. We do not know which one to follow. Huh. No, it says from the completion of first AGM, your appointment will be valid until the completion of sixth AGM. So it is 5 years only, no?
Between two AGMs, there can be gap of 16 months as well. So if you go by that, AGM can be conducted after fifth year as well. So here only 5 years. There after 5 years also we can conduct 16 AGM.
Okay, I'll take it. Okay. Actually not confident, but okay, I'll still give it to you. Yes, sir. Okay. So, sir, what is one example I can give you, sir? For example, according to Article 13.2, people, Article 13.2 talks about fundamental rights. I think I showed you this in the class also. What is Article 13.2? Fundamental right, it says, people, about the lawmaker does not have a right to alter. Yeah. Rama. Yeah. Number? Oh, is ಅದಕ್ಕೆ ಹೇಳೋದು ನೋಡು ಬ್ರಾಕೆಟ್ಸ್ ಅಲ್ಲೋ చేసినాను చూడు కరెక్ట్ గా. Sir, okay, now what does Article 13.2 of Constitution of India say? The state shall not make any law which takes away or abridges the right conferred by this part, and any law made in contravention of this clause shall to the extent of the contravention be void. Meaning what, people? A lawmaker does not have a right to do a law against fundamental rights. You cannot take away fundamental from rights from us. If a lawmaker does it, it will be considered as void. That is what Article 13.2 says. If you look at Article ಮತ್ತೆ ಟೈಪ್ ಮಾಡ್ಬೇಕಾ? If you look at Article 368 of Indian Constitution, the Constitution of India grants constituent power to make formal amendments and empowers Parliament. 13.2 said, Parliament, you don't have a right to do anything to this part of Constitution of India. You cannot do anything. 368 says, Parliament, you are superior. What is it saying? It gives a right, it gives power to Parliament to amend the Constitution by way of addition, variation, repeal of any provision according to the procedure laid down therein, which is different from the procedure. Meaning, you can vary, amend, change any part of the Constitution. Who can do it? Parliament can do it. 13.2 says Parliament does not have a right to change fundamental right. 368 says you have a right to change anything in Constitution of India. This says you cannot do it. This says you can do it. Now, can a Parliament take away your fundamental right? According to 368, yes. According to 13.2, no. Now, what to do? The lawmaker said, people, whenever there is a conflict between general provision and special provision, 368 is referring to the Constitution of India as a whole. It's a general provision. 13.2 is a law specifically made for fundamental right. Special provision will prevail. But not directly, I'm not saying just to read 13.2. The first interpretation is you need to try to read the entire Constitution as a whole. If you are not able to give an interpretation, then you will apply this interpretation. What is that? The special provision will prevail over the general provision. It's clear? 100%? Pakkana? Okay. Now, sir, try to see this. Specific rule will override a general rule. However, the lawmaker only at times, people, to avoid all the confusion, in a section only he will give it off which one is superior, which one is inferior, which one will be more powerful, which one will be less powerful. In the section only the lawmaker will put. How, sir? If at all he has written without prejudice. Without prejudice means, people, without affecting that section. That means both the sections are equal. You need to read both together. If at all the lawmaker has said subject to, now for example, SEBI, we saw in IPO, whenever you need to raise minimum application amount, it says 5% according to Companies Act, subject to anything specified by SEBI. Subject to means Companies Act only is telling, that section only is telling, this is not superior, that section is superior. If at all lawmaker has written notwithstanding, meaning whichever is section, in this section if they have written notwithstanding, that means this section is powerful. Understood? Pakkana? That's your third rule. Fourth rule, rule of beneficial construction or Hayden's rule or purposive construction or mischief rule. Why is it called Hayden's rule? It was first held in the case of Hayden. When did this case happen? So this happened in the case of 1584. That is when it happened. Sir, basically what are these people? To understand this, people, I'll give you one example, simple example. I think we had seen this only in the class, Smith versus Hughes. Now, what happened, people? We'll see that. Now, in one country, people, there was one act called as Street Offences Act 1959. What is the act name? Street Offences Act 1959. Now, if you read this particular act, people, it says, any person, if they do any activities related to prostitution on the streets, a person solicits, meaning if a person attracts a person standing on the street, it will be considered as what, people, an offense. There can be a case filed against that person and it is liable for any punishment. Now, there was a lady. What did this lady do? She was standing in her balcony in her house. She was standing in a balcony. She used to take a tumbler. She used to take a spoon. She used to make noise. If people used to walk down, whoever looks at her, she used to attract them to her house. When police constable saw this, the police constable filed a FIR against this lady. Now the question was, whatever she did, was it a offense according to this act? If you read the law, it says anything that is done on the street. Was it done on the street? According to the lines, it is done. Whatever she did is not an offense. Correct? Now in this case, what happened, people? They applied Hayden's rule. What is Hayden's rule? See, first of all, what was the intention of bringing in this act? The intention was to kill prostitution. It is not about where it is done. It is absolutely killing it. That was the main intention of the lawmaker, but he did not write it down properly. So we apply 4 questions in the law. What is that? The 4 questions are: first one, what was the law before making the act? There was no law. That's the reason they brought this law. Second one, what was the mischief? Law did not provide. Imagine previously we had a law. In that, people, there was nothing against this particular thing, whatever you are pointing out. Imagine before Street Offences Act, there was some offense. In that, there was nothing with regards to prostitution. In this, they specifically added prostitution. So, what did it not provide for in the previous act? What did it not provide? Prostitution was not covered. Now it is covered. The second question. Third one, what is the remedy the act has provided? Prohibition of prostitution. That is a remedy, no? The fourth question, what is the reason? It is for the benefit of the society. Imagine drugs. It can be any other thing. Correct? Now, for example, I will say you cannot do drugs on the street or on this college, or I'll say in certain places. Technically, that doesn't mean I am not telling you to do drugs in the house. Drugs cannot be done anywhere, illegal. Correct? Yes, that's what they are saying. Now, this rule is called as what, people? This rule is called as Hayden's rule, also called as beneficial construction. Any doubt? Pakana, 100%. In exam, this has to be there. And you guys can write an example what we discussed in the class, Price Competition Act. Yes, Pakana. Price Competition Act, I think I told you also. According to the Price Competition Act, if at all certain things are, if at all your prize money in the competition, if it is more than 1,000 rupees, then it will be called as what, people? A gambling. That is what was the law. Now, at times, people, if the prize money is more than 1,000 means there are so many activities where the prize money is more than 1,000. Example, kaun banega crorepati? The person is winning KBC because of his intellect. So that's what they said. Everything will not be considered as gamble. If at all anything is done out of their skill and judgment, that's why they are winning. You cannot consider it as gamble. That will not be covered under Price Competition Act. It is allowed. That's why KBC is allowed. Understood? I told you in the class, there were so many examples also. Dream 11 Allah. Yadado? Rummy circle. In certain cases was considered, rummy was considered as a skill, game of skill. What is that? Horse riding was considered as game of skill. Horse riding. You do betting of horses. A horse will not win by fluke. It will win because of the way it is built. How stronger it is. Or depending upon the rider. There are so many things in it. Correct? Okay. Next one, people, is rule of exceptional construction or common sense rule. Exceptional construction. Exception means what, people? Generally, you should go like this. Exceptionally, you have to go like this. Meaning what, people? General rule. What do you mean by and? Both. You need to read the rule as a conjunctive. Both have to be satisfied. Example, small company, turnover, paid up capital, both has to be satisfied. Sir, disjunctive or meaning what? Any one has to be satisfied. CSR. Agreed? But generally, lawmaker uses the word as and or. But they're telling you, generally that is a rule. Exception means what? Exception means, people, and has to be read as or has to be read as and. Exception. Sir, when will we do that, sir? Why will we do that, sir? Example, I told you, there was one case of something called as PMLA. You remember, Prevention of Money Laundering Act. If you look at Money Laundering Act only, people, there was a section called as Section 3. In Section 3, okay, first we'll see that only. Section 3 of PMLA. Okay, read people section 3 of PMLA. What does it say? Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with proceeds of crime, including concealment, possession, acquisition or use, and projecting or claiming proceeds of crime and projecting it as untainted money, shall be guilty of offense of money laundering. Understood this one? Na? What is this, sir? If any person is connected with proceeds of crime, meaning I did blackmailing, I did a kidnap, I earned money, I am getting it, but to the world I am showing it as a legal money. How did I earn it? Illegally. But what am I telling to the world? Legal. Untainted and tainted. Tainted means people, tainted means colored, black money. I am coming to the world and saying it is white money, not black money. Sir, what is the problem here? The problem is in these 3 letters. And why is it, sir? People, there are 2 conditions, people. See here. One, you are doing any activity illegal and you are earning money. And you are showing to the world it's a legal money. Earning illegally and showing it as legal money. Okay, I will do one thing. I will earn illegally. I will never show anything to the world at all. Now, whatever I did, is it money laundering or not? But it is and no. Understood? Here, and has to be interpreted as or. So, if you actually look at the scenario now, they say whatever is interpreted as and, you need to actually interpret as or. I hope you guys are able to understand. Because iOS घर को जाके हाथ ऐसा होता है. Now see here, money laundering offence attracted by mere possession of crime proceeds, projection as untainted money not required. Supreme Court interprets and in section 3 PMLA as or. Yes, sir. So earlier I used to give this example in the class. In 2022, they amended it of people. Now and is actually made or. Yes, sir. What we saw was a unamended act. Now it is or only. But for how many years? For so many years it was and only. Got it? Yes, sir. Now lawmaker, he saw someone has done a crime. He's saying, Your Honor, read the law properly. I'm not punishable under your act. Why? Because law is saying and. Now you tell me what should the judge say? He's following what the lawmaker said. Lawmaker interpreted and as or. So you did illegal also, you are liable. You did showing to the world illegal money as legal money also, you are liable. For both you are liable. Whether you do it together or separately. Clear? Okay. In the same way, sir, may can be also used as shall. Shall can also be used as may. In the same way, that is the reason this rule is called as exception. Is clear? Pakkana? Okay. In the class, I had showed you example of Official Secrets Act also. Next one, rule of ejusdem generis. Sir, what do you mean by ejusdem generis? Ejusdem generis means people, what is that? Same kind or same species. I'll give you an example, wonderful example. 2021, there was a case law. This was filed in NCLT only. What was the case law, sir? This was with regards to the Apple. Why da you will do this? Tell da. People, section 94 says, what does it say, people? Okay, so what does it say? Look at the second one, people. Wait 1 second. Okay, now look at second one, people. 94 subsection 2. The registers and their indices, except when they are closed under the provision of this act, and the copies of all the returns shall be open for inspection by members, comma, debenture holders, comma, other security holders, beneficial owners without payment of any fees, and by any other person on payment of such fees. One day what happened, people, in NCLT board, any other person, a random person nowhere connected with the company, asked the company, I want to inspect all your registers and returns. Company said, how are you connected to the company? I am nowhere connected to the company. I am not a shareholder, preference wala, debenture wala, I am nothing. Company rejected his claim. What did this person do? He directly went to NCLT. He opened section 94. Your Honor, other person is there, sir. I can come and inspect. A question was filed in NCLT. In this case, lawmaker specifically has even written in the judgment applying the rule of interpretation of statutes when there is a general word. When there is a general word, it takes the meaning from its previous words. Previous words means what? You look at member, you look at debenture holder, you look at security holder. That means they are all somewhere connected with the company. So when I say other person, you should be also connected with the company. You should not be some random person going on road. Understood? All of you. That is what is called as aegis dim generis. Nothing but people. Imagine 1, 3, 5, etc. What is etc. here? 7, 9. It takes the meaning from its previous words. I think I had given you this also. Cat, dog, and such other animals. Correct? Yes, I told you one more thing also. Contract Act also I had given you an example. I had given you one more example also. What is that? There was Customs Act. In Customs Act, people, it was clearly written, arms, ammunitions, and other products are prohibited from being imported. A person got wine bottles. The customs authority stopped him and they actually checked. They got the wine bottles. They said, you are not supposed to get the wine bottles inside. He said, where is it written? See the arms, ammunitions, and other products. Other product, no, it is. Correct? So iOS says it has to take the color of the previous word. So we are talking about Kalas Nikao, AK-47, Dodama Dodapa. Okay, that's what they are saying. Understood? But sir, remember one thing, people. Same, what is aegis dim generis means, people? Same kind or same species. It belongs to the same thing. Okay. General words are always followed by specific words to apply. People, when is this applicable? When they are asking you aegis dim generis, you need to write this. Enumeration of specific words. Enumeration means what, people? One word alone should not be there. It should be a series of words. Enumeration. Next one. Enumeration constitutes a category. It should not be like one is gun, one is lollipop, one is lace chips packet. Does it belong to a category? Illa. Third one. Such class or category is not exhausted. Dog, cat, rabbit, turtle, cow. I've written everything. And I've written other. Can you interpret anything there? So when there is no scope of interpretation, you cannot apply aegis dim generis because I've covered everything. Next one. General terms follow enumeration. Meaning there has to be some specific terms. After that only general term should be there. One comes somewhere, one comes somewhere. You cannot apply aegis dim generis. One is coming in 93 section. One is coming in 94. Aegis dim generis won't apply. No different legislature intent should be there. Legislator himself should not say, according to me, this is the meaning. If that is there, that will apply, not this. Okay, example done. Okay, next one, people. Secondary rules. Primary rules clear? Simple. Okay, secondary rules, people. Doctrine of contemporanea exposito or effect of usage. There's nothing but, people, custom is the best interpreter of law. When you're reading Indian Contract Act, I would have told you in the class also, you cannot read Indian Contract Act sitting today in the generation of artificial intelligence. Because the examples, the rules, the section still prevails around letters. 1872, sitting in 2024, those examples will feel outdated. But if you have to interpret that meaning, do not interpret as if you are sitting today. You have to read it as if you are reading what he meant in 1872. So you need to interpret the law not as on today's date, what he would have meant when the act was made. Sir, and not only that, sir, if at all I have any doubt, then they say contemporanea exposito est optima yet fortissima in league. Sir, bitpudi, humko ye nahi chahiye. Nothing but people. Correct. Simple. Simple thing, people. Contemporanea exposito. Simple. Contemporary authority. Meaning what, people? Simple da. Back then, when the law was made, was there any regulator for your law? Let us take, for example, today SEBI is there. SEBI gives you something called as interpretative letters. SEBI gives you something called as circulars. SEBI helps you to interpret. He would have given you notices. For that law, if there is any authority made, if he has explained you something, then that you need to follow. That is the meaning of the best interpretation is that made by the contemporary authority. Clear? Okay, sir. Next one. Doctrine of Nociter Associs. Yeah, sir. Vittidinga, sir. Sir, what is Nociter Associs? Very simple. Nociter means know your meaning. Associs means by your friends. Associs means associates. Know the meaning of a person. You are sitting around 5 people. What is your character? I can tell based upon your 4 friends. Correct? Naluguru. Correct? They're not that Naluguru. So, correct? That's what they say, no. Looking at your friends, I can tell your character. That's what they generally say, no. That's what is Nociter Associs. Nociter Associs. Meaning, depending upon the associated words, you can give the meaning of this word. So, that is what was Ejustim Generis also, no. Ejustim Generis is a generic word. This word can be interpreted, but it will have multiple meanings. In that case, you will apply Nociter Associs. Example, people, one day what happened? Okay, let us see from this only. Hey, the best example I can give you is, what is orange? Fruit. Now, this is called as Nociter Associs. Based upon the words around it, this will take the meaning. What do you mean by charge?
Charge created against it.
Correct. My phone does not have charge. Charge means what? Correct. Yes, sir. This is called as what? Nociter Associs. Correct. Okay. Now, this you cannot write now. Sir, example charge. So, to write an exam, there is one example I can give it to you. Why people will feel interpretation of statutes is difficult? Because you will not get examples. People, I've already made one marathon. I've already made in the previous old syllabus. There is one marathon which is running on YouTube also. There are some views for that video. So I hope you guys know that you will, when we are analyzing the video, I will know which chapter has the maximum views. So for all the chapters, it will be like this. iOS will go like this. And it will come like this. That's the beauty of iOS. Second thing, try to search videos on iOS on YouTube. If you find, come and show me. There will not be a single iOS video. No, I'm telling why. You will not believe it took me more than 3 months to just curate a proper material with examples for iOS. 3 months. Because now Smith, whatever we saw that, what is that, Smith versus Hughes, a prostitution case, that is not Indian case law. It was dealt in New York, US case law it is. Now I need to explain you the concept. But the scenario is not there in India. How do I explain you? That's what is all about teaching. If R&D is not there, people, a person who is good in communication, a person who knows a little English can be a teacher. Correct, huh? Yes, Sam. Okay. Okay. Now, people, what are you doing? Nociter Associs. So, people, one day what happened, people? Again, Commissioner of Customs and Excise versus Savoy Hotel. Savoy Hotel, one day what happened? People, one law graduate went to a hotel, ordered for matcha, get one orange juice. He got orange juice also. In the bill, people, he has put a sales tax. He said, hey, why the sales tax, sir? Sir, what are you saying, sir? Have you not read the act? Being a legal student, you have to read, no, sir. He got one act and he showed, see, sir, anything showed. We have to pay tax. Where is it written, sir? If you look at it here, while dealing with Purchase Tax Act, which use the expression, this is how it is written. You can charge sales tax. Imagine purchase tax for manufactured beverages, including fruit juices, bottled waters, syrups. So the waiter came and showed, sir, fruit juice. What did you order? Orange juice. Orange juice, fruit juice only, no? Because of this, I can charge the purchase tax on you. Now, student did not leave. He went and filed a case in the court that fruit juice, that is orange juice, is not covered here. He saying, hey, idiot, fruit juice covered, no? The matter went to court. That is only this case law. Commissioners of Customs and Excise versus Savoy Hotel. For you, you will feel, what is there in this? But can you see this? Such a big thing only, no? Yes or no? So in this case, it was decided, people, try to look at its associates. Manufactured beverage, meaning what? Artificial drink. Bottled water, meaning what? Something which comes in a sealed thing. Syrup means what? Syrup. Bottle. Syrup means what? You guys will drink, no da? Mocktails and all you do? I mean, you do, sorry, you drink? They put something in all, da? Hey, whichever cafe you go and drink something here, da. He will sell something and all. What is that? Pina colado. What is that? Mojito. They will say mojito. But no, you're illiterate. You should pronounce it as mojito. Okay. Mojito will get blue color. What is that? Syrup only. Correct, huh? Now on mojito or pina colado, cocktail, mocktail, you guys can charge purchase tax because everything is coming as an artificial one. The associate word says they are all artificial drinks. But what he ordered was a fresh fruit juice. My associate words nowhere interpret that there can be a tax on fresh fruit juice. They are referring everything to a can. Sir, what was his intention? Imagine if you open a real juice. Real juice, Real juice means they branded, real something and all you will get, no? Tropicana, fruity masa, canned juice, open karke dal. This is subjected to purchase tax. Interpreted, iOS. Understood, Pakkana. Beautiful. Okay. Next one, sir. Aids to interpretation now. Sir, whenever I am trying to interpret, sir, there are two types of aids. Helps. One is called as internal aid, one is called as external aid. Internal means people available in the statute only. External means people out of the statute. Internal aids is, first one is called as title. Short title, long title. How can a title help? PMLA Act. What is PMLA? Prevention of Money Laundering. POSH Act. What is POSH Act? Prevention of Sexual Harassment of Women at Workplace Act. Act only is telling you why the act is made. They are called as long title, short title. Today's date, there is nothing like long and short. It is everything as earlier it used to be there. Short is generally it will be short. In section 1, they used to say what is the intention. That used to be long title. But today that is nothing is there. Everything is considered as title only. If it is very lengthy, it is called as long title. Prevention of Sexual Harassment of Women at Workplace. Companies Act. Short title. Understood the difference of Prevention of Money Laundering Act. Sir, preamble. Preamble means Constitution of India only say no. Preamble, da? All Indians are your brothers and sisters. Except one is interpretation of statutes. Understood, da? That is literal construction, harmonious construction, liberal construction, okay, beneficial construction. Sir, now understood preamble. Preamble is nothing but people. It will tell you why this act was made. Sir, case law here, people wonder what happened. A Christian boy and a Hindu girl got married. The fathers of both the communities came and said, whatever the marriage happened, this marriage is not legal. And how did the marriage happen? They went to a temple and the boy tied 3 knots. According to the Hindu Marriage Act. Yes, sir. Now there was a challenge that was brought in the court of law, people, that The couple are claiming that what happened, what we did is a marriage. The parents are claiming what they did is not a marriage. Matter went to court. Sir, ಏನು ಕೆಲಸ ಇಲ್ವಾ? Court, everything they go. Actually, good thing only, good case only, noda. Now people, the court saw Hindu Marriage Act because that is how they got married. Now, according to Hindu Marriage Act, is this a valid marriage? Now, the lawmaker Papa, he took the book and he started reading the law. What does it say? The preamble, I mean, the section 5 says, yo, why? Doesn't this know it is marathon? Long title, preamble. Yes, people, it says here, a marriage may be solemnized between two Hindus. So, sir, here it is written as may. Meaning what? A marriage may be made between two Hindus. So, the couple said, sir, see, it is written as may. So, it need not be always Hindus. It can be other religion also. Since Hindu Marriage Act. So, couple said this. The matter went to court. Now, the judge got confused. Just section 5 actually says that. Now, what to do? May can be interpreted as shall can be interpreted as may. Sir, so take may and put to shall. Now, you only try to read the meaning. What will happen? A marriage shall be solemnized between two Hindus, meaning force them also and get married. Sir, humko nahi, hey, get married. Act only is telling. Who are you to say no? I cannot read may as shall here. What he means is, if they want to voluntarily, let them get married. Now, sir, what was the question? How to know whether this marriage can be considered as valid or not? Judge referred to the preamble, and the preamble said, an act. What is Hindu Marriage Act? It is an act to amend and codify the law relating to marriage among Hindus. Now, because of this, according to this law, that marriage was considered as not binding according to the court. They did a registration marriage, that's a different story. But according to the Hindu Marriage Act, this was not valid. Understood? Got a fair idea na? Pakka na? That's the beauty of preamble. Always remember, when the section is clear, do not go to preamble. If section 5 was very clear, preamble will not come into picture at all. This applies to all the internal aids. Wherever the section only is clear, you need not have to go and refer to long title, short title, preamble not required. Clear? Okay, sir, next. Heading and title of a chapter, meaning Companies Act only, Chapter 2, Incorporation of Company, Chapter 3, Prospectus and Allotment of Securities, Chapter 4, Share Capital and Debentures. So if you are getting confused between something, refer to the chapter, it can help you in something. Understood? Next one, marginal notes, whatever we are writing here, your entire section will be there. For example, we saw LLP Act, Compromise, Arrangements and Amalgamation. On the right side we wrote, the entire paragraph means these people can go and apply to NCLT. NCLT will order for meeting. The meeting should get a majority number 3/4 in value. That's what the entire paragraph said. This is called marginal notes. Always remember, marginal notes is not a valid internal aid, because marginal note is not given by the interpreter. It is not given by the lawmaker. It is given by an author. If you buy my book, I would have given this. How can you say this is the lawmaker's intention? You are seeing internal aid. That means something which is available in the book. In the book means he should have made. How am I making? Marginal notes are always given by authors, scholars. Understood? Research people. They do it. So that's the reason marginal notes is not a valid internal aid. Okay, next one. Definitional section. We have considered everything. Definitional section means refer definition only. But remember, means so include, mean and include. Means dead end. Include means add. Means and include dead end. Correct? Yes. In General Clause Act, you will see person includes they have written. They have written only 3 people. That means you can write, you can stretch. HUFO partnership, everyone are included. Clear? Okay, next one, sir. Illustrations, sir. Example given in statutes only. This is best example for Indian Contract Act. If you open the bare act, whatever are the examples given in your CA foundation now, that time materials, everything is given in bare act only. Lawmaker himself said, this is what I meant, example A, B, C. Everything is given by him only. Illustration. Understood? Next one, proviso. Exceptions, proviso, saving clause. Nothing but people similar to whatever we saw, notwithstanding, subject to, or what is that? Notwithstanding, subject to, saving clause. Both of them have to be interpreted together. Same thing. If at all I am saying this is not applicable to you, it is not applicable to you. Provision means what? Sir, in a private company, the number of members shall not be more than 200, provided. Generally, everyone is counted in shareholders, but some people are not counted. Past and present employees. It's a provision, meaning what? Exception. Understood? Okay. Next one, explanation. Associate company. Associate company means what? A company in which another company holds significant influence. I started breaking my head. What do you mean by significant influence? He has only given me the meaning. 20%. Explanation. Associate company, under that explanation is given by the lawmaker himself. Understood? Next one, schedules. How to prepare balance sheet? Schedule. It is also internal aid only, no? Yes or no? CSR. On what and all you will spend? Schedule 7. Why does schedule? What is schedule? Lawmaker, instead of putting some big formats in between the act looks very voluminous. So what I will do, I will keep it at the end. If you want, you refer. If you know, then it's interpreted. Understood? Okay, read the statute as a whole. So do not break and read it. You have to read it as a whole. Off, in direct off. I've kept it to 29. Okay, na? పైనే ఉందిరా అది ఏది సెకండ్ ఫ్లోర్ పంపిద్దామా ఓకేనా ఇది అంతే రంగ పైకి పోదు చాలా వద్దు పోతుందిరా అది రే కెమెరా చెప్తా ఉంటా నీకు Okay, next one people, external aids. External aid means people, internally it is not available, you are referring outside. Simple one, first one is called historical setting. So if you want to understand the meaning of the law, try to understand what prevailed or what happened during that time. You will understand. Best example is FEMA. When FEMA came into picture, before that we had something called FERA, fear only. That's why, I don't know, if you remember our introduction of FERA, I told you, in FERA if you did a mistake, imprisonment Allah, direct jail was there in FERA until 1999. That's the reason people never dreamt of doing anything between two countries. Got it? So historical setting. Why? There is a reason. Because East India Company. Consolidating statutes and previous law. I have a problem with GST. I'm not able to understand. GST is a consolidated law of various other laws. Example, service tax. Services. Earlier what used to be there? VAT used to be there. Sales tax used to be there. Excise used to be there. Now if I have any problem, I may refer the previous thing. What it meant, I can refer. The third one, usage. Nothing but customs. External, no. Now Hindu Marriage Act. How is marriage done? How will you know? Now Hindu Marriage Act said it's a marriage done between two Hindus. How is it done? By tying 3 knots. Where is it written? Hindu Marriage Act is not saying anything. Triple talaq. Why only 3 times? Of course it is not there now. Why 3? Customs. Got it? Saptapadi. Why not Panch? Correct? Customs. Earlier and later acts and analogous acts. Parimateria. What do you mean by that, sir? If at all there are 2 statutes which are talking about the same matter, you need to make sure both are satisfied. However, if there is any problem, if there is any discrepancy, if there is any repealed act, then you need to take it away. Later act will prevail. Dictionary definition. Obviously, when we don't have anything, you have to do dictionary meaning only. Usage of foreign decisions. Agreed? Smith versus Hughes only for us is a very good example. Salomon versus Salomon. You would have studied, no? Happened in India, na? Salomon versus Salomon. CA Foundation would have studied. Balfour versus Balfour. Carly versus Carbolic smoke. Hey, without foreign decisions, your Indian contract only is not there. At least 30, 40 decisions will come. Ashby versus Railway Carriage Company. Turkand's rule. Royal Bank versus Royal British Bank versus Turkand. All these are what? Foreign decisions. When the law is similar, when the circumstances are similar, you can apply the law to you. Clear? That's all. Ashtana, oh my god, that's all interpretation substitutes. My god. Sir, Ashtana, come and sit here, you will know. Huh? You come and sit here. Ashtana. It was simple, no? అట్లా వస్తాంటే అటు అప్పుడప్పుడు. Okay, Isham, let's start the next chapter. Last chapter. How's the Josh? We don't have at all, sir. Last time, even I don't know how we did it. We did around 11 hours in a day. I also said my team because we started at 9 o'clock in the morning. We ended at 9:45 the previous day. Sir, you ask the students, they will know. You will not know. Actually, we pushed because of them only. They said, no, sir, we can sit, and we did it. And even I felt, that product was not good because even I also pushed it because my timelines was completely packed. I had to fit in and I had to do that marathon. So today, if you look at YouTube, I think by today, that video will touch 1 lakh views. I think it is going somewhere around 99,850 or something. No, by default, in a day, I'm telling you that video comes around 400 views, and I'm talking about old syllabus. It's not there, and that's still getting views. What I'm saying is, if content is good, and that's what I felt. Okay, it might be a bad product for you, but if you do it in the right way, that will have a product. It will make sense for so many people. Correct, no? Yes or no? So because Siddharth said yes, let's do the next chapter. General Clauses Act. General Clause Act, basically I sense point coming from the interpretations part. So what I have done, people, you remember we had seen a big list of sections. You remember? Starting from section 5 we had started. 5 to 29 if you remember. So from here it started, yes. So what I have done, people, all the sections I've tried to put it in a single line. Meaning, what does section 7 say? In 1 line. 8, 1 line. 9, 1 line. If you know this, that means we would have studied all that section 5 to 29. Clear? So let us try to see about this only. I feel these are more important and we'll discuss the other aspects. Let us not get into the complete part of that central government to when the law was made. That is fine. But I'll be covering the rest of this part. Is it clear, all of you? Yes? Okay, sir. Now, first of all, sir, what is the meaning of General Clauses Act? Why do we even need it? If you remember when we were doing iOS and I told you, if a lawmaker is confused, first I will refer to the sections given in that particular act. If at all it is still not answering my question, then I will refer to the next act called as General Clauses Act. Sir, why is General Clauses Act so important? Remember, now for example, there are some words which will just be defined like that in any law. For example, I will say 2 kilometers. Here it might not be there. In terms of Factories Act and all, you will see a lot of it. 10 kilometers, 2 kilometers. For example, you cannot set up an industry within 10 kilometers of human residence. Now my question to you, 10 kilometers, how should I take? I will take it like this, sir. First you go Gandhi Bazaar, MG Road, and you go take a metro, come under, keep keep revolving here only. So you come over here, so this is 10 kilometers. Can I say, So where is this distance defined? Now this distance is required in so many acts. People, for example, within 100 yards of any school or educational institution, you are not supposed to sell pufu related products. 100 yards, how do I take it? That means like this, okay, now imagine the gate is here. I'm not supposed to set up any stall here like this, correct? I'll do one thing, ground floor, first floor, let us open one pufu. Distance is like this, no? Here who said? Ram is like, sir, wonderful idea. Huh? Yes, this clear, So, ఎవడ్రా నువ్వు ఇంత టాలెంటెడ్ గా ఉన్నావు సో పీపుల్ now what are they saying? They're saying people there are so many words which might have a common meaning and I can't keep writing this meaning in every act. So what did they do? They passed an act called as General Clauses Act. General meaning, what is the meaning of this general words? What do you mean by these things? They referred to all the acts, and if you have any problem in this word, you come and refer General Clause Act. For example, if you read Companies Act, people, they have said, he shall not be a director of more than 15 companies. He shall not be a director of more than 20 companies. She can be a. Law has been written like this. He shall not be a director of more than 20 companies. She can be a. So where is it given? So how many acts are there? So what they did, they passed one act called as General Clauses Act. General Clauses Act applies to all the central acts, not for the state act. What is there in your syllabus? This applies to all the central acts. Even states can also make their own General Clauses Act for the states. Now sir, what is the purpose, sir? To make sure whenever there is ambiguity, this gives you a source of interpretation. Second one, it avoids superfluity of law. Sir, another tutti frutti? Tutti frutti. Superfluity means what, people? The law was becoming bulky. You're making it a little thinner and sleeker. Why? Because I need not have to define these words again. Agreed? Yes, sir. That is what is the main purpose. The entire purpose was actually given in this case, and the case is called as people Mines versus Karamchand Tappar. In this case only it was said, General Clauses Act actually makes the law easier, interpretation easier. It avoids superfluity of law. Understood? Yes, sir. So, objective of General Clause Act 1897, it shortens the language of Central Act. It provides uniformity of expression. Financial year, defined here. It means same. Correct? Now, they have defined something called as month. What do you mean by month? For example, day after tomorrow, you will be celebrating New Year. Correct? Ugadi yaವಾಗ ಇದೆಯಲ್ಲೋ? Oh, sir, we are from foreign Britishers, sir. What is saying? Correct? Few people will wish. They will wish on Ugadi. Why? Now, can't I take Tuesday as a New Year in all my references? Month, Chaitra, Vaishakha. ಚೈತ್ರಾಗೆ ನಿಂತೋಯ್ತು ಸರ್ ಡೇ ಸರ್ ಚೈತ್ರ ಹೇ ಕರೆಕ್ಟಾ ಸೊ ಅಂಡರ್ಸ್ಟುಡ್ ಸೊ ಮಂತ್ ಇಸ್ ಡಿಫೈನ್ಡ್ ಹಿಯರ್ ಇಟ್ ಮೀನ್ಸ್ ಬ್ರಿಟಿಷ್ ಮಂತ್ಸ್ ಸೊ ಇಟ್ ಮೈಟ್ ಬಿ ಸಿಂಪಲ್ ಫಾರ್ ಯು ದಟ್ ಇಸ್ ವಾಟ್ ಇಸ್ ದ ಮೇನ್ ಪರ್ಪಸ್ ಆಫ್ ಜನರಲ್ ಕ್ಲಾಸ್ ಆಕ್ಟ್ ಓಕೆ guards against slip and oversights. If something is missing, it will help as an interpretation, aid for interpretation. Chief Inspector of Mines versus Karamchand, and this is what it said, superfluity. Clear, Adana? Okay, done. Sir, next one, sir. Applicability. Do you guys want this applicability? Technically, well, remember, I can bifurcate India into three things. One is before independence, after independence, and when the Constitution of India was passed. 26 Jan 1950 is when we adopted Constitution of India. Now, sir, I can divide these timelines. Now, whatever was before India, this is called as people British Raj. Before independence came, did we have any laws in India? We have so many, no? Indian Contract Act, IPCA, your tax, what is that? Sale of Goods Act. You have so many acts, no? Sir, they are telling all this was passed at the time of British Raj. At that time, who was there? At that time, we had people called as governor generals. Governor general or governor general in council. They used to govern the country. Sir, during this time, we call this as dominion legislature. Meaning what? Before constitution, before parliament came into picture, after independence, before parliament, there were laws passed. Now, what do I call the laws here? That is called as what people dominion legislature. Now, this is called as after that central acts. Here is where you get union list, state list, concurrent list, basically parliament, state legislature, states make their own act, central makes, parliament makes a central act. Correct? Now you need to know this to understand what is the meaning of this. This is not there in our syllabus. But to understand to whom does General Clause Act applies, it says it applies to all central acts. Meaning it means act of parliament, today's date. And it includes act of dominion legislature, meaning between 1947 to 1950. It also includes two governor generals, meaning before independence also. So General Clauses Act applies to all the acts passed before constitution, after independence. But remember, General Clauses Act does not apply to any act made before 1897. Understood? Before I came into picture, before this act came into picture, anything is there, for that it will not apply. Anything which comes after this only 1897 Act will apply. General Clause Act will apply. Understood? Yes, sir. Okay. Now, sir, central government. Okay, that's not. Okay, let us start with section 5. Okay, section 5. What does section 5 say, sir? Act come into operation. Sir, when does the act come into effect? Because people, you would have seen so many things. How is a law made? First a draft is made. It is passed in both houses of parliament. Signed by president. Published in official gazette. When is the act actually coming into picture? The first thing is they say, people, if the act clearly says that the act is coming into effect from this day, if the act says, people, then the act will be effective from that day. If the act is not saying anything, people, then the act comes into picture from the day the act was signed by President of India. If it is the case of before commencement of constitution, Governor General. Understood? That is what is section 5. Section 6, effect of repeal. What do you mean by effect of repeal? Now imagine, people, if any law is repealed, meaning what? There are so many laws that are removed in our country. Companies Act 1956 has come to an end. There are, your excise duties, service tax has come to an end. But imagine under that, if there was any law that was passed, imagine there is any penalty that is levied. I have subjected you to imprisonment. Now Companies Act 1956 came to an end. That means, does the punishment come to an end? The answer is no. Just because repeal means what, people? An act coming to an end, removed. Just because an act is removed, people, whatever are the punishments passed, whatever are the rights created, simple, I'll tell you. Under Companies Act 1956, Infosys was given certificate of incorporation. 1956 Act is repealed. Does certificate of incorporation of Infosys come to an end? No. It does not affect any right. It does not affect any privilege, obligation, punishment, penalty. Understood? Affect any litigation going on. Pakkana? Okay. That is your section 6. Next one, sir, section 7. Here only we will, simple things we'll do off. Section 7, people, revival of repealed enactments. Oh my God, section 7. 7 stands for Undertaker. Undertaker had 7 lives in our childhood. Even after die, he'll come. Dies, he come. Die, come. Die, come. Correct? That is what is section 7. Meaning what, sir? An actor can rest in peace. And again you can bring it back. Rest in peace. You can bring it back. We will lose hope on RCB. They will hit 250. Isala Cup Namde. They will again take us down. They will win one match. Isala Cup Namde. Correct? So people, a law, a section can be deleted and it can again be entered. Example, sir. Section 11 of Companies Act talks about commencement of business. We saw also when we were doing marathon itself. We had people, they removed it, they again felt a need, they reintroduced it. Section 10A. A section that is removed can never be again brought back to the same number. 11 is gone because tomorrow you need to know that someday this was removed. If I bring it back to the same thing, there creates a confusion. Now imagine you Google, I will get both the results. 11 has been removed result also I'll get. According to you, if they are reintroducing it, that also I'll get. Then which one should I follow? So to avoid confusion, a repealed section can never be introduced in the same section. Yes, sir. Next one, in case of repeal and reenactment, references in any other enactment shall be considered as references to the blah, 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 blah. First, let us try to understand section 28 before you read section 8. Section 28 says people, citation of enactments, one law can give a reference to another enactment. What is the definition of securities? Companies Act says, I don't know. Refer to SACRA, Securities Contract Regulation Act. Whatever SEBI says security, that is what is in Companies Act also. One act can give a cross reference to another act. Pakkana, Income Tax Act says, what is a company? Company is something as defined in Companies Act 1956. But sir, 1956 is deleted. If at all any act is given for a repealed act, and if at all any new act is passed, you need to read it also as new only. Even if it is not there, it is your duty to read it as if they are giving a reference to the new act itself. Understood? That is what is section 8. 28 says you can give a reference. 8 says if at all given a reference, if that act is repealed, you need to read it as if the reference is given to a latest act only. They understood that? The thing is, they will see how simple it is. And you need to introduce it in the parliament. A session should happen over it. Thing like that. Yes, sir. Section 9. Commencement and termination of time. A dividend has to be paid within dividend has to be first transferred to a separate account within 5 days. So imagine sir, dividend was declared on 1st January 24. I have to transfer it to a separate account within 5 days. So what will that be? Should I count first or not? First, second, third, fourth, fifth. So should I transfer to fifth? Or second, third, fourth, fifth, sixth? Sixth? Correct? That's what they are saying. Whenever a reference is given to the time, the day, wherever they are telling you, from this day, the day you should be excluded when you are counting. The 5 days does not include one. And the last day is counted. 5th day is counted. Unless otherwise specified in their own acts. Section 101 says clear days. They are only telling me. Understood? Okay, done. Section 10, if the code understood? If there is a problem, imagine sir, the lawmaker tells me if you have a problem, come and appeal it with the tribunal. Where did you say? Section 58, it says refusal for registration, 30, 60. In the case of public company, read as 60 and 90. Go to tribunal, no? Sir, if at all on the last day, whatever you are saying, the court was closed, sir. The court was not in session. No, you can go when the court reopens. On the last day if the court is closed, it is not. You should not think your 60 days is over. You need to read it as if when the court reopens, you will have a time to come and reappear again. Understood? Done. Section 11, measurement of distance. Pufu. Yes, sir. You need to take it as a straight line, horizontal plane. Meaning what, people? Now imagine if you go towards this Kerala and all, too much of valleys, hills, Mangalore and all. It is all hilly places. 2 kilometers. I mean, if I say 2 kilometers, shall I take like this? One tunnel will be there. Can I go? Can I keep it here? They're telling you, take everything 2 kilometers in a horizontal plane. So it will be like this. You can't keep anything here. That's the meaning of it. Understood? Okay, done. Section 12, duty to take pro rata. If at all you are smuggling wine, one bottle if you smuggle, 1,000 rupees is the penalty. You smuggled two. What will be the penalty? 2,000, that's all, that is pro rata. If you are doing anything more, apply it accordingly. If you are doing anything less, apply it accordingly. Gender, masculine includes feminine, feminine includes masculine. Correct? But don't say maternity benefit act, humko chahiye. Correct? That means people, whenever a reference is given, masculine means anywhere if a lawmaker refers as he, it includes she. Director, he includes she includes he, but not everywhere. So not only that, sir, number. Now only I said he will be liable. What if 5 directors are there? Singular includes plural, plural includes singular. Power conferred may be exercised by authority from time to time, meaning when the Companies Act was made, we gave power to ROC that you can approve that you can approve situation of Section 8 companies. You can establish, you can pass license. We gave power to ROC. We gave power in the 2013. That doesn't mean you can exercise that power only in 2013. That power can be exercised by the authority time to time. As and when the case comes, you can exercise your right. Next one. Section 15. Power to appoint, maybe by name or by ex officio. Who is the chairman of IEPF? Secretary MCA. I can directly write it as, imagine people, I will say, someone say Nirmala Sitharaman will be the chairperson of IEPF, or the appointment can be made as ex officio. Ex officio means what? I will give a reference to whoever is the minister of MCA. That person will be the chairperson of IEPF. For example, whoever takes FM will be a CFO of the company. Tomorrow FM faculties may change. Whoever is a FM faculty will only become a CFO. That is the meaning of ex officio. Ex officio means because of your designation in one place, you are earning another designation. That's the ex officio. Next one, power to appoint include power to suspend or dismiss. Say ROC has a power to issue license to do Section 8 company. If you do something wrong, then I have a power to take it back as well, revoke the license. Next one, to indicate application of law to person executing function of an office, it shall be sufficient to mention the office title. Meaning what, people, if I have to tell this law is applicable to a person. Now imagine there was a ROC called as Sajeevan of ROC Bangalore. I can say Companies Act is applicable to Sajeevan, or I can say Companies Act is applicable to all the ROCs of say Karnataka, Bangalore, any person. I can give a reference to the person or I can give a reference to the designation. Both are allowed. Next one, to indicate relation of law to successors of functionaries. Section 17 talks about government authorities. Section 18 talks about body corporates. Meaning IEPF is a body corporate. If I have to tell, IEPF applies to chairperson. So IEPF is a body corporate. SEBI is a body corporate. IRDA is a body corporate. Now for example, we saw NAFRA, chairperson. He should be a person of eminent. I'm telling chairperson. Why can't I tell it in the job description or in your appointment letter? Why can't I tell it? Because I'm telling it, it is applicable to every chairperson that comes to this NAFRA, not only you. So, just the way we gave a reference to the law in the government, I'm giving the same reference to a body corporate created under the law. Examples are RBI, SEBI, IRDA. In that authorities, imagine a chairperson is there. If I have to give a reference, instead of writing it in his appointment letter, do one thing. Write it generally in the law only, that this law is applicable to the chairperson of this IRDA, chairperson of NAFRA, whoever is a chairperson for him, the same rules are applicable. What is that? He should have experience in law, finance and all. Correct? Yes, sir. Or else I have to mention in there each of their appointment letter. Correct? So what if the chairperson has some problem? He has to leave. He has to vacate. Imagine he is on leave, sick leave. Then what will happen? whatever are the laws applicable people to the chief, to the superior. In his place, the next subordinate will come. So imagine chairperson is there, huh? He has an assistant. If chairperson is on leave, this person will take the authority of the chairperson until he is back. Sir, okay, but I am actually an assistant. What rules are applicable to me? Whatever is applicable to assistant or whatever is applicable to the chief. When you are taking the power of chief, whatever is applicable to chief, that only will be applicable on you. That is what is section 19. Section 20, sir. Notification order scheme rules shall have same. What is this, sir? People, Companies Act. We saw some amendments came. Section 23 and we saw section 89. In 89, they have given beneficial interest. I saw the sheet, people. Nowhere it is defined what is beneficial interest. What they are telling you, any notices given, any amendments made, any circulars made, in that again they will not define the meanings of the word which is already defined in the Principal Act. So the words in the amendments, circular notices will have the same meaning that is there in the Act. That is what is the section. Simple, huh? Next one, 21. Power to issue include power to add, amend. Correct, huh? I have given a power to a lawmaker. For example, Securities Contract Regulation Act. We created security related laws. Central government said, let us do one thing. Let us create a specific body. Let him take over everything with regards to securities. We created SEBI. The authority created will also have a power to add anything, amend anything, vary anything, rescind notifications. He can do everything. So authority created, he will have a power to amend it. So we have created SEBI. SEBI can do anything with regards to security laws. He can change it, he can replace it, everything is possible. Next one, establishment of any court, appointment of judge or fees with respect to the act which has not come into force. It shall not be effective until commencement of the act or regulation. For example, Companies Act 2013 said there were all sections talking about NCLT, tribunal, everywhere it is already written. But tribunal had never been passed at all. Companies Act 2013 had the words called tribunal. Yes, sir. For example, 58, it already had the word tribunal, but tribunal was not yet formed at all. When was the tribunal formed? Tribunal came into picture in the year 2016. Understood? They are telling you a law can be passed in parts. The entire law need not be passed at once. You can make a law in parts. Meaning what, people? As a whole law will be passed. But the effective of the law can be made or you can postpone it for a different dates. The next best example is NAFRA. When did NAFRA come into picture? Correct? So there were different timelines. Until that, clear? That's what they are saying. See here, establishment of any court, appointment of judge with respect to act which has not come into force, it shall not be effective. So 58, the tribunal word has no effect until tribunal is created. That's what they are saying. Clear? Then until then, what did we do? There was one more court called as CLB, Company Law Board. Until NCLT was created, we used to go to CLB. Clear? Section 23. How is a rule made? We have seen the first draft is made, committee, you will pass it in both the houses of parliament. The same thing. Correct? Section 24. Order, scheme, rules, bylaws of repealed enactments shall continue to re-enacted law unless otherwise specified. Meaning what, people? Imagine under Companies Act 1956, they have given some circulars, they have given some notices, they have passed some rules. These rules will even continue under 2013 Act also, unless otherwise specified. Meaning, if 2013 Act has clearly written, it has written also, this rule shall repeal all the acts, rules, notices, circulars, amendments made under 1956 Act, then everything comes to an end. If not, just because the Act comes to an end, the circulars, the notices, the rules, the bylaws does not come to an end. If you want it to come to an end, specify it. If not, by default, it does not come to an end. Clear? Next one, recovery of fines. Who will recover the fines? In the entire section you have seen, no. You have to pay fine or penalty. Who will come and recover it from you? If at all any person is created under the authority to recover the fine, he will recover the fine. If not, sir, follow IPC or CRPC, Indian Penal Code or Criminal Procedure Code, to recover the fines levied by authorities. If anyone is created under the law, follow that. If no one is created, then follow IPC or CRPC. Clear? One person shall not be punished for same offence under two different laws. Meaning what? Under Constitution of India, this is also called as double jeopardy. Meaning what? If I have done an offence, according to this offence, I can be punished under two things. Law says, now imagine people, check bounce case is a civil offence also, it's a criminal offence also. In both the cases it is defined. You cannot punish me here for 3 years, you cannot put me in jail here for another 3 years. For the same offence you cannot punish me twice. For example, imagine if I do any mistake with regards to shares. If a listed company does any mistake with regards to shares, SEBI is also applicable, Companies Act also will be applicable. I will punish you under this act also, I will punish you under this act also, cannot be done. This is only called as prohibition against double jeopardy. You cannot be punished under the same offence, for the same offence twice. Yes, Sam. Next one, sir. 27, sir. Service by post. Meaning, sir, I have sent, the court has sent you the notice. You did not take it. Now, whether this notice is delivered to you or not, if these three conditions are satisfied, that means it is delivered. According to me, 26, 27 are very important. Remember. What does it say? Court has sent you a notice. You did not take it. Is it considered as given or not? If these three conditions are satisfied, it is considered as given. What is that? Have you paid the money for the post? Have you written the proper address? Have you sent it by registered post? If three conditions are satisfied, whether he took it, it lost in transit, it is none of our concern. It is considered as properly delivered. Important exam, you may have this question. They will give you a scenario. Next one, citation of enactment we saw. Section 29, General Clause Act shall not apply to laws existing before commencement of General Clause Act. Correct? Yes, sir. Apart from this, there is some definitions which are very important that I will cover. Definitions, act is okay, affidavit, central act, central government. Central government, people, I'm not covering this one particular thing again, but what I will tell you, if you still want to learn about that, in the previous amendments, whatever, not amendment, in the previous marathon, whatever I've done, in that, in general clauses, I've gone into the central government also in detail. If you guys want, you can refer that also. You guys, open the video, whatever we have recorded, it will say, discussed in detail, just see that once. Exam point of view, promise on me, they will not ask. Okay. Next one, sir, enactment of good faith financial year, immovable property is important. What do you mean by immovable property? Land, immovable property. Benefits arising out of land, meaning what? In examples I told you, benefit arising out of land, people, I have a big place. Now imagine if you go towards this Coorg, Kerala and all, there will be big, lakes, ponds, rivers and all, backwaters and all will be there. Few people will rent it out for fishery. So a right given to another person to catch fish, this right is considered as immovable property. It will come under General Clause Act. It is considered as immovable property. Sir, another example, sir, I have a big land. In this there are mango trees. I buy from this person a right to take all the mangoes. How much ever it comes, it is my right. If I get less crop, my risk. Get more crop, my benefit. If I take a right to pluck all the mangoes and if I decide to sell, the benefit arising out of the land only, mango, immovable property. Hey, mango is not immovable property. I'm telling right to take the benefit arising out of the land. I will take the mango. That right is again immovable property. Sir, what about the tree? I sold the trees and the mango. What is tree considered as the immovable property or movable property?
Immovable property unless it's agreed to be severed before the contract of.
So if the tree is agreed to be cut, it becomes a movable property. Until it is agreed to be cut, it is a immovable property. As long as it is attached in the land and you guys have not decided to cut it, it is a immovable property. Once you decide to cut it, it becomes timber. Timber means what? A wood is specifically grown to be cut. Meaning you will use it for furniture. Correct? Yes, soil. In one of the cases it was held, soil is also immovable property. Soil. What will you use soil for? Benefit arising out of land only, no? Sir, what will I use? Shapa. I will curse you, no? That is benefit only, no? No. People, soil, you use it for bricks. Or nursery. Yeah, sir. Nursery, UKG, LKG. Plants, yes or no? See, things attached to the earth, building. This is land. Attached to earth is building, no? Or it can also be trees. Timber is an exception. Permanently fastened to anything attached to the earth. Meaning, sir, building is attached to earth. Permanently fastened. Windows. Correct? Doors. Those will come there. Okay. Next. So, standing timbers does not include growing crop, grass. Growing crop is people, it specifically is called as movable property. Goods. Grass, again movable property. Cattle feed, for cow and all they will give. Palak, methi, coriander. It's a grass only, no? Leaf only, no? Yes, it can be covered in both. Yes or no? Indian law month, Chaitra, Vaishaka, British calendar, official gazette, swear, writing. Okay. Yes, sir. Let us be complete, people. I have covered the main definitions and your sections. I have left central government and I would have left one authority. That's all. This I specifically tell you guys to see this previous thing because they have not asked a question on it. Here all of you. Except that I believe we have covered everything. Okay. Apart from this, any doubts? Any doubts? So by this we complete this particular syllabus part. Yes, sir. So if you guys want to go for a break and come, we'll also cover RTPs. Yes, people, go for a break and come. That is cover RTPs. 10 minutes. Yes. Let's be back at 8. Hey, go for 10 minutes and come down. RTPs alone are there, da. 12 minutes, da. Hey, क्यों रे ये ऐसा करती सो? Okay. So let's do your RTPs, people. Important from exam point of view. Concentrate. Amendments we have done. For people who are marking the timelines, whoever does it in the timestamp in amendment, whoever does it, there is 2 amendments which I have covered in the marathon only. If possible, try to give a reference to both the amendments. One will be in chapter 3, one will be in chapter 7. One is in section 23, one is in section 89. So just give a timestamp if anyone is doing it. A request from my end. Okay. Next one, people. Questions and answers, people. Let's start. So I told you, people, in your exam point of view, there are 2 types of MCQs you can expect. One is 1 mark, directly will just give it off. 2 marks questions. They can directly give you a question. For 1 MCQ, there will be 1 question. That's all. The next type of MCQ, people, there will be a lengthy provision. To go through only, you will take maximum amount of time. You will understand. Let us try to read this provision only. You will understand how difficult it is. For this, people always remember, let us follow 2 strategies. Strategy number 1, do not read the question first. First is go through the MCQ. What they are asking you, directly read off. And then go back and see, okay, what they are trying, and that part try to mark. Easiest way to save time. Is clear? Yes, sir. Okay, sir. Now applying that, I'm first going from the bottom to top only. Yes, sir. Okay, sir. I'm going from bottom to top only. Okay, what does it say? First one, it's talking about what is the last day for conducting a AGM. Something with regards to conducting AGM. Timelines becomes important. So I can easily say they're asking me a question somewhere revolving around incorporation. Correct? If not, when will AGM become a problem for you? That's all. It will be somewhere revolving around that only. What is the due date for connecting AGM for another company also? There are two companies. Okay. The Companies Act provides that in addition to standalone financial statements, the company shall also prepare consolidated. So see, for me, this is a keyword. Now when I'm reading the question, when it comes around CFS, read it twice there only, instead of coming from top to bottom. Okay. Next one, the Companies Act 2013 provides that in addition to standalone financial statement, the company shall also prepare consolidated financial statement which shall also be presented before AGM. Accordingly, the consolidated financial statements of Golden Limited for the financial year that even includes, same question na? Day. I'll bear a company, he'll bear a company. Please select which is correct option, which is the most correct statement. This is a bouncer. Which is correct option? Okay, we'll see. We'll read the question and come. Okay, next one, sir. That's all, huh? Okay, case 2, we'll go back. So there are 5 questions, people. Now try to read the question. What are you saying? Golden Limited is a listed company which is incorporated in 2013, having its registered office at Delhi and corporate office in Noida. It is registered office, there is something called as Golden Limited, which is incorporated. Because they're asking me about AGM, I'm writing down the incorporations for my safer side. Okay, it's a listed company with an authorized capital of 2 crore, 20 crore. Because there is nothing which is revolving around anything about this, for me it is not making sense, so I'm not writing anything about the capital part. The company is in construction activities like construction of buildings, roads, etc. Okay. On 8th Jan 2020, the company incorporated a wholly owned subsidiary, D Limited. So they have opened one company, wholly owned subsidiary, D Limited. When, people? 8th Jan 2022. Okay. Which is involved in supplying of construction materials like steel, iron, etc. D Limited elects to choose to prepare its first financial statement for the period from 8th Jan to 31st March 2022. Technically, are they doing it right? Huh? Okay, there is something here, we'll see. On 2nd Jan 2022, Golden Limited incorporated a newly wholly subsidiary, E Limited. What are they doing there? E Limited. When did they incorporate? 2nd January 2022. Okay. Okay, 2nd January 2022. Okay. For providing project management consultancy services to its customers or to parent company, on 5th Jan 2022, Golden Limited, through its subsidiary E Limited, acquired 100% partnership interest in XY. Okay. Golden Limited on 5th Jan acquired E Limited. Okay. Through E Limited on 5th Jan 2022, they acquired one more partnership firm, it seems. What is the partnership firm? XYZ and Co. Correct? Huh? Okay. For the XYZ and Co. Okay. E Limited elects to choose to prepare its first financial statements for the period from 2nd Jan 2022 to 31st March 2023. They are doing it right. And conducted its AGM on 16th August 2023. That is also right only. On 1st July 2022, the subsidiary company D Limited incorporated a new wholly owned subsidiary F Limited. What are they all doing there? Are you getting the point? Exam mein F Limited. Okay. And when is that? 1st July 2022. On 1st July 2022, they incorporated. Which one? D Limited incorporated a subsidiary F Limited. D incorporated F Limited. Okay. Next one, sir. Golden Limited prepared its standalone financial statements for the year 21-22 and presented before the board of directors of the company on 25th August 2022 for their approval, and the same were adopted by the shareholders in the AGM held on 2nd September 2022. Okay. Golden Limited prepared its standalone and consolidated financial statements for the year 2023 and presented before the board of directors of the company on 20th August 2023 for their approval, and the same were adopted by the shareholders in the AGM held on 26th September 2023. That's also within time only. On the basis of above facts and by applying applicable provisions for answer. Okay. What is the last date for conducting E Limited? Conducting AGM of E Limited. Now come back. We have our data. E Limited was registered on 2/1/22. So I will check if they are asking about first AGM or second AGM. It will be first AGM. So obviously my financial year will end on 31st March 2023. So my first AGM has to be 31st December 2023. I got my first data. Correct? 31st December 2023. Agreed? Okay, sir. Next. What is the due date for conducting AGM for Golden Limited for the year ended 31st March 2023? Obviously, they were incorporated on 2013 only. So, it's a subsequent AGM. It will be 6 months. It will be 30th September 2023. Where is it? A. Correct? 100%. Data is helping. Pencil exam you have to write. See, questions are revolving around dates. Now, if we had not seen or if we had not read the questions first, you would have wasted time in writing now the share proportion or share capital also. You will write everything. That's why I say go from bottom to top. The Companies Act 2013 provides that in addition to standalone consolidated, the company shall also prepare consolidated financial, which also be prepared at AGM. Accordingly, the consolidated financial statements of Golden Limited for the financial year ended 31st March 2022 includes financial statements of, first of all, people, consolidated financial statements. It shall include for all my subsidiary companies, all my associate companies. Astana? Okay. So as on 31st March 2022, who and all are registered? That is important. Agreed? Okay, let us see. Who and all are registered? 31st March 2022. He is not registered. F Limited. D is registered. E is registered. 31st March 2022. XYZ is also registered. Agreed? Yes or no? Now come and say. Who and all? I forgot. D, E, XYZ. C is also there. Golden Limited, D, E, XYZ. Agreed? Yes, yes or no? Anyone has a doubt why XYZ? This is a question. Okay, wait a bit. Question number 3. What is the answer given? 3 is C. What is C? What is 3? D, F, and XYZ and Co. So because institute says C, then it is C. Sir, what are you saying, sir? People, this is a little tricky part. Concentrate. Section 129 says, people, a company shall prepare CFS for all its subsidiary companies and all its associate companies. But nowhere I am speaking about partnership. But according to your AS 21, whichever company enjoys control over any other enterprise, you need to prepare CFS. Unfortunately, if you ask me, is it Companies Act? Answer is no. I hope you guys understood. In Companies Act is silent on enterprise and all. It is not written. It is only subsidiary and associate. Of course, it includes joint venture also. Associate only. Because in associate definition, joint venture is there. That can be a possible question. This was a tricky one. Clear? Yes, I'm just giving you justification. No, it is given. Clear? Okay. The Companies Act 2013 provides that in addition to standalone financial statements, the company shall also prepare consolidated financial. 2023, F is also added, no? We saw somewhere it came in 22 or something. Okay. Please select which is the correct option. Okay. Golden Limited had given the notice for holding AGM in Mumbai on Monday. Where is Golden Limited registered?
New Delhi.
New Delhi, yeah. Then why did they give Mumbai? They have given Delhi. Oh. People, where should I conduct my meeting, people? They have one corporate office, one registered office. So many places we say no, registered office. So where will you conduct? You have to conduct in Delhi. Corporate office is like a branch. Branch is never considered for us. In class we had seen example of Infosys. Pune is there, but we will conduct in Bangalore office or in Christ. I would have told you, within city, town or village.
P&D as Delhi.
Wait, what is it? Not first at Delhi. Okay, Delhi are 2. Then they are revolving around some other thing. 11. 9 to 6. Correct? Agreed? So this is 8:30. Between what time you have to conduct? 9 to 6. So this Delhi is wrong. My answer will be 11 a.m. B. Time also they asked of Noda. Okay, but that's what the answer. That's all. In terms of children, I think 5 questions were there. Let us take 4. Partnership, let us, it's okay. I think we might lose a mark there, but let us take it as 4 marks. It was a tricky one, I understand. Let's do the same thing here also. Considering the provision of foreign exchange, FEMA Vantu Guru. Which of the following options correctly determine the residential status of Mr. Rajat Kapoor? So to answer this, we need to see the question. But they are asking a question on residential status. We'll see that. Considering the provisions of FEMA, how much amount can company remit outside India? Schedule 3A. LRS individuals other than individuals will come here. Project. Okay, we'll see. Considering the provisions of FEMA in respect of purchase of residential property. Purchase of residential property. Okay, by Mr. Rajat in USA. Okay, we'll see. Basically, around capital transaction, we'll see. Bhavesh and LLP. Okay, that's all. 3 questions. Okay, we'll see the question. Residential status and some project related. So for me, which project it is matters now. Correct? Infrastructure or other projects. And next one is people your what is that? Residential property. We'll see that. Okay. OMX Software Private Limited is a private company, okay, and having its registered office in Bangalore. So it's a PRI and is a wholly owned subsidiary of OMX Software Inc. Okay. Okay, let us take there is OMC Software Inc. This is in US. This has a wholly owned subsidiary OMX. That's in a private limited in Bangalore. So I'll take it as India. Okay. Software Inc. is situated in USA. Mr. Rajat Kapoor, Shubham and Peter are directors of OMX Software Private Limited. Okay. Rajat, Shubham, Peter. Okay. Mr. Rajat and Shubham are Indian residents. Okay. I'll read it as Indians. Peter is non-resident. Okay. He is a PROI. And stays in USA. Mr. Peter is also a director in that company. Okay. Mr. Rajat left India on 2nd November 2021 for the purpose of looking after the business of OK. So Rajat is going people. So everything is starting from Rajat. Okay. He is leaving India on people 2nd November 2021. So my financial year, I take it this way, people. 2nd November 21. And I will take it as 31st March 22. Always split the financial years given in the question. Now I know for a fact there was a question on Rajat on residential status. Go and see until which year they are expecting you the answer for. What and all they are asking for. If not, why should I break my head? Okay. 22, 23, 23, 24, 23, 24, 23, 24, 24, 25 is nothing there. So I need data until 23, 24. Agreed? Now I'll split my financial year further. Now first April 22 to 31st March 23. In this year, what happened, we'll see. He left for the purpose looking after the business. He has gone for business. First answer we have, if a person has left outside India for any of the three purpose, he will be excluded from the definition of PRI. So he will be considered as PROI from the day after leaving India. So if he has left when 2nd November he has left, from 3rd November he will be a PROI. Okay. Rajat came back to India on 12th Feb 2022. Oh, Annabond has come here only. 12th Feb 2022 has come to meet his family and left India on 26th Feb 2022. A short visit. Correct, huh? Okay. And went back to US to look after. When did he go back? 26th Feb only has gone back. Correct, huh? Okay. And went back to US to look after the business only. Again, he has gone for business only of OMX software. Mr. Rajat again visited India on 25th August 2022. So people, here in the second time he is going, he went on 26th Feb 22 and he came back to India on 25th August 22. Correct, huh? In this period, he was in US only. Agreed, huh? Yes or no, da? Okay. Now, sir, on 25th he has come back. According to our provision, day of coming to India is considered as India only. So, you need to take, if they are changing, it will be from 25th only. So, I will be just marking 25th because he has come on that day. Okay, next one. And stays in India for the whole year. For the whole year he stays. So, I will take it as from 26th 8/22 till 31st March 23. He has stayed in India. But I know for a fact they are asking me a status for 23-24 also. So, I will write down 1st April 23 to 31st March 24. I don't have a data, but according to my last data, he has been staying in India. Have they given a purpose? No. A purpose you do not know. Correct? Okay, we'll see. Now, come and see the residential status. First of all, now we have how many years totally? He has first time gone on 21-22. So let us write down clearly. 21-22. Is he a PRI or PROI? Until 2nd November, he is a until 2nd November, PRI. After that, people, PROI. Okay. Next one. 22-23. In this year, what has happened? He has from 26th Feb 2022 to 25th August 2022. He has been in US for business only. Has gone, no? Yes or no? So he has gone out for business, people, and previous year condition is also not satisfied. So people, I'll be considering him as PROI. Agreed? And when is he coming back? He's coming back on 26th August 2022 and he stays in India for 31st March 23. So sir, now in this case what is happening, people? A person is coming to India but he is staying in India, and the purpose of, tell you had a question.
22-23 half PROI, half PRI.
2023 half PROI, half PRI. What is the next category?
Because 25th August he has visited and he has stayed for the whole year.
Okay, 26. Okay, let us take it like this. 26th. Okay, there is something called as PRI also. Okay, we'll come back to that. Next one is, we have 2023. Okay, next data is for 23-24. Previous year. Now, when did he come to India? 26th August 2022. He has stayed in India for 31st March 2023. Forget about August. September, October, November, December. Jan, Feb, March. 7 months. Let us take an average of 30 days only. 7 3s are 21. For a fact, I know it will be more than 182 days. In exam, if possible, if question is revolving around, this is an MCQ, it's absolutely fine. If otherwise people, then try to show the days also. Important. Yes, sir. So I'm just taking, it has been satisfying all the conditions. Then, because of previous year condition being satisfied, current year is still in India only, I will take his status as PRI. Why? Because previous year 182 days condition is satisfied. Correct, huh? Yes, sir. Okay. So we have our data, PRI, PROI, PROI, PRI, PRI. We have multiple. We'll see how the question is given. Okay, treated as resident in India for financial year. Okay, they have given only financial year. Agreed, huh? But we have multiple data. What we have done is right only. Now what you do, try to see 23, 24, which one says the other option. 24 we have only one 23, 24, PRI, look at for PRI. Option D says India for more than 1 year and non-resident for 23, 24. Is it right? No sir, it's wrong. Sir, non-resident for 22. Wrong. Okay, our answer has to be between A and B. Okay. Mr. Rajat Kapoor to be treated as resident in India for financial year 22-23 and financial year 23-24 since he stays in India for more than 182 days. Mr. Rajat Kapoor to be treated as non-resident in India for financial year 22-23 since he left for the purpose of carrying business and resident for financial year 23-24. People here, they are clearly talking about business. Relevant, That is what happened, They have not given me the date, but they have told me the activity. He has gone out for this activity. So from that day, he will be considered as PRO. For me, I feel this is more relevant. When they are asking you, in 1 year, if you can see both the status, you can implement the answer in this way. Easy na? Pakka na? Okay. Next one. Considering the provision of FEMA, which one it was? They are into some consultancy. Which consultancy? Software, correct, no? Consultancy from a computer, that's what, software. So sir, we know for a fact, Schedule 3 current account transactions, with the construct infrastructure related, $10 million, here it is $1 million. Okay, now let us look at $1 million. Bouncer, they have converted a million into INR. 1 million is equal to how much? 10 lakh. If we don't know conversion, it's gone. Where is it 10 lakh written here? 1 lakh per project. I know for a fact it's not. I know 2 is nowhere there. So $1 million is nothing but 10 lakh only, no? USD. Nice one, If not, we will search only for. That was actually the confusion between these two. If you just to go as 10 and 1, if you mark 10 and 1 and go, 60% of the people will mark this. You will remember 1 million, you will not remember. 1 lakh, 1 million. Marathon now only happened, no? You'll remember. Okay. Okay. Considering the provisions of FEMA in respect of purchase of residential property. I don't remember seeing anything on residential property, no? They have given, Mr. Rajat had purchased the residential property in USA on 27th April 2022, which was self-occupied by him for residential use. Okay. When 27th April 2022. Okay, we'll see that. Okay, so what is the question? Considering the provision of FEMA in respect of purchase of residential property, which of the following statement is correct? Purchase of residential property by Mr. Rajat is a current account transaction. Is it Mr. Rajat has to sell his property before returning to India permanently as he becomes resident in subsequent years? No such law was there for us, so I'll just directly put us into mark. Purchase of residential property by Mr. Rajat is neither capital account nor current account. Purchase of residential property by Mr. Rajat is a capital account transaction. Which one?
The answer is C.
Because he purchased when he was in.
Very good, sir. Why did they give you the people? 100 people, 100 out of 100 will mark this as B. Yes, sir. Today, marathon, FEMA, last topic was this only. Anything inherited or de Villiers, whatever we saw, when you worked there, you purchased something there. FEMA transactions exempted. Exemptions under the rule. That is what we saw, no? Now see, what is the date they have given? 22nd, 27th April 2022.
27th April, sir.
Hmm.
He was in India.
Where he came to India on 26th August.
25th August. So on 27th he was in India.
27th April. ಯಾಕೋ ಹಿಂಗೆ ಹೇಳ್ತೀಯಾ ವೈಡ ಆಲ್ರೆಡಿ ಇಟ್ಸ್ ಅ ಬೌನ್ಸರ್ ಸೊ ಬಿಕಾಸ್ he bought it when he was a PROI did a transaction outside India. It will not attract FEMA. I hope nothing to do with citizenship, where you were, where you are, correct? Okay, nice questions, no? Bhavesh, Yash and Chirag Incorporated LLP for doing the business of trading of timber under the name Solid Lakkad LLP. Chirag has shifted his residence from 12th block C, Kamla Nagar, Agra to 808 Bodla, Agra on 16th November 2023. Okay, he shifted on 16th November he shifted. Okay, Chirag informed the firm about change of his address on 20th November. Okay, 12th he has shifted, informed to LLP on 20th November. Sending a written notice, now by which date Solid Lakkad LLP is required to file a notice with the registrar. Any changes in details, you have to intimate ROC within 30 days. So by what date?
16th.
Within
16th, sir.
16th. Where which one I wrote it wrong? Okay, 16th it is. Within 30 days from when? 16th. Yes, sir?
16th December. Yes, sir. C.
16 December. Huh?
Option C.
You know what is the actual question there? I mean, answer is 30 days. They are trying to confuse you between two things. 30 days from you intimating LLP na, 30 days from the event happening. That's the at least I believe 40% of the people will go wrong. You will write from the day that is communicated. Today only we did LLP. 100 times I stressed on a point. 30 days from the change. 30 days from the change. Now children ಅನ್ಕೊಂಡ್ವಿ. Okay. Okay, drug software INC. First we'll see of the question. Nawaz and Lavina. Okay, answer ilva. Okay. We have to read. Okay, drug software company INC, a company incorporated in Australia, proposes to establish a place of business at Mumbai. So what are they talking about? Foreign company. The list of directors include write off the details. Arun, Ranvir, Ramesh and Nawaz are the directors. Okay. Lavina has been appointed as a secretary. Lavina is a secretary of drug software company INC. It is to be noted that Mr. Ramesh Malik and Mr. Nawaz, resident in India, are the persons who have been authorized by drug software company to accept on behalf of the company service of process notices. Okay, they are nothing but authorized representatives. Who are they? Ramesh and Nawaz. Same people only, no? Ramesh and Nawaz only are coming as authorized representative as well. So they are having both the capacities. Okay. Required to be served on drug. In relation to company's establishment, you are required to enlighten the drug with respect to whose declaration will be required to be submitted to the registrar for not being convicted or debarred from formation of companies in or outside India. When you are coming and establishing a place of business in India, you have to give certain documents to ROC, FC1. In that you gave one declaration that we are not disqualified from any authority in India or outside from forming any companies. You have to give a declaration. They're asking you who and all should give. I feel it is a little tricky one, but you can manage it if you guys know the rule properly. So tell me, what is the rule?
Wildly guess. Residents shall give declaration.
So one interpretation is they would have given only residents should give declaration. Next one, director and MD. That's a second interpretation. Third one, is secretary also is to be given? One place secretary will come. No. In FC1 only you will give. You will give the details of the directors and secretary of the principal company. Details will be mentioned. Details is different, declaration is different. Correct? The declaration will be given for directors and authorized representatives. You need to give a declaration for both. Yes, sir. Luckily it is same. Yes, sir. Okay, we'll see. Simple. Wherever Lavina is not there, first, if Lavina is there, take off the option. Definitely no. Secretary need not give a declaration. Okay. Arun, Ramesh, Nawaz, Lavina, obviously no. Here 1% definitely is short. I know 4 people has to give. So I'm going with this. Correct? Okay. Question wise, I hope it's a easy one only, provided you know the law. In our summary chart, specifically, we would have written this also under the documents to be given. Okay. Ram Private Limited is a holding company of Lakshman Private Limited. 1 second. 1 second. I will go. Okay. So the company secretary of the company advised that the directors of the company cannot be categorized as a small company. So small company. Ram Private Limited is a holding company. Lakshman is a subsidiary company. Okay. Its turnover is 1.8. Its turnover is paid up capital is 80 lakh. The board of directors wants to avail the status of small company. So sir, whatever it is, sir, end of the day, whether Ram or Lakshman, I am writing according to the definition of small company, 85. We saw this, started our marathon only with that. Small company, holding company, statutory companies, Section 8 companies cannot be called as a small company irrespective of your capital and turnover. Agreed? Yes, sir. That will be my answer. How will you write your answer, people? I can write my answer in 3 ways. The first one will be provision of law. I will clearly write according to, or I will write as per the section, as per section 2 clause 85 of Companies Act. Small company is a company other than public company having a capital not exceeding, turnover not exceeding, but does not include holding subsidiary, Section 8 company, statutory companies. Provision, the second one will be my facts. According to the given scenario, Lakshman Limited is a subsidiary of whatever it is. Let us imagine Ram Limited is a holding company, Lakshman Limited is a subsidiary company. Whatever they have given, I might be wrong. You got the concept, okay. Okay, now I can say, now according to the scenario, whether Ram Limited or Lakshman Limited, will they be considered as a small company? That is the facts of the case. My conclusion I will write, considering my provision and facts of the case, because it's a subsidiary company of so and so, the company cannot be considered as a small company. And what is the words exactly you will use? See the question carefully. The provision of company, you are required to examine whether contention of CS is correct. My answer will be the same. Conclusion, yes, the contention of, he said whether it is possible or not possible. Not possible. You will say, yes, the contention of CS is correct. It is not considered as a small company considering the facts as well as provision because it is a subsidiary. You write this way. If you do not get full marks, write again. Okay, Prakash and some of his friends are members of Focus Limited, a company with a paid up share capital of 1 crore. They all intend to propose a resolution at the forthcoming general meeting of the company, which is okay. Okay, shareholders wants to propose some meeting, it seems. is going to be held in CP New Delhi, the place where Register Office of Focus is situated. Okay. Kindly provide the guidance to Prakash and his friends on the requisite minimum paid up share capital they should hold to initiate members resolution. Members resolution. Section 111 says, what is members resolution? 3/4 of? Hey, ordinary and shareholder allada.
Members,
100%. Oh, okay, nice. Sir, how many of us are confused between section 100 and 111? How many of us think the answer is section 100? We are making a request to the company to conduct a meeting.
there are no, they're asking for an agenda to be included in the resolution.
Correct. They're asking specifically for passing a resolution. So, section 111, members resolution. If at all it is a resolution to be passed or anything other than a resolution which does not require notice, like a statement. 6 weeks or 2 weeks, that provision. They're asking you, guide them. How many people should make a request? 1/10 of the paid up share capital having a voting. People entitled to vote. Correct? Yes. So in this case, what is the paid up capital? 1 crore, 1/10, 10 lakh, entitled to vote. Now these people will make a request. So that's an advice you are giving. Mr. Prakash and Co. So you know how you will write? Provision of law. Provision first explain of. First see the second question. What are the other requirements the Prakash and his friends need to keep in mind for moving a members resolution? So write about 111 first. Or you can write it this way also. 100 first I'll write. To pass a resolution, the minimum requirement is, according to section 111 of Companies Act, minimum 1/10 of the total paid up share capital entitled to vote shall make a request to the company. That is a number of requests. They are asking me how. The things that you need to keep in mind, they are asking you, guide them. You need to give a request at least 6 weeks before the meeting if at all the resolution requires a notice. If it does not require a notice, 2 weeks prior is also sufficient. And you need to give, the requisition has to be signed by all the members. So basically I will cover those points. Anything the thing, so that is what you will cover under 1 and 2. One is request by how many people and this one. Okay, quite easy question only. Provided you remember the limit. Limit is that's all. That's it. Nothing else is there. PQR Private Limited operates as a manufacturing company, generating a turnover of 150 crore and holds an outstanding loan of. Okay, 1 second. Company generating a turnover of 150 crore. So what is the question?
Internal auditor.
Okay, internal auditor. Oh. 25, 50, 50, 100, 100, 200. That is a question. Okay, Private Limited operates as a manufacturing company, generating a turnover of 150 crore and holds an outstanding loan of 75 crore from a public financial institution solely in the previous financial year, with a total loan availed 110 crore. But 35 crore were repaid during the same year. So they took 110 crore, but 35 crore were repaid. Correct? And outstanding loan is at 75 crore now. Correct? Okay. The company's board has delegated the authority to CEO to designate an internal auditor to conduct an internal audit. However, the CEO believes that the company is not legally obligated to have an internal auditor. Analyze the accuracy of the CEO's perspective by referring to the provisions outlined in the Companies Act. What would be your response if the board of directors wants to appoint Mr. Nagendra, an ex-employee, as a CEO? If you look at it, people, there are 3 questions according to me. First one is applicability, because it's a private company. All 4 conditions will not apply. Yesterday only we saw on shortcut L&T Private Limited. So I'll only look at Aditya when I say shortcuts are important. In the exam you will not know which are the 2 conditions that is applicable. In marathon also we saw the same thing. L&T Private Limited. Loan and turnover is applicable. How much is loan and turnover? Loan is 100, 200. In our case, how much is turnover? 150. How much is loan? How much? 110 crore, 35 crore. Remember, loan at any point of time is 100 crore. What do you mean by any point of time? Throughout the year, it need not be 100 crore. At any given point of time, even one day it has touched 100 crore. You will come under the eligibility. So 100 crore is covered, sir. Now because of that, people, for this company, audit committee will be applicable. My first answer. Second answer, the CEO is of an opinion that we are not under an obligation. I will clearly write, the CEO's contention is not correct. The company has to appoint an internal auditor. There is a third question. What is that? Mr. Nagendra, an ex-employee who is a qualified chartered accountant, as an internal auditor. Yes, people, can a CA be an internal auditor? Possible. The question would have been challenging. What if he is a CA? Can he be appointed as an internal auditor? Meaning, if he is a chartered accountant appointed as an auditor in the company, that time not possible. Correct? Easy question only. Okay, the governments of Tamil Nadu and Andhra Pradesh collectively holds 60% of paid up equity share capital of Orange Limited. So it's a government company. The audited financial statements of Orange Limited for the financial year 22-23 were presented at this AGM convened on 17th August 2023. 17th August, date of AGM. However, pending the comments of the Controller and Auditor General of India on the said accounts, the meeting was adjourned. So pending comments, that means people, the accounts were not adopted. Then easy, you know which question it is. Therefore, the company did not file its financial statements with the registrar of companies. Afterwards, on receipt of CAG, the adjourned annual general meeting was held on 20th September 2023. Okay. Whereat the accounts were actually adopted. Thereafter, Orange Limited filed its financial statements relevant to financial year with the registrar within 29 September 2023. Examine with reference to the applicable provisions of Companies Act whether Orange Limited has complied with the statutory requirement regarding filing of accounts with the registrar or not. Have they satisfied the condition? So two things, people. Whenever the accounts are unadopted, you need to file unadopted accounts also with ROC. ROC will consider it as provisional in his books. Whenever the accounts are adopted, you need to file the accounts after the AGM is conducted within 30 days of AGM. Financials, no. Yes, sir. When did they file? 29 September they filed. Obviously, 30th September is the last day. So they have filed the final one properly. The unadopted one they have not filed properly. So I will write it as it's a partial compliance of law. Unadopted should have also been filed, and that is a non-compliance they have done. Agreed? Yes, sir. Okay. NOP Limited, since its incorporation 2002, is engaged in production of premium quality glass bottles. Okay. According to financial results of the company, the net worth of the company was 90 crore and turnover of was 510 crore. Eligible company, deposits. Okay. What is eligible? Who is eligible company? First one is NOP Limited. Limited. That means, see, name says everything. It's a public company. Next one, net worth of 100 crore. Or and both conditions are one condition. One condition. Next one is turnover of 500 crore. One condition not satisfied. One condition satisfied. So, sir, this is not satisfied. This is one condition satisfied. It's an eligible company. Okay. What is the question? We'll see. The company proposed to accept deposits as on 1st Feb 2024. They accepted deposits. Okay. They proposed to accept deposits, which would be due for repayment on 30th September 2028. So, they accepted on 2024. They repaid on 2028. Okay. Furthermore, the company has accepted a loan of 1.5 crore from Mr. P. Kishore, director, and the loan has to be repaid after 24 months. Company in its books of account records receipt as a loan under non-current liabilities. At the time of advancing loan, Mr. P. Kishore affirms in writing that such amount is not being given out of his funds. Okay. The same has been disclosed in board's report also. Okay.
Private company direct.
Public company के director, private company के director and relative. Whether company was eligible to accept deposits from public. What is the criteria for acceptance of deposit and tenure for which deposit can be accepted? Whether company was eligible to accept deposit. Yes, sir. Yes, sir. It is eligible company. You will write all three conditions. Public 100, 500. Okay. What is the criteria for acceptance of deposit? Criteria is that only 100, 500 and public. And what is the tenure the company can accept? Minimum is 6 months, short term 3 months, but not more than 10% of paid up share capital. Free reserve, securities premium. Correct? Short term I can take it, but not less than 3 months. That is the tenure I'll write. Whether the tenure decided by the company was in accordance with the provisions. Tenure. Day. Try to calculate. 1st Feb to 1st Feb 25, 1 year. Right? 25 to 26, 2 years. 26 to 27, 3 years. 27 to 28. Clearly they are going beyond 4 years. That is clearly beyond 48 months. Maximum is 36 months. Tenure is not right. Agreed? Easy? Yes, sir. Okay, tenure is not in accordance with. So do not invent your own words. When you are writing the conclusion, this has to be the conclusion. It is not in accordance with. With reference to the loan advanced by Mr. Kishore to the company, whether the same is to be classified as deposit, the answer is no. I will give a justification because they have properly given a declaration and also it is disclosed in the director's report that it is not out of borrowed funds, it is out of his own funds. Correct? Next one. Fine Publishers registered in Tokyo began operating in India during the financial year 2009. The company has duly submitted all necessary documents to the registrar within a specified due date. Technically 30 days. Have they given in timeline? No. On 1st March 2023, Fine Publishers has shifted its principal office in Tokyo. Is Fine Publishers required to undertake any steps due to change in address of principal office? Give your answer in reference to Provisional Companies Act. We saw both the form names also.
We have to intimate about the principal office and its address to our
Any form?
form. I don't.
We wrote that also. FC1, FC2. Initially you will file it. Changes also you will file it. Agreed? We had seen this also. Yes, you have to intimate. Any change. People, simple answer is. You know what is the answer? Any details filed with the registrar when you set up an office. In that any details change, you need to intimate. Director, secretary, everything will cover under that. No, because I would have given the details. LLP. Mohit is a creditor of ABC LLP. He has a claim of 10 lakh against the LLP. However, the assets of the LLP are valued at only 7 lakh. Now, Mohit seeks to hold the partners of the LLP personally accountable for the shortfall. Is it liable? No, people, limited liability. Partners are liable only to the extent of the capital contribution. The partners will not be held personally liable or unlimitedly liable. That will not come. So, in this case, no. General Clause Act. Yogveer Singh has a mango orchard. Mango, it will come. If not, orange will come. Fruit also won't change. Question is very simple. Pakka immovable property. The orchard has more than 100 mango trees. Yogveer Singh has sold orchard along with all the mango trees. Oh, people, two things. He has sold along with the mango trees. So mangoes also sold, mango trees also sold. Explain in lights of the provision of General Clause Act whether the sale of trees will be considered sale of immovable property. The answer is yes, sir. Because have they given any details about when they are cutting it? As long as things are attached permanently to the earth, it is considered as immovable property. Once it is agreed to be severed, cut, it will be considered as movable property. What is the principle? Mango is also immovable property only. Right arising out of the land, anything attached to the earth. Correct? What does the principle reading the statute as a whole imply in interpretation of statutes? Explain with the help of an example. You need to read the statute as a whole. You cannot break it and read it. You can give so many things. Article 37 also you can give. Article 13(2) and 368 also. You need to read as a whole. You cannot read this part and this part. So when a law is made, you need to read it as a complete document. I can give a reference of also. Section 101 talks about notice of a general meeting. Correct? Section What is that? Section 20 tells me that if at all a post is given, it will be delivered within 48 hours. 101 also, but it never, they say to add, but it is said that if you have sent, it is assumed that in 48 hours it will be delivered. So I am taking that assumption. That is what it is read as whole. Correct, huh? Okay, but you can give any example also. You have to read it as a whole. Next one, Mr. Shivesh, an Indian national, desires to obtain foreign exchange for the following purpose. Remittance of USD dollar 50,000 out of winnings on a lottery ticket. Lottery pakka will come. Without lottery, they cannot give you a question on FEMA. Can they do it? No. Please write under schedule 1 of current account transaction. You will get out of out. No one will touch schedules and rule. Pakka. But we have clearly classified it. I hope that is clear. Next one, US dollar 1 lakh for sending a cultural troupe on a tour of USA. Advise whether he can get foreign exchange. Cultural, where will it come? Schedule 2. You need to take central government approval, prior approval. Correct? That's all. So by this we complete your RTP. By this we complete your marathon. I hope this helped. Wish you guys all the best. Make sure this counts. Do let me know once the result come. Pass or fail. It is always attempt that matters. It's clear all of you? I believe you guys have taken up other questions. MTPs and all. If possible, what I tell you is people go through MTPs and RTPs. It's very, very important. It's clear all of you? Yes. So that's it from my end. Online people, I hope you guys were also able to learn something. If you guys have any doubt, I'll try. You can ask, but I'll try, but I'm not sure on it. But I hope it helped. Do let me know what is your result. We will definitely be the most happiest people if something works out really good for you. Thank you so much, people. Wish you guys all the very best for your exams. God bless you.